Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. All right. Good morning. Good morning. Good morning. How's everybody doing? How are all my biters in the bite club over there? How are you, Kurt?
I'm doing great.
Welcome for the first time, Daniel. Daniel from Black Belt Barrister. How are you?
Thanks for having me. Yeah, pleasure to be here.
I am so excited for this. We've been talking for a while, ever since you showed up in the chat during one of the live streams, because I had mentioned, I was like, I really would like to talk to a UK barrister so that we can talk about the UK trial. And so I'm very, very happy to have you here.
Oh, happy to be here, and thank you for having me. So many people might not know it's a split profession over here. So we have two branches of the profession, so solicitors and barristers. Barristers typically in court with the wig and gown that you probably see coming out of the courts of justice, which you can probably see over in the background somewhere here.
Exactly. So awesome. So why don't you kind of tell us a bit about what your channel's about, how you started your channel? Basically give us a little bit of a background.
So it's very similar, really, that I started this to help people understand bits of law, one video at a time, as I say. And it's the second channel I've started, but the first one was for martial arts. So it's probably easier to start there because I had so many people coming to me for one-to-one sessions. I've trained and taught for many years. And so I started the channel. That was many years ago. The same thing happened here with law, but during the pandemic and the lockdown. So found myself with more time on my hands. And so many people asking questions and can't necessarily afford the legal advice, or it's not worth paying for legal advice. So I thought this is the best way, as you probably did, to explain little bites of law one at a time. And the channel grew through the lockdown, and I've kept it going. And it's a lot of fun, helps a lot of people. I love getting the messages that say, you know, the videos are really useful. It's helped me resolve a problem in 20 minutes just by overwhelming them with evidence and everything that I say you should do, that we do as lawyers, to keep the evidence, keep a chronology, keep it consistent, and research what your position is, put that across. That's what I aim to do with the channel. And so I'm pleased that it's great. And congratulations to you, by the way, on 200,000. That's just amazing.
Thank you. Thank you. Thank you. Absolutely. And that's awesome. I mean, it sounds very similar to my story when, you know, having a little bit more time on your hands during the pandemic.
Indeed.
So deciding to start the channel to just to explain the law to everyone. So let me introduce you also. I know you met Kurt backstage. We've also got Nate the lawyer. Hey Nate, how's it going?
Gotta unmute myself.
Yeah. Oh, okay. and then we've got Rick Hogue from Hogue Law.
Hey there. Good morning to me. I think it's probably afternoon to you, if I'm guessing correctly.
It is over here. Yes, it is. It's coming up to 2 in the afternoon. But
yeah, for sure. So anyhow, so I know a little bit. I know some bits and pieces about the UK trial, and just for viewers, so that you know, I am keeping track of any kind of video from the courthouse for a verdict and whatnot. It looks like the only feed that is up right now is Law and you know what. So I don't want to be showing their feed because I don't want to get any kind of copyright issues. But I am keeping track of it. And so far what they're showing is the outside of the courthouse. So it's nothing on the inside, nothing crazy going on. So we'll be keeping track of that throughout the day. And yeah, basically that's about it. If anything changes, anything happens, we're going to be pulling up live streams right onto the channel, and then so that we can all watch together any kind of pertinent information. So,
and I'm sure we look forward to your verdict is in trolling chats throughout the day. So, enjoy that. Enjoy that. I know it's fun.
They've already told us that they're going to give us not less than an hour's notice. So we're not that easily fooled.
Yes.
The judge is back. The jury's back.
The jury's back.
A lot of those. Yeah,
big hearing happening right now.
Yes, of course.
Yes. Hey, black belt barrister. I got to ask, because as soon as I saw you were coming on, I was like, this is the question I got to ask this guy. And I know it's just me just jumping right into it.
Yeah.
But what the hell happened in the UK trial? Because I don't know what the hell's going on. Looking at this trial and looking at the UK, it's like, how do we get to such different results? If I'm jumping too far down to it, please just,
No, absolutely. No, I'm a flexible approach to this. There's more than one approach you could probably appreciate, but there's a couple of fundamental differences in the trials, and it really revolves around, from my view, it revolves around the defendants in the UK trial, which had a significant bearing on the evidence before the court. So because of who the defendants were, it dictated or curtailed to some extent the evidence that was coming forward. So what you will call discovery, we call disclosure. So the discovery or the disclosure of material was much more limited. It was limited to the defendants in the UK trial, and anything outside of that is what we call a third-party disclosure. So any third party, and you need permission for that generally. So you need to ask the court, may I rely on evidence from XYZ party who is not a party to the proceedings, not a defendant or not a claimant in the proceedings? And we'll get to it. And some of this was requested and denied. And so that, together with some other evidence that was a particular witness evidence that was not called, that there's a snowball effect. That plus, I know there are conspiracies. I'm going to call them conspiracies because I don't have evidence or facts one way or the other, as to perceived bias by some, which we'll come to as well. And that's all it is. And I'm not going to comment further on it. I'm going to say that's what it is. That's what it's seen by many people.
Right.
So there's a lot in this. I mean, it was a 129-page judgment, it's an extensive judgment. And for those that don't know, there was the appeal as well. So the appeal followed and the appeal was refused. And there are very narrow reasons why that was refused, and we'll get to that as well. But again, I'm probably jumping ahead now as well.
Oh, well, one quick question that's been hitting the headlines now. Even yesterday it came up again. Was the perjury issue? And the perjury issue they're talking about specifically with the UK didn't really have anything to do with the allegations, but the donation versus pledge issue, and that the judge's decision kind of had some dealing with the fact that Amber said that she didn't receive these funds, so that took away that motive for her to have done this or to make these things up for money. Is there any truth to that, or is any grasp at straws for that one?
It's addressed in the judgment, but it's not really addressed in the same way as, I mean, as you say, when I'm watching the US trial, my biggest question mark there is why was this not investigated a lot more in the UK trial? And it wasn't really a question of whether she'd actually paid it as opposed to pledged it. It was more as to what her motives were for being with him in the first place, i.e., was she a gold digger? And the judge came to the conclusion that she was not, because she pledged this money. And in the judgment, somewhere that I'll find in a moment, says that that's not what you'd expect from a gold digger. So again, we'll come to it. It's in the judgment. It's a long judgment. So I don't propose to go through all of it, but there are select.
Oh yeah. No, those are just like the two questions that I was like, What's up with this perjury thing, and what the hell just happened? But the UK, because we all were theorizing, and it's good to hear from a practitioner, because that's kind of what we all said. And in the US case, Amber is the defendant, so you can get a lot more. You can get medical records, things of that nature, because she's put that at issue, right? I have PTSD, so I can get you a psychological exam. When in the UK, if it's the son, you can't get her medical records in because they're privileged. So those nuances, but it really does show you too. The truth is really hidden behind these rules of evidence, because I think if you have the same rules, if you have the same evidence in front of the UK court, I do think you come to a different conclusion. But again, these rules are made to try to make the process fair.
Exactly. And these rules on third-party disclosure, they are there for a reason, because when I try to explain it to somebody, obviously not to you, but to people watching, when I try to explain it to somebody, I say, well, if there were no rules and it was a free-for-all, then you could go to court, you could sue somebody and say, I want this list of people to give evidence and they must come in. And if that was the rule, then there's nothing against it. Then suddenly you've got a lot of people that you're calling upon to give evidence, and there's not necessarily a good reason for that. So the good reason is born out of this requirement to have permission to adduce third-party evidence, third-party disclosure, get them to look for documentary evidence, compel them to submit bank accounts and so on and so forth. And if there weren't rules for that, it'd be mayhem. But this is why, coming full circle, for me, the fundamental problem in the UK case is who the defendants were. Now, I've heard sound bites of people saying, well, at least it allowed him to put his version out, win or lose. But at the same time, he could have put a statement out, so that there's varying views on that. But for me, it was who the defendants were, I think, had a drastic effect on the trial. Not to mention the rest, which we can talk about.
Yeah, no, and that would have made a huge difference in the United States as well. I mean, if Johnny Depp had sued the Washington Post as opposed to Amber Heard, that would have been a major difference because of the standard of actual malice, because it's much easier for anyone to say, okay, the person that says that things happened to her, if you can decide that she lied, you could probably decide that she lied knowing that she was lying or with reckless disregard as to the truth or falsity of it. But there's a lot more that would be required to show for another party that is relying on the words of that person that accused the person of it. So it's much, much harder in the United States to make that showing if it is against someone like the Washington Post. And it would be the same. Like I've said this many times, it would be the same thing if the Sun trial were in the United States. It probably would have ended up having the same result because of that standard.
Indeed. But interestingly, the point you mentioned about being honest, dishonest, willingness to be honest and dishonest should affect credibility. And this is one of the things we'll go through when we talk about this sort of in more of a chronological order. But the statements or willing to make statements which are perceived to be dishonest should affect credibility. And there's certain parts of this judgment where I do take issue. Now, I'm not quick to criticize a judge, let alone a high court judge, but I'm entitled to my opinion. And there's parts of it that I just disagree with. I think that it should have affected credibility. And the way I justify that is, as all of you would, if I were advising somebody, again, this is for everyone else's benefit as well, but if I were advising somebody as to good character, bad character, not that this was a criminal trial, but the judge even said, I'm applying those guidelines. So let's put it this way. In a criminal trial, if you've never had a previous conviction, you've never been remotely close to being prosecuted, you are of utmost good character. That goes in your favor naturally in a criminal trial. Those rules don't automatically apply in a civil trial, but the judge can adopt whichever approach and treat the evidence however he or she wishes. And in this judgment, the judge actually expressly said, I will apply those guidelines, and looked at credibility. But in doing so, looked at many of the statements and the emails, particularly with respect to the assistant, not assistant, and drew conclusions that there was no adverse impact on the credibility of her. And I would have come to a different view. So circling back, if I were to advise somebody and I went back through their previous correspondence, statements, things like that, I would be advising that this will go against your credibility. And that's what I would advise. And I stand by that advice. That's what I would say. And so this, for me, this judgment contradicts some of that. So that's why I justify saying that my opinion is, and I would take issue with some parts of this. And obviously I'm being respectful and polite, but as I say, I can disagree with some things.
Of course.
We've said horrible things about some of the practitioners and some of the cases that we cover, so it's more than okay, right? Kurt loves all Supreme Court decisions. You'll never hear him say an unkind word about Supreme Court, right, Kurt?
I have some unanimous Supreme Court decisions. Wilbur, let me tell you all about it.
Yeah. I've got a video on that, Kurt. It's a good time.
Oh man. So let's start by going through the claims that were in the underlying case in the UK. Do you happen to have any of the documents that we could look at that would outline those by any chance? Or maybe even just looking at the opinions, we could get that information too.
Yes. How about what I'll probably do is if I've got some slides to
I can share this
of the judgment, but
I've been calling you the British Holmes.
Demonstrative. Look at this.
There we go.
We got another slide guy with us.
Excellent.
Welcome to the war.
I love slides.
Yeah,
So-
we love slides.
So these sort of in line with what I was going to talk about. So the reason I've started with this is because obviously this the lower court decision was appealed, and I say appealed. They requested permission to appeal because we need leave or permission to appeal, and that was refused. Now, I should start by saying that permission to appeal a judgment in the UK is notoriously difficult. They are very rare. Appeals are rare by the grand scheme of things, and typically the test for appeals, which is actually another slide, but I'll come back to it. The test is that there's got to be a real prospect of success or a compelling reason for it to be heard. But when thinking about that, the appeal court is not really looking at the decision of fact made by the judge or the finding of fact made by the lower court judge. More, was there an error of law? Was there an error of procedure? Was the decision flat out wrong on that basis? Whilst looking at this, is there a real prospect of success? And so for those that don't know, the UK case was about an article published by The Sun referring to Johnny Depp as a wife beater. Later, that title was changed, but the original title was Gone Potty, How Can J.K. Rowling Be Genuinely Happy Casting Wife Beater Johnny Depp in the new Fantastic Beasts film? And that was later changed. But the two defendants for that was News Groups Newspapers Limited and Dan Wootton, the author of the article described as the executive director who wrote this article.
Quick,
and obviously the company that published it.
Quick question about about the process, because here in the United States, appeals are really just matters of law. The appeals court don't really go into factual matters. So is it the same there in the UK, or can the judge open up the books and look at the facts and make factual determinations, or are they really strictly confined to legal issues or issues of law?
Yeah, so you're right. It's broadly the same. There is a provision for new evidence, but the default position is that there will not be evidence in any appeal that wasn't before the lower court. So as you can see on screen here, sub 2 of this is our civil procedure rules. So all cases must follow these rules. unless it orders otherwise, the appeal court will not receive oral evidence, that's people coming to court, giving evidence in court, or evidence which was not before the lower court. So it is limited to that evidence. But when looking at that evidence, that the appeal court will look at how the decision was reached whilst looking at the evidence in line with the law, in line with procedure, and then determining whether that was wrong or unjust, and so on.
And just
so yes, broadly the same.
And just to make the point for the chat, in the UK, these are all judges decide both the facts and laws in the lower courts, not juries, right? You guys don't have, do you guys have jury civil trials, or is it judges?
Yes. So it's a very interesting point, which I was going to come to later, but I'll summarize it now. So there is, and it's within, let me find it on here. It's section 11 of the Defamation Act. So I'm not sure which slide that is. Hang on a minute.
Oh no, we can come to it later. I just was.
Yeah, it's an interesting point as it comes up, but
yeah.
I'll find which slide it actually is. Slide 5, I think. I don't know if I can control. Yeah, can I control that? Yeah, I think I can control that.
Yeah. Yeah. There you go.
This one, yeah. So this is from the Defamation Act. So the underlying claim was, of course, defamation, which I'll come back to explain in a minute. But the default position here is the trial is to be without a jury unless the court orders otherwise. But this raises an interesting point. So the default position for civil trials is there is no jury. It's a judge that makes the decision. And the reverse for criminal trials, at least when you get to a Crown Court, it's the jury. But we also have a lower criminal court, which is either a single judge or a magistrate, which makes the decision in the criminal cases. But the serious cases, it's decided by a jury. But here, the default position for a defamation case is that it's to be without a jury unless the court orders otherwise. The interesting point this raises is that the court could have ordered this to be heard by a jury. And I think that's very interesting, because I think that would have had a different outcome. So that's my interesting point for that. That's why I bring that up now, because you mentioned juries. I think that's interesting because I think it would have been a different outcome. It very likely could have been a different outcome.
Interesting. I want to ask you about that real quick. Let me just get this super chat right here. Detective Seeds, thank you so much. This is very generous of you. Says, you all look well rested. Verdict today, I hope. Also, hi, chat and fellow investigators. Yes, it was so great having Detective Seeds on the channel the other day. I'm looking forward to having him back. But I'm very curious about this question of how they could have had a jury trial in this case, but decided not to. What do you happen to know, like, what the standards would be for that kind of a decision, and why in this case they would have decided not to, maybe if they should have? Like, what goes on with a decision making like that?
Well, I'm not aware of any discussion about it at all, or any application about it, or anything. Okay. Just that I was looking into it, throughout the trials and in preparation for this. But and I thought that's interesting, because the fact that it is in the legislation, the fact that it mentions this, it provides that the court could order to be heard by a jury. And I think it's interesting because in certain cases of gravity and magnitude, as we say with the burden and standard of proof, again, we'll come back to. So the more serious a case, the higher the standard needs to be, even if it's the same legal definition of a standard as another case. So in a civil court, it's on the balance of probabilities, which is literally 51%, just more likely than not. However, the more serious, the stronger that has to be, the stronger that decision has to be. So in my view, if there were a proper application for this to be heard by a jury, it should have been granted because of the size, the publicity, and so on. I think it should have been decided by a jury. But that's,
Interesting.
It was an interesting tangent while I was looking at it. But yeah, the reason I start with appeals is really to explain what we just discussed, is that it isn't a rehearing unless the court orders otherwise. It is just a review of how the decision was reached and whether there was an error of law, procedure, and in doing so, is there a real prospect of success?
Yeah, that tracks with our standard as well. That when there's an appeal, it's not a retrial, it's not a rehearing. It's just examining the process by which that decision was made and trying to figure out if there was some sort of an error in that process.
Yes,
I am curious about this aspect where appeals have to be granted, because that's so different than the United States, because appeals on the first appeal is a matter of right. Has that always been the case in the UK, where you have to get permission to appeal? Or I'm also
in civil
curious.
cases, yes. In criminal cases, it's different. So we have what are broadly described as 3 types of criminal cases: summary only, which means it's not very serious, it stays in the magistrate's court, which is the lowest criminal court. Then we have indictable cases, or indictable only, which can only go to the Crown Court, which is more serious. And then what we call either way. And I say that they're referred to as 3 because the either way is, it could be tried summarily, it could be tried on indictment, but an either way is still an indictable offence because it can be heard in the Crown Court. But so with that said, there's an automatic right of appeal from the magistrate's court to the Crown Court. So if you are convicted by a single magistrate, for example, you have an automatic right of appeal to the Crown Court to be heard by a judge. And in that case, it's still not by a jury, but it's a judge and 2 magistrates. And that is different. That is done by way of a rehearing. So in criminal, it is different. In the civil courts, you do need permission to appeal. So you have to apply for permission first, and that is the first step. And if permission is granted, then you go and the appeal is actually undertaken by the appellate court.
What's the appeal from the Crown Court? What if you're just starting the Crown Court? Can you appeal from there?
There's different ways of appealing. So there's one thing we call appeal by way of case stated. So the case itself is stated to go to the Court of Appeal for a question of law to be asked and answered. And if the law was applied incorrectly, for example, then it can be overturned, quashed. So it gets quite complicated, the appeals process. But there's a whole appeal structure which goes to the view that judges can be wrong, and unless it's all the way to the Supreme Court, which is our highest court at the moment, until it goes there, then there's no other route.
Okay.
So our test for appeals is here. This is again from our civil procedure rules. So as I said, it has to have a real prospect of success. And this is important, is based on, this is why I started with the previous slide, is based on the evidence that was before the court in the first place. So the default position is only the evidence and the route to decision that was used in the first trial, the lower court, and is there a real prospect of success based on that, and then otherwise any other compelling reason for it to be heard. And then the default position again, in giving permission, it would be limited by issues and there may be conditions. So I wanted to just go over that briefly, just to say that for those that might have thought that an appeal, or it was an appeal and appeal failed, it was more that permission was refused, and it's a very stringent test. So permission to appeal is not given easily. And so I wanted to go over that very, very briefly first.
And so here's another question that people keep asking. Is there any mechanism in UK law at this point to further reevaluate / overturn / whatever the judgment with respect to the Sun case?
So there should be a route. If, let's say, for example, let's say the jury come back and it's overwhelmingly in favor of Johnny Depp. I say this is a significant difference, and it would be out of time. It would, like for the UK, it would be out of time, and it would be adducing new evidence, and so on. But there's nothing to stop a request on that basis, on the basis that there is fresh evidence, and so that's something that could be explored.
I mean, I wouldn't know for sure, but because as we're both well aware, the standards in the UK for defamation, like you expect the standards are so different that you expect the verdicts the other way around, right? So
yeah,
if they find defamation in the US and don't find defamation in the UK, it's like, what's up with this? And so you would imagine at this point that the UK might be interested in further reevaluation because they look like they have a bit of egg on their face at this point.
Indeed. That's something that I've been considering as we've been watching the trial and reviewing this one. So
yeah,
this slide, I think, was the conclusion to the permission to appeal. So you can see there was the application to adduce further evidence in the application for permission to appeal. But it even says, which is why I highlighted it, it's not easy to persuade this court to overturn findings of a trial judge purely on factual questions, which effectively they were. In other words, it wasn't a question of law. It wasn't a question of procedure. It was more, well, there's more evidence here, and the evidence wasn't looked at properly, but those are not reasons that the court is going to give permission to appeal for.
Yep.
And so because of that, the court said, we do not believe there's a real prospect of it being prepared to do so in this case. And it says it was full and fair, and he gave thorough reasons for his decisions. Whilst the judge did put reasons within the judgment, I do feel that there are assumptions within that judgment, and many may feel that there were too many or too broad assumptions. And again, we can go through some of those, but
yeah, for sure.
But typically, I mean, overall, there are always going to be some inferences and some assumptions made by a judge, because that's what they are there for. No pun intended. It is we need to rely on the judgment of a person who is upstanding in community, and that we rely on to give a just decision. And if it's not a jury, then it's a judge. As I said, I feel this ought to have been with a jury, but that's by the by. But throughout this judgment, I believe that there are a number of inferences and assumptions made by this judge. And whilst there were reasons, on many occasions we can go through, it seemed to me that Amber's word was taken on face value against other evidence, which was effectively discounted. And I didn't feel, again, I'm not quick to criticize a judge, but I didn't feel that there was a substantive reason for discounting other evidence whilst taking her word, especially with the issues of credibility, which again I'll come back to. I keep saying I'm going to come back. It's a long judgment, but there was a lot to look at in this. But typically, in a case like this, in a civil case of this nature, I would expect a judge to say, I prefer the evidence of X or Y party, as a way of giving reasons for coming to the decision, and say why they prefer that evidence. And for me, the why is always important. If it's a simple case and you've got a senior judge and they just say, I prefer his evidence because he was more credible, then let's say I'm in a road traffic collision, which there's a low amount of damages. So we're just talking about a few £1,000s or whatever. It's not that serious in the grand scheme of things. So you wouldn't expect a judgment this length deciding a case like that. You would just expect the judge to say, well, I prefer his evidence because he was credible on the stand. He was consistent, didn't change his account, etc., and leave it at that. I would expect that. But in here, maybe there could have been more, is what I'm going to say. But this, of course, does put the judge in a significant position of power. And that's where we sort of circle back to this jury issue, because with the size of this case and the implications that it has, I feel it should have been heard by a jury. But that's
yeah. That does seem to have made a huge difference in this case, for sure. So So this is basically the appellate standard, right? And then
Yeah.
why it wasn't really granted on the appellate level. What about
Yes.
the underlying case itself?
Yeah, so that should be coming up next. So the serious harm, this is taken from the Defamation Act. So defamation was originally a common law sort of wrong. And it's been codified a couple of times, but it now stands in the Defamation Act 2013. And so the serious harm element has got to be sort of proven by the person who's bringing the claim. And that's not a particularly well, it depends on who you are, really. If it's obvious that there's the potential for serious harm, then that bit should be relatively easy. What we often get is we get inquiries from someone saying, my neighbor has told someone around the corner that I'm a bad person, there's serious harm. Well, you look at this definition here, the reputation of the claimant, and is there serious harm? Well, telling one person around the corner, one person hearing one person's opinion that this person's not a nice person, that's not serious harm to the reputation of a person. But publish something in a national tabloid newspaper, which has serious ramifications for a person, both personally, professionally, and in every sense possible. And it's going to affect a worldwide reputation and many millions of dollars in this case, or pounds, or wherever he's being paid. But the serious harm is relatively easy to show that it is likely to cause serious harm. So that's the first bit. But then the burden shifts. So there is there's more than one defense. It's typically its opinion or the truth. So if you were to say, this is my opinion, I think this person is not very nice because, and that's my opinion, then you can't be sued for defamation on that. And if you're making a statement of fact which is wrong, this person did X, Y, and Z when they didn't, that's not an opinion. If I said I don't like this person because, and that's my opinion, that's one defense. The defense in this trial, this UK trial, was that it was the truth. They claimed that it was the truth. And so that's when they went through all of the incidents, broadly mirroring almost in time the US trial, but to try to bear out that this was the truth. But then, and that should be the next, we've talked about being with a jury, possibly, come back to that one. Ultimately, they wanted to say it was the truth. So this is, again, within the Defamation Act 2013. It's a defense to an action to defamation for the defendant to show. So the burden is on the defendant for the defendant to show that the imputation conveyed by the statement complained of is substantially true. And these words are important as well. And so for with all respect to non-lawyers, every word counts sometimes, especially if it's a legislation. So here we have substantially true. It doesn't say just true or completely true, wholly true, fully true. It just says substantially true. So the gist, the general meaning, the general, ordinary, natural meaning of what the article conveyed would be true. Not every word of it, not every imputation, every allegation within it, just substantially true. So they didn't have to prove everything, just the bulk of it, the gist of it was true. And that standard of proof is on the balance of probabilities. So with everything we've said about how serious it is and serious damage to reputation and so on, the balance of probabilities is only 51%. I say only, it's just more likely than not. But as I've said, at the very least in my view, and it is within our common law, the more serious a case, the more sure a judge must be, even though it's still on the balance of probabilities. So
now here's a question. Here's a question for you on truth. We actually got this super chat that just came in. I heard in the UK defamatory statement doesn't have to be true.
Well, a defamation statement is just something that is likely to cause harm to the reputation of somebody else. So the first test, if you like, if you're bringing the claim, is that it's likely to harm your reputation.
Okay. Oh, and
One of
then
the
you ask
defenses,
whether it's
yeah,
true or not.
yeah, one of the defenses is that it's true.
I see.
And so this, I suppose, this super chat question really comes from the basis that if it's just your opinion, then yeah, it doesn't have to be true because it's qualified as an opinion. But obviously, being a tabloid newspaper, they want to, quite naturally, want to print things as fact. They want to say, this is what happened. This person is whatever. And in this case, alleging he's a wife beater, which is a significantly, I'm not sure if this is a very well-known phrase in the States, but it certainly is here. It's probably, I mean, domestic violence is bad on any level, but the particular phrasing within the UK has a fairly abrasive meaning even within the context of domestic violence. So I don't know how that sits there or what, but I'm going to skip through the slides here. Here we go. So yeah, no, it doesn't have to be true. It can be opinion, but if it's stated as fact, then that makes a significant difference. So yes, so as I've said, this is different to the criminal standard, and there are questions by particularly from legal academics as to certain cases should be borne out to the criminal standard and whether the balance of probabilities should more closely mirror the criminal standard when deciding sort of high profile cases. And I think that's for a lot of people to discuss. I think perhaps it should. And again, I think that's probably why in this piece of legislation there is at least a provision to have this case heard by a jury, or it could have been. So
okay, yeah.
So then we come on really to the evidence within the trial, and I think quite to the detriment, there were the statements of Winona Ryder and Vanessa Paradis, which were submitted in support, but they were not called to give evidence. And so the way this works here, and that's probably in another slide, I think. So this is from within the judgment. So you can see it here. The claimant has served witnesses from various other people whom he did not call to give evidence. And so there's a rule about, you no doubt have similar rules, but with hearsay, everyone will probably understand hearsay better than ever in history as a general public population. But hearsay, something that is not said in oral evidence. So it's any evidence other than someone standing in court and saying this is what happened. So any statement of fact or a matter stated not in oral evidence that should have someone believe or act, or a machine to act upon the basis that matter stated is true. So hearsay, if you don't call someone in to give evidence, or if you filed a statement, that takes it one step further. Then if you don't call them in to give evidence, the other party, and this is a peculiarity, but then the other party can put those statements in as hearsay if they want to. So to put this in simple terms, if I were bringing a claim, or if I'm bringing a claim for a client, and we take 3 or 4 witness statements from different people, and they are served in court, but then we don't call them in to give evidence, and so we don't rely on their evidence because then we just don't feel the need or the time constraints, as in this case. Then the other party can use them as hearsay if it turns out there was something in there that they want to rely on. But here they didn't, because obviously these statements, I say obviously, but these statements were in support of Johnny Depp, so they didn't put them in as hearsay evidence. So I'll go on here. So it says these include his former partner Vanessa Paradis and earlier girlfriend Winona Ryder. So the lawyer indicated that had they been called, they would have wished to cross-examine them on their statements, but that was immaterial. Since the claimant not called them, he was unable to rely on their evidence that they might have given. And again, that's within our civil procedure rules, 32.5. The claimant having chosen not to call these witnesses, it would have been open to the defendant to put the statements in as hearsay, but that was not something they wished to do because obviously it was to their detriment.
Yeah, that makes sense.
So that was
do
the blow, really.
Do you think that it was ultimately a really big impact that Winona Ryder and Vanessa Paradis were not called?
Well, if I start by saying it would be speculation.
Sure.
But having said that, yes, I think if they were called, I think it would be much more difficult to sort of rule out their evidence as well, if that were the case, if they'd come to court and given live evidence, which is what seems to have happened with those that did come to give live evidence, as we'll go through the judgment. But I feel it would have made a huge difference. Yes, I think it would.
So in the United States, obviously, it took, as we saw watching this trial in Virginia, it took Amber Heard saying the name of Kate Moss, basically like invoking her name, like Beetlejuice, essentially, in order to bring Kate Moss into the trial, because otherwise she wouldn't have been able to testify according to United States evidentiary rules, Virginia rules. So what role would they have been able to play in the UK trial with their testimony for that to have been, I guess, like acceptable and according to the rules in the UK?
Well, it's interesting because here you can call someone to give evidence, and it's not really like a criminal trial in the sense that in a criminal trial, there will be certain matters which are restricted as being inadmissible. So they must be avoided, not adduced. And if they do come out accidentally by a witness, the judge will direct the jury to ignore it. Here, being civil and all the rest of it, if you call upon someone to give evidence, then that becomes their evidence. Of course, the court will always retain the control of a trial and the evidence that it hears. If you want to bring 400 witnesses, the court is likely to say, well, summarize it, will you? Let's not have them all in court.
Right.
And so much like if you've got like we have multi-party or action or multi-party claim, you know, class action in your case, but the term is loosely the same. If we get so many people with the same claim here, the court can issue what we call a group litigation order, so that the court will control how it hears the evidence and from whom. But if there's only another 2 witnesses, the court, I think, would struggle to rule it out. So if they come in to give their evidence, they come in to give the evidence. If it was completely irrelevant, the court will still retain the authority to exclude them as witnesses. But then that in itself might then be a route of appeal, you see. So if instead it was the court refusing permission for those to come and give evidence, that would then become a procedural issue. And then any application for permission to appeal would likely have been to say, well, these witnesses were going to give XYZ evidence and it was refused. Therefore, that is a good reason for this appeal to go forward and include evidence of these witnesses. So it's unlikely that have been excluded. And my understanding is that it's time constraints that they didn't actually come in. But
I see. So I did follow a little bit about why Winona Ryder didn't testify in the UK, or at least and maybe it wasn't made public the reasons why, but it seemed to have to do with the fact that she didn't want to be pulled into a trial at a time when I think her career was starting to come back. She was now in Stranger Things, and so she was really, like I said, just starting to come back. I have a suspicion that had something to do with why she didn't want to be so involved in it. Do you have any idea why Vanessa Paradis was not brought in?
I don't, without looking into it. I don't think it would take much to find that. But yeah, I mean, there must have been a reason. Is all I'll say, really. But I don't know. But I do think it would have made a difference.
Okay.
So that was that, and I think this just covers what I just said, which is the rule that the judge referred to. So it only applies if the party has served the witness statement and wishes to rely on it. The other party can use it as hearsay if they're not called and so on, but obviously they didn't do that. Then I came on in my notes here. I came on to what I've just titled issues of credibility, because there's a whole section of the judgment which is, I don't know if it's worth. Do I have? Yeah, I've got some more slides on it actually. There's a whole section of the judgment talking about issues of credibility, and obviously one of them revolving around the letter written by Amber for her friend, assistant, not assistant, but assistant in the UK, but not in the US. She apparently gave money to sometimes, but wasn't employing her, etc. If everyone is familiar with it. So I think this is the letter. Now, the issue here was that if she was writing this letter and any of it was disingenuous, then it should affect her credibility. But ultimately, as became a pattern through the judgment, the judge essentially accepted her evidence and ruled that this didn't have any bearing on her credibility at all. So I'm assuming you've talked about this throughout your streams. Forgive me, I haven't watched them all, but
No, it's okay. It's a lot of hours of streaming. No, we haven't talked much at all about the UK trial. We've kind of touched on it a few times here and there. For example, when I had Andrea Burkhart on, because she's followed this pretty closely, but she basically gave a pretty quick rundown of what some of the issues were that she saw in this case. But other than that, we haven't really gone through much of any of this.
Yeah, so this is essentially a shot at her credibility without saying too much more. But as becomes a pattern throughout the judgment, the judge accepted her evidence and essentially said this didn't have any bearing on her credibility, which I think is this next bit here. The reason I sort of take issue with this is because I'm no judge. I am but a humble barrister, but I've been around a while. I'm a judge of character. I'm a judge of many things. And when we train as lawyers, we look for inconsistencies and consistencies. And so we weigh all those together and we advise on the evidence. And I look at certain things and I'll just go as far as to say there is a question here which should really be considered as to what her role really was. And so obviously the question with her was about whether she was working in the United States or not, because she was not permitted to do so. And so the bit in green is where in cross-examination Amber had said that she was her on and off assistant, but not in the USA. And ultimately the judge accepted this, but I certainly think there were questions there, because I don't think it's in this paragraph, but at some stage she does say that in the US she did give her money from time to time, and so there should at least be question marks over it. Not necessarily going so far as to say that this whole letter was disingenuous or fraudulent, but certainly question marks. But in this paragraph from the judgment, the judge says, I accept her evidence in this regard. Do not consider the letter to be a lie. And then, however, she did not give evidence before me, and there's nothing in the documentation to explain the source of information that was then acting as her assistant. So to me, because she didn't give evidence and there's nothing in the documentation to explain the source of the information, there are just at the very least question marks over that.
Okay.
That was one of the allegations against her credibility. So for those that are, if anyone sort of lost track of this, what was happening here was for Amber coming forward as a witness, the credibility is essential. It's paramount. If a witness is found to be not credible, incredible, then their evidence should be either discounted altogether or given significantly less weight. And what was a pattern here was that there were lots of things to question this credibility, and yet they were all discounted. And following on throughout the rest of the judgment, her evidence was accepted pretty much on face value. And so, taken in isolation, this one element, you could possibly make a leap of faith and say, yes, fine, that's probably what it was. But there were lots of others. And so, again, as lawyers, you will all tell your clients, and I certainly tell mine, that when taken together, lots of different things allow you to form a conclusion. So, and the analogy I'll give you is this. I like analogies. It helps people understand.
Of course.
If you've got two people and they're otherwise near enough identical, they have similar day jobs and similar lifestyles and everything else. One of them has been arrested by the police 15 times, questioned, interviewed, and come very close to being charged for a crime, but not. But the other one has never been arrested, never been questioned, and never come close to being charged. You take the two together. Now, on the face of it, this person has never been charged. They've never been charged with a crime. They've never been convicted of a crime. Should be just as innocent as everybody else. But then when you look at two side by side, the mere fact that someone has been accused of something, it does allow you to draw some sort of inference, because why were they arrested? Why were they questioned? And in fact, an interesting point as a sideline tangent to this, and this is all of this sort of forms my thought process for all of this. I don't know if this is the same in the United States, but it's certainly the case here. And I know it's a tangent, but bear with me. If you are tried with a crime in the UK and you're acquitted, so let's say you go to the Crown Court, the jury find you not guilty, and you walk away. Let's say then there is a civil action, either on the same basis of facts or a different set of facts, whichever. You can use the fact that this person was tried in the criminal court in your civil claim. And here's the interesting bit, but because the standard of proof is lower, you can assert in the civil court that on the balance of probabilities, they were in fact guilty, even though they were acquitted in the criminal trial, because the standard of proof is different. Now, I find that really interesting because, again, as I've said, it comes down to credibility. So the mere fact that someone is tied up in a number of things taken together should, even if you don't draw an individual determination on any one of those, it should have an impact on your judgment overall.
It feels
anyone
very
else any thoughts on that? Yeah.
No, it just feels very speculative, because how do you know whether the criminal jury thought on the balance of probabilities they were more guilty than not? I mean, at least in the United States, you're saying beyond a reasonable doubt, which if you had to put a percentage on it, depending who you ask, you're somewhere 95% plus. So 95, 98, depending on what lawyer you ask. So it's like, well, okay, so they didn't reach 95, 98. How do I even know they're above 51? Because we didn't ask that question. Yeah. So maybe the jury thought it was complete crap. How do you know? You're just speculating. And
just to clarify, this is not your error, but just in case anyone missed the train of thought there. So what we're saying is, in a jury trial, it's beyond a reasonable doubt, or as we now say it to a jury, so they must be sure that XYZ happened.
Sure.
And
well, that sounds less intimidating than beyond a reasonable doubt. Wow. Those are definitely not the same to my mind.
Yeah, no, right. And the reason I think the reason the decision was taken to say that to a jury is because some people didn't understand what beyond a reasonable doubt meant. I thought it was quite clear, but anyway. So what we're saying is a person goes to a criminal trial, it goes on full trial in front of a jury, is found not guilty. They acquit them. They say they didn't do it. We've deliberated. They come back, not guilty, didn't do it. But then let's say the offense charged was criminal damage. So they were charged with the offense of damaging a car, let's say. And so in almost every legal case, there's more than one thing going on. If there's a criminal thing going on, there's almost always a civil thing going on as well. So damaging someone's car deliberately, property belonging to another, because you can't criminally damage your own property, but you can criminally damage someone else's property. There is a parallel civil claim for the value of that damage. So if you cause £1,000, $1,000 worth of damage, it's not only criminal, but there's a civil claim for the same amount.
Right.
So let's say they go to the criminal trial, and let's say the CCTV footage was rubbish, and that's all they had, and the jury say, no, we don't buy that. We don't accept that this CCTV footage was good enough. And by the way, that is almost always the case, because for some reason, every other day of the week, someone has one of these or something like it, and it's 4K and it's zoomed in and it's crystal clear. And yet, for some reason, CCTV is always small, grainy, black and white rubbish.
Yeah. Of course.
I don't get that. But that's one of the single biggest factors that will, let's use the phrase, get someone off a criminal charge. CCTV was rubbish. And so let's say they're acquitted of that. Let's say that the owner of the car then sues them in the civil court for the value of the damage done to the car. And they go to court and say, this person was tried for the criminal damage. They couldn't reach a decision which met the criminal standard of proof, but we asked this court to agree that it meets the civil standard of proof, i.e., here's the CCTV. It's more likely than not it was them, and I want my $1,000 to pay for the damage. And you can assert, here's the really interesting bit, you can assert that they were guilty. You can say they actually did it. And because it in the civil court is a lower standard of proof, they accept it.
That makes me really
UK
uncomfortable.
Expression, I think that's rubbish.
That makes me really uncomfortable how you go about doing that.
Yeah, I mean, it's not done often, but
we learned everything we know by watching you. What happened to you guys?
Well, I think we did separate ways some time ago, didn't we? But quite literally with our profession, so we have a split profession. But anyway,
we're more loyal to the law than the more loyal to English common law than the English are at this point. That's funny.
Well, you bring up common law. I think I've lost track. I haven't got it open how many people are watching now, but we certainly get a lot of people talk about common law like it's a completely different body of law or jurisdiction or something altogether. And I find that fascinating how people do misunderstand it and misapply it. And quite literally, some people say, this is me going off on a complete tangent, but it's entertaining anyway. Some people say that, legislation doesn't apply unless you consent to it. And that's obviously not true, because your consent is not required. The legislation applies regardless.
Right. You've got sovereign citizens too?
Let me pick up this super chat. Yes. I mean, broadly speaking, yes, the law of England and Wales, most of it is the same in Scotland, but it is it's strictly a separate system. And yes, they do have sheriff and high courts, and a lot of the law in Scotland is separate. It's one of the really frustrating things here. So this is another interesting fact. So I don't and can't practice in Scotland, for example. That's part of the UK, because I'm at the bar of England and Wales. And so it has to be separate. A lot of it is the same. So a lot of the law is applied UK wide, but it all splattered throughout the government websites there's separate laws for Scotland all over the place. So it makes it difficult, not just for us, but for the poor folk in Scotland as well.
I mean, coming from a system where we can only practice in whatever states we're licensed in, and have taken some sort of a bar exam, most likely. I understand that frustration.
But at least you've got at least it's a federal system, and it's sort of what you set out with, isn't it? This is yeah, but yeah, I find that interesting anyway. But there we go. I hope that helped.
Just real quickly from my American colleagues, doesn't this seem like what was being described as how it works in the UK? Wouldn't that seem like it comes up against 404B?
Yep.
That's what makes me so uncomfortable about it.
And what's 404B for my benefit?
Prior acts evidence.
Yeah.
Okay.
So it gets a little too close to that live wire for me.
Yeah.
The idea that you can use there are exceptions for pattern evidence. So the only way that you could, well, not the only way, but a common way that you could bring in someone's prior acts if they've been done a lot the crime the same would be if there's some sort of unique pattern that could identify them. So it's some sort of unique signature to them. So this would be most common in like homicides because they have a particular method of committing the murders. And so it's like, well, they've been implicated in other murders that have the same signature. We're charging them with this particular one. We can use these prior things to show a common pattern of behavior. But other than that, the idea that, like for a DUI, for example, this would never happen. If I had, been arrested 10 times for DUI and never convicted, the 11th time, like the jury's never hearing about the other 10 because it's ridiculous, to us.
And in a lot of cases, even if you were convicted,
even if I were convicted, they're not hearing about the other 10 until sentencing. Yeah, that too.
Previously doesn't mean that you did it today. It would be considered, impermissibly misleading.
Hey, I may have robbed those other 50 stores, but I didn't rob this one, man. I have to charge that crime separately.
And that is basically the premise.
Yes.
Yeah.
That's right.
And that's why I asked earlier about Winona Ryder and Vanessa Paradis being not testifying and the fact that they could have testified because in the United States, and that's exactly why, is that 404B character evidence reason is why
we keep out prior relationships because he might have been a saint to them in prior relationships and still be Amber, or vice versa.
Exactly.
Both ways, right?
Exactly.
Yeah, he might have been a dick in the past. He might have been a saint in the past. Either way, we keep it out because what matters is what happened here. Yeah.
That's the basic premise.
Yeah.
God bless America.
So, yes, and also, by the way, guys, if you are wanting to learn more about the UK law, Black Belt Barrister is linked in the description below, along with all the other guys that are showing up on this panel today. Throughout the day, when people pop in and out, we'll be adding them just like we did during the regular trial itself as well. So be sure to go and check him out, watch his stuff, subscribe to his channel, all the great, YouTube-y stuff. We were talking about how the United States and the UK, YouTube doesn't exactly like to cross-pollinate viewers unless we actually do these kind of collaborations. So I'm really, really happy to have him here, and you guys should definitely go and check out his stuff as well.
I'd like to ask a question about the solicitor-barrister distinction.
Yeah,
because so as I understand it, and please correct me if I'm wrong, barristers are ones who practice in court. Solicitors are ones who do the transactional paper law. And my question is, when does a professional have to make that decision? Are there two different schools? Are there two different licensing tests? Could a person be both? What is the whole nature of that distinction?
I heard somewhere that solicitors can get barrister privileges.
Sorry, say again?
I had heard somewhere that solicitors can get barrister privileges. I don't know how that exactly goes.
Yes. So it gets quite muddy, I'm afraid. But the answer is yes, and yes to everything you said, essentially. So, yes, broadly speaking, the distinction is barristers are who you see go to court with the wig and gown. I say broadly because, coming back to your point, solicitors can acquire rights of audience and to wear a wig and gown, although I think the gown is slightly different, but would also go to court. They're known as solicitor advocates. But then broadly, solicitors, as you just said, handle the paperwork without being disrespectful, which is filing claims, serving documents, receiving documents, putting the documents together, and typically or traditionally would come to a barrister for specialist advice, specialist drafting, so actually drafting the claim, sometimes drafting witness statements, but usually that's a solicitor. And of course, going into court. On the next question, yes, there are two very different routes to qualify.
Sure. Okay.
We call it bar school, as you call it law school generally. We call bar school for barristers. And it's just a solicitor's training course, I think we call it here. And then there's the last bit of the sort of qualification procedure is very different as well. So a barrister, even when qualified, must then get what we call pupillage, which is essentially a further year of training, which now chambers, which is where a barrister will practice, are required to pay the trainees, the pupils, for that year. But only in the second half of that year, they can actually earn anything. So it makes it a very difficult decision for a chambers to take on a new pupil and pay a new pupil. Typically, only 1 or 2 a year per chambers. And if you take raw numbers per year, you're only talking about 200 or 300 new places each year. So it's quite competitive.
These are like chambers in a court, chambers before a judge?
So that's where the term comes from. But they are literally buildings typically surrounding the court buildings, but essentially just offices, but buildings surrounding the court buildings, but still referred to as chambers because we like our traditions, as you can probably see from the wig in the background.
Well, there's a super chat question about that. Why do you wear wigs and we don't?
Well, it started. There's a whole. I literally have a book on it. But I'll give you the short version. It started as in before it was even used in court. It started as a believe it or not, a fashion element, and it was adopted for court proceedings for anonymity. And even in this case, if you look up the judge, Judge Nicol, if you look him up with and without the judge's wig, it looks very different. It looks a very different person. So it was anonymity, and we maintain it today. We've eliminated it in some trials. For example, a lot of civil trials. So unless you're with what we call a circuit judge, which is a different level of judge, so district judges, which is the lower level of judge, we don't wear the wig and gown in those trials. Criminal cases we do, but not in the lower courts. We don't wear the wig and gown in family cases or what you call a juvenile, we call a youth court case, because it's designed to take the seriousness down. This other question here for me, is it Hollywood or judges, magistrates do actually wear the powdered wig? Well, the wig is quite literally handmade horse hair. I can show you if you want. It's literally over here.
Show us.
It would be kind of cool, actually.
If you are interested, I'll grab it.
Yeah. I'll take the shared screen off so that we can see it a bit bigger.
The glory of it all.
I love it.
Then. So
it's so foreign to what we have. So
yeah,
I also heard that they're quite expensive.
Bland in comparison.
They are expensive. Yeah. So we honor the traditions, and there's a lot of stories behind them. So this is the gown. You won't hear me with the microphone, but this is the gown we wear, which I don't know if you can see very clearly because it's just black, but literally look a bit like Dracula. This is interesting on the back, which is sort of like a pocket or a hood, and there's two theories behind where it come from. One is a mourning hood, which was like literally a mourning, like a black cap in mourning of someone who's died, and supposedly when the king died. And then on the front there is a strap which is supposedly that was over your shoulder to hold it, but now is sewn in as part of the gown. The other theory is, I don't know if you're familiar with the phrase of slipping money in your back pocket, but taking money quietly, because traditionally barristers were not seen or not supposed to be seen to be taking money for their services. So one other theory is that this was designed to, when barristers did need to take money for their services, that it could be placed in here without them really knowing about it. So I love that. It's a real story behind the gown anyway. This is the collar. I don't have the bands here. They're in the side somewhere, but literally, so this shirt I'm wearing now, obviously a bit like a dinner suit collar. We would wear that in the Crown Court. And And this is what I mentioned, is literally is handmade horse hair wigs. Mine is a traditional style, which has a point at the front here. Only one in about 30 have got that. Normally they're straight across. So that will be straight across.
If I naturally grow out the style, do I still have to wear the wig, or can I just do it the old school way?
Well, this is what some people say, that I was born for this profession, obviously, with the hairstyle. So, but there we go. It's horsehair, the handmade, and I believe is one of, if not the first, registered patents in the UK. The design of these. So
wow,
quite old. So there it is.
That seems about appropriate. That the very first patent that would be filed by a lawyer is, you know what, I'm going to protect myself here.
Yeah, absolutely. And I say that about everything. So if I'm getting something new and expensive, I'll take photographs of the box and I'll film the box opening just in case it's broken. And the amount of times that saves such a palaver, such a hassle of sorting it out. And
can you do different colors of hair? Could you like dye it? Could you do like a tie-dye thing, or is that frowned upon, or what?
It's an interesting question. This is from the place called Even Ravenscroft, which is the sort of traditional wig making legal outfitters, and this is what they call salt and pepper. So if you see some of the really light hairs, some of them are what they call sort of virgin white wigs, which are almost bleached white. This has got a mixture of different colors to make it this color, and traditionally they will get darker over time with use. They get dirty, they get dusty, they get soiled, whatever, they get darker, and they also get battered and torn, and you can see some of these coming off here. And the tradition is to not get it repaired and just leave it to sort of fall apart over the years.
Oh, well, we have a question right here, but do you have silk?
Yes. So do you mean does Don mean the program silk, or do we mean the Queen's Counsel? So a very senior barrister we call a Queen's Counsel, which this is very heavy cotton, and it is quite heavy. But when you're Queen's Counsel, you, as the saying goes, you take silk. So this, instead of being heavy cotton, is literally made of silk. Still black, but
cool.
Made of silk. So that's probably what that means.
I'm so fascinated by the wig. It's so funny because it's like, it seems like such a simple thing, but what do you do to care for it? I mean, do you have to keep it from getting dust on it? It's so interesting because it's made of horsehair, right? So I at least have the only experience that I have with dealing with horsehair is for the bow of a violin. I grew up playing the violin, so but all you do is just put resin on it so that you can play it. But I mean, other than that, I never had to care for it.
No.
Scotch guard, lots of Scotch guard.
Well, not a lot really. I think they can go for cleaning services, but I don't think anyone actually does that. But I leave it on here to air, because there is a tin. I can grab that for you as well. Actually, there's what we call a wig tin, and there's an interesting story behind it. 1 second.
This is great.
I'm loving all of this. It's like I know we started off talking about the Johnny Depp trial, but I'm so fascinated just by
the longer he talks, the more I'm glad we don't do this.
So there's an interesting story behind this. So this is what we keep them in, and the judges' ones are literally taller because their wigs are bigger. And these are handmade. They're made to order. They cost hundreds of pounds to have made. You don't have to have it made, but it's nice too, because you spent enough time earning the wig, earning the right to wear the wig. So the interesting story behind it is that one barrister about a year and a half ago now, probably a couple of years ago now, was stopped in the Crown Court by security, saying, "You can't take that into court." He said, "This is my wig tin." He said, "No, you could hurt somebody with it." He said, "I'm the barrister." I'm representing these people. And he said, "No, you could hurt somebody with it." And so this went back and forth, and he left it with security. But now, following that and a few incidents like it, we now have like a court ID system, which is about time, really. It's literally on our phone, in our wallet, on my iPhone or whatever else you have, to show your ID. So we don't even get searched now. If you're part of that scheme.
New York does that, where you can register for an attorney pass and just skip security.
Yeah.
Yeah. Usually in California, I show my bar card, and then well, you still have to go through security, but you have a separate line at least.
Yeah.
New York doesn't have a bar card.
Okay.
Is P numbers then like how old our wig is? Is that how this works here in the U.S.? That was a joke. A lot of laughter here. Have you never been in a conference with like another lawyer who asks you like what your P number is to determine whether they should talk with you? Because I have.
Oh no, but I haven't in. I mean, sometimes when you get a new filing for a new case from someone else, and you can see the bar number, because every time the bar number has to be placed on the document to make sure that this is actually a practicing attorney. And so, I mean, I feel like every time everyone kind of looks at the number just to see like how fresh is this attorney, or how ancient is this attorney. And in California, so when I got licensed, it was already getting into the 300,000s. So, and I remember the first time that I came across someone that had like 5 digits, and I was like, how is this possible? How are you still practicing? It was a very interesting case, and technology was not his strong suit.
Do you have a number, a UK barrister?
Yes and no. So it's even this is another interesting factor here. So I have a number with what we call the Bar Council, which is our representative body, but I don't give that to anybody other than either them or there's no need to give that to anybody. I'm just registered with them. If someone wanted to check that I am registered, that's the number that they would check that I'm registered. What we go by is a year of call. So the year we were called to the bar, but this is potentially misleading. So I had my pupillage sort of lined up to start on the day that I qualified, and my 12-month pupillage was cut in half. I only did 6 months, and this was at the decision of our regulatory body. So I was practicing to be able to charge, eligible to charge for my services within 6 months of qualifying. Now, the reason that's important is somebody could be called to the bar 7-8 years before they get pupillage. So there's a very interesting and slightly disparaging statement made by a fellow barrister in a seminar that we jointly hosted. And she had just finished her pupillage, and I'd been practicing for several years by that point. And she said she was quite a bit less junior than me. And I thought that was wrong because she just finished pupillage. So her year of call was several years before mine.
Ah, I see.
So because the way we're listed on the board, you see, is the year of call. So if you're called this year, you're at the bottom.
Let me answer this. So P number that Rick referred to, that's your bar number, right?
Yes. Yeah.
In Michigan.
Yeah.
Okay.
Yeah, I have never heard it called that in my life.
It must be a Michigan thing, I wonder.
Yeah, because in New York, you don't even put your bar.
We're out here in the Great Lakes, and we use our numbers, and we put some letters on them. I apologize.
In New York, for instance, you don't even put your registration number on any of your documents. Florida, you do. Okay. But yeah, in New York, you don't put your registration number. It's literally just for the court system. It has nothing to do with any sort of front-facing.
In California, we call it an SBN, a state bar number. But I'm also very fascinated by the system by which you become a barrister in the UK. I mean, while we're here, we've got time to spare, right? We might as well talk about it. I love time.
I've written the day off, so yeah. The process of becoming a barrister. So it's been in change for a number of years, but typically, and certainly the way I did it, you've got to have either a law degree or a degree that you then take a conversion to make it a law degree. And so it covers what we call the 7 foundations of law. And to put that into context, you do it in great detail in the law degree, which is, when I did it, it had to be a minimum of 3 years. You couldn't do a shortcut of 2 years, for example. But if you don't do that, let's say you do a science degree and then you want to come and be a barrister, you can do a conversion, which is referred to as the graduate diploma in law. So the way I explain it is this: in the normal degree, you have to read and study and learn how to do it yourself. In the graduate diploma of law, they just give you the answers. and you have to know what the answers are. That sort of how, at least someone that did it told me, and I trust what he says because he's now a practicing barrister. So I take that as his word. They tell you the answers on the conversion. Either way, you can then go to bar school. So it's not, you're not done then. You're eligible to go to bar school and train to be a barrister. That is typically 9 months of hell because it's a very, very intense course. You have to know all of the civil procedurals and all of the criminal procedurals, because when you qualify, you are eligible to just go off and do whatever you like. You can be a civil barrister, a criminal barrister, a family barrister, whatever. You can go off and do whatever you like. So the minimum requirement is you do your fundamentals of law, contract, land, trusts, all this sort of stuff in your degrees, your degree. And then when you come to bar school, you've got to know the civil procedurals and the criminal procedurals, each of which is a book about this thick on sort of Bible thin paper. But either way, you get to know all of that. And then when you qualify, you can come out and practice, providing you get pupillage, which is the difficult bit. Pupillage is the difficult bit.
Okay.
Explain
pupillage.
So it's the vocational stage of training, and you cannot charge for your services. You cannot, as we say, hold out as a barrister for services unless you've got a practicing certificate. So you get a practicing certificate when you've completed pupillage. But this is where it's really, really tough to become a barrister. So there are, I think I looked up, there's 100, off the top of my head, there's 140 something thousand solicitors, maybe 150,000 solicitors. There's only about 17,000 barristers, and those are split throughout chambers. I think there's a few hundred chambers, but you have to do your pupillage with a registered training or an authorized training organization. So you have to apply to one of these chambers. Chambers is just a collection of barristers that have come together to share the costs of running an office, a website, clerks, marketing, and all that sort of stuff. So they share the costs of all of that. That's a chambers, and it's registered with the Bar Council, just as we are individually registered. They have to train you for this year, or in my case, 6 months. They have to train you, and they have to pay you whilst they train you. And most chambers only do 1 or 2. In fact, it made legal news just the other day because the chambers, I think, did 9 pupillages in 1 year. 9. And that made legal news because it's quite unheard of, really, for that many, unless you're doing it with the state, which is the CPS, the Crown Prosecution Service. I think they do about 30, but it's the nationwide state prosecution service, so they take on more. They have to do that, and that's the difficult bit. So you're going to apply for that, and if you get your pupillage, you do your training, and then you can qualify. Then you get your practice certificate, and then you can practice. That's the difficult bit.
Okay. Interesting. Yeah. Very, very different than the United States, where
they just let us out there.
Just let us out in the wild. Basically, I mean, we've got 4 years of undergraduate school where we can have whatever kind of degree that we want. It can be, Kurt's computer science. I'm history major, sociology minor,
economics,
exactly. Yeah, so we've got a decent array. I think a lot of lawyers come in with liberal arts degrees, which is why I often like to knock liberal arts degrees because I'm one of them. And a lot of times it just kind of they just sort of feel the draw to law school after that, partly because, well, what do you do with a liberal arts degree? And number two, that's often one of the things that has drawn them is just that kind of interest as well. But then 3 years of law school, then you take the bar exam somewhere in whatever state that you want to practice in. And after you pass, you're just kind of let out into the wild. So some states have some exceptions, like California, for example. You don't actually need to go to a law school, an ABA accredited. So the American Bar Association accredits the law schools to make sure that they are meeting certain standards. And so in California, you can do, it sounds like maybe something that's a little bit, I guess, somewhat similar to the system in the UK, I guess, kind of, but not exactly, where basically you can take what's called the baby bar exam first, which is essentially what you would do for your first year of law school, take an exam there, and also have a certain number of hours where you are working in a law firm under an attorney that is in good standing with the California bar. So a very famous example of that is Kim Kardashian. She's been doing that for a while. She's been trying to pass the baby bar exam. Last I checked, I think she had taken it a third time. I don't know if she's passed it the third time. But I can understand why it would be difficult if you aren't doing any sort of formal schooling for it, that it would be difficult to pass. Yeah. But yeah, so that's basically the American system. It's much more loosey-goosey than the UK system.
What about transfers? Do you get international transfers, such as someone at the English bar coming over to the States?
Yeah. So when you go to, at least in my school anyway, we had what were called LLM students, which is, so in the United States, when you get your law degree, it's a Juris Doctorate. Technically, you become a doctor of the laws, and then you can get a master's in the laws after that, which is flip-flopped from basically every other graduate program in the United States, where you can get a master's first and then a doctorate. But for whatever reason, law is different. It's weird. So you can get an LLM either as a normal American, just so that you can focus your studies in and kind of become like an expert in one specific area, or as an international student, you can get that degree in the United States. It can kind of help you find your footing somewhere in the States. You can take the bar exam in the States as well. I remember when I was in California taking the bar exam, there were quite a few international students around me, particularly from, I think it was largely like on either side of me. I remember when I was taking the test, I think they were both from China. So there were multiple, coming from Asia into California. I guess it's relatively common given the geography. But yeah.
That's interesting. I did an LLM at the same time as I did bar school. So I really
it's a joint
enough. Yeah. So I don't know whether you whether you'd see that in the same way, but I did my.
Yeah, you can go get a joint degree. There were the crazy people that got a JD and an LLM at the same time when I was at Michigan.
It's usually like a 4-year program instead of the usual 3.
And heavy lifting.
Yeah.
Respect to my joint degree brothers and sisters.
Yep.
It was tough. It's tough.
I was just thinking about it. We do actually have some remnants of that separation between solicitor and barrister, because I think technically you are a lawyer once you have the degree. You just are not an attorney and counselor until you're admitted to a jurisdiction.
Yeah. I think it's the same here as well. You call yourself a lawyer when you have the law degree. You just don't practice as a lawyer, which is
right.
Essentially what you're saying.
And that's the thing that is always very scary for brand new law graduates. I remember my friends and I were like, can we technically call ourselves lawyers when we haven't passed the bar exam yet? Because, every bar jurisdiction says you can't hold yourself out as an attorney in our state unless you have actually passed the bar exam, you're in good standing with the bar, et cetera, et cetera. So it's like everyone was kind of in this like weird, awkward, like gray space. And I'm sure every single year, law graduates feel the same way. I as largely as a joke, I basically resolved to call myself a doctor of the laws, because obviously no one would take that as like me holding myself as a lawyer. I can see Rick shaking his head.
When I first
started, with everything I know about you, Alita, so it's fine.
When I first started, I was still considered an associate of the firm. I just couldn't sign the documents. I was working under the tutelage of admitted attorney.
I was going to actually ask, because when you start at a firm straight out of law school, and you're asked to do a public letter of any kind, they have a special signature block, not yet admitted, pending, bar, June, whatever year.
I just had my partner sign it for me. I would draft it, he would review it and sign it, and that was how they operated. But
we were allowed to send communications, but it had the notation that said pending admission.
So we have something similar, and ours is quite strict. And so even when you're fully qualified, you have to be careful not to put barrister anywhere on your profile. They changed it fairly recently. I think it now has to say unregistered barrister, which I'm not sure anyone would really like to put, but I do know that some people have put barrister on there, or what they do is graduate of what was the BPTC, the Bar Professional Training Course. I think it's now the BTC, the Bar Training Course. It keeps changing its name. It used to be the BVC, the Bar Vocational Course.
You don't want to run out of B's.
Absolutely. And then when you're a pupil, you have to call yourself a pupil barrister to make the distinction that you're not yet a fully qualified practicing barrister. So anything to make sure you're not telling people you're really a barrister, unless you really are.
But that is interesting with the 1 year, because it sort of reminds me of like a residency in a medical program, which I think is an interesting way to do it.
Yeah.
I think there could be more practical aspects. There are a few states that still let you do it without going to law school. Virginia, New York, I think requires 1 year of law school. California,
New York requires 1 year of law school, or you can clerk for a judge to fulfill the year.
If you can clerk for a job if you can clerk for a judge with no law school experience, better for you, I suppose.
It's 1 year of law school, and you have to do, I think, at least 2 years of practical work under a licensed attorney.
Yeah, so there are a few schools that still do the old school system, and I think there's a lot of merit to it, because you graduate law school and it's like you don't know how to do anything. You know all the theory, but you don't know how actually do it. It's like, okay, I know I need to file this kind of document. What does that look like? How do I actually go about doing that? How do I format it? It's like,
where does it go? Who do I talk to? It's
interesting because that is getting. I think that's changing a little bit. Certainly, when I went to law school, they started having practical skills for lawyers as a required course, and that's becoming, I think, more common. And even on the uniform bar exam now, some states don't use it, but there is a practical session where, for instance, they'll ask you to draft a will or something.
Oh, really?
Yeah.
Interesting.
Okay.
And by the way, I wanted to introduce, because I realized John popped in earlier, and I didn't introduce him. This is his first time on the channel here, actually. So to all of the viewers here as well. And obviously, you haven't met Daniel yet either. So welcome. And also Sean, this is Daniel. He's as you can tell, he's a black belt barrister from the UK. So we're talking about the differences between the United States and the UK in terms of the legal systems, and also, centered on the topic of the UK trial for the Johnny Depp versus Amber Heard case. Well, that was versus the Sun, of course.
I told folks we talk about whatever during verdict deliberation days.
We do, indeed.
Right? I thought we were going to roll into grousing about the bar exam, and I'm here for it.
I can do that too.
So,
I had to do it twice, so don't. Yeah,
I'm studying for it now. So,
what jurisdiction, Kurt?
Huh?
What jurisdiction?
In Texas. Well, because we have the uniform bar exam now, effectively like 20 states simultaneously. But yeah.
Oh, very nice. Very nice.
But
Florida still doesn't accept the universal.
Yeah. Well, it didn't exist when I took law school. I took the exam in 2007. There wasn't no such thing yet. Let me ask a couple other questions to our barrister friend. What is your focus, and are the nature of focuses among barristers in the UK different than the nature of focuses in the US? I have a sense that perhaps the US is more specialized, but perhaps that's not fair.
I think most barristers will specialize, and even if they specialize on a number of different things, there'll still be a specialism of sorts. So I suppose the category that is broadest, I would say, is common law. So because common law has quite a wide range of different things, it could come under property and housing and land and trusts and various other things. So common law can encompass quite a lot of things. My specialisms are in company law and intellectual property and civil disputes, and it spreads into defamation and disputes of that nature. So, but I do try to stay quite broad, because I have a broad background and experience. In my training, it's funny. Well, funny, not funny. I said I don't want to do family law, but I ended up doing loads to do family law during my training. I found I was good at it. I got people talking. I got people to resolve their problems without fighting.
That's good.
But I wanted to come back to civil, commercial, and company and intellectual property. So that's what I do. That's what I enjoy the most. Yeah. But I think there was I think there's one or two questions I didn't quite answer earlier on, which was when and how does someone choose which route, solicitor or barrister, because they are very different. Even if you start out as a solicitor and then take your rights of audience to become, well, you don't become a barrister, you become an advocate of the higher courts. I think you need to make that decision very early on. I think it's a distinctly different route to take, even if you overlap later on. So I think you need to take that early on, and I think it is a big difference. You have to be sort of outspoken and confident, self-assured, whatever, to stand up in court. And not everyone wants to do that, but they still want to be a lawyer, so they go and be a solicitor. Mm-hmm. There's another distinction between the two, which is the overlap of the two. Now, I'm sure there's no special qualification or license or anything else outside of your practicing remit to be able to file a claim, file a suit. But for us, there's a distinction. By default, barristers cannot do that. We call that litigation, broadly speaking, and that's whether it's criminal or civil. So we by default, we cannot do that. It's an authorization to conduct litigation. There are only about 1,000 barristers that do that, and I'm one of them.
That's surprising.
That's fascinating to me.
And even dealing with the public, here's another big distinction that I didn't really cover. We cannot, by default, take instructions from members of the public. It has to go through a solicitor. But again, we can get authorized to do what we call public access, which is taking instructions directly from an individual or a company. And that goes hand in hand with litigation, because you can end up in the situation where you can take a client and you can help them, you can advise them, you can go to court for them, but you can't file the claim for them.
That's interesting.
So strange to me.
Unless you've got authorization to conduct litigation. So I thought, you know what, I'll just do it all. I'll take all the boxes. So I'm a mediator, a litigator, a public access practitioner. I do all of it. I thought that's the easy way of me getting around this nonsense. So I do it.
I suppose we have an advantage in the U.S. in that respect, because once you're admitted, you can practice pretty much anything with very minimal exceptions. Patent law would be one exception on the federal level. Have to be specially practiced for that. That's about it.
I think that's pretty much it. I can't think of another
about
one.
It. Anything else is open game.
But I think that's the idea, is that we're sort of trained in law school to be generalists. That you could at least speak intelligently and know how to find the right
You can
law.
solicit the client. You can file the paperwork. You can do the will one day and argue a death penalty case the next. I mean, there's infinite flexibility, which is kind of nice, I suppose.
Yeah. Well, we do have that flexibility in what we practice. I could say, forget all of this. I want to go and do, nuclear something or other law, tomorrow. But I would have to be competent to take the case on. Sure. So I couldn't hold myself out as being competent at doing it unless I'd read into it first.
Right.
But that should go without saying, I think.
Same. I think that's one of the realities that people, being said about lawyers. We don't necessarily have all the answers, but we have a decent bet at finding them.
That's right. Mm-hmm. I have books. Books tell me answers. It's great.
Exactly. Absolutely. That's my favorite answer as an attorney is, I don't know the answer, but I will research and find out.
Exactly.
I mean,
that's almost always your best bet.
My stuff is really high tech.
Yeah, that's right. That's right.
That's constitutional law, isn't it?
And I have another. I have another question, since you're somewhat more on the ground if you don't feel comfortable answering this question, feel free to pass. But I'm curious as to your perception as to knife crime in the UK, because our what limited information we get in the US seems to suggest that it's a real problem and scourge, and I don't know the degree to which that's true, or you see more of it, or if you can comment about it anyway. But I'd be interested in a UK perspective.
I think it's a serious problem, and there are very strict laws, and there's a lot of debate and dispute about the laws, because although the laws are very strict, the typical response is the laws don't prevent knife crime. And I agree, the law itself doesn't prevent the knife crime. If someone's going to go out and commit that, they will, law or not. I mean, what I usually say is, well, it's against the law to kill somebody, regardless of whether it's against the law to hold a knife, right? So it's against the law regardless. However, there has to be something in place to, at the very least, have the boundaries set. And so, I mean, I've got one on my table right now, but I have a pocket knife, which is an exemption in the law, and some people carry it around and have use for it. The counter argument is, well, is there ever really a need to have a knife with you unless you're out camping or whatever, which would amount to a good reason? So the position in the UK is this, that you have to have a good reason to have any blade or pointed article with you, unless it comes under the exemption of a folding pocket knife. Which I think a bit bizarre, and I can demonstrate why I think that's bizarre. So if I reach across the table, I can find my my folding pocket knife. So this is obviously a folding pocket knife, very tiny. It's only got literally a 3-inch blade hilt to point. It doesn't lock, but it's quite stiff. But because it doesn't lock, it's perfectly legal to carry in public. Save for certain places like schools, courts, hospitals, police stations. Just don't take it there. But otherwise, it's a fairly serious weapon. So, people are right where they say that the laws themselves don't prevent the knife crime, but knife crime is a serious problem. There was a video circulating just about a week or two ago, literally. Schoolboy out in public with crowds of people, wailing this knife around at anyone that was in his way, and it's a serious problem. Just as and I think any weapon can create a serious problem. And so
that exception's sort of interesting because, and no legal advice to anyone, don't take my word for this, but it's very similar to kind of how New York handles its knife laws, where they have what's called gravity knives. So anything that opens by a mechanism or under its own weight is illegal. But that folding pocket knife probably would not be.
Yeah, there really aren't any gravity knives. I mean, that used to be a thing, but I mean, you'd have to go out of your way to find a gravity knife. A switchblade, you'd have an easier time finding. A gravity knife, not so much.
Well, a gravity knife is
that became a huge debate because of the butterfly knives. Does that count as a gravity knife? Because it doesn't technically open under its own weight, but with a little manipulation, it can.
I suppose.
That became a really interesting court case a while back.
I just can't help but think that we also should have Ian Runkle on this discussion about knives and various weapons and whatnot out of Canada.
It's interesting. It's interesting as you debate like these various policies and various regulations, because I think I saw an article along the lines of Canada was looking to freeze firearm purchases. I don't know the extent to which that was, I misread it or overly broad or something. And of course, we have in the US our own controversies dealing with firearms regulation. The UK, you have your controversies dealing with, what, and I find some of these distinctions a little bit interesting because like, well, it's a pocket knife, but it doesn't lock. So that's, the distinction we're going to draw. And I find some of that a little bit arbitrary and interesting, but it's just like, and it's like, why here, somewhere else?
Same here. It's got to be no more than 3 inches, immediately foldable at all times, doesn't lock, isn't gravity fed, doesn't come out with a push of a button, and doesn't have any slogans indicating harm on it, like, die, scum, or whatever written on it, something like that. That would make it illegal. Gravity knives, yes, they're banned as well. Flick
so
knives.
The knife that Amber bought Johnny be illegal?
Good question.
But there's the thing. I mean, so with this, it doesn't lock, but it's fairly solid. You have to use quite some force, but it is immediately foldable. The immediately foldable bit is a common law decision. So the law itself is Section 139 of the Criminal Justice Act 1988. Yeah. There's an exemption within that for folding pocket knives, and otherwise it's an offence to be in a public place with a bladed or pointed article. And interestingly, that could be whether it's sharp or not. So a butter knife, which is obviously it's got a dull edge, which is used to scrape butter, has been held to be a blade for the purposes of the legislation.
Wow.
Okay. Yeah, I mean that makes sense logically.
So, so here, Okay, Schmitty D says, I'm not sure about other states in Australia, but in Victoria, carrying a pocket knife is illegal. It's considered as carrying a lethal weapon. Very, very interesting. Coming from the United States, where all of that is 100% fair game. I mean, other than certain venues, obviously, as Daniel suggested.
New York
New
York City might want to have some words, but yeah, generally speaking.
Interestingly, in New York, you can, as long as it's legal under what we discussed, you can carry it, but you cannot carry it open. So
yeah, I actually did a video on
pocket.
this some time ago with the comparison of different states and what the requirements are. There's a whole load of different requirements of concealed, not concealed.
The public can't see it.
Yeah,
You're only, which is so strange to me because it seems odd that you're only allowed to carry a knife concealed. That seems somewhat almost backwards.
Yeah, absolutely. Let me just pick up briefly on the super chat that was on screen for some time. Question from me, which was so a QC is a Queen's Counsel, colloquially referred to as silk because of the gown that they wear, which is made of silk rather than heavy cotton. Question: as an American litigator, shocked, handed off the case to a QC for the most important part. So a Queen's Counsel, there's only, I think, around 1,800 Queen's Counsel in England and Wales, and they are the most senior of the profession. Usually, at the very least, 15 to 17 years in practice. So the most senior, the most experienced barristers become QCs, and not just barristers. Actually, I think just not long ago, there's some solicitor appointed Queen's Counsel, but that's why it's the most senior of the profession. So you very often have what we call a senior leading a junior, so a Queen's Counsel leading what we call a junior barrister, which is an odd term in itself. You could be 15, 20 years in practice, but if you're not a Queen's Counsel, you're a junior.
All right. So interesting. So how does one become a Queen's Counselor?
So there's a whole application process, which is very intense. And I think it would only really be entertained if you're in excess of, as I say, 15, 17 odd years in practice, and very specialist, and you have interviews and everything else. So it's it's quite a specialist process.
Okay.
There's an honorary QC. You can be given an honorary QC title, but if it's honorary, then you can't advertise that fact when you marketing for work, if that makes sense, because it was an honorary appointment rather than an earned appointment.
I see.
The distinction is interesting.
It's almost like a pro-oc kind of thing.
Yeah.
Almost. It
like
feels
doctorate versus honorary doctorate or something. I don't know. Anyway.
Yeah, something like that.
Yeah. Interesting. I'm wondering if there's any sort of parallel between that and I think in France they have a notary, which is like I think that's very different than what we would consider a notary in the United States. I don't know. I have no idea if it's at all similar in this sort of like scheme, but in the United States, you have a notary is just basically somebody who takes like a day on a Saturday to take some training, and then they're able to basically verify if someone's signature that they did right before them is the actual real signature. They put a stamp on it. They say, okay, you can go take this to the bank.
I want an answer to this super chat, because writer to the signet sounds like the baddest ass thing ever. I didn't know it existed until right now, and I want the title. How do I become writer to the signet?
Something new on me, actually.
Okay.
Is it special? It's probably specialist in Scotland. I don't know.
All right.
Well, I could, again, as all lawyers say, I could look it up.
Exactly. I'll research it and get back to you.
Knows the answer.
So interesting. Just picking up on a point just a moment ago about what you can do when you become a barrister. So on my practice certificate, obviously, rights of audience is the big thing. So it reads as follows: to exercise the rights of audience before every court in relation to all proceedings. I've got the conduct of litigation, which isn't standard, but I have that. Another standard is administration of oaths. Another standard is immigration work, probate activities, reserved instrument activities, and I also have registration as a public access practitioner, as I said, because otherwise you can't deal with the public directly without having that, which I still think is odd, but those are the rules.
That goes back to the whole anonymity idea, if you trace it back.
Maybe, or maybe it's part of the training, because none of our training, actually, that's not true. I was going to say none of our training involves dealing with the public, but it sort of does, because we incorporate conferencing, what for the solicitors course they call interviewing and advising. We call it a conference with the barrister. So ours is to get to the real root of the problem, or the root of the issue, or the root of the crime and the offence, and advise on it. So in a nutshell, the solicitor will typically come to the barrister for the specialist advice and drafting and going to court.
Interesting.
So, yeah, there's a distinction for some reason somewhere, and it's stuck. But here we go.
Well, let's we can go through some more super chats. Here we go. Terry Morgan, thank you so much for your very generous super chat. Says, question, UK, how can inquiry be started into alleged undisclosed conflicts of interest of the judge? Or, for example, son working for the same group as the son, and the alleged connections with his wife and daughter heard at a meal with one. Can public opinion force hand to investigate? Now, I know that was one of your slides that you kind of skipped through. We can share your screen again.
Yeah,
so
it was something. This is not my slide. It's something that I found to highlight. That
I've seen it elsewhere around the internet too.
So people are raising the questions, and as I say, not my slides. They're not my questions, but people are raising the questions. To answer the question, how could that be looked into? I'll start by saying it probably won't, but there surely is a mechanism for that to happen. But it could either be through the court system, potentially even a judicial review, albeit it would be out of time of the decision because it's a public decision by a public body and so on. But I don't really know. There must be some mechanism. But that's the slide. If I can just hit left and right. Where was it?
Yeah, we'll find it. I've seen this before. Yes.
Yeah. So again, I was looking into it. These questions came up. I found this, and so the bit about this again, I'm going to say it as it is. I'm going to say what the slide shows. Because I haven't looked into the factual basis of it, whether any of it is true, but this is what people say.
Right. And to clarify, like, we're not endorsing this idea. We're just presenting this idea as having been put out there, otherwise. So none of us are claiming to have any sort of facts that substantiate it, but it is a very interesting concept and a very interesting theory.
Yes. And so with that said, and thank you for that, with that said, in that light, this sort of whoever did this investigation or produced this slide, it shows that Robert Palmer, right in the middle there, obviously the judge's son, works for Talk Radio UK, which also employs Dan Wooden, who wrote the article. And obviously Talk Radio UK, you can show, owned by ultimately the same company. So the Sun having published the article, it raises the question as to whether there was any bias there. That together with, I think this was talking about Amber Heard having gone to a party, who's mutual friends with someone, and the judge's wife. So I think what I can say about all of this is that it is not uncommon for a barrister within chambers to be on the opposite side of a case. In fact, that's quite common. It's not uncommon for a judge to have some connection with the barristers who are presenting the case. Again, that's quite common, owing to the fact that it's a small world at the English bar. Bar of England and Wales, I should say. So there's only 17,000 of us. Obviously, even fewer senior barristers, as in Queen's Counsel, and even fewer judges. So, as you can see at the very top, Doughty Street Chambers, very prestigious chambers. It says employed by, but chambers don't employ the barristers. The barrister is just a member of chambers. So it's almost the same legal status as a club. And so this is just setting out potential links and potential bias, and that's what this is getting at.
All right. Yeah.
I'm
Yeah.
glad this got asked because I had this question, but I tuned in kind of late, so I didn't know if it had already been answered. Because I'd seen this before, and this doesn't look good, if even part of it's true.
I mean, the point here is this is twofold, and this is, but it's entirely possible that there is bias, and the decision was biased for all these reasons, but ultimately it would be unlikely, ordinarily speaking, because a judge shouldn't be biased. But it's not to say it's impossible. Because
it is a little tangential when it's written out this way. The relationships are pretty tangential.
This is a little conspiracy board.
It's a little conspiracy theory. It's a little corkboardy.
I would say most of them are. Yeah. The one that calls into question is his son working for talk radio. But if that were
he works for talk radio who employs. I mean, that's like, it's like, I work for a huge outfit, that the idea that I know someone who also works for them and that there's some sort of relationship between us is farcical, at least in my case, without more. So,
and if I put this into context, I've been instructed on a number of cases for and against what we call a local authority. So effectively the local government for that area that handles, let's say, a child case, and the local authority is applying to the court to remove the child from parents because they believe the child is in danger. So I might be instructed to represent the local authority in support of that claim, or I might be instructed by the parents or by solicitors on behalf of the parents to defend against that. Now, I could be doing both in the same day with different cases, or in the same week or the same month. So for someone, and people have, not against me, but against colleagues of mine, people can and have said, hang on, you were in a case with, this counsel, a week ago or whatever. Therefore you're biased in their favor, but that's just not true.
Yeah.
Because we're professional, and it doesn't happen like that. Even if I didn't believe my client, even if I felt that they were really guilty of something, it doesn't matter. That, you all lawyers, it doesn't matter. What you believe doesn't matter.
Yeah,
you can advise them as the strength of the evidence.
Even here, you have repeat players. I mean, there's a major plaintiffs firm that they sent, Guinness and mugs to our Christmas party just because we're collegial people. We can be advocates. We can be zealous advocates for our clients.
This chart is a little bit like saying, for a barrister friend over here, that one of your mutual friends went to a dinner party with counsel for the opposite side. Therefore, you must be in the pocket. Like, do you even know that happened? Probably not. Because, this is interesting information. One of my friends was at a dinner party with this other random person. It's so conspiracy theory.
It is.
Well,
it is. What do I think is? Go on.
Oh, I was going to say, I think you can get the dinner party part of it off to the side, but I think it's the issue of, at least here in America, if there's the appearance of impropriety, that's enough that there's an issue. That even at the lowest level, okay, this seems, your son works for the company where this guy wrote the article. I think, but I think that's more than enough. Hey, I mean, there's come out recently, I think, Kurt, I don't know if you've heard about this, but people had done some analysis of, federal court cases where there's, a ton of cases where the judges should have recused themselves, and there were actually true conflicts of interest and impropriety issues, and they didn't. I just think, what? It doesn't hurt to say, look, here's how good we are, here's how above board we are. Yeah, you know what? This may be like a little iffy. You know what? Done. That's how good we are. You don't have to worry about it.
I don't know. If I was a judge in this case and brought this with a motion to recuse, my inclination would be, no.
I mean, a very quick search. Sorry, a very quick search says around 200 people employed by Talk Radio. That's just it's coming from LinkedIn. I don't know if it's accurate, but that's what a quick search says. 200 people. It's fairly small in the grand scheme of things. But how many people do you really know personally? It's probably not 200. The chances are he, didn't know this other guy. Maybe you did, maybe you didn't. But I think the more important point is that, as you say, in the public perception, clearly, because this chart has popped up, and this was the main reason for bringing this chart up, is this chart exists because someone has arrived at this conclusion, if this is indeed factual, that his son works at the same place.
I'll take their word for it. But we are at the cork board, and it's always sunny for Philadelphia territory, and I'm just like not having it.
So all I would say is if this is the case, and if this is a factual representation, it would have been better to not do the case. It would have been better for public perception to have someone else do it, or have a jury do it, as we mentioned earlier on in the stream.
That's a very good point right there, Daniel. And I was going to say that I've been in a case where the judge had his son-in-law was a brand new attorney at the firm that was at which the opposing counsel was working, right? So basically, the opposing counsel's firm included his future son-in-law. It was like they were engaged or something like that. And so the question was, is he going to prefer their firm over ours, knowing that, you know, his future son-in-law is going to be working there? He's like a brand new, like, baby lawyer right out of law school, this kind of thing. And so we had a question of like, wow, like, is he actually going to recuse himself? Because I had never seen that in actual practice. I had heard about it, I had read about it, but I'd never actually seen it. But in that particular case, the judge determined, I mean, and he had a whole reasoned opinion for this issue as to whether or not he was going to recuse himself. And so he basically had this whole reasoned opinion. And he said, actually, you know, I understand that there, you know, there are those that, you know, might not be able to set aside some kind of a bias or whatever. But in this particular case, I really don't see that there's an issue for me here. I don't see that there's any reason for me to, you know, favor one side over another. Of course, we are trusting that the judge is being fully honest, and who knows, because judges are human too. But I do agree generally that the standard is the mere image of impropriety is going to be enough in the United States for the judge to say, I'm going to be recusing myself here. I'm not going to be handling this case. But also, I mean, on top of that, that's, as you pointed out, that probably is all the more reason why that should have been a jury case as opposed to a non-jury case, because it adds even more weight to his position and his potential for bias and his potential to be swayed according to those biases, and the higher consequences for that on top of it.
Indeed, and I maintain that view. If there were a jury trial, you know, charts like this probably wouldn't exist, whether it's based on fact or not. So
yeah,
either way,
we'll start putting the jury on the chart, how they had dinner relationships with random people. I tell you what. Yeah.
See, wow, Barrister, a lot of your fans who came over don't have very good opinions about the son.
Oh well, I mean, the son is trash. I mean, we agree.
No, I know,
that
but
much.
When you see like they're not worthy enough to be your chips to be wrapped in them, like that's
yeah.
Yeah.
Well, they're fairly frequently sued for getting things wrong and having putting photographs saying this person was convicted of X, Y, or Z when it wasn't. That they got the photograph wrong. It wasn't that person. There are mistakes made. There are mistakes.
That's a big mistake.
Yeah.
Especially if you knew what the crime was, but I can't say.
Yeah.
Wow.
Terry Morgan also wants to know, regarding bias and conflicts, would a successful UK petition be enough to push a review of this?
There was in my searches, I came across a petition. I think it was a change.org petition. So it's not like a government petition, but it can go as a signature docket to go to someone in power to. So I'm not quite sure who that was aimed at, but anything is possible.
Okay.
There's public office for virtually everything. So if they wanted to do a full review of it, I'm sure that there would be a way of doing it. If not, then it flies in the face of a democratic system. But
of course. So, that was going to be my question with regard to that super chat was, is there an official petitioning process by the public in the UK that would be different from the United States, or would that be more of a change.org kind of thing?
There is one. There is an official petition to Parliament, and I forget the numbers, but it's something like if it gets more than 100,000 signatures, it's debated in Parliament as an issue to take action on. So there is an official route for that. Yes. Yeah. A lot of people go to change.org because, quite frankly, they've got the system set up quite well to email people, and then with one click within your email, you've signed the petition. So they make it very easy, which is why it works quite well.
Oh yeah, that makes sense. Hick Chick 112. Oh, sorry. Says no. I don't know if you had another thought on that. I didn't want to.
It was a tangent about change.org, but it doesn't matter.
Oh, okay. Would a loss for the son financially affect the son's employment? My guess is I wouldn't assume that right off the bat, unless he had some sort of a partnership interest in it, like a financial interest in the overall company, which I feel like that would have come out about that rather than just him being an employee at this point. I'm not sure if you have any other information on that, Daniel.
There's no automatic effect on employment. It would make its own choice, and I would suspect they would stand by their. I mean, he was an executive editor who's described as. I think they would stand by their editors one way or another, because sometimes they'll get things wrong. I think if it had the rep, I mean, I'm guessing, but I would think that if it had the reputation of just firing somebody because something was disputed successfully in court, I just don't think they would do that. They might choose to do it, but I don't think it's certainly not an automatic thing.
Yeah. Elizabeth B says, are there difficulties in becoming a barrister based on someone's accent? I've heard there's some discrimination in that regard.
So here's a very broad answer to that question. There was I think there was a program that actually brought this into sharp focus, just called The Barristers, I think the program was, which I think it was that program. I might be stunned to be corrected, but I think it was that program where someone was applying for pupillage and was going in, and it was not so much an accent as the attitude, and it was almost, I think the person that I'm speaking of was mimicking someone else in an unfavorable way, which is not something that really ought to be done, especially in a professional setting. If you did it as a joke outside, it's probably fine, but in that setting, it wasn't. But I don't think, I know it's a perception that accents really matter. I don't think that's the case now. I mean, you can't speak for all chambers. I'm sure some chambers want a very particular type of person and so on and so forth. An accent is not automatically a protected characteristic. If it could be shown that it was an accent from a particular place, and the view or the decision was taken because of the origin or the nationality, that would make it a protected characteristic, and yes, that would be an issue. Bethany says accents are tied to class in the UK. Yes and no. Traditionally, yes, but I know a lot of people that are well spoken. Most people probably don't think I have a regional local accent, particularly when they know where I grew up. But both my parents were working parents. They worked very hard. I certainly, respect the way they grew up. So I don't think accent can define you, or certainly not from where you're from. I accept that a lot of people do take it that way, but it's not. I don't think it's so widespread that it's a huge issue.
Yeah. No, that it's a very interesting perspective to get, and I understand that there could be some sensitivity around that kind of a topic or question, especially since, I mean, it's a completely foreign concept to us in the United States, since we have accents all across the board. And I mean, sure, an accent might, hey Nate, an accent might, I mean, obviously it'll indicate where you're from, But in the States, I you know, some people will have biases attached to various accents, but yeah, as far as like class is concerned, that's not so much of a thing in the United States. Jeet Rasmussen says, "Is glassing as serious in the UK as in Australia?" Now, I've only recently started to hear about this issue of glassing in Australia, and I've only really been able to sort of glance at this topic, really. But it's apparently a real thing in Australia, that if you using glass, that you seriously harm another person, it's like a separate criminal charge, or a separate claim, I suppose. I don't know if you have that in the UK as well.
Yes, in fact, it comes under, well, quite clearly under what we call an offensive weapon. So we have, it's probably similar or the same. We have 3 types of offensive weapons: those that are made as an offensive weapon, you know, a gun or a large knife would be something like that. Then those that are adapted to cause harm, and then those that are carried with the intention of causing harm. So it's the middle one that this glass would fall under. So if you took a wine bottle by itself, is obviously not an offensive weapon. If you carried it with the intention of hitting somebody with it, that makes it an offensive weapon. But then if you break it to reveal a sharp edge, then that is then adapted to cause harm. It's an adapted offensive weapon. And if you use it, then yes, it's very serious. So you don't just have the causing harm element. You've created an offensive weapon and then used it. So yes, it elevates it.
Yeah,
we part of the same offense.
Yeah, we have that same concept here in New York, where let's say a regular baseball bat isn't a deadly weapon, but if you wrap it in barbed wire, then it becomes a deadly weapon. Or if, like you're saying, with a glass bottle, you break it and you know it's sharp, then that would be a deadly weapon. So
essentially, you turn it into a melee weapon.
Yeah.
My only reference is with video games, but I can see that happening in real life as well.
but that only makes sense if you take a common household item and make it, you know, and try to kill somebody with it, then it changes the dynamics.
Oh, and here's a follow-up to that previous super chat about the writer to the signet. D. London 1144 says, a writer to the signet is a member of the oldest society of solicitors in Scotland and derives the title from historically being the clerks working for the Secretary of State. Interesting.
I got Scottish roots. I want it. I'm in.
The Scottish man up there.
Love it.
Yeah, it dates back to 1369, apparently.
Huh. That's so fast. I love hearing about the history behind all of these different changes.
Yeah, so a judicial officer who prepares warrants, writs, and other documents, being originally a clerk in the office of the Secretary of State. So, yeah, so we would have England and Wales. It would just be a court officer, and so a lot of it's another area for debate in the UK, in England and Wales. I'll specify. So a lot of people are talking about warrants, such as search warrants being issued and things like this. And some people are arguing that it doesn't bear the judge's wet ink signature, therefore it's not valid, which is obviously nonsense. Some of them are issued electronically and not even by the judge, by the officer of the court, but it's still by the court, so it's still valid. So there's lots of these arguments that circle on social media, and people believe it. And you know, without being disrespectful, I think some of them it's quite outrageous what circulates and that some people believe. Some a lot worse than that.
Oh yeah.
Greg Rogers says, Black Belt Barrister, how are judges selected and then moved to more senior courts?
So you say judges, so I'm going to exclude magistrates, because magistrates are 99% unqualified, and there's a few that are qualified. But so leaving magistrates aside, the lowest is a deputy district judge, which is the lowest rung on the judges ladder. Barristers or solicitors or even legal academics. I don't know how it works with legal academics, but certainly with practicing lawyers, you have to be practicing for 5 years before you can apply for that position. And a deputy district judge is a part-time role, so you are paid when you sit. as a judge, but you can still practice. A district judge, as in a full-time district judge, would probably progress from a DDJ, and you'd be selected for that position. But then once you're a judge, you no longer practice, and from there you would become a circuit judge. But again, you'd be the traditional saying is you'd have your shoulder tapped, because it used to be very sort of secretive and private. Now it's very much more open, and there's panels and so on. And so from a district judge, you could go to be on a circuit judge. Circuit judge you either see in the civil courts as a circuit judge, or in the Crown Court, often referred to as a Crown Court judge, is a circuit judge, just to add another layer of confusion. And then beyond that, you get obviously high court judges in the criminal courts, often referred to as a red judge because they have a red gown and so on. Typically, you're appointed and selected, but from the lowest rungs, you can apply. If you're very senior, I think there is an application process for senior positions, but you'd have to be senior in your role to really warrant an application of merit for that.
So am I mistaken in what you said? Did you say that you basically stop practicing as an attorney when you become a judge? Are
Yes.
you able to ever step away from being a judge and then go back to practicing as an attorney afterwards?
My understanding is no. I think you can't. I'd have to look it up to be sure, but I think you can't. Just as I'm fairly sure that you can't practice once you become a full-time judge either.
Well, that's interesting.
So it's either staying as a judge or retiring after that, basically.
Yes, and there's a saying there's a saying at the bar that when you become a judge, you take a 300% pay cut because you earn more as a barrister.
That's true in the U.S. typically too. But yeah, you can go backwards, as it were, in the U.S. There have been even federal courts of appeal judges that have occasionally resigned to go back to being for example, I mean, Merrick Garland, well, I don't know if it's a great example. Merrick Garland resigned as a chief judge of the D.C. Circuit to be attorney general, which is, kind of the practice of law one would imagine. So that's a pretty good example.
No, I had a family friend who used to be a state court judge, and then he went back to criminal defense work because he said the money was better.
Yeah, the money's definitely better.
Yeah, I would say so. Charlie wants to know, how is it applied in UK law? Judge relied on Rocky and Whitney accounts for events they were not there for, could never be used in the US case. Whew.
So hearsay is by default not admissible unless it's admitted, and that's a decision by the judge, whether it's a civil or a criminal trial, because it's a decision of law, and all decisions of law are made by the judge. Albeit obviously in a criminal trial, the jury make findings of fact. In a civil trial, the judge also makes findings of fact. And so, so in a nutshell, the judge made the decision as to what hearsay was allowed. And so this is why, moreover than this chart we looked at, I say, and this is my opinion, that there's a lot of evidence that was what I would call double standards, really, which is applying a rule of evidence to, let's just say it, to Amber, and allowing certain evidence, and then either disapplying or applying the rule in reverse to Johnny Depp. And actually, if I skip to the end of my note here, I had yeah. So in particular, one of my thoughts were that in this judgment, the judge had specifically said, and I'll find the slide in a minute, but it specifically said that evidence given under oath is essentially more reliable because it's taken under oath or affirmation with to tell the truth, the whole truth, and nothing but the truth. And so thus took Amber at her word for everything that she said in court, and almost just disapplied any other evidence. But when it came to Johnny Depp giving evidence, very often disregarded what he said, even though it was said in evidence. And so I'm of the view you can't have it both ways. You either apply it to both or not at all. Now, right. I accept that some witnesses are are less credible than others. But that comes back to the issue of credibility that we talked about at the outset. So again, if you've got two witnesses which are otherwise indistinguishable, they just turn up. So if you, again, I'll use an analogy because I like it. I think it helps. If you've got a road traffic collision, two cars hit each other, you've got four people standing on the pavement or the sidewalk, and you want to know what they saw. Well, they're each independent. They're not related to anyone in the vehicles. They'll just tell you what they saw. They'll come along and they'll give their views. So they should all be taken the same. If one of them has a long-standing record of being accused of dishonesty or all this sort of stuff, or even accepted some of it, which is part of it in this case here, that goes to credibility. And so if you've got someone that has all of these question marks over credibility, you can't really apply this rule so strictly that they said it in court, so it has to be true. I don't buy that. As a lawyer, as a businessman, as a human being, I don't buy that. Just because someone's standing in court does not mean they are always telling the truth because they said so. Otherwise, they wouldn't have criminal trials, would you? Because you wouldn't have a defendant denying the crimes that they're accused of, and then they get convicted.
Right.
Believe it or not, some people actually lie, even in court. So that's
not Amber, though. Amber's telling the truth.
I was going to say, I mean, in this case, someone has to be lying because it can't be that all of these things are true that have been testified to in court.
Well, if you take the bit about Amber saying that she had been violent, and then in this case said she was being sarcastic, and so on the recording, if you listen to that in isolation, she's admitting to being violent. In court, she said, I was being sarcastic. It's like, yeah, I hit you and being sarcastic. And the judge accepted the court account on the basis that I've just said, on the basis that it was said in court.
See, in the United States, I feel like the trust works in the opposite direction, because the idea that, and that's the whole idea of impeachment in the United States, is that the statement that you made when you didn't have a lawsuit pending, you weren't under the gun, you didn't know that someone was going to be deciding your fate in one way or another. Yeah. You basically had no interest to be lying under that previous statement, or at least less of an interest to be lying. That prior statement seems to be much more trustworthy in American courts rather than the one that's in court right now, where of course they are very aware as to who is analyzing them and the statements that they're making.
Well, quite. And therefore my example with the four innocent bystanders that witnessed a car collision, they don't know them, they don't care to lie, they'll just tell you what they saw. Whereas in the UK, specifically England and Wales, because that's where I practice. But there is this assumption. It's an old assumption, and it's probably, I think it has too much reliance placed upon it, that if you swear an oath, that you are taken to be taking the truth unless it can be shown otherwise. Now that is a good default position to start from if you do take any other factors into account, such as you've been accused of doing half a dozen different things which are inherently dishonest. Therefore, your word should not be as credible as it should have been. So, for example, we talked about the assistant Macmillan. The dog smuggling incident. So she pleaded guilty to illegally importing dogs into Australia. The judge said, in fact, I might. Should we bring this slide on screen again? It's not.
Oh, yes.
And I'll find it wasn't that, obviously. It's this one. So this is in relation to this. So she pleaded guilty to illegally importing dogs into Australia. The judge said the offence to which Ms. Heard pleaded guilty involved knowingly making a false statement. As Ms. Callahan said, it was not a trivial offence, but the nature is so far removed from the evidence which Miss Heard gave in this trial, its relevance is for her credibility is marginal at most. Now, with utmost respect to the judge, I disagree. Because knowingly making a false statement and pleading guilty to the illegal importation of an animal to a country, as was said, is not a trivial offense. But I know it's not. It wasn't a defamation crime or anything. It was an importing a dog illegally crime. But to me, that affects her credibility.
Well, with the, with all due respect to the UK system, in the United States, this is definitely relevant, because this especially perjury in a criminal case, that you can bring that up because that's directly affects your credibility, because it's not perjury for what happened, it's perjury to the system, right? You were in court and you've said something to a court, no matter what it is, that they've been able to determine is false. So even here in the United States, you can bring it up in any case, right? You were found to be perjuring yourself, in this situation, if it's in the U.S. court. So I'm surprised the judge would say, well, you've lied to courts before in the past, but that's not relevant to whether you're telling the truth to this court now. And that's generally just not the way it rolls.
That's exactly what this paragraph of the judgment is saying. And as I said, with all respect, I disagree. I do not think it's marginal. And, no one's, as I said, I'm a humble barrister. No one is necessarily to take my word at it, but I would bet that if you put this to public opinion poll, you'll get a high degree of people say, yes, it's relevant. It's not, as he put it, marginal at most. But there's more than that. And this is really why I think a lot of people in the UK that took an interest, and worldwide that took an interest, took the view that there's at least perceived bias in this case because of the way that these were approached. And you can tell that there wasn't a great deal beside that gave more reasoning than that, other than this is what she said. It's the evidence she gave at trial. But more serious than that, the allegations that she'd forced Kevin Murphy and tried to force Kay James to lie for the Australian proceedings. I think this is the next slide, but the judge had found there was no evidence that Kate James was actually asked to sign a statement. Now, this is, I won't swear, but this is legal manipulation, I think. This is,
you could say bollocks. That's fine.
Yeah.
This is lawyer twisting, and it shouldn't come from a judge. But here so what we've got, I'll explain it and then we'll read it. But what we've got here is saying there's allegations that she was forcing him to make a dishonest statement. But because there was no evidence that he was asked to sign a statement, or no evidence that he was asked to sign an untruthful statement, then it doesn't matter. I think it does matter. So
I would think her being pleading to some sort of offense that includes dishonesty as an element might be material towards her credibility in some sense. Yeah. And I'm wondering at this point why it didn't come up in the U.S. trial, to be honest.
Let me find this bit in the judgment.
Yeah, so, I'm wondering the same thing.
That seems,
so let me read this. Let me read this out. So
material.
I don't think it's in the slides here, but I'll read out. So for those that are interested, it's paragraph 131 of the judgment. So it says, on the 11th of October 2015, Ms. Heard wrote to Ms. Murphy. She forwarded the email chain above. It may be that Ms. Heard also forwarded the chain to Marty Singer below and said, Kevin, what do you think? Could you possibly reach out for us? Do you think you could get her to do it? And what she was referring to, which I think is above, yeah, there's a bit above that as well. So all of this is essentially she's asking someone to make a dishonest statement, although didn't actually give them the statement and say, here, can you sign it? And it obviously, because that didn't happen, it wasn't a dishonest statement. Judge is essentially saying, because that didn't happen and wasn't asked to sign such a statement, then it doesn't matter. So this then goes on to say, Mr. Murphy said in re-examination that he'd refused to ask Miss James to make a statement. In any event, submitted the suggestion Miss James might be asked to make a statement was not truthful, came from Miss Mary Singer, so on. So, however, even though Mr. Murphy said that he made the untrue statement for the Australian proceedings because of the pressure that she put on him, he said that when he expressed discomfort at making a full statement, she said to him, and then it goes on. So he's saying,
yeah, I think I remember hearing about this now.
So this is where the divergence comes in. So he's saying that he made this untrue statement because he felt uncomfortable of the pressure he was put under, and yet the judge is essentially saying because she didn't ask him to sign the statement, then it didn't affect her credibility.
That's really parsing some really, really narrow straws here. Like, my God, there's something else going on here. I'm not to, well, it's in the UK, so they can't get me. I'm in the United States. This sounds very corrupt. I'm just gonna say it. And no disrepute to the profession over there, but none of this is making any sense, because so she tells him to lie, but she didn't tell him to sign the statement. It doesn't matter, since she pleaded guilty to lying, but it's kind of different than what's in this case. It's it seems like the judge kind of went out of his way to find this. Is anybody else feeling that way? Maybe I'm just alone.
I am too, and I do want to clarify that the statements that we're making that are in, pointing out how the American system is different from the UK system, none of that is intended to say that the American system is better than the UK system. I'm more fascinated.
No. Yeah, I'm not saying
I'm much more fascinated by the fact that we have these divergences, especially because we have a common system, especially because the American system comes out of the UK system. So all of that stuff to me is just absolutely fascinating. And of course, we get things wrong many times, all the time. We talk about this on our channels quite a bit as well. Our many disagreements with American cases too. So I just want to make that clear to everybody who's watching, that we're not trying to like disparage the UK system at all. But I do agree with you, Nate. I do. There are enough things here that just kind of keep stacking up that it does sound like this was a very strange case that was decided in a very strange way.
Yeah, no, get me on a roll. I'll start disparaging some U.S. courts, some U.S. judges. I'll start disparaging the entire U.S. Supreme Court. No problem. Where do you want to start?
That's true.
I've now found the first bit of that email, which is slightly further up in this bit, and because we've gone slightly out of order, but it's not on a slide, unfortunately, so you have to listen to me read it. But this for me this is what did it for me, because this was accepted as a fact that she wrote this email, bearing in mind what we've just said about he wasn't asked to actually sign a statement, but this was her email on the 9th of October. This is in the judgment, paragraph 129. On the 9th of October 2015, Miss Heard wrote to Carl Martin and Marty Singer, in the course of which she said, the only thing, and this is Amber Heard writing this, the only thing we are missing is evidence of the process being initiated, however, not completed, and therefore the dogs weren't taken on the trip. That is obviously harder to prove since it involves documents something that didn't happen. However, since I know we attempted to bring them at least once before on the Australian trip, I can ask Kate to include that in her statement. Would that be helpful? If that would be helpful, that would be great, was the response. And then the response to that was, Kevin, what do you think? Could you possibly reach out for us? Do you think you could get her to do it? And following on from that, because no statement was actually produced and asked to be signed, it goes through several more paragraphs and essentially says at paragraph 147, which I don't know if I put in this slide. Yes, I do not, as a result of all of that, several paragraphs later, I do not accept Ms. Heard sought to pressurize Mr. Murphy into making a full statement for the Australian proceedings. And then accepted he did have primary responsibility for making the travel arrangements. On his own account, was prepared to give a false evidence to the Australian court that's not encouraging starting point for submission that his evidence is now to be believed. So here's the double standard. So because he was considering making this false evidence to the Australian court, his evidence wasn't believed. Or at least that was his starting point to say, the judge says that's not an encouraging starting point for the submission that his evidence is now to be believed. Accordingly, I do not consider the allegations regarding those to impinge the credibility. But she asked him to do it. So person A asks person B to make a dishonest statement. Because person B is thinking about doing it, that makes person B not credible, but person A is okay because person B didn't actually sign it in the end. I just find that a stretch too far. Personally.
Yeah. Yeah. It is very strange. It is very strange, especially when you stack everything up together. You've got Miss James, you've got Mr. Murphy, you've got Johnny Depp, you've got all of these other people. Another question that has come up is, well, I suppose we should really get some more super chats in here. But one of the questions that I have also is about the police testimony, the LAPD. It's my understanding that the UK judge also disregarded their testimony because of the fact that they did not file a police report.
Yeah, so there's a few references to this in the judgment. And part of it was because there was no, supposedly no pocket notebook entry, as we would call it. So notes of the visit. But there was, as surfaced, I think it was literally a few days later, the body-worn camera images, video. Mm-hmm. And essentially, as I remember from the US trial, someone, the question was raised, well, wouldn't people give you their names and whatever? And she said, no, because people don't like us. Okay. And I mean, sure, right? I mean,
let me ask you this question. Assuming, okay, let's take as a given, which I'm not sure is true, but let's take as a given that all the evidentiary issues in the UK were correct. So in terms of like what should be admitted and should not. So a lot of these are conclusions based on the judge's assessment of facts. So do you disagree with them? And if you do you disagree with them to the point where you think that that could be reversible error? And again, I'm assuming that all the evidentiary issues were correct. The reason I asked the question is because if I'm putting myself in the US, if this is a US case, I'm thinking about this as a Court of Appeals judge. Assuming all the evidentiary issues are correct, I'm not 100% sure there's anything I could do about it as a Court of Appeals judge. So that's one of the reasons I ask.
So there's quite a few decisions that if you look at and follow the rules, it might seem odd, but it's within the rules, so it's okay. And there are some decisions which are purely literally a judgment, a judge's judgment as to what weight to place on certain bits of evidence. And I think those are more questionable. But the problem with that is then you are attempting to impugn his judgment, which is not a ground of appeal.
Yeah, basically that's the same problem in the US. The way we'd be phrasing this is essentially as abuse of discretion, right? Because if there's a legal error, we're talking about clear error. So I've taken away all those issues because I'm working on the premise that all the evidentiary issues are correct. So I'm taking away clear error. So the only thing left for me is abuse of discretion. The judge is now in the position of the finder of fact. Like the jury, the judge in the position of finder of fact is the assessor of the evidence. Like a jury, they have the power to assess the evidence, regard any witness or disregard any witness in whole, in part, in fraction, not at all. They can think they're lying about some things and not lying about other things. That would be fully consistent for a jury to do. So it would be consistent for a judge to say.
Or is Kurt's audio sounding bad?
I'm sorry. Is it a problem? Can I move it closer?
It's fine here.
It's fine here to me.
Is it okay? Then it might be me. It might just be me. Sorry. Continue. I'm going to turn off my camera real quick while you talk.
No. So I was just saying like where the judge is saying, for example, like I found that they're pleading guilty to this, but I'm also going to find that they're not lying. Like a jury could theoretically do that too. Like whether or not the Legalbytes forgot to mute. We'll look past that. So I one of the reasons I asked this is because, like, I mean, is it so manifestly bonkers as to defy reason is basically what I'd be trying to do as a court of appeals judge. And I'm like, probably not. Yeah. Even if I disagree with it, even if I do different things as the trial judge, I'm not sure I can do anything about it.
But the thing is that this is a horror show in I think, errors, because I think you're right. This is abuse of discretion, but I also think that, and this is essentially a quintessential he said, she said case, right? He said he did it. She said she didn't. I mean, he didn't do it. But in this case, when you're talking about credibility, all of these things I think are critical to assessing someone's credibility who's telling me that something has happened to them, right? The fact that you would go and have people, make false statements to authorities on your behalf, the fact that you did make false statements to authorities and then had to plead guilty to it. The fact, all of these facts, it's like, I understand maybe one piece you can say, okay, I'm going to disregard it, but all of this evidence, and now it starts making sense why this had to be 129 pages, because this doesn't seem like a judgment based on logic, but this seems like a judgment based on excuses. How do I get around these bad facts? And let me explain to people how I'm dismissing these bad facts. And every time you go through a new one, it just seems like it's building up. It's like we at first it was just like a little molehill. Now we're at mountain status. Like, really, how much more do we have to ignore to get to the place where Johnny Depp loses? This is a lot that we're ignoring already.
It is a lot. I agree. And it might go to some, and maybe you can speak to this, barrister friend. I apologize. What is your name? I keep calling you barrister
Daniel.
friend. Daniel, perhaps you can speak to this issue. To your degree to which, because it's been suggested that the wokeness is been particularly absorbed in the UK system, perhaps more than the US system. And so perhaps there is some baseline cultural zeitgeist bias that might be influencing this decision.
I was going to ask if the Me Too movement had anything to do with it. If you had any opinions on that. If you can give opinions on that, I recognize that could be a complicated question.
We can't hear you if you're speaking.
Oh, you may be muted for some reason.
Daniel, we can't hear you if you're speaking.
Yeah, I think you're.
Let me try that. Is that better?
There you go. Oh, yes.
There we go. Right. So I pressed that by accident. So I think it'd be impossible to say that there was no impact. I think that would be silly. That there is clearly an impact. Some will say it's a huge impact, and some will say it's only the right amount. And we can't say for sure which it is. Yes, I think there's probably a lot of this going on in a lot of cases, and potentially this one as well. I think a lot of people will, and I'm saying this from other people that have said it to me, and it's a general feeling that you get from talking to people and other channels that I've watched that have discussed it and so on. I think that there is a sense that you try to deal with an issue which is clearly sensitive and clearly affects a lot of people very negatively in a lot of ways, and it's almost like an overreaction to deal with it, to go so far that it's almost ridiculous. I mean, just the other day there was news from a government minister that schools don't have to make certain special arrangements in certain contexts. I forget the wording for trans and things like that. So I think that there is a quite a wide remit on this, and I think it has to affect cases like this. And I think it would have at least been in the judge's mind that if he were not to write this in her favor, a lot of people will think that he's ignoring domestic violence, which if he were ignoring domestic violence that was there, then that's wrong. But that's not to say that it's there in every case that jumps up. So it's a minefield, isn't it? Let's face it. it's a political or legal minefield.
It absolutely is. And this chat is very interesting. It says BMG 313 says, look at the relationship of Judge Nichols' wife and its connection to Me Too. There definitely was, at least in his home life, with respect to this case. So I don't know if that is true. Do you have any knowledge of the wife of Judge Nichols and whether she was particularly active in the Me Too movement? That would be interesting, at least.
Yeah, I don't, but again, it's something that would, for those that are interested, but would warrant investigation, wouldn't it? Because there's a slide. It's right near the end. If I just whiz through, there's this I came across. If there are reasons that a judge would feel that they should recuse because of any kind of bias and things like that, this provides guidance on when they should do that. And there was part of it which, there's no need to read any of this out, but it goes into, you can probably see from point 2, guidelines which are likely to be applicable despite the absence of hard and fast rules are: friendships with personal animosity towards a party is also a compelling reason for disqualification. Friendship might be distinguished from acquaintanceship, which may or may not be sufficient reason for disqualification, depending on the nature. Current recent business association, various different things. So there's a lot of things here. The number one, a judicial office holder should not sit on a case where he or she has a close family relationship with a party or spouse and whatever. That's obvious. But all of these things underneath, any one of them could raise a flag for virtually everybody. So in one sense, where do you draw the line? But in another sense, if this chart is true and all of those connections are true and they're not just completely tangential and so far removed that they don't have any impact, if they are all true and they are more than 6 degrees of separation, then perhaps the judge should not have sat on this case.
Yeah. I would tend to agree with that. And I know someone in the chat earlier pointed it out that there's a similar kind of issue with Justice Clarence Thomas on the Supreme Court with regard to some of the January 6th issues, with his wife having been very, very centrally involved. So just, also again, pointing it out that we are not going to be here to say that the American system is any better or less corrupt.
although on the plus side, I use the term loosely, the judicial ethics do not apply to members of the U.S. Supreme Court, so it's totally fine.
But if they do, but there's no enforcement mechanism, because that's the rule. Because the Supreme Court's the highest court in the land, so there's no court that can come in and say we're going to suspend you.
Now wait a minute. Impeachment is the enforcement megonism that Congress doesn't use. It isn't my fault.
You want to bring back some Judge Chase action? Impeach some people old school.
But for all the lower courts, though, the Supreme Court is the enforcer because they can remove. So it's that type of thing.
They don't use the power as much as they do to be the administrative court. Supreme Court, I think, should be whacking around the lower courts a little bit more, but that's a personal opinion.
Yeah.
What is your Supreme Court like in your system? Because is it relatively new? Didn't they kind of just invent it, or am I being totally obtuse?
It's relatively new in the grand scheme of things. It was previously the House of Lords, but 2009 replaced by the Supreme Court. Essentially the same function and very limited in what it hears. It's got to be, a significant question of law and public importance. So,
how many cases a year do they hear?
I couldn't tell you how many, but not very many. Literally like a handful.
Okay.
But there was one, an interesting, totally off the wall case, but interesting in the fact that it doesn't necessarily matter how much the individual case or claim is for, but if it's of a national effect, then the court will hear it. So there was one case, there was an individual if you think of parking fines, I don't know how the parking fines, how private parking fines work in the United States, but we call it a parking charge notice. So we've got the official government one, which is a fine, which is a penalty charge notice. We have a private equivalent of a fine, which was the kind of the point of the case, which is called a parking charge notice. The difference being the latter is effectively a charge or a bill for administrative fees arising out of breach of contract because you've overstayed your parking or you haven't paid or whatever. Now, most of them are 50 or 100 pounds or whatever. This one particular one was 85 pounds. And so the individual said, no, this is the equivalent of a fine. This is not lawful, and challenged it. And it went all the way to the Supreme Court over 85 pounds. And the question for the court, along with it, heard it together with another case, which was of a similar principle. And the question was, does this amount to a fine? Because if it's a fine, then companies can't issue it. And long story short, with a similar length judgment, said, no, it's not a fine. It's a reasonable amount to charge someone in breach of their contract. And so
that makes sense.
Yeah.
So number one, welcome, Ian. Glad to have you here. And it looks like you've got your equipment back.
Ian, the Runkle's here.
Back
My life
from
is
the ether.
improved.
My wife made it. So I've got my gear back. So hopefully it won't be quite as much of a mess of audio failures and video failures and everything else.
And I hope your puppy's doing well. I know you were at the vet.
Got to go back for x-rays tomorrow. May have a torn ligament, and got to check that out because he's a sweetheart and he's taking it well, but we'll have to see. Hopefully he's doing good.
I guess Nate had to drop out. But then once we, I think Daniel had to step away for a minute. He private chatted that. But so we'll do an introduction once he comes back. But I am seeing this. Folks are reporting that lawyers are arriving at the courthouse. Most likely, I haven't seen anything. I've been monitoring Twitter, at least Shanley Shaw Painter's Twitter. The last thing she tweeted was 2 hours ago. It's a photo of a makeshift Pirates of the Caribbean ship in front of the courthouse.
Perfectly normal face.
Yes, that's right.
Yeah. And then I've been monitoring a couple other live streams to show that the holy cow chat.
Well, I mean, it could be a lot of things. It's not a verdict because I'm sure we would have heard.
No.
It might be that they have a question, or it could be just that they're camping out there because the judge did tell them to be within 10 minutes. So, maybe they're just camping out there. That could be a fun thing.
It could also be that the judge has said, hey, we're about to let them out for lunch, so we're going to talk to them real quick or something like that. And they want to be there when they let them out for lunch or something.
You might as well justify that day-long waiting bill somehow.
That's right. Can I charge twice? Can I charge Johnny Depp for the time and charge the client I'm also working on at the same time? Is that a thing I can do?
Oh, no.
Double billing?
I think there is some guidance on that.
Oh my God. No, we're not doing ethics discussions here on billing.
That's fine.
Runkle, stop it.
I have a question for you, sir, on some Canadian news I saw relating to firearms. So I saw a headline. I don't know because I just
did a big long video. It was cool.
Well, Runkle can educate me and educate everyone. So what is the latest and greatest on what the Canadian government is trying to do vis-a-vis firearms?
Greatest is not. So there's a whole bunch of things they want to do. They want to ban the transfer of any firearms.
Mm-hmm.
So basically that everybody who's got a handgun of any new handguns. So everybody who's got a handgun would get to keep it, but you can't sell it. You can't give it away. You can't inherit it. So basically what this ends up being is confiscation on the long term because without any sort of compensation, of course, because, they're just going to say, oh, well, you can't inherit it. So your heirs get nothing. Which is pretty terrible if you're talking about people who have very extensive collections, some of which might be worth, hundreds of thousands of dollars in some cases that I'm aware of. But they're also looking to put in some restrictions on magazines, which if they're phrased, and I haven't been able to go through the legislation yet, but if they're phrased the same way that they were talking about last time, may end up banning something like 70% of the magazines currently used on the market.
Sure.
So there's going to be a whole lot of people who are sitting there holding magazines for various items who don't realize that they will have become criminals overnight because it was very badly phrased. They're looking at banning airsoft as well as banning a lot of air guns. And in perhaps a real bit of twisted irony, a lot of the air guns that will be banned will have been ones that were specifically designed to comply with Canadian law. And what I mean by that is that Canadian law has said that you don't need a firearms license for an air gun that shoots under 500 feet per second. And so, but the US just classifies air guns as not a firearm if they're an air gun.
Mm-hmm.
So what you end up with is a ton of air. The US is, of course, the biggest markets. They design the guns for the US market. And so in the US market, they shoot at 700 feet per second, 1200 feet per second, whatever it is. But for the Canadian market, they drill a little bleeder valve in it. So that, and they literally call it the Canada valve, or in some cases, the Canada hole. And its entire purpose is to cut the air pressure so that it shoots under 500 feet per second.
Mm-hmm.
The new rules would say that anything that looks like a firearm that shoots over 500 feet per second, but itself shoots under 500 feet per second is now banned. So all of these things will be specifically banned because they were designed to comply with Canadian law.
Because it looks like it.
Because it looks exactly like the American model, which shoots over 500 feet per second.
Okay. And when you're talking about transfers, are they banning new purchases as well, or?
Yep, new purchases, sales, giving any of that.
Okay, so effectively they're trying to ban firearms is basically the short of it.
Banning handguns anyway, yep.
Okay.
And they're also, the effect on rifles is going to make, there's a number of rifles that may not be possible to bring into compliance. Because if they have an internal magazine, it's just not going to be doable. So,
well, I'd like to claim dibs on anything that is made illegal that you own. So feel free to send it my way.
That is probably not going to be a thing, but
okay. I just thought I'd offer, take it off your hands so you can be in full legal compliance because I'm a good friend.
And I'm sure at what is it? At a full market value, I believe was the pitch you were making there, correct?
I know. I believe I was saying, I'll just take it off your hands as a courtesy. I'll pay for shipping. How about that?
So, sorry, I popped away for a minute there. I just was checking in some other sources to see if there was any new information on the jury. And
sure.
According to Law and Crime Network, they were like, "Hey, do you have any more information on the jury?" They're like, "Well, it's been a total of 4 hours, 2 hours yesterday, or 2 hours on Friday, 2 hours today, and we have the composition of the jury." So basically no one knows anything. There's it looks like, everything is as we already knew. They of course have the laptop with the evidence on it, and they are deliberating. So the attorneys that are in the courtroom, maybe they're just standing by so that they can answer questions if they come up, or maybe they're just waiting for the judge to bring them back into the courtroom, excuse them for lunch, and then eventually bring them back in again.
And I will say that courthouse cafeteria is actually pretty good as cafeterias go. So, they might just be hanging around because
the down low from Ian.
Well,
not a bad cafeteria.
It's real information we need.
It is actually something that weighs into things, because when the cafeteria is awful, people are more likely to go somewhere else to wait.
Yeah, for sure. But just in case, when I stepped away, I hadn't yet introduced Ian. This is Daniel Ian. So just to introduce you guys, I know it's mirror image, so I always do it wrong.
Yes, the tough one is it's the opposite.
Yeah, exactly. So just to introduce you to Daniel is a barrister from the UK. He's been talking with us about his knowledge of the Depp v. the Sun case from the UK and kind of what happened there. And we've been talking about so many of the differences between the American legal system and the British legal system. And I'm so happy to have you here now too, because you can give us insight for the Canadian system for where that differs from both or neither or what have you.
They both say the Crown a lot. I know that.
Yes.
Yes. Yes.
And you may also appreciate my channel name then if you're from the UK. The Runkle of the Bailey channel name.
Indeed.
So here's a question for Runkle. Ross Wolf says, Runkle, do Canadians never lose all their firearms, ammo, and accessories in boating accidents?
That is something I can never advise, because the boating accident thing is people talk about this and it's always sort of code for I am pretending I lost it. But
no, it's a real phenomenon. It's
I
tragedy.
did not realize this until like a month ago or so, and like someone had like mentioned it on the channel. I was like, huh, okay, weird, and then like turned on to the next subject, and I didn't realize until later on that that's what they were suggesting. And I was like, oh, great.
Yeah, I mean, the thing is that handguns have to be registered, and you also have to report them as lost. So if you suddenly have a missing handgun and and it's never been reported as lost or stolen or whatever else, they're gonna have some questions for you later down the line. If
it's not lost, I know exactly where it is, at the bottom of the lake.
You'd still have to report that. So, you know, if you're saying I lost this in a boating accident way back when, and as a general life rule, making false police reports is a really bad way to go.
Of course.
Yes.
Of course. Here's another one. Peter West says, thank you for pioneering this format. It's a great way to make the law accessible to non-legal types. I will first off say that I did not pioneer this format. I did not make anything up new. I haven't revolutionized anything. This format has existed for quite some time, most notably out of Recato Law's channel. I think the Rittenhouse trial was the first time that we had a fully live stream trial from the beginning to end with a full panel of people joining in, like a rotating door of people. So I appreciate your kind words and your generosity. I will fully disclaim responsibility for coming up with the idea, because I did not. And all fairness goes to who actually came up with that, of course. Question: I know you didn't do this for the money. You all have great jobs, but did this experience make you consider full-time law tubing? Well, I know quite a few of the folks in LawTube have been aiming for basically doing this full time. I myself am, as an American military spouse living overseas and knowing that a lot of my life is going to be spent outside of the jurisdictions where I am licensed. So having an economically viable channel that can support my income and support my family is absolutely fantastic, because then I don't have to worry about finding a new job every 3 years. And that is one of the biggest struggles for military spouses. American military spouses is what I'll speak to. Across the board. So it's a big issue. That's why there's an organization called the Military Spouse JD Network, or MSJDN, and they are geared towards all kinds of different creative solutions to help military spouses who have Juris Doctorates, who are lawyers, and to sort of facilitate their ownership of their careers while still also supporting their military, their spouse who is in the military. But anyhow, I can't speak for anybody else, but I don't know if anybody else wants to pipe in on that, on the doing YouTube full-time thing.
From I don't know things I would love to, but it won't be full-time. What I would like to do is turn YouTube into my income, and then do the law pro bono, and just help people
absolutely
for nothing, because there's lots of people who can't afford a lawyer. And if I can get to a place where my economic model is the YouTube, then I can help those people for free. And this is everybody, that makes our society fairer.
Exactly. Rick,
I think all I was going to say on this was that, it's been a special time. It's been 2 months of very high levels of content creation and streaming and everything else. I am, personally looking forward to a little calmness after this verdict comes in, and also seeing what the baseline is in terms of what works and what doesn't. Throughout my almost 4 years now, about 3.5, years of doing this. It's continued to grow and eat more and more of what was initially a marketing endeavor for the firm, and that's suddenly eating the tail here. But I love this stuff. I love talking with all my legal friends here, and we'll see. I'm a little bit squeamish about being beholden to a platform that can end a channel in 2 seconds. We will see on that, definitely.
Yeah, that is for sure.
And I've been looking to do this full time for a long time. I've talked about some of these issues on my own channel as well, but my current job I've had for almost 15 years, and for the last 5 years or so, I've been in increasing, let's just say, it's not been going great in terms of my mental health. That's a good way of putting it. And so this channel was not devised originally for that purpose, but as it has grown and the issues in my day job have become more unsustainable, I'm looking to do this full time. So I'd hoped to hit 100,000 as sort of like an arbitrary benchmark of where that was going to happen. But I think either way, my job is going to end in the very near future. It's been a good job. There's nothing inherently wrong with it. It isn't to say it isn't something I wouldn't do again in the future, but I just feel like I need a break. I mean, I could always go back to it. It's not like I lost the credential or anything. So, I figured I'd give this a full-time go and see how that worked. So that's my answer to that.
Sure. Let's get some more questions through here, and then we can get back to the discussion, because I'm sure there's so much more to talk about this UK case, the UK Depp case as well. So let's see here. Melissa's
curious about something from the UK. I'd heard that they are much more vigilant about going after perjury, because here it's very difficult to get any interest in even pursuing a perjury prosecution unless there's basically like 2 absolutely contradictory affidavits or something. But I've heard that the UK pursues more of them. So is that something that can...
in a sense, that there is a sort of, I'll call it a group of cases that will do that. It's normally if someone's trying to avoid or evade liability for something, and in doing so, they commit perjury and make false statements and so on and so forth, rather than turning up at court as a witness, saying this is what happened, and someone else says the reverse, and then the judge says, well, I don't believe you, I believe them. That's not going anywhere. There's no unless it's a really, really serious lie that has significant consequences, real consequences, other than the judge just saying, well, I don't believe you, I believe them, so this case is decided in their favor. That's normally it. Whereas, to use an example, we have a system here with driving. We have points, penalty points. So a typical, you're speeding, you get 3 points. You speed again, you get another 3 points. If you get 12, it's called a totting ban, and you get banned from driving for 6 months unless you can show hardship. But what often happens, and this is where they are hot, and they will, the authorities will pursue these cases, is if someone tries to take points for a spouse or a friend or relative or whatever. So they try and take these 3 points so that the other person avoids the ban. That is, then it's perverting the course of natural justice. They are doing something deliberately dishonest, deliberately cheating the system for themselves and for their friend or family or whatever. Those, yes, they will, if they are found, they'll find themselves in the Crown Court being prosecuted themselves. So that's probably where you got that from. Those are quite common, actually, surprisingly enough. But as for a witness just not telling, if it's taken not to be telling the truth because the judge found it in favor of someone else, that's probably not really going anywhere.
Right. It's come up in the context of the UK trial, because it seems like a lot of the testimony has now been contradicted in this second trial, which is an unusual circumstance.
Yes, to say the least. I mean, it's not impossible. It's just not the norm. If someone turns up at a civil trial giving evidence, it's either found to be credible or not. And if not, judge makes a ruling in one direction or another, and that's typically it, unless it's always possible. It's a bit like, let's take family cases, because there are some really, really serious allegations made between parties within family, either children or divorce cases. Usually the children cases, the serious allegations made against each other. And they come in a schedule, and then the judge will say, well, 1, 2, and 3 are, I find, did happen, but the rest didn't happen. Nothing else happens with those. There's no, typically there is no follow-on, prosecution of that party for making a false allegation and all this sort of stuff. It just typically doesn't happen. Many say that it should happen, and it would stop people making false allegations, because I probably agree with that, because there's obviously reasons not to, but I might agree with that on the basis that if someone's made a serious false allegation, that's pretty bad, especially with some of the allegations that we're talking about here. So as there are in this case, there are some serious allegations. Maybe there should be follow-up in each and every case, and that would dissuade people from being dishonest.
So I know that we were talking about perjury generally. Any thoughts on the court possibly investigating in the UK for her statements that she saying in court in the United Kingdom that she actually donated to the ACLU and to the Children's Hospital of Los Angeles?
Let's take a look.
Now that she's actually had an affirmative statement in the United States, not quite, admitting, no, I didn't. Well, I guess she did because, she was trying to weasel out about the pledge versus donate. It's the same thing, same.
Yeah.
But
I take
eventually,
it to be the same thing, but no, they're not the same thing.
Yes, exactly.
So this is dealt with in the judgment at paragraph 577. So, and I've even highlighted this bit. So I don't know if this is in the slides. It probably isn't. Doesn't matter. It says Ms. Herr's evidence was that she'd given the sum away to charity, was not challenged on behalf of Mr. Depp, and the joint statement issued by Mr. Depp and Ms. Heard as part of the deal memorandum acknowledged that this was her intention. I recognize that there were other elements of the divorce settlement as well, but a donation of the $7 million to charity is hardly the act one would expect of a gold digger. So it was more in the context of whether or not she was a gold digger or not. But it also says that it wasn't challenged. So I suspect because also perjury in the sense of being held criminally liable is a, sorry, excuse me. I'll just mute that. Is a fairly serious thing, and so would be held to the criminal standard. And as I say, it's not impossible, but probably wouldn't happen. I think it doesn't often happen, but it's not impossible if it's found to be. If a case is brought, but I don't think it's likely.
Okay. Yeah, sounds about the same for us. And then Terry Morgan says, question, given Heard's testimony was disproven by so many witnesses for the JD case, at what point can it be said that she committed perjury? Or rather, at when can we state she committed perjury as a fact and free from legal comeback? I'm not sure I understand the second question about when we can state she committed perjury as a fact, because the question of whether or not someone has committed perjury is a legal question rather than a factual question. But you can have your interpretation of the facts. You can understand things the way that you understand them, and you can have everyone else say something completely different on the stand. It doesn't necessarily make it perjury, at least in the United States anyhow. the thing that sort of raises an eyebrow for me personally is this question of, she said one thing in the UK and then she said another thing in the United States under both of them while testifying in an actual trial court. So that's the one part that gives me a little bit of interest on this question.
Yeah, and I'm just looking for the actual statements. I think I have some links to them. I've got one document which is her testimony, I think. What's the date on this? I think this was used in the UK trial. I've not read this yet. I'm just scanning it.
Sure. Yeah, well, we can ask another question while we wait, and rather than putting you on the spot. If Elaine appeals, if Amber appeals, can Elaine choose not to represent? Absolutely.
Yep.
And Amber can also choose not to have Elaine represent her as well. Depending on the claims that she has for appeal, she may automatically need someone else to appeal as well. For example, if she makes some kind of a claim of an ineffective assistance of counsel, it would be a very awkward thing for Ben Rottenborn and Elaine Bredhoff to argue in the appellate court that yes, we were ineffective in our role representing our client in the trial court.
There was actually a case out here where somebody tried to do that, and the sort of joke around the courthouse was, well, doesn't that kind of prove itself? If if they're willing to take on the appeal as ineffective assistance of counsel on their own,
sorry, Uncle.
Yeah, it's a bad look.
Stopped. Yeah. No, I think ethically, I don't think you really can go and claim you were ineffective on an appeal. That's why you've got to let somebody else handle it anyway. It's just it's not usually a good idea to.
It's an inherent conflict of interest.
Yeah,
of course.
And also, based on the way Elaine acts in court, I'm not sure her writing is going to be any better.
Fair point.
I mean,
Melissa C says, how does a large national firm pick a trial team? Camille Vasquez in California, Ben Chu in DC, WD in Boston. So I don't know exactly. You know what? Rick could probably answer this a bit more, having worked in a big firm.
Not a big firm with multiple offices so much.
Okay.
I did work at a firm that had offices in Chicago and Florida and Poland, of course. I think you can move between branch offices. So let's just take the last firm that I worked at, and it had offices in Detroit, Lansing, Grand Rapids, Ann Arbor. And in general, especially in the modern era, you can coordinate teams across all sorts of things. So you're looking for specialists. You might be looking for people that work together who might have been on a team in close proximity and then moved to a different office. I mean, I don't know the history of Camille and Ben Chu and everything else, but for something this high profile, one of the things, I assume it's Chu's team, he's looking for is their best female litigator of a certain age. I mean, we've talked about the optics a lot here. But Camille Vasquez fits that to a T. Not to disparage her merit, I don't even think anyone would challenge those at this point. But that when you're assembling that team, especially optically, you're looking to have important things. Camille sitting next to Johnny Depp is a useful optic throughout the trial, and so that could have been part of putting this team together. You also might just ask the firm, who's got history here, who's interested in doing this, and seeing what goes on there. It's in all large law firms, there's going to be bureaucracy. There's going to be things like that, but it's probably Ben Chu's show. In general, the senior partner is going to be siloed, have authority over a lot of aspects of that. And then, he gets to pick what he does. But in terms of Los Angeles and DC and everywhere else, none of that is really a problem for a big law firm. You've got massive expenditures and resources put into video conferencing like you have not seen. Everything south of holograms in the conference rooms of big law firms, and sometimes holograms. So I think it's really finding the best people that fit what you're trying to do strategically, talent-wise, and optically. I can only count for, Detroit to Grand Rapids in terms of setting these teams up, but it was never any barrier to us.
Yep. And I will say too that it makes sense for Ben Chu because he's right there in the DMV area. It also makes sense for Camille Vasquez because she, I believe, has been his attorney representing him in California. I think the other case with the personal injury case brought by gosh, I'm blanking on his name right now, but brought by the other guy that says that he punched him on set. I took a peek at some of the latest filings on that case maybe like a week or two ago, and I saw that Camille Vasquez was on there if I remember correctly. So I think she's been going into court and representing him on that matter as well.
And that would make a lot of sense too. A different relationship that makes sense for this 100% makes sense.
Yeah, exactly. So the other one is Dennison. You know, he probably is just one of the big name partners, had a very big interest in the case, and
what he does.
Yeah, he's their expert guy.
He's the expert guy. And I'll stand by Dennison until the end of time on this stuff. I thought he did great. So come at me, people.
There were a couple where I thought he could have done better, or
agreed.
But even there, he got out of it when he was in trouble, which you got to give somebody credit for being able to back out of a bad cross and come out ahead.
Oh yeah.
So, but they only entered him halfway through the trial, right? So, like, he was their expert guy coming in on a helicopter.
Exactly. Yeah, they basically airdropped him right into the trial, and then he popped in, popped out, and then came back in again when there were more experts to direct or cross.
That's how we knew it was expert day.
Exactly.
There's just Dennison sitting there. It's like, okay.
It's like having somebody that's normally on special teams, right, in football, sure. Right? Did I say that right?
Special teams, sure, or pinch hitters, or anything like that. You see them and you go, okay, I know what the situation is.
Yeah. I know enough.
That's baseball and American football.
Yes.
Just so we're clear to any barristers in the chat.
Yeah, exactly. Yeah, I know enough football to be able to have conversations, mostly because my brothers played football in high school and one of them in college, and so, when it gets down to things like special teams, as soon as I said it, I was like, did I say that right?
You know what? It works enough, all right. So we're just gonna let it go, Alita. Yeah, no, I think it works just fine.
All right. So all right, well we'll leave it where it is. 40 Doherty says, if there's a special appeal or hung jury, will same lawyers handle the retrial or will fresh eyes come in?
Who knows?
We don't know.
It'll be a new trial, a brand new one.
I could absolutely see them going. Like, Depp's team was fantastic, so I don't see much reason to swap out there.
Agreed. And I don't see much reason to keep half of Amber Heard's team. I hate dunking on her. But she's probably great at non-trial civil litigation, and I think that may have been the lesson here. Yeah.
But the point is, it's a brand new trial. Anything could happen.
Exactly. And that's even assuming that they decided to bring the trial a second time, because they may decide. Yeah, they may decide not to. Oima says, question, in the UK, does the burden of proof lie with the plaintiff or defendant? That's an interesting question.
So it depends on which bit. So, and which, I'm assuming we're talking about this kind of claim. So if someone wants to bring a claim for defamation, it's on the claimant to prove that there was serious harm. And then any defense, the burden shifts to the defendant. So in this trial was the UK trial, the defense was the defense of truth, which is a statutory defense. The burden is on the defendant to prove that it was substantially true, not completely 100% true, just substantially true. So it's a split burden of proof. I assume the question was in relation to this case, if that's the case.
All right. Miss Lorraine 77 says, question, do you think that COVID and travel restrictions had an impact on Vanessa testifying in the UK?
Yes, forgive me. I think you asked this question earlier. Quite possibly. I do know the trial was put back, I think, at least a couple of months because of COVID. So quite possibly that had some impact with the travel. I would think so. It sounds about right.
Venigor 10 says, BBB, can you confuse everyone by explaining the difference between English and Scottish systems of law?
Okay, right. So we have the Westminster Parliament in London, which is the supreme lawmaking body. But just to confuse things, we also have other parliaments, which I won't get into. But there's UK-wide legislation, which is an act of the Westminster Parliament, which will apply for the entirety of the UK unless bits of it apply to Scotland. There'll be some acts which just apply to Scotland. They usually have Scotland in brackets after the name of the act. If there's sufficient differences, there'll be 2 acts of parliament, one of them for Scottish rules. And we have the Bar of England and Wales, which I am a member of. So as a barrister, I can practice anywhere within England and Wales, but not Scotland. Scotland, they're called advocates, and the court system is different as well. So we often have jurisdictional overlap, and we often have arguments about jurisdictional overlap as well. So we've had lawyers saying that you can't sue an English company if you're based in Scotland and vice versa. But there's all sorts of rules about that as well, which I won't go into. But yeah, it gets confusing.
I'm sure. Dexy Dean says, question, could the UK case initially have been raised under the Scottish court system and under Scots law been more favorable for JD?
In reverse order, I don't think it'd be more favorable, because whilst there are differences between the law for Scotland, it's not that drastically different that it would have made a significant difference. And could it have been raised? Good question. I'm not sure, to be honest. I know that cases like this almost always, because of the value and everything else, must be started in the High Court. So interesting question. I'm not sure.
King of class. Oh, and by the way, I didn't introduce you. Rob popped in from Law and Lumber. Rob, this is Daniel, the black belted barrister.
Hey,
so he, as you can tell, he's helping to reveal the mysteries of the UK court system to us American lawyers.
It appears I have a
hopefully vice versa.
family law practitioner on the panel right now. Finally.
Yep. And I mentioned to us American lawyers, us and the Canadian lawyer, of course, too. I don't want to exclude Runkle here. So anyhow, just wanted to introduce you guys. So King of Class says, I like the wig. I like how it dissolves the person and symbolically represents law. Also, as a woman, I feel it would help unconscious bias. That's an interesting concept. And I also like the symbolism of it too, that it basically takes away the individuality aspect and says that, you are here as a representative of the court. You are here to represent the ideally the best of the law, right? The thing that the law is supposed to be doing here properly. And I think that's a very beautiful sort of metaphor as well.
Yeah, it's a very nice way of putting it. A lot of people think of it like that.
Yeah. Morgana says, that gown or uni gown plus hood for uniformals.
I'm not sure I understand the question, but
okay, I didn't either, and I wasn't sure if maybe you would.
I think it's a loose suggestion to wear it for formal events for universities, but
okay.
I think that was the question.
Okay.
Good idea.
Triwa Leachin says, what is the difference between a solicitor and a barrister? Well, we touched on that a little bit.
We did, yeah.
Yeah.
Very simply, the solicitor ordinarily will prepare all the paperwork and file the claim in court and make sure everyone's got the paperwork, and instruct the barrister for specialist advice, specialist drafting, and actually going to court, putting this on and presenting the case. I say broadly because there's so much overlap. I wouldn't know where to start. It'd take half an hour to explain, but some barristers do solicitors' work. Some solicitors also do barristers' work. So this
makes sense. Susie says, shout out to BBB. Silex, qualified legal
the Chartered Institute of Legal Executives.
Okay.
So And yeah, possibly right. There's, I mean, I'm sure there's a lot of you. I don't know how many are there of Silex, but in essence, it's someone who is qualified to do a very particular area or process of law, but not practice in the sense of a barrister or a solicitor. If that makes sense. There are certain legal processes, a bit like conveyancing. You buy a house. Conveyancing is all of the process with transference of the ownership of the property. Solicitors can do that right out of qualification. Barristers can't, for some reason.
Don Hinton says, question for BBB. When you speak of chambers, is that just a group of barristers, or does it include solicitors? How close is the series Silk?
Yes, so in reverse order. So Silk is a television series by the BBC. And I'll come back to the question itself afterwards, but we call them a set of chambers. So let's say you get 15, 20, or even 200 barristers together to share the costs of rooms, office, printing, paperwork, website, marketing, clerks, assistants, and secretaries, and so on. Then that is a chambers. It's registered with the Bar Council, as we are individually registered with the Bar Council. So that is essentially a similar legal status as a club. Does it include solicitors? I'm sure some possibly have a solicitor in-house, certainly if they've crossed over to being a barrister. So you can either be a solicitor advocate and then become part of chambers, or you can take the transfer and become a barrister. Don't ask me why there's a difference, but there's a difference. And you could be, so therefore you could have solicitors as part of chambers. How close is it to the series Silk? Interesting point. I started to do a teardown of these episodes of Silk. I got as far as episode 1. And then I was slightly put off because the BBC raised a copyright strike, to which I replied. I contacted their lawyers directly and said, you realize this is fair use, and it was the BBC that lobbied the government for fair use under copyright in the first place. At which point they didn't respond to the appeal and let it slide. So that's on my channel if anyone wants to check that.
Absolutely.
How close Silk is really to. In fact, I can probably find the link to it to the video. For the most part, it's quite close. It's quite good, actually. I think it's really well structured. There are bits of it that could probably be better, but overall it's quite good. I'll find the link to the one that I did.
Yeah, then we'll add it to the chat. We'll add it to the description. That would be great.
Found it, so I'll grab the. I'll put it in the chat box here.
Yeah, absolutely. And then we can also add that to the description as well.
Yeah, sure.
There it is right there. Perfect. And then Amanda Lou Jones says, I've got a little bit of an echo here. I'm not sure where that's coming from.
Yeah, I hear it too.
You'll find with me.
Oh, okay. Amanda Lou Jones says, BBB, is there a platform we can DM you? I have a 6-year corporate class action in UK. Our QC has changed and made a big difference to our claim.
Okay. Yes. I mean, I'm on most platforms. My handle is the same on Instagram, on TikTok, although YouTube's obviously better, but it's the same on TikTok and Instagram and everything else. And Facebook. If you just Google it, you'll find a dozen ways of contacting me.
All right. Awesome. Alrighty. Melissa C says, hi from Bermuda. As a colony, we have English QCs come for high profile cases. Mm-hmm. We also have our own QCs. Would they be able to practice in England?
I would have to check the rules. But if it's possible, I think so. Because there are certain sort of expat regions and so on that are international practice. I'd have to check, but I think it's certainly possible.
Turbulence Jordan says, question, we still follow Roman Dutch law in South Africa despite British colonialism. How do you see the future of lawyers and courts in 100 or 300 years from now? My jaded answer is probably not changed all that much because of how slowly the law changes, at least in the United States. maybe we'll finally get Zoom court down.
I think there'll be a lot of AI coming into play, and probably quite rightly so, because I think there's quite a lot of bulk, let's call it bulk at the bottom end, a lot of cases that should be very easy to decide and could be easily decided with AI.
Like essentially a form of like pre-screening for salacious litigation, like random contract claims, landlord-tenant disputes where you've got people who are back rent, stuff like that.
Yeah, exactly. And there are some totally frivolous and even vexatious claims that take a long time to sort out and ultimately get through. Even if they're baseless, it can take years to just kill the litigation.
Although my immediate thought when you say that is, I think of the movie Back to the Future, when he actually goes to the future, and they say there's something about how they only have a certain number of hours before Marty's son or grandson is convicted. And he was like, wait a minute, wasn't he just arrested yesterday? And he says, yes, because the judicial system has become so efficient ever since they got rid of all the lawyers.
Yes, I remember.
That was the line.
But it makes me think of that, because every time I hear that line, I'm horrified, because I'm like, what about due process rights? What about the ability to put on a defense and all these other things? But it's interesting to hear to think about how these kinds of changes and developments can have so many benefits, but also have some potential drawbacks in various ways. But I think you're absolutely right that the ability to sort of weed through a lot of the claims that shouldn't be there in the first place could be very beneficial to our overall system, just to get to the ones that really should be heard. So, anyhow, Lone Star Law.
Yeah.
Oh, it says Black Belt. Please explain court system. EWHC, Commercial Court, Privy Council, Supreme Court, etc. You can. I understand this is a very broad question, so you can
it is
limit that however you would like. Explain the whole thing.
The whole thing, right? Which is usually the first year of a law degree, but let's give it a go in one. So let's pick some of the terms. So the commercial court. So let's start by saying that there are different courts that hear different types of cases. Quite obviously, there's the criminal courts, known as the magistrates court broadly, although it's not only limited to criminal cases, but all criminal cases start their life in the magistrates court. Then irrespective of whether they go onto the Crown Court, which is where the bulk of serious criminal cases are heard, then obviously you've got the Court of Appeal, and then the Supreme Court, and you've got the High Court, which will hear different types of cases as well. Broadly will be split into different sections. So picking up on the example, the commercial court is going to hear things such as the name suggests, commercial contracts and business disputes, insurance disputes, financial disputes, import, export, banking and arbitration, shipping, and all these kind of things will be the commercial court. You've got business and property court, which is a slight tangent to all of that. You've got the Privy Council, which is more, think of it as intergovernmental decisions and things like that. But otherwise, there are different groups of courts that will hear different things. So, for example, you've got an employment tribunal, which will hear the obviously employment disputes, as opposed to going to, I don't know, the Crown Court or the High Court or whatever. So I suppose that's a broad answer to the question, hopefully.
Yeah, and like I said, limiting that question as well as you as much as necessary is totally acceptable. I saw another question in the chat that someone was like, "Legalbytes, please explain the universe for me now." It's about the same.
Yeah.
Let me move this cattail out of the way here. Marion P says, "Is this case affecting the British public and politicians' view of certain legal policies now that there is a direct comparison between evidence and handling?"
It's a very interesting question. The way I think this will be dealt with is that there are distinct differences in the two trials, in that the defendant is different, or defendants in the UK trial, and therefore the evidence that was heard, and indeed the evidence that was called, is different. Therefore, they are too different to be compared. I think that's going to be the explanation. Although the underlying complaints are the same, the incidents are in effect the same. The distinction between the trials is going to be who the defendants were, what they were trying to prove, against whom, and therefore what evidence was called or not called. I think that'll be let's call it an excuse, I think, to any criticism.
Sure. And before we get this next super chat, I have seen an update on Twitter that the jurors have stopped deliberating to take a shortened lunch. At this point, they will have deliberated just over 5 hours in total. So sounds about right. I think that probably is why the attorneys were brought back to the court, is basically just to be there for when they go to lunch, and then when they come back, my guess is they'll be there at the courthouse again. When Ray says there is no way you can actually sit there and say this UK case wasn't shady. They didn't allow Johnny to even present his evidence, so that trial was BS. How can anyone defend or justify it?
So I have voiced an opinion on this. I'm entitled to do so with all the respect that is required. But on reading through it, I feel that there are certain standards which are applied to some evidence and in the reverse to other evidence. And I don't think that's right. But as I say, I'm but a humble barrister. I'm not a judge. But I think if it were put to popular opinion, I think you'd probably be right.
Aaron Kelly says, question, was the conclusion in the UK really over first-person sources, i.e. they had reason to believe it was true?
I'm not sure the IE sort of links with that, but so it wasn't all of first-person sources. In fact, there was sort of hearsay evidence included and used. Sort of the part of the problem that I have with it, really, and I think a lot of others have with it, is that some evidence was excluded on the basis that it was hearsay, which was detrimental to Johnny Depp, and yet some evidence was included when it on the same kind of analysis that probably shouldn't have been in favor of Amber Heard. So it wasn't all first-person sources.
Right. All righty, next one. Alex Page says, the evidence of the UK trial was about what the Sun knew, right? For Johnny to win, they must have known it was false and still ran the story. That would have been the standard in the United States. How does that differ in the UK?
So I don't know what their reasoning and investigation was behind it. They obviously, they changed the title of it. I don't have in front of me what they changed it from and to, but it's in the judgment. But they did change the title. Let me see if I can pull it up, because this was telling for me. At the very least, someone took the decision to say, perhaps we should change that. So it was originally on the 27th of April, 2018. It went on the website as Gone Potty, how can J.K. Rowling be genuinely happy casting wife-beater Johnny Depp in the new Fantastic Beasts film? And it says in the judgment, from about 7:58 on the 28th of April, i.e. first thing the following morning, it was changed to Gone Potty, how can J.K. Rowling be genuinely happy casting Johnny Depp in the new Fantastic after assault claim. So the latter obviously it's not a statement of fact, it's a question.
Right.
If there's been a claim, they can state that there's been a claim, whereas the original title is making the statement. Someone took the decision to change it. That says to me that either they were just being cautious and said, let's change this in case there's a claim against us for it, which, it's the Sun. Maybe sometimes they do, sometimes they don't. I don't know. But someone took the decision to change it. And to me, that at least should ring an alarm bell.
Yeah.
That's my take on it.
I don't know. I mean, we don't want to discourage them from getting out of the line of fire if they change it in advance. I always hate the implication that because you changed it, it must have been a violation to begin with.
No, quite. My point is that someone took the decision to change it. If they were absolutely sure about it, then leave it, or don't do it in the first place. But
I know, but I think that we lawyers are often giving advice that's essentially like, maybe this isn't a problem, but if you want to be 100% sure, you could do this thing.
Yeah.
I know I've given that advice. It's a non-zero risk. You want to make it a zero risk. That kind of thing.
Likewise. So it might just be that.
It could be. I don't know. I mean, that's the point. Is I don't know.
But I think knowing that the Sun as a publication is quite bold.
Sure.
And if I can say in their defense, I can say I think because of the reputation and because of how bold they are, they would probably do a lot of investigative work before doing something. Therefore, I think ordinarily would be very unlikely to change the title. But who knows? I don't know.
Fair point. Angela Daly says, BBB, what are the inns? Gray's Inn, Lincoln Inn, Inner Temple, Middle Temple, etc.
So that's it. There are 4 of them. And so to become a barrister, you must be called to the bar. There's a whole ceremony where I'm with Inner Temple. We don't wear the wig, but we wear the gown to be called to the bar. In Middle Temple, you do wear the wig and the gown, but you have to be called to the bar. It's a whole ceremony. And to do that, you've got to be sponsored by someone else to say that you are of a good character and so on, and someone that ought to be called to the bar. And so they retain the sole right to call new barristers to the bar, and without which you cannot practice. That's what they are. They're collectively the inns of court.
Okay. SMKD says, do barristers do both defense and prosecution?
Yes. In fact, it's, unless you work for the CPS, the Crown Prosecution Service, in which case you'll be prosecuting. Otherwise, we have what's called the cab rank rule, which means the case comes along like a cab, you must take it, whether it's prosecuting or defending. It's to be impartial, unbiased, and fair.
All right. Izzy says, can anyone sue the Queen in the UK or Commonwealth? My guess is probably no.
Not as far as I'm aware.
Kind of sovereign immunity.
You really can't go after sovereigns, folks. It's kind of their deal.
Yeah. Same thing as in the United States. We have something called sovereign immunity. You can't sue the United States government unless they have given you permission to through some kind of statute. So there's only a limited number of those. Make of that what you will. Draw your own opinions of that, but that's the way things are.
And now an 8-hour discussion of sovereign immunity.
Gawa says, Daniel, please explain the principal procedural differences between Scots law versus RUK and in burden of proof. I can't wait. I mean, you've kind of discussed this a little bit. We don't need to go too much in depth as
a lot of it's the same, some of it's different.
Yeah. There you go. Yeah. Vicky Melcher says, will UK decision be looked at again? Sorry if covered.
I think it's unlikely. It's not to say that it's utterly impossible. There's no sort of standard route for appeal. It would, you can always make an application to the court on the basis that, new evidence and, there's a very good reason for it to be heard and so on. So not impossible, but unlikely, I think.
Mm-hmm. Don Hinton says, quick question. Does QC change to Casey as appropriate?
No one really knows, although it did the other way around. It did change from KC to QC when it went, obviously, being King's Counsel to Queen's Counsel.
I guess no one's had to ask that question for a very long time.
Indeed. So no one really knows.
Oh, wow. Myra M says North Ireland, different system or part of UK system?
So again, we have UK legislation, which is effective across the whole of the United Kingdom. But Northern Ireland has its own sort of court system and legal practice system as well, despite that there is UK-wide legislation. And so, in fact, there are bits of law that only apply to Northern Ireland. There are even bits of law that only apply to Wales, particularly when it came to coronavirus legislation. There was bits for England, bits for Wales, bits for Scotland, bits for Northern Ireland. You just think, just make one for the entire place. It would be a lot easier.
Yeah. And especially coming from an American perspective, the UK geographically seems so small in comparison that it's like, looking at it from an American, it's like it seems relatively doable to have one rule across the board. In the United States, it's a little bit more difficult to have something from Florida and California and Minnesota, to have the same rules across the board. It could be a bit more difficult. I can understand that. But that's just a kind of a silly opinion from me. A non-PI lawyer says, am I pronouncing that right? Silex? Or Silex? How would you pronounce that?
Yes, Silex, really, yeah.
Silex, okay. With civil practice rights akin to solicitors, I conduct litigation without supervision, and I've conducted FT trials. I'm not sure FT. Before CJs in the county court. Not all lawyers in E&W are sole or counsel.
No, that's true. CJ is a circuit judge. County court is just the bottom rung of the civil courts. So most claims in a civil nature will go to the county court. If they are of a certain value, they can start in the high court. Defamation will be in the high court.
All right.
Again, this is the narrow limb with Silex and others do have certain rights with solicitors as well, including litigation, which is the bit that I mentioned barristers ordinarily don't do. In fact, there's only 1,000 of us that do litigation, including me. But I just thought it's just so much easier that I can just file the claim for somebody. So I just do it.
Fair. Lone Star Law says, did the UK case involve GDPR at all?
Well, GDPR, for those that don't know, is essentially data protection.
It is.
We had Europe to thank for most of it. And even after Brexit, we had what we call the retained GDPR. And now there's talk of getting rid of it. It's certainly not mentioned in the judgment. So I don't think it really had any bearing.
I don't know where it would come up, honestly.
No.
Aki no Kitsune says, BBB, do you think the more common use of cameras and broadcasting in courts in the US will affect the likelihood of cameras in UK trials?
It's an interesting question. I think it should. I think that there should be at least a discussion to say this is proven to be it's proven to be a successful thing for this trial. And let's also take the view that justice is supposed to be public and transparent as well. So apart from a very limited number of criminal trials which are held in private, family cases which are held in private, youth cases are held in private, all of the others, you can go and sit in the public gallery. So I personally think, what's the difference? Just put it online and let people watch it. So I think there should be a discussion over that. Yeah.
I'm all in favor of having as many public trials as possible. And I know that there was another question. There was another super chat earlier in the queue that I saw earlier. I can't find it right now, but that was very similar to this, that was asking us to basically debate whether or not these public trials are a good thing or a bad thing. But it sounds like, it sounds like you and I agree on that, Daniel. Rick, I don't know your thoughts on whether or not it's been an overall net good or bad thing for this case or for other cases.
I'm in favor of them being public. I mean, I think we all have to note as YouTubing lawyers here that there's a certain amount of self-interest in having that content available to us. But in general, I think it's a good thing. I do think that there is a qualitative difference between how many bodies you can fit in a courtroom and digitally broadcasting it to millions of people. We have to decide whether that's an important difference, but I do think there is a difference there. So, having the court reporters and literal court reporters, not the people that are serving in that role, reporting on it to us from a courtroom and the people that can actually fit in there and see it is a much more limited audience. I think it's a good thing overall. I'll be on your side at the end of this, but I do grow concerned with how people that aren't invested in actually following the process or learning the ins and outs of what's happening do take things on the very edges of the internet, certainly very, very far, and whether or not that's something that can be controlled or whether we need to worry about it at all. And I'm not coming down on one side or the other there, but I have seen some stuff I would have rather not seen with respect to Ms. Heard or Mr. Depp or either direction there. So, I'm of a mind that says, yes, it makes sense to do it. Yes, it makes sense to broadcast it publicly. I'm on your side generally, but I don't think we should discount that there are, in fact, negatives as part of that process.
Fair point. Fun Time says, question, what is going on with the ACLU? Oh, yes, we have a number of super chats asking about the ACLU. I understand that they have, so there are a number of cases filed across the United States. There's in California, there's obviously Virginia, there's also in New York. These are the areas where they have had to basically open up a case matter in order to get discovery, get information and serve subpoenas and things like that in these various jurisdictions. New York was one of them because of the ACLU. So what has happened is the ACLU was compelled to provide certain documents to Johnny Depp's side for the purposes of litigation. Generally speaking, when you are compelled to, when you're a third party and you are providing documents, usually your reasonable fees in providing those documents are going to be paid for by the party that's requesting them. However, the ACLU is requesting something like $86,000 or $87,000 for the production of like 80 pages, which to me seems a little bit insane.
We did already know this. This was at the very top of the trial. I think there was something that brought it back up to the zeitgeist with a new motion or something like that. Because we knew the ACLU was engaged in this.
The ACLU guy was testifying. I remember pulling up that affidavit and that responsive claim, like they were asking for all of that.
Yeah, no, it was early. It was early days that we saw this happen. I don't actually know what churned it back up to the top of social media. But yeah, obviously reasonable minds can differ and unreasonable minds on whether or not $80,000 is a legitimate cost for the ACLU going and producing, a bit of documentation.
Yep, exactly. So as far as extra details on top of that, I'm going to take a look at that after this live stream, probably, unless we really have time to kill and we're willing to sit here and do research while we chat, which, I mean, maybe, who knows? But that's definitely one of those that we can, if we go into tomorrow and we need things to talk about, that's another topic that we can definitely go into for sure tomorrow.
We've got things to talk about. I was going to summarize the Final Fantasy plots in order. I mean, I'm ready to go. So we'll talk about legal aspects of those.
Yeah.
Get excited.
Great. I was looking for a nap and I needed good content.
ASMR by Hogue.
I'm just messing with you.
Yeah, so it is a lot. Selling HEV, I will agree with you. This is a lot of money for computer stored documents, and the thing is, they're entitled to have fees, their reasonable costs for producing those documents, but again, it has to be reasonable, right? Like if they just happen to be completely disorganized with all of their paperwork and they've had to have people working on it nonstop for weeks and months, and it's because of their own fault, they don't get to charge Johnny Depp for that. That's not reasonable at all.
And the word is defray. It's not indemnify. The word in the statute is defray. So I mean, they're going to get into a fight about that. But see, that's the thing about the legal system. How much do you fight it when your lawyers are charging you money to fight it? So you got to go figure out that balance point of what is your lowest amount of money, and the ACLU damn well knows that, as every well-resourced litigant does. So, welcome to law.
And there's a way that some lawyer when I was training put it. You know, sometimes you have to have this sensible conversation with the client as to how much they want to win.
Because how important is it? Because it's going to cost you some money.
Sensible conversation with clients coming from the fellow family law attorney on the panel. One can hope.
Yeah. There's no emotionality in these decisions, right?
Certainly not.
Pure rationality.
And especially when it comes to, I've never done family law, but I have done trust and estate litigation, which comes pretty darn close to family law.
It does, in fact.
Because you're talking about families warring with one another, within one another over mom and dad's estate, oftentimes, or somebody's estate. And you believe me, I have heard many a story about many a person's childhood and the relationships with their parents and with their siblings, for better or for worse. I always like being an empathetic ear. However, I also have to remind clients in those times that I am billing for this time, so that we're not hanging out at a bar over drinks. As much as I would love to be there for you and empathetically provide a sounding board for you.
It's always an interesting part of the practice when people just want to talk. And you're like, well, a little bit, that's okay, but like, my time is my job. So it's an interesting part of the process, definitely.
It's one of the first conversations I ever have with new clients that are going through a family law situation. Is I ask if they are seeing somebody to counsel with them through this, and if they're not, I give them a list of people that I've dealt with in the past or have worked with in the past that can help them on a therapeutic side of it as well. Because you have you have an attorney, and yes, we're great. We give good legal advice, and we listen to the things that you're saying, but it's not like we have the training to help you through those things. So I always recommend that for anyone going through litigation, find someone to help you with that side of the process.
Speaking of process, Alita, I have to bounce to do some law.
Okay.
I will be back.
Okay. Sounds good. It was great having you, Rick. Give me just 1 minute here. Okay, so Nadia Bodker says, greetings from Denmark. Thank you so much for this. Question, if AH got charged with perjury in the UK, what would be grounds for the retrial for JD in UK? So would there be any kind of possibility for a retrial, Daniel, based on what you know? To me, if it's anything close to the United States system, my first thought is it's probably not likely.
Yes, you'd be right. It's probably not likely. It's not impossible. There's always a mechanism. So we have a procedure to apply to set aside a judgment. It's normally going to be done within certain time, in certain criteria, and so on. There was a case not that long ago, actually last year. There was arguments about fraud in the lower case, and essentially the basis of fresh evidence is a huge dispute, and ultimately the decision made by the Court of Appeal was declined to remit this issue of fraud back and just dismissed it on that basis. So it's not impossible, but it's very unlikely. I don't think anything's going to happen with it, and maybe that's a criticism of the system, but I think it should stand to reason that if there is proven perjury, proven fraud in a case, then it should be looked at, opened, and
I
think that should probably happen.
And then Alpaca wants to know, if JD wins in the US, could that alone constitute grounds to attempt reappeal of the UK verdict? Loving all the coverage from you guys. Thank you. My guess on that one is also probably no, because it's two different entirely different systems in different cases.
Answer. Yeah. Same answer.
Yeah.
I mean, there are some potentials. I was thinking then of potential secondary claims against other parties for knowingly making false statements and so on, but probably not going to happen.
Yeah, that's my thought. Matt Cornell says, thoughts on UK versus US orders for costs?
I don't know a huge deal about US orders for costs. I know that they can be quite severe in the UK. Sorry, I'm assuming that question was at least in part directed at me.
Yeah,
but
I think maybe orders for costs. That's a term that I'm not as familiar with. Is that for like attorneys' fees and costs at the end of a trial,
yes.
or okay? So my understanding of the UK, correct me if I'm wrong, isn't it that the losing side always pays the costs of the winning side in the UK?
That's
Or
the
is that
default
not
position. It's certainly the default position. Yes.
okay? Yeah, in the United States, the default is that both sides pay their own fees, unless there's some sort of a specific statute that shifts that. In this particular case, because Amber Heard has alleged the anti-SLAPP defense, and because that is alive and well, if the jury makes a determination in her favor on the basis, specifically on the basis of the anti-SLAPP statute, there is a provision there where her attorney's fees can be paid for by Johnny Depp.
Okay, yeah. So here it's much well, it sounds much more severe here then. So here the losing party by default pays the costs to be assessed if not agreed, and we have entire trials about the costs alone.
Oh, wow.
Sometimes when they're so significant and not agreed. If there's elements which are brought in, and let's say a defendant brings in an issue and loses it, then there'll be a cost mitigating exercise to say, we wouldn't have spent all this money arguing about that point if you didn't bring it up. So you don't get those costs.
And this was a huge part of American early jurisprudence, where we were deriving our own American law, and we took the English common law to form the basis for us. And we kind of parsed it out and said, do we want to keep certain pieces or change certain pieces? Which is why we actually developed, we call it in the US the American rule, where if you're a litigant, you fund your own case and you are responsible for your own attorney's fees. And then the reverse of that is the common law rule, which is what the UK system had and what we originally had before we kind of decided we wanted to change that.
Mm-hmm.
And I think that a big reason for why the United States does it that way is because of, for better or for worse, the American system wants to encourage people to openly file lawsuits. This is why we have such a low standard for our pleading standard, basically to allow any claim that has any possibility of being heard, allow it into the court system so that aggrieved parties can have their matters be heard. It's very similar, if you think culturally, to the idea of Americans. We love the First Amendment. We love our freedom of speech. It's like the strongest trump card that you can use in any legal argument is the First Amendment. So it's just a similar sort of attitude, I think, is basically to have your voice be heard through the court system as easily as possible, and to try to encourage that by preventing people from being stifled from filing a lawsuit if they are a truly aggrieved party. So, yeah.
And in contrast to that, one of the big, in fact, not just one of the big parts of our advice, but one of the parts that lawyers are often criticized about is if you don't give warnings about the adverse litigation cost risk. So you bring a case and lose, you're not only responsible for your own costs, but the cost of the other party. So do I think which one do I think is better? I probably lean towards yours because my experience is a lot of people don't bring a claim because of the risk of costs against them if they lose. And even when they do bring a claim and they win, and I think there's a number of reasons I would probably favor yours. Pay for your own costs, and then there's no sort of real. It's used as a threat often. I really think it's used as a threat here in the UK. I think the cost risk is a threat, i.e., I sue you, I win, you lose, you got to pay my fees as well. And I think it's used as a threat quite often. And a lot of people either don't bring a claim for that reason, or they give in to a claim for that reason.
Right.
Is it the same model in domestic cases? Like if you file a claim in a custody battle or in a divorce case, how do they allocate fees in those particular cases?
So this is the default position is very different. So divorce and more so children than divorce, but divorce is usually the same as well. The default position is there are no order for costs. So you pay your own, or you have legal aid, as we call it. So that default position is different. There are exceptions, and that is when a party's behaved very badly or not engaged with the proceedings, then you get an order for costs, so they pay your costs. In the family work that I did, I've had more than one of those orders in my client's favor. They got to pay my client's costs. But the default position is no order for costs.
Okay.
And as well, we've got another rule as well. Excuse me, another rule for what we call small claims. People often refer to it here as the small claims court. It's not a court. It's the county court, but it's a small claim within the county court. And in terms of monetary value, it's not more than £10,000. And the default rule of loser pays doesn't apply in small claims, unless again there's impropriety, fraud, failure to cooperate, follow rules. And again, I've got a number of orders for costs for my clients in small claims because defendant didn't cooperate, defendants lied, there's fraud or whatever. Yeah. So there is an exception for smaller claims.
Alrighty. Let's get some more questions here. Nihon Hanguk says, any panelists play. Oh, I'm getting an echo again.
You're okay here.
Oh, okay. Nihon Hanguk says, any panelists play TTRPGs? Fate is my fave. I think this might be a Rick question. Maybe we'll have to save this one for when he comes back. Moving forward, says, after this trial, can we discuss issues like employee laws? Amazon's reactions to the unions was strange from my background, South Africa. We can definitely discuss employment litigation issues. Amazon and the unions. I think Rick has talked about that one probably even. Lucky says, seen the lovely Depp pics jamming with Jeff Beck the last 2 nights. He looks so happy. I would agree. Greg Meyer says, good morning and afternoon, everyone. Question, do you agree that a longer deliberation period equals bad news for Johnny? No,
not
at all.
Better for Johnny.
I think so too, because it means that they are going point by point through each claim, each cause of action, and each jury instruction, and making sure that they are going through it in a reasonable fashion. So if they are taking their time, I mean, think about it. The folks that have really dug into the facts of this case on their own before coming to this trial, what side do you think that they tend to land on? Amber Heard or Johnny Depp? Johnny Depp's side. So if they are taking more time to go through all of these facts, my guess is that they are probably going to land more on his side than on the other. Rachel Taylor says, do you think Johnny was still trying to protect Amber? That's why he sued the son to begin with, not her.
Yeah, I don't think he could get to her through the son. I think it was the Washington Post article that was the only way that because she published that article. She was the author. She was the person who was the speaker in that. Yeah. Proving that she was the speaker and she was the party defaming through the Sun article just doesn't happen.
Yeah. Simon Tupper says, if JD loses, can he appeal on the grounds that AH did not comply with the order to turn over her phone? Seems unfair. Possibly. It depends, because there was a motion for sanctions and there was a ruling on it, and that does have an impact on the court as well, or on the case as well. But that is ultimately an evidentiary issue. Those tend to be more difficult to overturn on appeal. But that is quite a big issue in this case. Is the metadata of those photos? Those photos are very important. So, can he appeal? Yes. Can he win? I don't know. Elena Vlad says, hey guys, thank you for all your great work. Question, why Amber's side was allowed and not stopped by the judge for misrepresentation of the law? Very sneaky. The judge is not necessarily going to step in and correct an attorney on their closing argument if there's no objection on the record. Sometimes they will, if it's bad enough. But Elaine was, I think, skirting the lines well enough so that she was not exactly making as egregious of an error as what we were identifying, but enough that she was definitely skirting it for sure. Her definition of actual malice was improper, entirely improper, in my opinion. Christine MUA says, thoughts on leaning into AH watching from a rare vantage point how institutions protected JD. Didn't see much evidence of nor argument against. Yeah, I mean, I suppose the institutions that she would have been pointing to are his support network around him, but that's not much of an institution. I mean,
are we talking about now, or are we talking about like back then? Because you could make the exact opposite argument back then, where institutions protected Amber Heard, and institutions. I think I don't really get the question.
Yeah, I mean, I think that there probably was evidence against that because of the fact that there was evidence on the record of testimony by, for example, Richard Marx, who said that in Hollywood at the time that the Washington Post article came out, there was a massive tide against a lot of men that were just accused of stuff because that was the wave of the time. So yeah, I would agree with that, Rob. Becca Detetman says, would you mind pinning the topic of discussion? Well, we're a bit free flowing here today, but
we're kind of all over the place. You got a floating pin?
I suppose I can. Aussie Lawyer says, oh, I'm going to save that for him. And also I need to make sure that I've got these captured here as well. Mr. DNA 1987, and hello, Michael.
Hey, what's going on?
How are you, Mike?
I'm great.
By the way, this is Daniel over here on the side.
Hi, Daniel.
He's a barrister from the UK. We've been talking about the UK system and the UK trial, so just kind of hanging out and talking. So
very cool.
Yeah, so glad to have you here, Mike. Mr. DNA 1987 says, if physical evidence is found to be false, such as visually modified photographs following the trial, would the failure to exclude or disallowing proper scrutiny be considered factual or procedural?
Interesting question.
Generally speaking, Court of Appeals gives very, very, very strong deference to the trial court, because the trial court is there judging the veracity of the witnesses that are proposing the exhibit. And essentially, they would have to be clearly erroneous to have excluded it or allowed it in order for that to be even an issue considered. And even then, at the appellate level, you have to prove that one piece of evidence, had that ruling gone the other way, that one piece of evidence would have changed the outcome.
Yeah.
It's a steep hill.
Exactly. Very well put. Laurel Grass says, sanctions versus Amber Heard and attorneys in Amber Heard's opposing CHLA petition. Sanctions and $47,3250 payable within 30 days. Sanctions versus Amber Heard and attorneys in AH opposing the CHLA petition. I'm not sure what you're referring to there exactly. The sanctions that I'm aware of are for the metadata issue. I'm very, very sorry, Laurel, for that. Fangirl of Justice says, does that mean that none of AH's witnesses that only had a depo wouldn't have been admitted as evidence unless they went to Virginia in person?
Does what?
Do I need to explain deposition to Ben ASA?
Yeah. So the reason why the deposition was admitted as testimony was because of the fact that they were unavailable. So, meaning that they weren't able to be there in Virginia in person. So I'm not sure that I understand this question as you.
Can't be
in this
compelled,
case, it was clear that there was a grand bargain. We've discussed it before between the parties to allow a bunch of depositions in.
Right, exactly. Women's World says ACLU wants to sue JD because he asked the court to legally compel them to release documents related to the case. They want 82-253. Is this legal? Well, I don't know about legal or illegal. The question is it proper or is it reasonable? Then that's a question that's going to be decided
It's horrible.
It's a lot of money.
I'll tell you that much.
Yeah. It's a lot of money for like 80 pages of documents. They're going to have to show exactly why that's reasonable.
My guess is they slither away and resolve it rather easily because, I mean, the ACLU looks horrible here. They should really not want to continue any press on that topic.
Yeah, and I think their affidavit of attorney's fees also included some billable time for their motions to oppose the subpoena. So you might not want to be asking for that one when you lost it.
Yeah, I mean it's in New York. This is out of a cause of action filed in New York. That where they had to respond. I don't know. Yeah, so, I mean I don't know the specific rules, but the whole thing's dubious.
Yeah. Jason Gervais says your mods are amazing. Possible to get them a tasty beverage with this? Understood if not possible. Thank you so much for this is very generous. I don't know exactly where all of my mods are located, so I don't know if I can actually get them a tasty beverage, but I will see what I can do to take care of the mods for sure. Miss G says, question, why could E. Baskin testify as old GF to JD? I think it's because it's to rebut his claim since the very beginning, saying none of his former partners will ever. You'll see that no one has ever accused him of DV. No one has ever accused him of hitting a woman before. That because basically, like none of his former partners have ever accused him of hitting them. So I think that's what they had brought her in for, was to rebut that claim by Johnny Depp's attorneys, by Johnny Depp. And I don't think that it really successfully rebutted it, in my opinion. Oslo Hiker says, if Heard loses, will she be in debt for life or can she declare bankruptcy? I'm not sure about the bankruptcy question.
If they whack her for $50 million, she either has to work something out with Johnny or declare BK. There's no two ways about it.
Well, the BK question is more complex. Under 11 U.S. Code 523, there's a possible exception depending on how the jury instructions read. I'm still working on a video that breaks it down.
Really?
Yeah.
It's complicated. I don't know if it's going to be non-dischargeable or dischargeable. I have to compare the actual instructions, the final instructions, with the code provision.
I mean, if you're going to start looking up code provisions, then I don't know if I can discuss this with you.
I'm not going to. Yeah, I'm going to just. We'll save it for the sovereign citizen cases. I'll bring it.
Absolutely.
Well, just a point on the bankruptcy thing is a real point of contention for me, because bankruptcy threshold in the UK is £5,000. So if you prove that you owe at least £5,000. There are some things that you can't exclude, such as sort of child maintenance payments and things like that. But otherwise, prove you owe £5,000, including judgment debts, you can declare bankruptcy. And it goes back to something we discussed earlier about the different systems and who's responsible for costs and potentially bringing claims and stopping claims from even starting. Very brief story. So a convicted mortgage fraudster files a claim against a company for over £2 million. The claim had no basis whatsoever. The claim took 5 years and tens of thousands of pounds to defend and get shut down, only for her to then not be able to pay it, disappear. There's a route to try to recover those funds by filing for bankruptcy, but it's a long-winded process and you probably end up with nothing. And long story short is, well, should this claim have been allowed in the first place? And there are lots of questions like this raised about these sort of claims, which really shouldn't be allowed in the first place. I'm going to do a full video on this story for some of the juicy details, because there's some very interesting legal aspects about trying to sue your lawyer, and I'll say no more. But my channel's linked in the description below if you want to check that out.
Yeah.
There you go.
If you ever do a BK case, I'd love to chat with you. The difference between the UK and the US system for bankruptcy purposes.
Why don't we join forces on that then? I can
that'd be fun.
you on this video. And
awesome.
See, one of the real exciting things about doing this stream with you guys is because, as you said earlier, it's difficult to encourage YouTube to sort of share the audience, because I 99 or whatever it is % of my audience is in the UK, and I think surely someone else should be interested in these videos. Yeah, YouTube doesn't do it unless we do it ourselves. So I thank you for having me on. And,
of course. Yes,
likewise,
so
I think
much.
the reverse is true. We're a smaller place, but I'm sure the UK audience is interested in US law as well.
Yeah, I think I love the idea of hopping over to everybody else's channels as well. It's what we do on all of our other channels as well. Also, Hiker says, if Heard loses, will she be in debt for life or can she declare bankruptcy? We just answered that one. And also, Fangirl of Justice gave a little bit of a clarification. Question for Daniel. I think he was saying that the witnesses in the UK had to be there in person to testify. Would that mean that the depositions would not be admitted like they were in Virginia? Okay. Thank you. Thank you for clarifying.
Well, yeah. You're not going to have somebody testify live and then show a deposition.
But didn't the UK presiding judge, didn't he review the sworn written statements as well and give them weight?
Oops, sorry, I'm on mute again. This was part of my my issue, because as a default position, I'm sure the rules are very broadly the same in the US, in that hearsay is not admissible unless there's a good reason, or a law, a rule, or whatever. And all of that would be hearsay because it's not in oral evidence. And so hearsay is one of these things, because I guest lecture at the bar school here in England as well. And hearsay is one of these things that even the law students find really difficult to understand. So I can fully appreciate that a lot of people will find difficult to understand. So if I may, think of it like this. If it's not a person saying it in court, and then you can ask them questions to clarify and test what they've said, if they're not in court saying it, it's hearsay, because you can't test it. Even if it's written down, or a drawing, or a recording, CCTV, whatever it might be. If it's something that is designed to prove the truth of something, to convince you as a person that it's true, or even to convince a machine that it's true, or to act on it that it's true, it's hearsay. And as a default, it's not admissible unless there's a reason. The famous reason is, res geste, as we call it, is your dying breath. It was him kind of statement. Then that's one of the exceptions for hearsay. So if you've got nothing else, take what you've got, and that's one of those examples. Yeah.
Okay, and then she's got a follow up in the chat. So a recorded depo would be the same as attending in person in the UK. Is that correct? Or
so let's look at how the so in some cases, as long as it can be tested, because if they're not cross-examined on it, then it's just evidence that's admitted, because it doesn't carry the same weight as an in-person witness, but it might be admitted on that basis. I'm sure there's reference to it in the judgment.
So it sounds like it's not the ideal, but it'll do if you don't have anything else, essentially.
Essentially, yes.
Okay. Saito Kata says incarcerations by population: US 0.7%, UK 0.88%. Which systems protect citizens better? I doubt US citizens are 10 times more likely to commit crimes that leads to jail. I don't know that I can answer that question.
I'm not a statistician.
Yeah, and this one came in twice actually. That one, yeah, I don't know. That really would take a massive analysis of data to try to figure out which system protects citizens better, because you would also have to figure out like how do you define protecting citizens? Is it protecting citizens' rights to due process? Is it protecting citizens' right to be protected from crime? Is it there are many different ways in which a citizen can be protected. It depends on what perspective you're taking to answer that question. So Dion Infantry says Amber testified in present tense and Kate in past tense. Did someone pick it up? No, you know what?
No.
I did not pick up on that.
So I know someone who did pick it up. The body language experts guys on their channel, they were talking a lot about it because they obviously, you're familiar with them. They came to the conclusion, staking their reputation practically, saying that it was dishonest on the basis of all of the things taken together. I mean, any one of us as lawyers know that any one thing doesn't make someone dishonest, but you take 5 or 6 of those together, as they say on their excellent channel, you take them together, sure enough, you can predict their level of honesty. They pick that up. Present tense, and different people jumping between the two, and in the same sentence, the same description of something. Yes, there's.
Yeah. Peggy Vucenic says, question for Alita: bought a violin but can't afford lessons. Any beginner tips? And what are the chances for getting a short tune from you while we wait? Well, my violin is not here with me. It is with my parents back stateside. So unfortunately, there won't be any violin.
Yeah, we want a recital.
No recitals from me.
Violin claim.
I can show some other photos and videos of me playing at some point, but I can't actually show me playing. Also, I haven't picked it up in like a year or two, and it's been a while, and it was only last time I picked it up, it was for Christmas music, which is incredibly easy in comparison to some other stuff. So I unfortunately I'm a bit rusty, I have to admit. But in terms of tips for beginners, I think that one of the hardest things to do is to get the positioning right for your hands and to properly hold the bow, having kind of a loose wrist while you hold it. So I think, practicing how you're supposed to hold your wrists for both of them, and in terms of holding your fingers on the neck of the violin. So that's probably one of the hardest things. So practicing that on the side quite a bit can also really help overall, because your form will ultimately dictate how well you can play later on. Don't skip over those basics. Baron von Lark, and I'm not an expert violinist, by the way. There are many people who can play the violin far better than I have ever been able to. Baron von Lark says, lots of love from LV. Have been a fan of y'all since JD was on the stand. Question from a budding lawyer: writing a paper on Tuesday, right to be forgotten, and the mess it made in Tuesday
in the UK or EU.
Oh, in the EU. Okay, sorry. Any insight? Pray for me. On the right to be forgotten. Okay.
Yeah, so this is referring to European legislation, which does provide a legal right to be forgotten. So I've acted for clients and made requests of Google to remove certain things from not from the listings as such, but in response to certain search terms under the right to be forgotten, to remove certain listings when you search for certain terms. That is a UK EU law enforced in the UK sometimes. Writing a paper on the right to be forgotten, the mess it made. I would say if you're writing a paper on it, as most lawyers would do, look at both sides of the coin here. So if someone is, let's say someone's convicted of a crime and they don't want it to ruin their entire life, but one paper just insists on writing about it every year, you might want it to be forgotten at some point. So think about it from both ways around. That's what I would say.
Phil H says, did the judge bring the jury back into the courtroom to correct her mistake with the jury instructions? Not that I am aware of. And I doubt that she's going to be doing that anyway, because that also has implications, could be an appealable thing to do as well. So,
and the parties, I understand, have agreed on the jury instructions. So that makes it a fairly difficult thing to raise an appeal on if you've agreed that it's appropriate.
Yeah.
So here's a question from me, maybe. What if jury members have a question for the judge on a clarification in the US? They pass a question through, bring them back into court, and explain the answer. Is that how it works there?
they'll write it on a paper, ask the judge for the clarification, and then I suppose they do bring them back into the court.
I mean, it depends. They have a discussion beforehand. The judge kind of discusses the question, how the judge wants to handle it, gets the input from the lawyers. The judge can then choose to write the answer and send it back, or the judge can bring them in. Generally speaking, you want to bring them in. Or if the jury is asking BS questions, you send a written response back to kind of tell them, I'm not going to bring you in unless you actually give me a real question.
Yeah, the judge will actually contact you. I get the questions a lot when you're sitting waiting for a verdict like this. The judge will actually call your office and say, hey, the jury wants to know if they can see the police report. The answer is no, they can't. It's hearsay. How do you want me to tell them? Do you want me to pull them back in, or can I just write that note? And they'll actually approve it with both sides. And then if I'm say, yeah, just tell them, tell them it's hearsay, you can't do it. And then they'll do it. I never get pulled in because it's always something dopey like that I don't feel like walking over to court for.
And speaking of which, apparently the jury currently does have a question. So that's according to Shanley Shaw Painter. She tweeted 51 seconds ago that the jury has a question. So I'm wondering what is going to happen. I'm looking at the current live streams right now. So far, there's nothing. So there's nothing to share. They're just outside the courtroom, or outside the courthouse, rather. So
are we going to find out what the question is? Are they going to broadcast that, or are they just going to?
That's what I'm searching for. That's what I'm looking out for. So if that is something,
generally that would only be the judge and the attorneys. And I don't know that you can't say it. I don't know if you're forbidden to leak that.
Well, because during the Rittenhouse trial, when we were searching for any and all information, we would find out the questions by the jury.
Yeah. If it flops around long enough, it'll probably be leaked out somewhere.
Yeah, I mean, because it's written down, and so basically we would see the note from the jury. We would see a copy of the note from the jury that would be released to the press. So I don't know if they'll do that here, because in this trial they're a little bit more guarded with some of their proceedings than they were during the Rittenhouse trial. For example, we didn't get to see jury selection, whereas in the Rittenhouse trial we saw everything. So
based on the age of the jury, I wouldn't be surprised if this is one of the first times we hear the what happens if we don't agree.
Yeah.
Could be. Adel Breidenbach says, I have a theory on your last recap. JD on rebuttal was bait to get Amber Heard under cross, so CV could nail her litigation coffin. Thoughts, South Africa? Well, actually, this probably came out right around the time of my actual last recap from day 23 and day 24, the closing arguments, where I'm pretty sure I if I remember correctly, I just filmed it not too many hours ago, if I can think that far back. But I'm almost positive I said something to that effect, that I'm pretty sure that Johnny's testimony was intended to draw her out so that she could feel very tempted to get to have the last word. And that, it was really not good for her case. So I do agree with you, Adel. Sam Johnson says, question regarding JD in insurance, I think. Number 3, I think he wins. Not proven. She EXP expects firsthand between 2016 and 18. JD getting protected from abuse allegation. He was dropped from Pirates on that suspicion. Also malice and reckless disregard for truth of that statement. I have to kind of pick this apart a little bit here because I'm not sure I'm understanding this. Okay, so I get that he was dropped from Pirates. Not proven. She EXP explain
first-hand experience hand between 2016 /18.
Oh, I see. Okay, that he could win on number 3 because of this idea of the institutions protecting men. We were talking about that earlier. That maybe that they could show that it didn't protect him because of the fact that he was swiftly kicked off of Pirates of the Caribbean. I'm thinking that would show institutions actively not protecting him when there was an allegation out against him. Does that make sense?
Mm-hmm.
Okay. All right, cool.
Does to me.
Next. Next one. Stuart Ellis 2 says, why was the UK Depp heard trial so bad? Well, but a bit of a discussion starting from about almost 5 hours ago.
The very simple answer to that is who the defendants were, which dictated which evidence they could call or not call, which ultimately meant that Amber could pick and choose to some degree which evidence came forward and which didn't. And the judge didn't. Essentially, judge said Johnny Depp has to give everything over, and she can give only, what essentially ultimately what she wants. It's a bit more complicated than that, but that's the summary.
All right, I think we have the question.
Everything written in the op-ed. I think the confusion came in this particular one because the statement in question is the title of the op-ed. So I think they're just confused as whether it's the whole op-ed or just the title is the statement. And it's clear that the title is the statement. So I was going to answer to say the title is the statement in question for number 3. Does that seem appropriate to everybody?
Slash it better be. I'm getting on with my day.
So I'll rewind a little bit too once it's clear that this is the end of it, so that we can make sure that we see the beginning. Sorry to cut everybody off, and sorry to not use the feed that I wanted to use, but that's okay. I'm sure we'll be fine.
Well, sounds like they're going right
which
where we
they've
all thought.
phrased as headline as opposed to title. But
Right, because the headline is the alleged defamatory statement. So I can say the statement is the headline, and not the entire op-ed. Is that what you want me to say? All right.
Thank you.
The statement is the headline, not the entire op-ed. All right. I will send that back to them.
And just so we're clear, Your Honor, the wording would be what again?
I can give you the copy of this one. Okay, it says the statement is the headline, not the entire op-ed. Everybody's,
I'm just.
Uh-oh.
Okay.
Is there a
While
problem
we're waiting
with
for that, and Mr. Chu, I did get your motion. I'm not ignoring you, but I am kind of ignoring you because since the jury has the case now and it's out of my hands, I appreciate your motion, but I'm not going to entertain it at this time.
Oh, he has
okay?
a motion
Thank
too.
you, Your Honor.
All right, thank you.
Just can I have one moment, Your Honor? Just want to.
Oh my God.
Oh my gosh.
I'm surprised they're there. I'm surprised they're sitting in court.
That's a scout. She's working out of another. I think she's working out of another courtroom right now. To leave this one open.
Oh.
All right, are we satisfied with that answer? Okay, I will, we'll make copies of this first and then I'll get it back to the jury and I'll get it back to you, okay? All right, thank you.
Thank you, Your Honor.
Recess. Thank you. All right.
I apologize to everyone for stepping out and
that's
sometimes
okay.
life intervenes. But what was the question that they brought? Because it sounds like a liability question, which is interesting.
It was whether the defamatory
I want
statement
2
was.
copies, so that's what we go.
I'm going to play it
just
from the
read into
beginning
record
here so
the
that
question.
we can see this first part here.
It's basically in regards to number C, items 1 and 3, and number C is a jury instruction on the finding instruction for the online article title. The question is, does question number 3, the statement is false, pertain to the headline, I spoke up against sexual violence and faced our culture's wrath, or does it pertain to the content of the statement, everything written in the op-ed? So I think the confusion came in this particular one because the statement in question is the title of the op-ed. So I think they're just confused as whether it's the whole op-ed or just the title is the statement. And it's clear that the title is the statement. So I was going to answer to say the title is the statement in question for number 3. Does that seem appropriate to everybody?
Oh my God.
Yeah. So, okay.
Yeah.
All righty. Cool. Well, what do you guys think?
That seems to comport with our analysis that the biggest issue they have is that title.
Yeah.
Yeah, I think so. I would think
How
so.
do they get to that question first, though?
They're trying to split the baby.
They're confused. Either they're confused, or they realize they're not going to get an agreement unless they have a consensus on one.
Yeah, maybe they're trying to narrow it down.
Well, I think that's part of the issue. Is my understanding is Virginia, you need unanimity even in the civil matter. So maybe they're trying to split the baby, 1 for Johnny, 2 for Amber, and that's
what I was predicting.
Yeah, and maybe Runkle can help me on this one. So when jurors 2 and 8 were kicked, I had 8 pegged as my 4-person, just based on how involved and how in tune she was, and kind of how frustrated she was when she was notified that she was no longer on the jury. But 5 I had as being firmly pro Amber.
I don't know. I don't have her firmly.
But I had her as the holdout. If there was someone who was going to show skepticism to giving Johnny anything, I had her as my holdout.
Yeah, I don't know. She was very hard to read is the problem with her. And so I'm just sort of concerned that a lot of my notions about her could be reading in too much into a face that is like, a lot of the jurors should be playing poker. So I'm always sort of cautious about that. But because a lot of the others who were more expressive were sort of showing a leaning towards Depp, that means that she's sort of the risk on all of that. I don't know that we have a holdout situation just so much as I didn't.
Sorry.
It seems.
I agree.
It seems to me that what I was sort of imagining is that my read on things is that the argument about abuse, while you can make out, they could probably say, listen, we think that that claim or that those statements are not, that we're not going to give it to them on the simple abuse, but that they don't believe the sexual violence aspect.
Yeah,
and I think that's this question. I think is in keeping with that.
Mm-hmm.
Yeah, and that's what's sort of interesting because usually, again, I'm always on the defense side. If you have a liability question, that's usually good for me, but this seems like a parsing as opposed to a pure liability question.
Yeah, John, that's kind of what I was I didn't mean to say holdout in the sense that someone is opposed to it, but I think that when I meant that, I meant someone's going to need. She was the one that was going to say, well, someone show me the law and how this is actually intertwined with it and actually bring us back to a more comprehensive discussion. I think that's where we kind of are, like, splitting the baby. What's the most egregious statement? Are we talking about the article in whole or just this one sentence? I disagree. It's the article in whole. And then someone says, okay, let's do clarification.
Yeah.
So,
I hate to say it, but I don't think this is a good question for Johnny.
I don't think
it's a bad one either, though.
I don't either.
I think it's specifically a bad question, and here's why. If you're trying to figure out, is it just this, or are we referring to the whole thing? It makes me think we might have agreement if we're referring to the whole thing, but if we're only using this statement, then we don't have agreement. You've got if someone's parsing that issue in the jury, that's when you ask the question.
I think that's one possibility, certainly. I think the other possibility is that they might be saying, listen, do we have to consider the whole article, or can we just narrow this down in terms of our discussions? Yeah. Especially because, as I recall, the rest of that article was very heavily redacted. Mm-hmm. And they might be saying, listen, we can't come to a conclusion on the whole article because there's a whole bunch of redactions. But if we can just look at the head...
Their question is on the falsity of the statements.
Because in opening statement, Rottenborn read the entire op-ed to the jury. Mm. So I don't think it is redacted. The Sun article, or not the Sun article. Well, I guess it was an article in the Sun as well. But where Waldman's statements show up, that one was heavily redacted. But the Washington Post article, for whatever reason, was not. I can't explain the difference between the two.
My question is, if they are trying to separate out one statement from the rest of the article, I don't know why that's necessarily negative for Johnny, because it seems like they might be stuck at the falsity of the claim question. That would be my reading the tea leaves, which obviously is not, it's kind of futile effort. But if they're stuck at the falsity question and they're separating out one from the other, that seems to me to go to they're very uncomfortable saying not liable on the SA claim.
I can predict. I'm going to predict that they're going to have an answer on at least that first statement, the sexual violence. They're going to have an answer before the end of the day. We're not going to hear it until they come up with a full verdict. But I think that when you narrow it to that specific sentence, they're saying, look, if I can say that this sentence, if I can get the jury to say sexual violence, because we all agreed that was Johnny's best argument in the defamation context, right? That one sentence, the title. Mm-hmm. And we were worried that they weren't even going to get to consider that. But if they've got that one and they're trying to narrow it to that one sentence, I think they can get unanimity there. And then it's going to be how long until the rest of them are broken, or how long until we're
that's sort of what I'm saying. Is if that's in their crosshairs, then I think that we're making a reasonably decent prediction.
Well, the other thing is, how does this affect the republication aspect? Because that's a big issue here, right? So you could be saying, listen,
so they didn't ask about that.
But they
already passed it.
No, they may not be, because
they had to have, because that's. Sorry, go ahead.
The headline is the only part that she has not said she had any part in. So they might be saying, listen, we have to ask this because we don't think there's republication. So if there's nothing outside the headline, then Depp loses. Or, the flip side of that is that they could have already gotten past it, as you guys were saying, and saying, like, we think there is republication. We're kind of reading tea leaves here. A lot of these things can be interpreted either way. So that's kind of where we're stuck.
Yeah, I see that point as well. If they're trying to separate it out, maybe they're stuck on the republication question. That doesn't seem like the way they framed the question, and I only caught a little bit of it, but you make a very good point.
You caught it all.
Yeah. Wendy's Cafe says you might be overthinking this. It could be that they're trying to come up with an amount to award him based on the op-ed headlines. They may already have a unanimous verdict, just now discussing damages. Possibly. That could be, but I'm leaning towards the likelihood that they are trying to figure out the definitions at this point. I think that one of the complicating things for the jury is going to be determining, if they can take each of these statements in a vacuum, or because all of them come from the same article, right? And they also are going to be looking at this as, this is what would a reasonable reader reading these statements see these as, right? Because they are they're in the context of a greater article. The reader didn't just read those three statements. The reader read the entire article, right? So I can understand their confusion around that, to say, like, wait a minute, is this saying that this is the entire article? Statement one is the entire article, or is this just much more narrow? Either way, I don't see how that's particularly beneficial or damaging to Johnny Depp. It's just a definition to narrow the scope of what it is that they are looking at, what it is that they're even trying to figure out here. But that's just me.
I'll say from my perspective, with the amount of hours they've already put into deliberation, if they don't have some sort of an idea of where they're going with this, if they're asking a genuinely neutral question, I would be a little surprised, but I've been wrong before.
Oh man, just when this is warming up.
Yeah.
I've got a deposition I have to go to. If this verdict comes in while I'm stuck in a boring deposition, there's gonna be trouble. I don't know with who, but somebody. I'm gonna take it out on Canada, I think, just because Runkle's here.
Oh man! And just so you guys know, in the chat, there was no motion that was denied. It's being ignored, according to Judge Oscarati. We see you, Mike. Thanks so much for joining us. And there's been a motion that has been ignored by the judge, but we don't know exactly what that particular motion is for. I'm going to see if I can try to find out. If anybody has any information on that, email or DM me. I'll try to
pull it up.
Keep things open.
Yeah, Rob, can you pull it from? Does Virginia have a similar court filing system to my places?
If they have it uploaded, because in this case they have been notoriously slow to publish things that have been filed, and also they don't publish everything that they do. But if you guys are cool with it, I need to step away for just a minute. Are you guys okay with that? If I do that, or does anybody have any urgent needs before I go? Okay. All right, then I will be right back. Just give me like a couple minutes.
Quick, she's gone. Let's. Oh, sorry.
I got you, Runkle.
For a good 30 seconds. You have to wait 30 seconds until you take over a channel.
But if there are any super chat questions that come up, feel free to answer them in my absence if you guys want, if you guys need any discussion points. But otherwise, I'll be back in just a minute. I'm watching you, Runkle.
All right, so who wants to be the moderator today?
It looks like everybody's left, so there's not all that many of us. I propose anarchy.
Let's trash the place. No, there's a number of comments just saying they might just want to clarify whether it's the headline or the whole thing, which I think is fair enough.
I think that's fair, and I think that's what Alita was saying.
Yeah.
I also don't know why you'd ask that question if I don't find that at this point they've been deliberating for 8 hours, 6 hours, that you'd ask a purely neutral question.
Yeah, it's a long time just to come to number 3, isn't it? And then
I mean, this is a very diligent jury because they were paying an incredible amount of attention during the jury instructions. And jury instructions are usually boring, but that is like they were locked onto that. So it could be that they're saying, hey, we're getting close to a verdict. We just want to check our work and make sure that we're not screwing something up. The problem is this is not a terribly revealing question. It's not like,
I mean, it could be that they're absolutely clear on what their decision is. And they're just, someone's popped up and said, hang on a minute, is it the title or the whole thing? And so they could be clear. They could be halfway through everything else and come back to this and saying, well, hang on a minute, is it just the title or is it the whole thing?
And they also might have been reasoning in the alternative, in the sense of saying they might have been sitting there, not because sometimes juries are reluctant to ask questions. And so you can end up with them sitting there going, well, if it's the whole thing, then we find X. If it's the title, then we find Y. Let's shoot a question over just so we can fill this form out and get out of here.
And that's sort of what I was saying. When a jury comes back and asks a liability question, usually it's good for the defense. In the way that they framed this question, I read it a little bit differently, and I'd love to get all of your opinions on that.
I mean, it's tough. I think that you're probably right in the sense that it's more likely that this is good for the defense, but I'm not certain because it's not one of those questions that is just super obvious as to what it means. Mm-hmm. Sometimes they'll ask a question that's like, well, if we find that Joe had the knife, can self-defense still be made out? And at that point you're going, okay, yeah, we know where the jury's head's at.
It was a very neutral question to me. Overall, like, I think that could be read multiple ways, which sucks for us, but hopefully that means they're, I guess, giving this an honest review.
Oh, absolutely. And I also think that maybe that suggests that they're at some sort of a consensus barring the question. I'd be really surprised, and I think it's very bad for Johnny's camp if this goes into tomorrow.
Do you think so?
It's going to go to tomorrow.
I had a decent feeling that we would be going into tomorrow as well. I don't inherently find this to be problematic for Johnny if it takes 2.5 days for deliberations, because it could also just be, it could very well be the case that they got in on Friday and everybody said, so Amber's lying, right? yes, 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 yes. And then they're like, okay, but they spent 7 weeks on this trial, and we want to appear that we have been, putting all of our thoughts and deliberations into this as seriously as they have put into everything. So we want to make it look like we're taking this as seriously as possible. So let's hang out for a while and ask some questions.
And I think that's a very sensible human perspective on it, isn't it?
You can also get fights just over money, because there's all sorts of possibilities that they might be saying, listen, we agree some payment has to be made, but how much?
Could be.
That's not a bad argument. I actually,
it could well be.
Well,
I
and
don't think that juries sit there and worry about their own reputation and how long they took to find a result. I just haven't seen that borne out, but I know that is a theory.
I could offer some insight
from that happening. Oh, go ahead.
Sorry, yeah, I offer some insight, not from a jury, but the closest I've been to being on a jury is being a mediator, because as I mentioned earlier, I ticked all the boxes so I can do whatever I like. So I trained and qualified as a mediator as well. And so in that, you get to see not discussion, but you get private, and as the mediator of the case, and their desire to hear the discussions that go along with that. Sometimes you bring them back together and then they go back to private rooms again. The point of all this is, in my experience, it's almost always obvious right from the outset that one party is going to be paying the other party. It's a question of how much. And there's this sort of almost pretense as to whether they are going to do that or not. And eventually you get to numbers. And when you get to numbers, it's a question of, well, what do we agree is a reasonable amount? But I always get the sense in everyone that I've been to, either as the barrister or as the mediator, I've always got the sense that everyone knows from the beginning. Maybe the jury went in with that in mind. Maybe they went in knowing right from the outset. But this is all a case of, as you said earlier, is it the headline or is it the whole thing? Because if it's just the headline, it might be this. But if it's the whole thing, it might be that, or vice versa. Or, that's my insight.
Especially because the headline in some ways is kind of worse. So they might be saying, listen, does the rest of it water it down?
Yeah, exactly.
That's an interesting insight.
Does the rest, absolutely, I agree. Does the rest of it qualify it and quantify it and provide reasoning and dilute it somewhat if it's just a bold statement as it is? Because the UK case, the headline, we're all about headlines here. So the headline was everything. So maybe that is it. Maybe the headline is the big thing.
It also might suggest that they're either snagged on the attribution aspect or they've gone past it, and you're talking now about the damages claim. But maybe they're just snagged on the attribution question.
Yeah, and that is, I think, a real possibility here, is that they're going, we don't know if we can, decide that this was republished, and if she can be held responsible for it.
I hate reading the tea leaves. This is the most uncomfortable thing for anybody who's not a lawyer. Sitting there having lunch while the jury's out and wondering when you're going to get that call to come back to court it's very, very stressful.
Well, even for lawyers, stressful.
I've got a speculation on what this motion was that might have been denied. The possibility that Mr. Chu was seeking clarification of the jury instructions. A lot of people noted that there was either something that might have been a little bit off on the verdict form. or in the instruction?
Oh, this was the question of if 1, 2, or 3, then go to 4 or 5.
Yeah,
it was a little bit
that.
misstated.
Yeah, and she basically said, no, the jury's already got it, so it is what it is.
Which is the right move. I mean, any attempt to clarify something that you've already given to the jury was going to read into in one direction or the other. You don't want to add prejudice to something like that.
I agree. I also think that it was a very poorly written form in that regard specifically, because I read it with Kurt the other night, and it's basically, it's just poorly framed. It's technically right, but it's if you believe all of the question of 1, 2, or 3, or if you don't, if you answer no to any of them, then do not proceed to question 4, which is the damages claim. And it's just poorly written.
Brian Wood said, judge stated when repeating the question that they are on the number 3 false question doesn't mean they answered yes to the questions before that.
No, of course not.
It could very well be that they also had a number that they wanted to work out for themselves. So they had a number of things, and this is one that they ultimately decided that they were not able to work out for themselves, and they needed some.
Well, and that's where the defect of the form kind of comes into play, is because questions 1, 2, and 3 are the 3 statements. 4 and 5 are the damages claims, and who knows? It's really, as I said, a poorly written verdict form.
Yeah. Bernhard says, if it is the headline, then the republishing tweet itself shows the defamation without having to click the link. I believe so, based on the screenshots of the tweet that we did see at evidence in trial, or in evidence at trial. Yeah, it does look that way. And along with her tweet, which said something about, something to the effect of, I wrote this, et cetera, for reasons being I'm Amber Heard. So basically clarifying, like, I wrote this. So yeah. Amy says, question, if the jurors agreed the article was not defamation, then why would they ask about the headline? Good for JD, this inquiry, or no?
We don't know.
Yeah. Yeah.
Unfortunately, the honest answer.
Abhishek Agarwal says, is it enough that each member finds at least one statement out of the 3 defamatory for it to be considered unanimous? They need to all agree on one statement. It can't be that each of them finds one statement that is defamatory. They all need to agree on the one.
Yeah, so long as it's all the same one, we're good.
Yep. Yeah, exactly. Because they only need one, but they all need to agree on that one.
Yes.
Suze D says, am I remembering this right? SA claim and headline only and not the rest of the op-ed?
Yeah,
that's so. Yeah. Monica says the body of the op-ed never claims SA by Depp, only that she experienced it as an adult. Could that play into the question?
Possibly.
Could be.
It's any number of things at this point, given.
That would have been a great argument at closing.
Yep.
Mr. DNA 1987 says, didn't their answer somewhat contradict jury instruction FF, which instructs to consider statements in the larger context of the article? Ooh. That would contradict a little bit.
But is the actual headline, you can't consider that a statement?
Yeah, the statement itself is the headline. FF, I'm trying to scan. I've got the instructions open in front of me. And
okay.
Do you want to share the screen?
Let me see. Sure.
So Benchu found an error that I found, or
we don't know.
Oh.
He said, I have a motion, and the judge said, I'm not entertaining it. That's all we know.
She said, I'm not ignoring you, but I am ignoring you right now.
Yeah.
Yes.
So which means she hasn't denied it.
That's fine.
So there's AA.
Unfortunately, they didn't credit you, Kurt. So
that's unfortunate. I found another mistake, by the way.
Oh no!
Did you find
Maybe it was that one.
Where? So you go from TT to CC 20 Z And yes, if the chat is wondering why these are 38 pages and why they're confusing, it's because they are.
Because they're drafted by lawyers.
Yes, exactly.
But see, I like the instructions being broken down by like one thing on a page instead of with some courts it's just a big story you have to read straight through.
So that was damages.
I think it's easier to focus.
My
chat is
experience,
saying
they
FF
just,
is page 15.
my experience, they just pull out basically a box of cards that everyone agrees are the pattern jury instructions. They just read those and send them over to the jury.
I like how they have a number at the top and a page number at the bottom. That's not confusing
I know.
anyway.
So thank you, chat, for telling me it's page 15. I'm going.
It's like which page 15?
Yes.
Oh, now page 15 is ambiguous.
All the wires are blue. Which one do I cut?
There it is. Page 15 of the Adobe document.
Okay.
Yep. It is contradictory a bit. Yeah.
I'm not sure that's contradictory.
I don't either.
Because again, we're now talking about
you have to
just
determine
not
whether or not
seizing
the
on
title
one
is
word or
a
phrase.
statement. Yeah.
I'm not sure that's contradictory.
This is the attribution, isn't it? Like well, not attribution, but it's like this is the implication argument.
Yeah, because FF is also the counterclaim statement.
There's apparently a second question. People are saying from the jury.
Oh, awesome!
I think the idea is in the body of a work, you can't just seize on a phrase. I don't know if that necessarily applies to a title in the way that's being litigated here. Because I think a title does stand on its own.
Well, the statement itself has to be read as the statement. That is what is at issue.
Mm-hmm.
But again, the basis of the defamation by implication is that you have to you have to take that statement in context to determine whether it implies something either further or less than what the statement says in isolation.
Well, it's like if Kurt makes a joke toward me and I'm like, Kurt, why did you shoot me? And that gets published out there. Yeah, it needs to be in the context of that. I think that's what it's trying to get at more than separating the actual clauses.
Well, can I show you another problem I found in the jury instructions?
Yeah, where is it?
So if you go either to statement 2 or statement 3, it doesn't matter. Take your choice. It's up at the top, for the questions the jury has to consider.
The findings.
Yeah,
guys.
Well, the way it's written at the top, it's wrong.
At the very top.
Yeah, well, yeah, for the top of number 2 or number 3 of the statements to be considered. Just keep going up. You keep like this, the first, second, third statements the jury are to consider. The actual.
Right here.
No, further up where they're actually doing them individually, where it has the checklist.
No, so you're talking about the form. You're talking about this.
Okay, yes, the form. I apologize then. I'm sorry. So, not number 1, but go to number 2. Okay, scroll up just slightly. Okay, so here's the mistake. It says, as to this statement appearing in the op-ed entitled A Transformative Moment for Women in the Washington Post print edition and the online edition, Amber Heard, I spoke up against sexual violence and faced her crouch wrath that has to change.
That's a compound claim.
Yes, it is. The way it's written, you technically have to find the statement is defamatory in both of the articles, not one or the other. So it is
that is absolutely wrong.
Yeah, so it is technically possible to read that statement as defamatory in one of them, but not the other. And the way it's written, you have to find it in both, and that's wrong.
Uh-oh.
That's a really great catch, Kurt.
I'm here for legal issues because that's how I roll. I roll deep into law. Yeah. Rolling.
But you're right. That is a conjunctive.
So essentially,
statement.
this should have been posed as 5
It should have been
questions.
or. It should have been or, not and.
Yeah.
So just like when the oral instructions, there was the and versus or mistake, there was the any versus all, there was the nature of the three instructions, and now this is now a fourth error in the legal things.
This is what we like to call grounds for appeal.
Yes, this is what we call grounds for appeal in La La Land.
So
yes.
I wonder. So now I definitely want to know what Ben Chu's motion was.
I would love if he fought that one, because that one is clear as day.
Yep.
Yeah. So four errors in the jury instructions, but the other issue is they obviously agreed to this, right? So
no, it's not that they agreed to it. They hammered out little issues and objections along the way. Some of them were resolved by agreement. Some of them were resolved by the judge saying, "I understand your agreement, but I'm going with this."
Okay.
So we don't actually know what the appealability posture is right now.
Yeah. Poor Ian.
If that's the motion, that is a silver bullet.
Because now if Johnny Depp loses, now he has grounds of appeal, because the way this is instructed, right? Johnny Depp now has grounds for appeal because maybe the jury found one, not the other, and you don't know because the form is ambiguous. So now Johnny Depp has grounds for appeal if he loses.
Assuming it was not a stipulated instruction.
Unless it's stipulated. But...
Assuming it's stipulated, yes. Although even if it's stipulated, technically speaking, if it's clearly erroneous, you could still appeal. So there's still some remote chance there.
I actually think that is clearly erroneous as a matter of law, the way it's written.
So even if it's stipulated, you might be able to appeal it.
Which for folks,
welcome to Fun Times in Law with Kurt Mueller.
That's an extremely high bar, but
I understand.
Have that there.
I know it's a high bar, but
it's one of the rare times where I think you might actually have that.
Yeah, it's an error. It's a I want to appeal an issue I didn't preserve territory. Fun times have by all. Yeah.
And it's extremely material. It's not like you can argue that it's harmless error.
Is there anything to the fact that this is distinct from the actual instructions? This is the verdict form itself, not the instructions, which actually conveys the law.
If you're going to argue with me that the jury form can't be, I'm sorry.
I'm not saying. I'm not taking that.
I apologize. That sounded overly aggressive. I apologize. I was just going to say you can view the also set of instructions. What they gave early. So now you have grounds for potential appeal. Yes. Yeah, there's now.
So it looks like there's a lag that people are experiencing. Try refreshing the feed. Okay.
So on the liability question, the following statements. So boom, 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 but it doesn't draw any difference between the online versus the print.
Which is ambiguous.
Because the print didn't have this one, right?
Right. Exactly so.
Okay.
Absolutely right.
Yep.
So the verdict form does not conform with the formal instructions.
Yep.
That's grounds for appeal.
Yep.
Unless this is to suggest basically that regardless of which medium it was published in, all three of these statements are being conveyed or published.
And that was what she sort of verbally said, which is also a problem.
Depending on which side I'm advocating for on appeal, it means whatever I want it to mean.
That's kind of true.
Yeah.
Like depending on which side you want to play with it, you can.
That's the nature. That's the nature of appeals. Yeah.
For a case like this, it's just too loose.
I'm still admitted in Virginia. Hire me as your appellate lawyer either side. I guess I got options. I'll move back. I'll take a space in Rob's home. We'll work on it together. It'll be the two firm.
You can do all the writing.
Show. Two firm show.
Tell Provoc me in. I'll just do research for you.
There you go.
I'd be fascinated to see what the case law is on that sort of discrepancy between the formal instructions, the verbal instructions, and the actual verdict form.
Yeah. Oh, John, don't tempt my ADHD. I actually have like some work I need to do. If you put that shiny penny in front of me, I'll end up in a rabbit hole that I'll never get out.
I like how it's just my forehead on stream with the super chats. So I just have to remove them.
Rob, I love research more than anything. That's actually my favorite part of practicing law.
One in the chat says verdict is live. That's not true. I'm watching.
So there's
an hour warning.
Yes, there is an hour warning, so we will know, and we'll also put out a text message, and also just to prove it to you, here it is. So yeah, and
I like the architecture.
Yeah, right. It's not bad. It's not bad.
I'm always a fan of Art Deco.
Although I don't know that I would actually call that specifically Art Deco. We can get into a whole discussion of architecture.
That might be an interesting conversation for another time.
Yeah. Well, I mean, depending on how long it takes to get to this verdict, we may start getting into more sideways conversations from the law.
Topics.
Yeah, exactly. Marie V. Sand says she didn't write the headline, but as it was only in the online edition, she could have asked for it to be changed if she didn't agree with it, and she didn't. So does it mean she agreed implicitly? Well, not necessarily with the actual title itself, but in her tweet, she could have said, I don't necessarily agree with this title, but this is everything else is what I wrote, or something like that.
I think it's beyond that. I think that question's kind of gone, because that retweet, I looked at that thing several times. They put it up on the screen. I don't know why Rottenborn threw it up there like he did. It basically was all but like saying, I published this over and over and over again. I published this. I published this. I published this.
Yeah.
In literally those words, today I published. Yeah. So as far as statements affirming and adopting, I mean, it's hard to get much better.
Well, you tried to argue that, you need to add content to the material. I published this does add content to the material, because anybody can put a byline, but you personally saying, that is me, that's my byline, that's adding content.
Yeah. John Granville says, I'm having trouble seeing how you get any design / intent and malice from just the headline if she truly didn't write it. Am I totally incorrect here? It comes from the tweet, from republishing it in the tweet, really.
And choose motion, if it's dealing with any of these issues, presumably preserves the issue for appeal.
Yeah.
So
certainly,
even if the judge ignores it, the fact they brought it to the judge's attention. Hi, Rich.
And again, there's the actual malice question, which is she would be in a position to know if it was true or false, period. So actual malice is not an issue in this case.
Actual malice is a gimme. For me, it's a gimme.
On both sides.
In my opinion.
Agreed.
What are we talking about, kids?
Errors in jury instructions and ambiguities.
Well, also you missed a jury question. Amazing.
Right.
Like we actually got one.
No, that was a legitimate. I'm sorry. Did that sound sarcastic?
No.
What was the question? See you, Rob.
I'm going to do a little bit of work. Rick, you keep me updated. We're going to swap out. I'm going to do real work. You do this stuff, and then we'll change.
God love you.
So the question was whether the first statement was just the title, or whether that statement basically means the entire article. So in other words, if they find yes on the first statement, do they have to find yes on the entire article? And we were kind of going back and forth about whether that was good for Johnny, bad for Johnny, neutral. I'm kind of neutral, because I see that as just a definitional or defining question, just trying to figure out what's in, what's out, so that we can kind of triangulate here what we're trying to look at.
I'd have to look at the language of the actual instruction.
Yeah, I don't. That's such a wild. I never even occurred to me. Why? How could that not be separate? It's the other two are included in the article.
Well, I think part of the confusion is coming from some of the jury instructions here, where they're talking about how these statements have to be taken in context, and like you can't just take them in a vacuum. So it's like it's a very strange thing, because all of these different statements come from the same document, and you have to say ignore the rest of the document, but don't ignore the rest of the document. So I can see how this would be incredibly confusing for the jury.
Yeah.
Yes. Well, the three documents can certainly inform. The three statements can certainly inform each other. The ones that you're allowed to see, because I would think. I mean, one of the best arguments for winning on counts 2 and 3 is that you held up that count 1 was republished. Because once you framed the article about SA or SV, then what you're talking about in the article's body feels different.
Why did you not give closing arguments? That's exactly how it should have been framed. I just don't think they did it.
Yeah, I mean, I think they had a couple of problems after looking at the closing arguments again. I don't think they hit the implication concept hard enough, because I still think those sentences can be read as true in kind of a vacuum. So I think they should have hit implication harder, and I think they should have hit the, she republished this. So once you're talking about SV, we're talking about a very specific kind of abuse, aren't we?
Yeah.
So.
Yeah.
That's
brilliantly said.
Yeah. And then Carrie Harp says, is it because the same statement below is in both articles? This question isn't about the title.
Number 1 only asks about the online article, so it doesn't have the same problem. But questions 2 and 3 ask about them in the context of both simultaneously.
Yeah.
So there's a problem.
Yeah.
Yeah.
Mental wellness with Shelley says, question didn't answer stay on the stand, or didn't Amber say on the stand that she did write the article, and yes, it was about Johnny Depp when questioned by Camille. That is true. That is correct. She did when she was on.
That's not a question at issue here.
Yeah. Yeah. The question is whether she wrote that specific headline for the article, not the article itself. Mr. DNA 1987 says, not disagreeing that the statement is compound, just not sure if that will mean anything to the jury in a legal context. Jury brain versus lawyer brain.
I'm not disagreeing. Like what a jury will choose to care about is kind of impossible to determine. When you hold multiple mock trials, even watching the exact same thing, you'll get different things from different juries watching the exact same evidence. Literally the same thing, you'll get different opinions. So I'm not saying what the jury will or will not choose to care about. I'm saying here's some possibilities if that are open. And also, if you're looking for grounds of appeal, you're looking for a legal error, I'm like, well, here's a potential area that opens up a legal option. So these are just noting of possibilities. It's like, put a pin in that as a possibility for later. So that's all I was trying to do.
The jury can still get it right, but this is a way that we could lead a jury to a wrong legal conclusion.
And it's also a way to attack it on appeal, even if they get it right. So there's because the jury was misled or they were misinformed, because here's a whole bunch of contradictory things, so we don't know what they meant. So there's possibilities. It's all you're trying to really do is generate possibilities.
Yeah.
And with the invoice of lawyers that were involved in this case, that should have been tighter.
Yeah.
Yeah, probably. Honest mistakes. Shouldn't it be the defamatory implication, i.e. JD abused AH, that needs to be false rather than literal statements made? It's literally true that she spoke up, even if her story was all lies.
That's Rottenborn's argument.
Yeah.
Right. But the question is, whether she made any kind of misrepresentations, even if technically what she was saying was true, but the way that she was saying it was suggesting more. For example, suggesting that he abused her with SA, but that wasn't the case. For example,
the instructions are not great at dealing with the implication when they ask the yes.
What is that noise in the background? Sometimes there's just this noise static. Feels like.
Yeah, I'm not sure.
Is that me? It might be my fan.
No,
it almost sounds like a TV's coming on and off or something. Like there's another feed somewhere.
Let me ask, why didn't they at least try any claims in false light as opposed to pure defamation? Because I don't know if that's not a Virginia thing or Because maybe that would have been an easier case to win.
I don't know, actually.
Right.
That's not anything that I have looked into before this point, but that's a very good question. Let's get some more questions from the top.
Is not recognized in Virginia.
Oh, it's not. Okay.
Okay.
I can answer that one. The little internet. But no, yeah, I think implication is designed to do that for them, right? Their implication law and precedent is weird. So I think, and that's why the jury instructions are so oddball to me. And I thought this when they were read, which is you have like these 7 pieces of things you're supposed to consider. Like, is the statement false? Does it imply something that's false? All these things. And then the yes/no question is just, is the statement false? It's like, well, that's not actually taking into account all the 8 things you just told me to take into account. If I'm just a robot that reads the sentences, right? Now, I don't think the jury is going to be that robotic, hopefully. But I did think it, even as I heard it, that's not quite as broad as you would want it to be on that. And I will say in terms of pops, Alita, that my today, my StreamYard keeps trying to turn my audio on to automatically adjust, and I have no idea why.
Oh, I'm doing that because you're too quiet otherwise.
All right, well then you go nuts. You know what? It's your channel. You click on whatever button. I'm trying to fight this malicious ghost in the StreamYard. It's actually Alita.
Ooh, I'm the boogeyman.
I will no longer press any of those buttons. Whatever you say goes.
I was wondering why it kept lowering. I should have just told you I was raising your volume because we had complaints that your voice was too low. They wanted to hear more Hogue.
I get that a lot in life. Yeah, you're not a very loud person. I wish you could speak a little bit more loudly. I wish we knew your opinion more. Yeah.
I also saw a comment saying I was breaking up. I don't know if I'm clear or I should be turned up or what.
Live streaming. You sound good to me.
I think you're fine. Yeah, you do sound good. I think there was a period of time where StreamYard's feed into YouTube was poor, and so there was a lag, and so there were some issues there. So, but I think right now it looks like the stream is healthy according to what I'm seeing, the data that I'm seeing. So I think it's all good right now.
I'm fascinated by this question. I'm fascinated.
Yes, well, I saved it specifically for you because I figured this is one that needed to be asked when you're around. Nihan Hanguk says, any panelist played TTRPGs? Fate is my favorite. I don't have an answer for this question.
Now, you read that very carefully, Alita. You know what the TT is there, right?
I mean, RPGs is role-playing games.
You got it, but you know what TT is.
Tabletop?
Yes,
no.
Tabletop. And specifically, it's not just, hey, I like to play board games that have an experience bar next to them. It's your Dungeons and Dragons type games. And the answer is not in a very long time. You might not believe this, but it's somewhat tough to get professionals together on any kind of regular basis to do anything that involves imagination. Because mostly after the workday, they want to die. So I still do get a chance to play sometimes on the holidays. Mostly I played BattleTech back in the day. So that's a variant, of course. There's a bunch of these different ones. But I love the concept. I love the imagination. And it's one of the things we like most, me and my daughter, about Stranger Things, is their continued incorporation of that as an element in their show. So it's a fantastic question. And the answer is, God, I wish I could do it more. But life just gets going fast. And it's hard to find those sessions.
There you go. And if Ian were here, he would have a lot to say about Dungeons and Dragons as well. I know he's talked about it quite a bit. I love our nerdisms. Aussie Lawyer says, Hogue, did you see the truth slide regarding the issue of truth relating to imputations?
I feel confident in saying no.
Okay. Carly Loves Big Bang, German Hogue fan club, says, here we don't have juries. Yeah. Here we don't have juries, but we have specific trials where 3 judges equally decide, 1 professional and 2 lay volunteers, to secure the participation of the people. Does something similar exist in the UK?
Wild.
Sorry, let me reread the question.
Yeah, sure. I know it happens to me all the time.
We're all trying to spin plates, you know.
Yeah, so the only time we get that is on an appeal in a criminal case from the magistrates to the Crown Court. You get what we call a professional judge, a Crown Court judge with 2 lay magistrates, and that is then a rehearing of the original trial. So not in a sense where it would replace a jury. So a jury would be for criminal trials, and that's it. But that would include inquests, which is deciding how somebody died. So if there's suspicious circumstances, or you're trying to say, let's say a theme park operator may or may not be liable for the death of a person on their premises, then you have a jury involved in that as well. Other than that, I can't think of any. Obviously, apart from appeals, you get 3 judges, but that's not the same thing.
And I'll give one fun fact to folks, is in the United States, we do have one state that does not follow English common law. It follows the Napoleonic Code in various forms, and that it would be the state of New Orleans, or excuse me, the state of Louisiana.
Which is, yeah. Same.
Which actually does basically it does basically follow the civil law, which is in most of the world these days.
Yes. Yeah. Louisiana is what I learned in law school is anytime Louisiana came up, they were like, disregard it. They're crazy. They're weird. If you're not going to practice in Louisiana, just don't worry about it.
That is the section I remember in law school too. And Louisiana.
So how do they deal with it then when you're at law school and you may go to
They don't teach us laws.
state? No,
No, they don't teach us anything in law school. They teach us how to read cases that are applicable on a broad basis, and they say, go figure out the law of the jurisdiction you're going to practice in after the fact.
Right.
I mean, literally.
Yeah, they basically teach you first principles and how to find the answer, not what the answer is.
Right.
Exactly.
It's God's honest truth. Now, if I can go back a step, because this is just massively interesting to me, and I'm sorry I was gone for it when it happened. What was the panel's decision on whether or not the jury question was good or bad, for whom and why? Just overall?
I'm neutral on it, I think.
You're neutral on it?
Yeah, agreed.
Neutral?
I actually think that it was probably... So the way that I framed it was usually when you have a liability question, it's good for the defense. But the way that they framed the question felt a little bit better for Johnny if they're trying to separate out the title, that maybe they're splitting the baby.
Okay, interesting. Because I read it as I see a fight. I see a fight between whether we can incorporate the article, which is primarily Amber's argument, that there's all this extra BS in there about laws in Washington, D.C. and things. And so that would soften the headline, or whether or not we just have to read the headline by itself. So I'm not as positive. I think it's a fight, and I don't know which direction that goes, because I think it depends on what the sides are for a fight like that. But it's interesting that it sounds to me like someone has taken up the argument that the rest of the article can soften things, and was just told no, which means that answer is good for Depp, I think. But the fact that there's a fight at all is very interesting.
I think the idea that they're trying to take the statements in a vacuum is probably good for Depp, because I think that his best argument is one statement. The other two are less clear. So if they're told, take them each in their own light, then that might shift whoever to saying, all right, statement one's the title's bad.
Right.
That
no,
was
and I
basically
think
where I came from it.
I think the answer is definitely pro Depp. And I will say the other thing that I think is pro Depp, as I think about it, is I think the republication question has been answered, because you don't have that fight.
They didn't ask about that.
I know they didn't ask about it, but I don't think you ask that question if you've got a republication disagreement.
Well, and that's where I agree with you entirely. I think they've already decided republication. I think they moved on to falsity or the context question.
Yeah, no, I'm thinking about this. I think that whole sequence is good for Depp. I'm put my flag in good for Depp. All right, thank you for allowing me to go back in time to discuss these things for a moment.
Yeah, of course.
I missed that. And so now we can proceed with the rest of our show. I apologize for the hijack.
No, that's okay. That's okay. We kind of round robined it for a little while. Mike was he felt pretty strongly that it was not pro Depp,
right.
For his reasons. But I still remain somewhat neutral on what that fight is. But I do agree that it means that they probably are not fighting about the publication of the headline through the tweet, because I mean, either that, or maybe that's the next question that comes out and they just haven't gotten there yet.
Well, right. As a lawyer, I look at the republication as the first principles. We can skip the rest of all of this if she didn't write it. So I view it as having happened after the republication. And then I think that there's an interesting part where there's an Amber Heard fighter in there for reading the whole article to soften the statement. But the answer is a loss for whoever that fighter might be. So I'm planting my flag in pro Depp on that.
All right. One thing that was interesting was that Elaine Bredehoft delayed quite a bit before she agreed with the judge's response to the jury. Yeah, even Rottenborn seemed like he was like, yeah, it's fine. And then she's like, okay, you guys are good. And then Elaine's like, wait. And then finally, like after we couldn't see her, she was off frame. So we couldn't see if she was like looking through something or talking about something. But then finally she was like, yeah, we agree. That's
or just
fine.
making a long enough noise that she could potentially come up with something. I think it's a bad answer for Team Heard. I think Elaine is wise. Look, let's give Elaine credit. I think she's wise to note that and be like, is there anything I could say here? So, I mean, I think it's a pro-Depp response. And as I said on Friday, I'm not sure Depp can win on 2 and 3. I think if one gets through, Depp wins on 1.
Exactly.
I think that's a fairly common opinion.
Yeah.
Well, it wasn't on Friday, all right?
That's been my opinion for 2.5 weeks.
Okay. All right. You weren't on the stream.
So did we actually ever answer this question? Does something similar exist in the UK?
Yeah, broadly I did. Yeah.
Okay.
We answered.
My apologies. Okay, then we.
But you sort of were describing an appellate system similar to what we have here, where after a trial it goes to a 3-judge panel, and then we have en banc. I don't know if you have a similar system, but
yeah, broadly similar. Yeah.
All right. Lexi says, question for the panel: most interesting case you took part in? Without revealing any sort of client disclosures or anything like that. Client
I've
confidence.
negotiated some really cool promotions at places like E3 for some really big video game companies you would recognize.
That's cool.
That's all I got, people. I'm not a litigator.
My most interesting one doesn't even have anything to do with litigation, but I helped to facilitate a donation from a trust to the Getty Museum in Los Angeles. So that was pretty cool. It was a donation of items too. So pretty cool. I don't know about you guys.
For the relative sake of anonymity, I can say that one of the most interesting projects I engaged in was my last year at law school, where we were trying to get rid of a publishing requirement for LLCs in New York, because it was just a total monopoly by newspapers, where you'd have to pay them $6.5 to $8,000 to publish just to start a small business.
Right.
And we did not succeed as of when I left the project, but it was one of the more interesting things I did.
All right.
Access to justice for entrepreneurs. I like that
Absolutely.
story.
I like it too.
What
Daniel,
is that? Is that New York?
Do you have a particularly interesting
Yeah,
case?
that was New York.
My stuff is patent law dealing with computer databases and search engines. The way I'd like to put it is Google and people who want to be Google. So I've done stuff relating to Google and also a lot of very, very niche stuff that exists in backend that the user would never see, but deals with how data is selected, created, presented, blah, 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 blah. So
that's all.
Yeah, it's very, very technical.
I could never do.
The Google case I worked on was interesting, and I guess I won't say much more because I don't remember if it was published or not. So I'll just
Yep.
Always a good choice, Kurt.
Yeah. Daniel, how about you?
I've been trying to think while we've been talking. I think being carefully selective about what I say for anonymity, but I managed to, I won't say even what type of case it is, but I managed to track somebody who'd made a fortune in cryptocurrencies and around in excess of 30 different bank accounts with different payments to and from. Traveled around the world, tracked him down, and got a huge order against this person based on all of this money that had been made and effectively taken away. And it's quite an interesting case. And one of the novel cases from cryptocurrencies, people think they can run and hide. Not always, not for me.
I like that. Sean, how about you?
I'll tell a little bit about it, but I'm going to save this for maybe the 10,000 subscriber special.
Yeah.
I was involved in defending a guy when I was in the public defender's office. He had an issue with licking women's toes.
Oh my!
Like he'd run up to women, like, you know, and be like, he'd be like, "Hey, what's your name?" And just like, yeah, like right there.
What, you just like get down and start licking their toes?
Yeah. I mean, there's not a whole lot to it. Wow. He walked up to a girl at the like shoe store and said, "Hey, I want to get these shoes for my girlfriend. Can you try them on for me real quick so I can see what they look like?" And the girl working there said, "Sure." And as soon as she popped her shoe off, yeah, he was he dropped to the floor and yeah.
Okay, that's different.
He did to a couple women. Well, and got me on the 6 o'clock news too, trying to deal with him. So that was the bigger part of it.
Oh my gosh!
And it's out there. It's out there. Wow. I'm not gonna.
Alita, show us your feet.
Nope, not after that. Never. Yeah. Well, never anyway, but definitely not after that. Also, by the way, so I took a poll earlier to ask, do you think we see a verdict today? 17,000 people voted. 55% said no. 44% said yes. So we're basically even split almost on that one too. So folks are undecided.
What time is it right now? It's 2:30.
Yeah.
God, I am genuinely still surprised that it's taking this long.
I'm not all that surprised, to be honest, because I have a feeling that they're gonna take their time to circle around through everything. They're gonna take a very literal approach to analyzing the law, and then somebody's gonna be like, "Hey, hang on, guys, we have to take a step back here. We get to remember how we walked out of that courtroom, and then we walked into this jury room or jury deliberation room, and how we were all feeling about this. They're gonna have to reconcile their logic side with their emotional side and try to come up with that, because if they went strictly logical, very, very literal, it probably would go on the side of Johnny Depp not winning. But if they are also going to allow for any kind of emotion involved, which they're human beings, usually that's going to be the case, they're going to have to reconcile that with the things that they saw, right? Like the testimony about the finger. Well, sure, but they're gonna want to analyze all parts of it, though, I think. And then they've also got the counterclaims to look at.
Yeah, nobody cares about the counterclaims.
I said Thursday.
Yeah.
So, I think there's definitely a degree of waiting around because of how long the trial was. I think if I was on a jury that was watching and hearing evidence for 7 weeks, I would want to take a few days to at least give the appearance that I've given it all of its due.
I'd want to do the exact opposite. I've been here for 7 freaking weeks. Let's go get our free lunch.
Yeah.
Send in a verdict form.
I've only getting paid $30 a day. I gotta go.
Yeah. In Florida, it's $15 a day.
Wow.
Yeah. Stephanie says, Alita, Quebec has notaries, law school plus LLM plus extensive testing. They do any non-litigious law, wills, real estate transactions, etc. So I didn't realize that Quebec had that as well, but I have heard of this, and it seemed like it was like a higher certified kind of level of lawyer in the jurisdictions that have it, that isn't like a notary public like what we have. That's a very, very basic thing in the United States.
Puerto Rico is kind of similar, where their notaries are like paralegals.
Puerto Rico, you said?
In the States. Yeah.
Interesting.
Oh. Alita, I'd step away for a second.
Yeah.
Did you ask, are you guys notaries by default once you get your license in your states?
No.
Oh, okay.
I am.
Yeah, I was going to say, because I am.
It's not by default, but I don't have to take the exam. I just have to pay the fee.
Mm-hmm.
Huh.
Yeah. We have something similar. So on my default inclusion for my practicing certificate is for administration of oaths. So same thing, near enough. Not as a public notary, but for oaths.
And even in New York, I forget where in the CPLR, but you can basically sign a letter of attorney, and that is the equivalent of a notarial oath. Where you can certify that somebody swore to a document.
Yeah, we have the same. I mean, in fact, I sit on a panel that deliberates the frequently asked questions for our profession, or our half of the profession, the barrister half of the profession. And one of the common questions is signing a statement of truth on behalf of a client. A lot of people think it's litigation, which we're not by default allowed to do. but it's not litigation. And then some people think sending a letter is litigation, which is not litigation. And so there's all these debates, but it's actually relatively straightforward. I mean, litigation is very narrowly defined, which you'll probably find is very strange that we can't do, sort of out of the box, as it were. But we have to have an extension to the practice certificate to say we can conduct litigation, which is literally lodging a claim, filing documents in a claim, filing a defense, and so on. There's only about 1,000 of us that do it. 1,000 people in the UK, in England and Wales. 1,000 bats.
It's amazingly low. I can't believe it. It's like it just opened up a shingle, man. I'm ready to go move over there. Damn, it's like no problem with getting business, I would imagine.
Well, good luck getting the qualifications.
I can speak English. That's
pupillage is the difficult bit. With the number of applications, I don't know what the statistics are currently, but it's horrendous. It's something like 15 to 20,000 applications for maybe 200 or 300 places or something like that every year. It's horrendous. That's the difficult bit.
But yeah, in New York, you can sign attorney affirmation, which is the equivalent of notary, and you don't have to take in either New York or Florida if you're already a licensed attorney.
Roima says, is that the same Robert Palmer that sings Addicted to Love?
Mm-hmm.
Sounds good. Sariel says, question, how wasn't the evidence about JD's drug use more prejudicial than probative, especially when AH's arrest for IPV was not admitted because of prejudice when it actually constituted a precedent? Well, it was a pretty central argument for Amber Heard's team here, right? As to the whether or not things happened the way that they are alleged to have happened. So the idea that Johnny was on drugs and drunk all the time had to do with his memory. The argument that they put out there and they reiterated it in the closing is that how can we possibly trust anything that Johnny Depp says about what he remembers? Because he's been drinking and on drugs for so many years and so long and so constantly that there's absolutely no way that he can possibly remember anything. So we don't trust him, and neither should you. That's basically
that was, in my opinion, the worst expert testimony I've seen in that trial.
It absolutely was. It was like, because he drinks, therefore he has memory issues. Never mind, like actually testing him and asking him and indicating from the things that are specific that he's doing and saying and things that he's like in his behavior that are indicating this is somebody who is forgetful. This is somebody, like I would have expected something along the lines of like, yes, I watched his testimony and the way that he answered indicated that he's, like something about his meandering responses or something to say he meanders so far that he clearly is making up something new and then coming back and then finally answering. It's not that he actually remembers it. It's that he's making up something new to fill that void in his brain. But there's nothing like that.
To those who don't know, I did period of time in MedMal and I've dealt with psychiatric issues. That was a disaster of an expert. He was so bad, and they absolutely nailed him on the Goldwater rule in such a way that I don't believe a word that this person says. He literally is just a hired gun, and I hope that the jury saw that as well.
But have you seen his qualified testimony performed by the voice actor that does Franz Doofenshmirtz? That's the question, because it's awesome.
I have.
DM it to me, because I would love to see it.
I can make that happen.
All right, perfect.
Yeah.
This also goes back to what some refer to as double standards in the English judgment. So there's a couple of examples off the top of my head. One was the judge saying that although Amber accepted that she loses her temper, doesn't mean she gets violent. And yet reverse assumptions made against Johnny Depp, such as the photograph with lines of drugs on the table, assumed therefore that he was on drugs, even though he hadn't. Well, he said he didn't recall whether he'd taken it or not, which you might suggest that he would just flat out deny it. In fact, he was, in my view, he was being honest and say, well, I don't know, I can't remember. But the assumption was made that he had. And so there's a number of things like that throughout the judgment that many find, and I sort of agree that there were the same application of a test applied differently to both parties, and I don't think it should be like that, especially with the credibility questions raised.
I agree entirely.
Alrighty, next one. Okay, nope. This is the next one. Polly Rogers says, I would be more concerned about Camille Palmer, who is very liberal and pro women's rights, single moms, that would affect the judge's viewpoint. So this was having to do with the schematic that we were showing earlier. So could be. I mean, when we're talking about the influences of political movements on the people that impact the people that make the decisions, that's always a possibility, right? Because we're all human, and that's why we try to have these measures in place, whether we're talking about the American system or the UK system, to try to protect from biases. So, and whether they work well or not can depend from case to case, and in the way that it's applied sometimes. When Ray says there is no way you can actually sit there and say this case wasn't shady. They didn't allow Johnny to present his evidence. Oh, we already read this one.
I gotta believe that. I thought I was in the Matrix for a second.
Yeah.
My understanding from this morning was he chose not to. He might have had the opportunity. Right? Am I misunderstanding that?
That the UK case was BS?
No, that he had the opportunity to bring live testimony. He chose not to.
Oh, in the UK?
I think some of it was not a case of choosing. I think there were time constraints because of COVID, and I think certainly the trial date was moved, and quite probably I don't know, but quite probably there were travel difficulties and time constraints with actually having live testimony there.
Okay.
Yeah, I'd need to look at that, but it was certainly to the detriment anyway by not having it there. But because those, and I think there was certainly the intention of having them there because the statements were served, and you normally only serve statements either because you're having a live witness or you're serving it together with a notice of hearsay. But there was no notice of hearsay, so I presume that they were intended to be called but weren't. So therefore, I don't think it was a choice not to have them give evidence. I think it was some other reason they couldn't attend, which I think was detrimental.
All right.
Thank you.
The Triggered Limey says, question, not sure if this has been discussed as I arrived late. Is it possible to make an educated guess on the length of deliberation, or is it impossible to determine? Thank you. It's basically impossible. I mean, we could try to make a guess, but it's never going to be educated because we have no idea what's going on in the brains of those.
And I swear to God, if they come back as a hung jury, this judge is not letting them go home for a long time until they figure it out.
She's going to make them sit and wait for a long time. You sit in there and think about what you've done.
Back in there.
Basically.
I don't care if you have to fight it out and slap each other around. Just come out with a verdict, damn it.
Okay, Kurt.
Trial by combat.
Delicious Treat says, question, ACLU filled motion to have JD legal fees. Yeah, we discussed this one earlier. Definitely. And we can get into more detail in a bit if it does look like there's more information on it that isn't really new from what we discussed before previously. But yeah, it's any kind of request for fees for document production have to be reasonable. So the ones that are asking for the money,
unreasonable.
It does, and instantly it does, right? For like 80 pages of documents, I've gotten a heck of a lot more than that from Wells Fargo before, and it did not cost anywhere near that amount. So
it's usually like 10 cents a page.
Yes, that's typically the case. So that's an insane amount. Is my immediate
so they're only
reaction.
overpricing by a factor of 10,000.
Yes.
Okay.
So my big question is, what are they using to justify that? What is their argument? I definitely want to see it before.
Are they embroidering the paper with gold?
Calligraphy?
Yeah, I suppose so. Selim says this would again be inadmissible vis-a-vis 404B. No, I'm not sure exactly what you are talking about. I apologize that we didn't get to this one earlier, but If it's 404B, for anybody that isn't familiar, that means character evidence, basically. So maybe they're referring to the testimony of Winona Ryder and Vanessa Paradis from the UK trial. Those are not initially
but the UK
allowed.
doesn't have that doesn't have that
Right.
rule.
Right. That's what I'm saying is that we were talking about how they could have possibly testified in the UK trial, but my point is that in the United States they can't automatically testify in American trial unless they are brought in the same way that Kate Moss is brought in, by basically saying Beetlejuice 3 times, saying Kate Moss once is enough.
Nice.
It's how it happened, right? Delicious Treats says, question, thoughts Markle versus Mail lying in documents. Oh, do you have any thoughts on this one, Daniel, on that case? Had you followed that at all?
I did at some point, not currently.
Very fair point, because I have covered many cases on this channel, and if somebody were to ask me what I covered like 3 months ago, I probably would struggle and need to look back at whatever notes I had from that time, because I forget these things all the time.
And I assume this is the private letter to her father case. I think it's talking about.
I think so.
No clarification. I think it must be that. In which case, I sort of, well, a friend asked me, "What do you think?" and I told them, and I was right. So these issues of privacy are taken quite seriously. So
more in favor of enforcing privacy.
Yes,
makes sense. Makes sense. Okay, from what I've understood so far about the UK system, that would make sense. Alicia Davis says, "Why do you think the verdict is taking so long?" They're going through it, and they want to feel like everything is right on multiple levels, logically, emotionally, metaphysically, perhaps.
I would disagree with the characterization of so long there. I would.
Yeah,
I know the panel.
I was ready in 5 minutes. It's like, how long does it take me to fill out the forms?
I know the panel has given you certain expectations, but I don't view this as so long.
I can always be wrong. I'm just saying I've had much more complicated cases that have come back faster.
But how long was the trial in those cases?
2.5 weeks, usually, give or take.
Okay. So multiply it by 3. Are we there yet? For how long it took?
We're getting close. If it's not back tomorrow, there's something going on back there.
Yeah. No, I would agree. I would definitely agree. Another possibly complicating factor here is the fact that they didn't have anybody create any kind of a timeline for them, a visible timeline, so that they could line things up very properly. So they may also just be sitting back there and saying, what the heck happened in this case? Let's try to compile all of our notes so that we can figure out the basic timeline of.
I think Amber's team did that intentionally.
Oh,
but I also think we're past that based upon the question they asked.
Well, but that may be what they did on Friday, though. That may be,
true. That's
you know,
true.
and then the first hour or two today, that may be where they ended, and then they're like, okay, let's start at question 1 now. Here we go.
The year is 2012.
Let's go back to 2013. Isn't that the
well?
joke?
Technically, we have to go back
the year
to
is 2012. And a young unknown blonde woman meets
2009.
Johnny Depp.
2009 in a rum diary.
Yep.
Let's begin.
The year of 1970, Johnny Depp was born. Let's start with that.
To answer the super chat on screen, that's 404B. All day.
Yes. That, and I think the hearsay stipulation also, or not the hearsay stipulation, but the stipulation for other people's recordings with other voices. It appears to be that the case that the parties agreed that they would allow secret recordings of the two of them, so long as it was only the two of them.
Individuals.
Yeah. Exactly.
And that's just to avoid the fact that California is, and Florida for that matter, is one-party consent state, or is a two-party consent state, which is a ludicrous rule in my mind. It only protects people who are doing the wrong thing. But That is what it is.
I don't know about that.
And the police, but we repeat ourselves.
Come at me with my recordings, man. Ask for my consent.
Wow. No, please don't come at with me.
Nothing debate though. I've had cases that have gone entirely one way because of a covert recording, which by default, you'll need the judge's permission to bring in. But you get one party saying this is everything that happened, and then you get a recording, and you think, wow, totally reverse, and it decides the case.
Two-party consent laws, in my personal opinion, only protect people who are doing the wrong thing.
This just sounds to me of you'd let us in to search your house if you weren't doing anything wrong. I don't agree.
If I'm party to the conversation with you, why can't
I'm part of a
record it
conversation in a specific way that I'm
record
not
of
on
it?
alert for. If I don't know that there's a freaking recording being made,
Just walk around presuming somebody's recording you. It's the 21st century.
now wait a minute.
That's the view that I take.
Lives. You want us to live our lives as if we're being recorded. This sounds like a hell state.
We might
kind of
that
view
might
that
be
I
a
take.
conversation for another time. I don't want to hijack the stream.
Oh no, I mean, we are here for a long time today, so we've got time. But let's get to the next super chat.
Let's play a
Josh
party
wants to
game.
know-
Anyone want to play Trivial Pursuit or something like that?
Well, we could definitely start getting into that.
When do some jackpot games, that'd be fun. Play murder
when
mystery
we eventually
games.
run out of topics, we can definitely start playing some games on these streams.
I'll destroy you all at Monopoly.
Excellent. No, I'm in. Let's go.
Sounds great.
I'm starting to feel like we're all the lawyers of the case, and we're in the advocate's room right now, like buying time while the jury's out.
Yeah, just chilling. Just chilling.
Yeah, exactly.
I've played bridge in one of the lawyers' lounges.
Yeah, but I also know that the folks in the chat really want us to go over two things before we do any of that. Australia audio. I know that, guys. I see it. Australia audio and Jennifer Howell's letter.
Oh,
those
okay.
two.
So I should step out before those, right?
We can't go over those. We can't go over. Alita told me we can't go over those until I hit 100,000 subscribers.
Oh, there you go.
Is that what she said?
You're almost there. You're almost there, Kurt. So we've got to get you there. What you need another 5,000 subscribers.
5,000 subscribers. Yeah.
Let's do it. Let's get him there. Kurt is linked in the description below, just like everybody else here. Guys, if you haven't already subscribed to his channel, be sure to subscribe. Let's get him to 100,000. Let's get yet another lawyer in LawTube up to a silver play button. Let's do it.
Yay. Thank you.
You'll be pleased to know that was the first thing I did was subscribe to you all when I got your link.
Thank you.
Perfect.
Nice
Thank you. And likewise, Sarah S. Nassif says, "Hey guys, are you reviewing the letter to Whitney and the audios from Australia? That would be fun to watch." Yes. I think that is something that will be happening tomorrow for sure. Especially if there's no verdict at the end of today. I have a feeling we're not going to get one. For some reason, I have that feeling right now.
That's a gut reaction. We still got hours left.
Oh, I know. We've got about 2 hours left until they get released. So, but even if not, I still was planning on going over those. Even if we already got a verdict, I was still planning on going over this because I know a lot of people want to get our reactions to those. Yes. So that's Sarah Nassif. Let me just make sure that I have these that are here. Okay. Gil Gordon says, Dan, it's Pomeroy's time. Good luck, U.S. working that out. Clue, Rumpole. I'm not sure I understand what that means.
I think it's a code.
Pomeroy, it's time for a drink.
Oh.
Yeah.
Okay. I can work with that. Certainly.
Well, it is about 8 p.m. here, so that's probably explaining.
That makes sense. Jose Martinez says, any thoughts on the rumor that the ACLU is suing Johnny Depp? Would they have a case? Weren't they the ones that co-authored the idiotic piece? It's not about any kind of specific liability. All they are doing is trying to get costs and fees associated with their massive document production.
Costs and fees. They're trying to inflict pain.
Yeah.
Feel as that as you will.
Yeah.
We seem to be short $3.5 million. So $3.5 million in production costs.
Well, they're not short that from Johnny. They're short that from Amber, and good luck getting that now.
No, it's been donated. The
general counsel said it's all the same to them. So I consider the ACLU flush.
Yep.
Yeah.
Van Endra says, question, Hogue might be the best for this. Have you heard of Valparaiso Law School?
Sure.
Located in Northwest Indiana, went defunct in 2020. New York Times wrote an article on them in 2016. ABA censured them in the same year. I may have heard about this. I remember around this time, there were a few law schools that were kind of coming under fire for the fact that they were still unable to get their graduates into jobs. And so there were a number of lawsuits and whatnot.
The ABA and their accreditation process is a strangely political one that I won't dive too deeply into, but there are a lot of moving parts because you are really out of luck if your law school loses ABA accreditation. And they have, there's a lot of stuff that there is, I'm not going to use the word corruption. I will say there are political pressures placed on schools and institutions of all sizes. And those have interesting impacts. But yeah, there was a lot of stories about various law schools and universities during especially that period of time that were defrauding their students for any number of reasons, whether that's the education itself or the job placement, et cetera. So I know Valpo, but yeah, it's interesting. New York Times likes an article like that, don't they?
They do. They definitely do. RJ Esposito says, question, I teach English in Italy and I have studied legal English for years. Where can I read more on the language used in the various categories of law? 1 out of 2. And then I'll read 2 out of 2.
I love this question, but I don't know the answer.
So far, I'm familiar with tax law and language used in contracts. All my lawyer students have all said your channels have been super useful. Wow. Thank you so much. That's awesome. That's super cool.
Well, the legal language as such is falling more and more out of favor, and I think for the best. You know, at least when I was in law school, and I think most of us in law school were taught to write more in more common English. So it's not as bad as it used to be with devise and bequeath and trying to remember the difference between the two. And
I still use therein a lot, and therewith all my variations on there. Heretofore, I use a lot of recitals. I don't know how else you're supposed to say that. So yeah, obviously contracts a little bit easier. You can go find terms of service wherever you want. Certainly some of the tech companies try to do plain English stuff. I think you can actually have a pretty good class on why that's sometimes a problem. You try to get a little bit to, hey, fellow kids, and you lose some of the clarity as to what you're trying to protect against in the legal document. Yeah. So I have my thoughts on that. I could talk for probably 10 hours on plain English versus legalese.
Oh, we should definitely have that as a topic.
We'll save it for verdict watch day 3. Rick talks about plain English contract writing. Come on, come all.
Basically, all the legal language basically just boils down to it being basically memes, kind of at the end of the day. Very, very slow, very persistent, slow to change memes. Basically, someone once said it in a court case or a court document, and it worked. And then other people were like, cool. Ooh, shiny. And they took it and it kept working, and it kept working, and now we're stuck with it forever.
Precision is important. I will die on that hill.
Yeah.
Precision is important, but also a lot of lawyers, and I don't know if this is the same in the UK, Daniel, but at least in the United States, it seems like lawyers also oftentimes will write because they've seen other lawyers write in the similar way, and they want it to look distinguished. So you'll see pleadings that are filed where it begins like the party is described hereinafter as plaintiff and defendant, and and it's just like it's overly formal. Where you really could just strip a lot of that down, have it be super clear so that everybody understands exactly what you're saying. It doesn't have to be too pompous. You just write what is intended and what is simple and what is clear, and then you're good. But for some reason, it's like lawyers think like I have to write these things that are super formalized.
Absolutely. You'll take whereas from my cold dead hands, Alita.
Well, sometimes there's only 1 or 2 words that will really convey your true meaning, and those have to go in.
Yes.
And they might sound unnecessarily specific, but only those will do. But otherwise, yes, just plain English and just say what you mean what you say. And for studying legal English, I would say read some modern judgments, and probably the higher the court, the better. Read some Supreme Court judgments, because whilst they might be very well drafted judgments. They are written in plain language for people to understand.
Yeah, for
I
the
think
most
that's
part.
probably the best idea.
And if you want coverage of Supreme Court opinions, uncivil law is the best place to have them.
There you go. There you go. So yeah, RJ Esposito, thank you so much for your questions. I hope that we were able to answer those basically.
No, Supreme Court cases, contracts, terms of service.
Yeah,
I think those work. I think those work.
Yeah.
Some Supreme Court justices are better at writing than others. You will quickly learn that, definitely.
Also true. Also true. Lori Lanny says, Ian, wasn't this gun law just a first reading unbeknownst to Trudeau? Oh, this was, earlier when he was commenting on that. I'm so sorry that I didn't get this in front of him. It could be, I have not been tracking it. So
he does. I know he has a 3-hour video where he goes over it. So you can definitely check in with him.
Yes, I believe so. Akisu Emi says, can you guys tell us what to expect on your channels as we shift out of JD/AH trial? Well, I will be... so I'm probably going to be monitoring actually that other Johnny Depp case that I referenced where Camille is his attorney of record in Los Angeles that was filed by somebody else that was on set with him, says that Johnny Depp punched him. I have no idea if that's going to go away after this. Who knows? But I'm interested in at least tracking it. So there's that. Then also Marilyn Manson is a very interesting topic to me, partly because he's been coming up so much in this trial and partly because I was already kind of curious about that case anyway. Similar sort of defamation issues there. And just very interesting stuff. How about
and
you
in
guys?
January on my channel, we'll be covering the Daybell trial out of Idaho with the cult murder case, the bar case. So that'll be interesting.
Well, I'm going to keep doing what I do, which is business and law topics, primarily through pop culture, video games, technology, and more. You've already seen that. We're going to keep doing headlines because people seem to like that. And we're going to have some fine friends over there, I think, from time to time, talking about headlines, talking about games. I'm working on some stuff with some people. So we're not going anywhere. Johnny Depp and Amber Heard is not our only bailiwick, if I can use fun words. So no, I'm super excited for virtual legality and doing more of how I grew the channel to begin with.
Absolutely. And John does not yet have a YouTube channel, but I suspect that maybe he'll have one at some point soon.
I've reached out to folks to try and figure out what would be a good way to start. What is a decent case? I got some ideas, and if anyone would like to reach out to me on the Twitter, let me know, and I'm going to try and start making it happen.
All right.
Well, the best way to start is to just start.
Yep. That's what everybody says.
My first videos were about garden law and tree law because we went into lockdown and everybody's arguing about whether you can cut the branches off your neighbor's garden because everyone spent more time in the garden, suddenly realized how annoying it is that their neighbor's trees are overgrowing their garden. Literally, this is what people were debating.
But again, you're talking about property. That's the most ancient law that's ever existed.
Well, there you go. There's your first topic.
Go look at any of our first videos if you're worried about production values or whatnot.
Oh,
it's all baling wire and gum holding these things together.
Mm-hmm.
Fair enough. But yeah, if anybody in the chat right now has a suggestion, feel free to reach out to me. I'm looking for what I want to start with.
Yes. And Daniel, what kinds of topics are you looking at on your channel?
So aside from trees, I haven't done trees for a while. No, I do some of the headlines as well, big ones, small ones. People do like the headlines. They do like to they like to hear how the courts handle people that are breaking the law, acting badly, and things like that. But also some of the really in-depth cases that might affect privacy and everybody's lives. And so there's one case in particular about these Ring doorbell cameras or Nest doorbell cameras recording, and whether it's invading the privacy of people walking past and recording and all this sort of stuff. There was an in-depth judgment. Someone was using the footage to harass somebody next door. So it was a long-winded judgment. That's on my channel if you want to watch it. But
really interesting.
That's
really do affect a lot of people.
I'm excited to learn about the UK law from you and from your channel. That's going to be so cool because now I have no excuse to be like, well, I don't know anything about UK law.
Well, I was going to say in the U.S. that's a no-brainer because there's no right to privacy in public spaces, but that would be interesting from a UK perspective.
Yeah. So very, very briefly, it was if you are surveilling areas outside of your property into someone else's. So picture you've got your camera permanently trained on a neighbor's garden. So every time they come in and out, and that's suddenly quite invasive. And so there's a fine line, literally a defense line. What you can.
Well, in a neighbor's garden, at least in the U.S., you'd probably have the same decision because it's not really in public at that point. You're still within the confines of the home.
Absolutely right.
So, yeah.
I love this super chat.
Yeah,
seeing each other over the tree branches, and it's absolutely right. I mean, we've had cases where there's a strip of land, probably no wider than that, front to back of the property, and both sides have been arguing about it and spent over £100,000 in fees arguing over it. And
stranger things have happened in the U.S. too.
Yeah,
absolutely. So we've got a couple super chats here that are for Ian. He's not here. I'll save them and see if maybe he'll come back, and if not, I'll try to screenshot them later for when he does eventually come back to the channel. But Wendy's Cafe says, Ian, have you had a chance to check out the Yaniv guilty verdict from the other day? Thoughts on that nasty person? And then Moomix Gaming says, for Runkle, what province do you practice in? Much love from Nova Scotia. So I will save those for him when he hopefully comes back. And if not, then I'll try to save them for eventually another live stream. Be rational and nice when in this global sandbox. That's an interesting name. I like it. Says, question, any paper/websites that Dan Wooten works on, past, present, or future, should be considered fiction. He associates with frauds and crooks. All his authoring should be wrapped fish or lighting bird cages. Ian Hurton Albertan. Well, that's an opinion.
I'm trying to decide whether this person like snuck through a statement one with the Q colon and the question mark. Because I feel like Ron Burgundy.
I do feel like fiction. I'm Ron Burgundy.
No, I like it. I don't know this person from Adam. I know what y'all have told me about the sun, etc. It's interesting. I've certainly read a lot of headlines from some British outlets, and some of them are very vociferous in some very interesting stances.
Yep, for sure. Old Dog says, I'm a U.S. veteran and marksman. I believe in the right to bear arms, but mass shootings must end. How do we fix this? Oh, that is one heck of a question, especially in the United States where we do have a strong Second Amendment. And that's probably not one that we're going to be able to get into on this particular channel at this particular time. Mostly because I'm certainly not a Second Amendment expert by any means. I basically kind of glean what I get from talking to other folks, but it's certainly not a focus of my channel personally. So, what? Yeah, I know. Mr. Bites happens to be here. He says, I'm a veteran. I said, yeah, I know.
I'll respect that, but I do have a few opinions.
Okay, yeah, you guys can share your opinions briefly without getting too far into the weeds, I suppose.
No, I don't need to do that. It's your show.
Well, no, I mean it's fine. We can go ahead.
I think that the issue when it comes specifically to mass shootings is one, recognizing that those are the exception by far and not the rule. And the solution is not disarming the populace. The solution is, in my opinion, better mental health and better tools for the police to potentially incapacitate individuals that might engage in that behavior in a clear way. This last tragedy could have been dealt with in so many ways. I think there were 2 separate 911 calls. There was posting on Facebook, and nobody did anything. Even after he crashed his truck into the school, and started shooting into the building. Nobody did anything. If we have a reasonably well-armed police force and a reasonably well-armed citizenry, I guarantee you there are probably parents that wish that they had a gun and they would have gone to that
There were
school
parents
and
who
tried
wanted to
stop
leap.
this.
There were parents who did leap over the gates.
Yeah.
The police were arresting and handcuffing the parents rather than going inside. My contempt for the police in this situation is pretty high.
And again, it's not all cops are bad. It's not defund the police. This was a failure of their raison d'etre.
Yeah. Fancy term, but I love it.
All right.
That's my opinion.
Cool. All right. Glass half full says, question, I would like to know if a black belt barrister is full-time on YouTube, and maybe I can get the rest of this question here. And his story. You skipped him, Alita. Welcome, Runkle. Please discuss CDN robes. I'm sorry that Runkle's not here again now that we've finally round robined to this. But I didn't want to put Daniel on the spot. So I wasn't sure if he wanted to answer, but I suppose I should have asked.
No problem. No, not full time on YouTube. I would consider it. I enjoy it. I enjoy mostly getting the feedback of people that it's helped and how many people watch and so on. It's growing, but no, not full time. I still practice. I'm still in the court sort of semi regularly. I also lecture on the bar course. I also run my businesses because my background, my story, if you will, is I've been in business for some 20 years or so before becoming a lawyer. One of my businesses was already law. So I became a lawyer after starting the firm, if that makes sense. So, or the chambers. So I do it all. I do what I enjoy, and I wouldn't stop doing any of that because I enjoy doing all of that. And as I've started YouTube, I love doing YouTube because it helps to reach so many people. I know it sounds cliche, but I really enjoy the messages that come in. Just yesterday, some guy I've never met said, "Thank you so much for the videos. In 20 minutes, I've resolved a problem that's been going on for ages because of 2 or 3 of your videos." And that's just fantastic for me. So I would never stop doing it. Full time, I would never stop doing everything else. I would do as much as I can, but I would never stop doing the other stuff as well.
Makes sense. Patty says, how are judgments collected and what time frame are we looking at if there comes a judgment against either Depp or Heard?
Most aren't is the short answer.
Most are not.
Unfortunately, that is correct. As far as a timing is concerned, if there is money that she could give, I'm not actually sure. I don't know.
Check.
Yeah, that's something to look into.
I mean, in theory, you can garnish wages. I don't know because she's a citizen of California. I don't know what their rules are, but like for instance, in Florida, you can't go after somebody's house. You can't go after their first 2 cars. It's very, very difficult to actually get a sheriff's attachment and take things away to satisfy it.
Very disappointing. Go to their house and take their stuff is my preferred option.
I agree with you, Kurt. Unfortunately, it's just not the way that it works.
Very sad.
Crown V says, Hope, will you be reviewing the audio from Australia as well as Hal's declaration today on live? I don't know about today, but we will for sure be doing it tomorrow, I think. I mean, assuming that Rick is going to be here. I can't promise that he's going to be here, but I will.
We're going to get this stuff done. But yeah, we've got we've got a guest here today. We've got a lot of fun things to talk about. But it's entirely up to the host. You can direct this question to Alita in the future.
Dapper Dave 2021 says she didn't give to charity. That is a misnomer. JD lawyer gave initial money to charity from divorce and she got really upset. Musk gave most of the money. That's definitely what it looks like from the testimony.
To be clear, JD gave her money to the charity without giving it to her first. I think that's important. JD tried to claim credit for that in some ways. It's like, yes, okay. So you don't trust her to actually donate to the places. That's fine. But it's her money. You agreed to give her $7 million. You gave her 6.8 because you spent $200,000 giving to charity.
Yeah, but the flip side, Hogue, honestly, is he was literally told, stop just giving it directly to the charity, give it to her.
I know, but JD doesn't, and that's fine, but I don't give Johnny Depp credit for donating to the charity.
No, I'm not giving him credit. I'm
I think some people read it that way.
Okay. I won't disagree.
Nick Edgington says, would a private prosecution of her be possible?
For what?
For what?
I'm not sure.
And where?
Yeah.
The only
also a good question. As we are talking about multiple jurisdictions here.
The only places that I'm thinking, because I know California has a private attorney general for tax claims.
And also, I think they're also for like Americans with Disability Act claims, or the California equivalent.
Yeah.
It'll just be employers. It'll be employers from around the country for lost wages coming from watching Legalbytes.
Oh,
come on now.
Oh no. Oh no. Don Hinton says, do the jurors get free lunch? Do they lose that if they return a judgment before lunch? I think yes to both of those.
God help me if the lunch is driving the verdict process.
Yeah, but honest to God, it does happen where a jury will literally wait for their free lunch because they're paid so little and then return the verdict.
Sure. Yeah.
Just circling back to the donation / pledge issue, you might see, I don't think I can put it up on screen, but there's an additional slide I've added.
Okay.
Which is a single screenshot, very short one. That's the one. So this is taken from Amber's, I think it's a third witness statement in the UK. I don't know if it's big enough on screen, if this was the right one. Is this the right? Hang on.
I think that there is a paragraph 5 or 6 that talks about her actually doing the donation.
Yeah, so this was the first bit of that. So
yeah, this was donated, which is pretty strong.
Yes. So that was that.
And that is perjury.
Because donate and pledge are the same thing.
No, not in any accountant's mind.
Not in anybody's mind.
Yeah.
Apparently the ACLU's mind.
It's when they're trying to defend their ambassador. Believe me, the ACLU can't build any buildings with its pledges.
So that was clear enough to me.
Can't build a building with bricks that haven't been laid yet.
Yeah, because I remember this question came up a lot earlier, and it took me a while to find. She's got about 7 statements, but there you go.
But I think she did represent to the UK court, if I'm not mistaken, that she actually did donate the funds, not just pledge.
That's what she said.
Yeah. Yeah, I believe so.
That's very much what she said.
Yeah. So, yeah.
And now we're 6 years later, and they still don't have the funds.
Was Johnny sue me, even though I had the money for 13 months?
Yep, that's exactly the closing, Kurt.
Yep.
I'm omniscient. I knew he was going to sue me 13 months in the future.
Apparently.
Well, all right. Unless, sorry, was there another page that you wanted to show from that, or another portion?
No, that was the clearest one for me. That she made a statement that she donated the entire amount. So that is unambiguous to me. However, whatever she wants to call it. But exactly. The question was raised as to the comparison between the two, and I think she would say the same thing. In her mind, it's the same thing. So what she would say is, well, what I meant is that I've intended to give this amount across, which obviously doesn't have the same meaning for most people.
Can I ask real quick, what is the process by which, I don't think it's going to go anywhere, but if it were to, what would be the process? Because she made diametrically opposed statements in 2 courts of record, both in common law jurisdictions. I'd imagine that would be considered.
Strictly speaking, there'd be 2 routes for bringing any sort of prosecution, either by the state or personally, because any individual could lay an information to the magistrate to start a prosecution, because this is it's a serious offence. But as you say, it's probably not going to happen.
Okay.
Yeah. Well, Here's another question. Is everyone catching up on sleep now?
Well,
I drove somebody to the airport at 4 a.m., which is why I've been in and out, just losing it.
Headlines and Hangout, 7 a.m. Eastern.
There you go. R. Ross, thank you so much for this generous super chat. Says, verdict on Michael Sussman prosecution. Any commentary?
I will note that one of the juror statements looks suspiciously like jury nullification.
Okay. I know literally nothing about this case.
I read a few articles while I was not with you all, and I agree with Kurt's assessments.
Yeah.
Okay.
This is like Clinton's lawyer, right? One of them?
Yes.
And so he had given, so he was being charged with lying to the FBI, which, everyone loves, 18 U.S.C. 1001. And one of the jurors was quoted, I'm going to paraphrase this, as saying something like, I can't believe he was charged. There's more important things in this world than lying to the FBI, which sounds suspiciously like jury nullification, but yes. So,
okay.
Yeah.
Cool. Shikhar Singh says, when are the results going to be announced? Any ideas? We don't know.
5 minutes ago. You missed it.
We have a crystal ball. We don't have a
You missed it. We've already discussed the entire thing, man. We're on to other topics. Different times.
Mr. DNA 1987 says, if she claims ineffective counsel, how are they able to defend themselves without breaking attorney-client privilege?
They can break attorney-client privilege, as a matter of fact.
Absolutely.
Because that is an affirmative way to do that. That's a perfect example of how to waive your attorney-client privilege is by making that actual relationship an issue in the courts.
Same here.
Okay.
Same in the UK. Yeah. So you write an advice for someone, and then they try to sue you over the advice. The whole advice can go in as part of the evidence.
Yep. We're not that dumb.
HRAX, thank you for the generous super chat. Says, question: how can a defendant have a burden of proof? Isn't defendant always innocent until proven guilty? It depends on whether they have either certain burden shifting provisions in the law, depending on what law that we're talking about.
Affirmative defense.
Or an affirmative defense. Exactly. So there are basic defenses, and then there are affirmative defenses. And so if you have, a general defense would be, if Johnny Depp sues Amber Heard for defamation and she says it wasn't a lie, that's a general kind of defense. She doesn't have to prove anything necessarily. She doesn't have any burden. The burden is all on Johnny to prove that. But if she has an affirmative defense to say the anti-SLAPP claims, then she puts on I believe that's an affirmative defense, is it not? I think so.
Anti-SLAPP is actually it's a counterclaim. Anti-SLAPP is a counterclaim.
But she carries a burden.
An affirmative defense is not actual malice. That is an affirmative defense.
Yeah.
Okay. So there you go. Yeah. So there are ways in which you shift the burden, either by asserting an affirmative defense or by meeting a certain threshold of evidence, depending on what law we're talking under. And there are ways in which it shifts back and forth. For example, actually, with regard to anti-SLAPP claims, in California, basically, if you bring an anti-SLAPP defense onto the opposing side, you only have to meet a certain threshold level for your claims for the anti-SLAPP issues, and then the burden shifts to the other side to rebut those claims. So it's like a tennis match that goes back and forth based on how much you've shown. Then they have to show a certain amount. Then you have to show a certain amount, and it kind of just goes back and forth like that. So that's some ways in which that those things can happen.
But primarily here, her burden of proof comes from her countersuit.
Yes.
And also it's worth noting that innocence and guilt isn't actually a thing in civil litigation. We're talking about liability.
Yeah. And even more simply, just to use the criminal example, if the argument is you shot me and my argument is no, I didn't, then that's a pure defense. Right. And you have to prove that I did. If my argument is I did in self-defense, then there is a little bit of a burden. There is a burden shift on me where at that point the state has to prove that I didn't do it in that. Criminal is probably not the greatest example, but that's the one that came to mind.
No, that's okay. And every jurisdiction is going to be different on that. So you're going to have different burden shifting all over the place.
There's some other ones like that. Yeah. So, okay. Because,
insanity.
Insanity is, so there's I didn't do it, which is just a straight defense. Then we have excuse, which is relatively rare. But this would be like I'm authorized by some other law is legal excuse. So this would be, for example, the police in terms of like,
use of force
participating in a drug buy, as part of their thing. It's like, well, it's legally excused because they have legal authorization. Then there is other kinds of what's in the call other than excuse. It's shit. What is justification in the category of? Along with duress, what's in the category of? Anyways, there's other things other than excuse where, like, for example, you've got duress. I was made to do it. Justification. I had a really good reason for doing it. Necessity. I had a really good reason for doing it. Yeah. It was really good that I did that thing. Yeah.
All right. Majestic Donuts 003 says, new to law. So is Supreme Court different? I know you can't appeal after the case, but can all cases go there? Is it different in UK or Canada? So unfortunately, we don't have Runkle here to answer for Canada, but we do have Daniel here who can attest to the UK system. I can tell you a little bit about the Supreme Court, even though Kurt is the resident Supreme Court guy here. The guy who covers the Supreme Court, but basically you have in the United States, you have a first right of appeal. So basically to the middle of it, there's 3 levels, generally speaking, that we're talking. Leave it at that for right now. I can add some complexity to it in a minute. But yeah, basically trial court, appellate court, Supreme Court. Let's just say we're in federal court system right now to keep things a little bit simple.
New York will do it backwards.
Yes.
No,
New York
shut up, Law and Order.
And West Virginia doesn't have an intermediate appellate court, so hey.
So with those exceptions out of the way, generally speaking, trial court, appellate court, Supreme Court. So you can appeal to the appellate court, and then you have to request to have your case heard at the Supreme Court. They can decide whether or not to take your case, and usually it's going to be if it is something that is a unique question of law, either because there are multiple jurisdictions that are coming out in different ways on the same topic. So, for example, when they took up the Obergefell case, I believe that was one of those cases where it was multiple appellate jurisdictions were coming out in different ways, and it was causing all kinds of problems between the states. So the Supreme Court said, you know what, we're going to take this one, we're going to decide on it, and then just have everybody follow the same rule here. Or if there is a federal issue that is implied here, that is particularly important. So there are various reasons why the Supreme Court will take it, but typically it has to be something that is unique and that kind of almost like requires the Supreme Court to step in to answer that question. I don't know if you guys would add
the U.S.
anything
Supreme
to that.
Court takes about 0.7% of the cases, so it's about 1 out of every 130 cases, give or take, they take.
And it's usually when I guess it's 13 circuit courts and the federal circuit. So when
Federal
the circuits
13.
Is federal circuit 13? Did I get that?
Because there's 11 numbered ones in DC and federal. That's 13, right?
So when the circuits disagree is a very, very strong indicator of when the Supreme Court's going to step in to try and maintain uniformity of the laws. Outside of that, it's going to be really tough for you to get there outside of some sort of original jurisdiction, which almost never happens. And they always take a certain number of death penalty cases.
Mm-hmm. Yeah. So circuit splits are your most common, and then like cases of particular importance.
Yeah.
But you're only talking about, because the Supreme Court's kind of been on the decline recently. It used to be more like 130 cases a year. Now I think it's more like 70 cases a year. So taking like half the cases they used to for whatever reason.
Yeah, I think last term it was like 70, 78, 82, somewhere in that ballpark.
The Supreme Court used to have to take a lot more cases. When did they change it? Like 80s or 90s? They used to have to take a lot more cases by mandatory review, but they
was
changed
that
that.
that was the Judicial Reform Act of, God, the date's going to escape me, but you're right, Kurt.
Yeah.
They basically relieved a lot of original jurisdiction from the Supreme
and
Court.
mandatory appeal court cases, because there is a difference. As long as we're dealing with the technical, there's a difference between the Supreme Court taking a case on certiorari and a Supreme Court taking a case on appeal, because occasionally the Supreme Court has to take a case when it's appealed. So an example of that would be a redistricting case. So if you have a redistricting case in federal law, it's decided by a 3-judge district court, which then has an automatic appellate right to the U.S. Supreme Court, as opposed to a normal case, which is decided by a 1-member district court, then a 3-member appellate court, which is then certiorari to the U.S. Supreme Court by discretion. Are we confusing everyone yet? I can keep going.
I'm good.
All right.
How about in the UK?
So we have a permission stage. So assuming you get through the permission stage and you have the appeal and the decision is against you, then you can appeal that decision and go further. But if permission to appeal is refused, the default position is there is no chance to overturn that. So if there's no permission, that's generally the end of it, which is kind of harsh, but that's the way that it is. So only if you've been given permission to appeal and it's been heard, then you can appeal again and get all the way to the Supreme Court. But ultimately, you need permission first, and that's the problem. And that's the problem with the UK case, because permission to appeal was refused. So strictly speaking, there's nowhere to go with that.
And that's sort of interesting because and everyone can correct me if I'm mistaken, but I think in most states, at least at the state level, your first right of appeal is mandatory, but a second right of appeal usually is not.
I believe that's correct. Under the federal law, there is one right of appeal that's required, which is incidentally why in West Virginia, because they don't have an intermediate appellate court for some reason, every case that's appealed gets heard by the West Virginia Supreme Court, because they have to, because there's no one else to do it.
Yeah, but there were like 20 people living in West Virginia.
It's not that bad. Wyoming has fewer people, but you know.
That was a joke.
Okay. Okay. Sorry for killing the joke.
It's okay. It happens. It happens. Next question is, Represent says, all is there legal aid in the US? The UK needs more pounds. We do have legal aid.
There's legal aid.
There's legal aid. It's extraordinarily underfunded compared to the need, but yes, there is legal aid.
It's the same here.
All right. Next one. Raggy Wright says, Metro article says that the judge can choose to accept a majority verdict in JD/AH case to avoid hung jury. Is this true?
Oh,
Not
that's
for many
your
of the Virginia statutes I've seen. I don't. We need Rob to roll in here, or maybe Kurt.
I don't think so.
The statute says unanimous in black and white.
Yeah.
It doesn't refer to any other subsections. There is no other, notwithstanding the foregoings.
Yeah.
So you never know what equitable powers the court may have, because
Metro may be full of it,
but Metro might be wrong.
If it is, it's news to me.
Gwen says, claim/counterclaim. Can a jury reach a verdict on one but hang on the other? If so,
Absolutely.
does the two claims must be retried with another trial, or does the one reach verdict stand?
Technically, in the discretion of the court, practically, the one verdict's going to stand.
Well, I mean, they're talking about
the one verdict.
They're talking about the claim in one and the counterclaim, so there's no discretion there. If you give Johnny Depp the win on the one,
yeah, if you give him the win on his primary claim, and you hang on the second one, then they could choose to retry the second claim, but the first one is a verdict of a jury.
I think so.
Yeah.
Right, Kurt?
Yep.
All righty. Utah Valley Schnauzers Outwood says, Hogue, Brandon Sanderson fan?
Who isn't?
Who is Brandon Sanderson?
He's an author. He's a fantasy author.
Okay.
As a matter of fact, if you're interested in board games, there's a version of Call to Adventure, which is one of my favorite board games about telling a story, which you get to make fun faces at a dinner table or whatever that you're playing the game with. And they have one that's just for Stormlight Archive. Check it out.
Paula Duke says, Runkle of the Bailey, first time I saw a Canadian who didn't share about hockey in a live stream. Ha 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 ha. I'll say that one for
you. Clearly
himself.
haven't watched all of Ian's streaming with us.
He has made some references. He has indeed. Kirsty Mix says, sorry if silly question, but can the judge in the Johnny and Amber case themselves do outside research and ghost on social media, etc.? Y'all are amazing. Absolutely. Sure. Because she is not a finder of fact. So it doesn't matter what she does in terms of the information that is out there about this case. The question is whether or not she wants to, because sometimes you can start to come across criticisms of your decisions as a judge. I know that, you know, in the Rittenhouse case, Judge Schrader started to come across some criticisms of him yelling in the court. And so I think that started to sort of mess with his head a little bit. So I would always advise, if a judge were to ever ask me for my advice, that would never happen. But like,
I don't know what you're talking about. I wake up, I say, you know what? There's comments to read today. Let's read all the comments because it's a good way to start your mental health day. Is this not what I'm supposed to be doing? I thought this is what I was supposed to be doing.
I know. So that's more of the issue there. But she is absolutely allowed to go and seek that out if she would want to.
I refuse to believe there's a ton of negative Judge A stuff out there. Well, you know what? I don't refuse to believe it on the internet, but anything is possible. It's hard to complain about Judge A's performance, I think.
I did see someone had tweeted something out about her being a misogynist female judge or something for not letting in certain evidence or something. So,
wasn't
you know,
an article was written about that, like that she was, wasn't that one of the headlines, Richard?
Yeah.
I wasn't on my channel.
About her being misogynist because, you can't get a break from these people.
I don't know what to do with people. I shouldn't even have said the sentence because I know how the internet operates.
Of course.
But it's just remarkable because she didn't judge Ito it. She didn't make any like obviously crazy decisions. Yes, there are some I would disagree with, but none that I even think rise to the level of mistake. And whatever, internet, you do you.
Can I just say, all right, I don't love it, but does this conflict in any way with Rule 201 on judicial notice? Like it just,
John, help walk us through it.
Yeah.
Help. What are you thinking? Help us walk through the thought.
All right. So what I'm thinking is, so 201 is judicial notice of facts that just exist. So the law of gravity.
The court can say, I understand that gravity exists. You don't have to prove it.
And they can instruct the jury on that.
Okay. Yes.
The fact that it is constrained, to me, you know, if you say something about something, everything else is excluded. I have a problem, and I think that there is a motion that one could make. I don't think it's applicable in this case. That if they are in the case of, you know, the judges getting personally accused of things, I think that there is a realm in which the judge is not allowed to take notice of things that the jury is not allowed to unless it's officially noticed by the litigants. That's sort of the thrust of my thought. I don't know if I explained that well.
But surely Judge A doesn't have to prevent herself from being on the internet or watching anything else. She just can't use it in the judicial setting. And we trust judges more than we trust juries with that.
Right.
Sure. I just, I don't know. I think it's a potential point of impeachment of the judge in the appearance of impropriety. If it's used. I don't think she did it here, and that's not what I'm trying to say. But I think that the fact that we have such a specific Rule 201 on judicial notice would suggest that the judiciary in a jury trial is not supposed to take anything else into account. And I don't know if that's followed appropriately all the time.
All right. Next one. Natasha Albert says, is the jury in today? Any updates? The jury is in today. So far, they've asked one question, and that's about all we know.
They're talking about it in a sealed room right now as we speak.
They are.
I think it's very unlikely we're going to see them today.
You still got an hour. You got an hour plus left.
Yeah, but
hour and 15 could happen. It could happen.
And they're technically allowed to extend their day. The judge said
they
that
are.
Could go
it's
later.
worth noting they're not ejected from the courthouse at 5.
This is true.
But they'd have to.
Can
be
I ask out of
close to a verdict.
curiosity, just again reading the tea leaves, if they do extend the day, what would you read from that?
I think they're close. I think they think they're close if they extend.
Yeah. But my guess is it's probably not going to extend today, and it's probably going to go into tomorrow, and maybe tomorrow we could see an extension.
It's 3:45 on the East Coast. It's like, if they turn it in now, they can be done by 5. So that'd be nice, right?
I don't know. My Thursday's sounding pretty good. We'll see.
Yeah.
They could come up with it like 2 seconds after we say any of that, by the way. I mean, we get a notice. We get a notice in 60 seconds from now.
That's also true. How late can the jury deliberate each day? They can technically go as late as they want, kind of, sort of, within reason.
I would go so late. Keys to the courthouse. Run around the quiet courthouse. Good time. No? Deputy's going to prevent me from doing that, aren't they?
There have been overnight deliberations.
They said, the judge says you can stay as late as you want. But we don't serve dinner here, I believe was the caveat.
Well, then they're definitely out by 5.
Let's see here. Let's get some more questions here, because I think that Daniel only has a certain amount of time left with us because of the timing. So I want to make sure that any kind of super chats we have in here, we that are addressed to him, that we try to get to him. So let's see if I can find as many as possible here. Mr. Pickles says, "Can I see the entirety of the UK? I believe that is a joke, and I believe the answer is no."
Not at the same time, anyway.
Yeah,
we kind of had a war about that, give or take. So,
yeah.
K-Ped says, "What power does the Queen have overrule the government?"
Yeah, so strictly speaking, Queen can do what she likes.
All of it.
Probably won't, but could.
All right. Ray the Noblesse says, "Is it true the UK's judge's son knew Amber personally? If yes, what should the consequences be now?" The answer to that is probably didn't know her personally. However, there seems to be a financial relationship between him and the publisher for The Sun, meaning that he was employed by a company owned by the publisher of The Sun.
Can we talk more about the Queen? Because the whole thing confuses me on many levels.
Oh, God. That's such a rabbit hole, Kurt.
But
it is.
The one thing that really confuses me is the whole idea of royal assent, because I know from my flow charts that the last step in something becoming a law is the Queen saying, yeah, that's cool with me. But apparently the last person who said no was Queen Victoria, if memory serves correctly. And so, like, on some level, what's the point of asking? Because they always say yes. And apparently some people have commented that if she ever were to say no, it would trigger a constitutional crisis, which so the whole thing is bizarre to me. You want to comment on that?
Yeah, I think the constitutional crisis is a bit of an exaggeration. It would go back to, I don't think it would ever be a straight no. I think it would be a no, I don't like this because of X, Y, or Z, and they would go back to have it corrected. But you're right, it hasn't happened.
Make me king. I'll say no all the time. It'll be great.
Oh, okay. Raziel Kane says, "With the global effect this American case has had on the reputation of the UK court system, would this affect or cause changes going forward?"
Knowing law and the legal systems, I don't think it's going to change a thing.
It'll move an inch in 300 years over this.
Yeah.
Yeah. There's too big a difference between the two cases, although, and that might be a stretch for a lot of people to think about, but because it was different defendants in the UK case, it is fundamentally a different claim, even though the substance of it was the same. So, it's too much of a difference.
So here's a super chat. I don't want to get into protracted discussions on gun laws. I know that the chat finally moved away from it, but there is a question about how strict gun laws are in the UK. So that is strictly informational. So we can ask that question if you are okay with answering.
Yeah, I know bits of it. I'm not an expert by any means, but I do know that they are very, very strict, to the extent that if you, let's say I held a gun license, and let's say I went to the doctor to say, hey, you know what, I'm feeling a bit stressed, and the doctor prescribed me something, that's it. Gun license is gone. I never get it back.
which is a pretty strong disincentive to going to see the doctor, which kind of defeats the entire point. So fun.
Exactly. Well, exactly. Well, these are the arguments, aren't they? So,
and as to applying to the U.S., Heller and McDonald have fairly settled that issue, at least for now. That
and NYSRPA is coming down any day now.
I'm looking forward to that. Can you bring me on?
Oh, when we discuss it? Oh, sure.
Yeah, that was
sure, but you have to be prepared, because if that thing drops at 10 a.m., I'm going to be streaming at like 10:15.
Go to Kurt's channel for that talk.
I'm going to go right back to the oral arguments, because that
so
was
what does Bernhard say, Alita?
Bernhard says, can JD sue another UK news outlet that copied the Sun verbiage as vehicle for a new trial?
Ooh,
interesting question. Yeah, because if it's been republished, then republishing something is not a defense to the claim for defamation itself. The claim for defamation is as it stands, and this is coming back to the burden of proof thing again. So the first burden is on the claimant. Does it cause, or is it likely to cause, serious harm? Usually obvious. And that's when the burden shifts for the defense. It's a statutory defense of either, truth, which is, it was substantially true. Not entirely true, but substantially true. But it would still be a trial, because it would be, is it substantially true? But yes, potentially it could sue another paper for republishing it.
May I ask just really briefly, because we have the actual malice standard.
Sure.
Would it not be an argument that a court in this jurisdiction in this country found it to be substantially true? In this case, we're just republishing what a court has deemed true. Would that not be a defense?
At the moment, it would. I think if the jury come back in your case and sort of in everybody's view overturn all of that, that's a very, very interesting spin, because it's clearly the reverse. Effectively, even though it was against different defendants, it's essentially a different decision. So there'd still be a trial to be had, and so no doubt the decision from your jury would come back, if it's in Depp's favor, would be a point of evidence to bring in this case and say, whilst our court said this, your jury said that. That's a very interesting.
Well, and that it goes back to this morning a little bit, because in an English court, they could bring in our jury's verdict as evidence, whereas we could not bring in your jury's verdict as evidence.
Indeed, and I think it's weighted in your jury's favor because they've heard more evidence.
Okay, interesting. I appreciate the answer.
Steph Jack UK says, BBB, do you think sentencing standards in UK provide enough of a deterrent when it comes to things such as knife crime, murder, etc.? Hint, I don't.
No, I don't.
Okay.
I don't think they're severe enough at all. But there is also there is the counter argument that a more severe punishment doesn't necessarily deter the crime. I'm not sure how much I agree with that. Although there are examples throughout Europe where rehabilitative facilities are better than punishments, but we are moving in that direction in trying to assist and rehabilitate, such as community work orders and things like that. But then with some of the punishments that I've seen, I don't think they're severe enough. I don't think they're a deterrent enough. In fact, some criminals, and I say criminals having been convicted, they've done it because they find life in prison sort of easier than trying to fend for themselves. So I don't know. There's a whole debate there. It could go on for hours.
2012 Jameson says, if JD wins in the US, how much will the UK be ridiculed? I don't know. If it is, it'll just be for a period of time for one decision, as opposed to a whole host of many other decisions that come out of the UK court system.
Why would the UK be ridiculed? I don't want the entire US ridiculed over some of our crappy decisions.
Exactly. We have plenty of decisions that many of us will criticize from various perspectives. So Sagar Manaktala says in India, sometimes false DV complaints are filed to police before a case just to harass, negotiate better alimony. Is it common in the US or the UK? Well, I think that kind of happened in this particular case.
Well, I have to say I've seen a number of cases with a long list of allegations, very, very serious allegations, the kind of which you'd normally be on a very serious trial for and going to prison for a long time, if found guilty, and all of which found not proven. So the short answer, yes, there's a lot of those allegations, and they just serve to protract and prolong the case unnecessarily.
I think abuse of the legal system is not unique to any jurisdiction.
Indeed.
Natalie O says, is the UK jury selection and instructions the same as in the United States? Well, this is assuming that you have a jury trial, since civil cases typically they do not, is what you said. But I guess in a criminal case, how does that work without having to spend too much time? Because I know we've only got a few more minutes left with you.
Yeah. Yeah, so if you're called up for jury service, you get a letter in the post. You say you've got to come to court. You don't know what trial you're on until you get to court, or even if you're on a trial as a juror. And so once you're there, you're all in a room. Then they just randomly select you. They check that you don't know the defendant. You don't know the witnesses. They don't know you. You've got no financial connections. Great, you're on the jury. Then you swear an oath and you're sworn in. And then there is an opportunity for objecting, to one of them if the lawyers know or the defendant knows, hey, we know this chap for whatever reason. Legal arguments are made. Judge will make a decision to replace that juror, and then off you go.
And then I think we've gotten actually maybe a couple super chats that I think I saw coming in. So, asking this question, Emma Damon wants to know video on the UK trial versus this US trial from Australia. So I think this is for I think for Daniel here.
There's no video as such of the UK trial. They don't broadcast, so I'm not sure what that's referring to. But
I think the question was more about whether you plan to do a video.
Yes, I see. Sorry, it's getting late.
No, that's okay. I mean, you have been here for about 7 hours. That's incredible. The fact that you have stuck around for this entire time, I really appreciate it.
Yes, awesome. I think it's a good idea, and I think probably I might as well, since I did some reading and research for the UK case, and I've been watching the US case. I think it's raised some very, very interesting questions, because the way the evidence has been brought out or not in the case of the UK trial, and the weight that's been put on it and not in the UK trial, versus you don't know what the jury are doing, but you do know that they've had the benefit of all of the evidence. So I think, a video would be forthcoming.
Cool. Versailles Mom wants to know, Daniel, do you ever get confused for Ray fines?
I get confused for a lot of people.
And also, if so, does anyone ever call you the barrister who shall not be named?
I think they're referring to the secret barrister. I've sometimes been asked if I am, but I'm not.
And then Manny Fabani wants to know, can you tell us the experience of retiring from the Blue Man Group and going into law? What drove you? Oh, this is a joke. Clearly a joke. Patty Joe Sloss, thank you so much for this generous super chat. I really look forward to Daniel's follow-up video, and awesome Rob will participate, and Alita too. Mike's recent video with Rob joining that had the sovereign citizen subject was just hilarious. Thanks for all of LawTube International. Great information. Of course. Yes. Thank you so much, Patty. And yes, I think that's it'll all of these collaborations will be so great to look forward to as well.
And actually, thanks to your stream, I'm now fewer than 100 subscribers short of 140,000. So thank you all.
All right. There we go. Let's get them to 140. If you have not already subscribed and you are interested in learning more about the UK, the laws in the United Kingdom, and all of the things that are developing out of there, so that we can do more comparisons between American law and UK law, I think this has been awesome. I've really enjoyed learning more about this. And so yeah, be sure to go into the description right now. Click on the Black Belt Barrister. and check out his stuff. Subscribe to his channel, watch his videos, like his videos, all the great YouTube stuff that we love to do here, and really grow this whole community of lawyers out on YouTube.
Oh wow! And now it has gone over 140,000.
Yay! Awesome!
Fantastic. No, it's been really great fun, and I am busy most of the day tomorrow. Otherwise, I would say I'll be straight back tomorrow. But if you'd have me, but sometime in the next day or two, or week or two, whenever, it'll be great fun to come back.
Well, it was a pleasure to meet you.
Absolutely.
Thank you for hanging out with us so long.
Yes, likewise. This has been wonderful, and I would love to have you back again.
It'd be my pleasure. Thank you very much.
And I suppose we have one last question for you, right here on a super chat. And I hope that we aren't missing any. I apologize, guys, if there are some that others have asked that we won't be able to get in front of him. But here's one more. What, if any, says, question for Barrister, was the Jimmy Savile case an open secret in the UK? I had never heard of him till the documentary. Absolutely chilling. I know nothing about this.
Yeah, if you Google it, you'll find out why it's chilling. Yes. I personally think that a lot of people knew about the details, and yeah, I think open secret is one way of putting it. I think a lot of people knew about the details before it was actually all revealed. And for anyone that doesn't know, Google it or will be revealed. And so that's
He was a children's TV host.
Yes, let's leave it at that for a live stream, and everyone can Google it to find out more.
And you can probably figure out what he was accused of based on that.
Yes, indeed.
Yeah, there you go.
Can I just say I love this username? So thank you for that.
Agreed.
What if any? It's very good.
Definitely agree. Definitely agree. All righty. Well, thank you so much, Daniel, for coming by and for sticking around for so long. I'm amazed. I just
couldn't leave.
when I told you that it would be fluid and you could basically come and go as you liked, I did not expect that you would be able to stay for basically almost the entire stream. So I'm honored that you would spend so much time with us, and I'm very happy to have you here.
Thank you all so much. I will be back again. Thank you for your time.
See ya.
See ya.
Take care.
All right. Let's go through some more super chats here. All righty. Okay. Going back to the top here. Salted Denim says, for those of us that can't actively watch the live, will you pretty please if and when the jurors are back from deliberations? Thank you so much. Absolutely.
Yeah,
I will be. Yes. I will be putting it on all of them. Crafting with Amy says, question, you appear blurry to me, year end or I need exam. It may have to do with the connection between StreamYard and YouTube. I think that's what's going on here, and I apologize for that. Ben Casperson says, can you show Hogue the Australia tapes? Yes, we will. We absolutely will. We'll be going through all of those. Selenai Chivit says, about ACLU, can you explain how they came up with the $86,000 to prepare documents? Isn't this amount of money a lot for computer store documents? It absolutely is. I think we actually showed this one earlier. But
it's ridiculous.
I don't know how they came up with $86,000. I'm going to see if I can dig into that a little bit and see if they have declarations attached that have any kinds of explanations as to how they reached that massive number.
I'm sure it's labor. I'm sure they did some math with labor.
Absolutely. Maybe some lawyer math, but we'll see. Wolfgang Puck 3102. Legal aspects of Class V set for us. Go.
One is chaos incarnate, and one is law and order with a little bit of what that law actually means. So the legal aspects of that particular fight are really the philosophical decision. Play Final Fantasy VII yourself. Cloud is not rebelling against the state. Cloud is rebelling against the status of being controlled, not by the state, but by those that seek that control of state or godhood. Final Fantasy VII. But again, I don't want to ruin anymore.
Yeah, I'm seeing in the chat that it's lagging.
Sephiroth did nothing wrong.
Oh my god.
The only way to save the village. Am I right?
All right.
So
all right.
I'm seeing the lag. Sorry, guys.
StreamYard are just trying to prevent you from listening to legally wrangle Final Fantasy VII.
They're trying to save me on my hot takes.
Yeah. Give it a minute and it'll come back. It'll come back to space and everything will be fine.
This is Genova.
So let's go.
It's Genova's fault, people.
Genova, yeah.
Absolutely is. Right.
Just be assured that whatever answer we gave was fantastic and not to be missed.
Absolutely. Are people okay? Some people are saying it's back. Other people are saying beep beep boop bleep. Other people are saying it's very crackly. Lag is too big. I'm sorry, guys. It's like it comes in a wave and then it goes, and I am not sure.
It's always wild because our connection to each other really doesn't ever waver. That wasn't like a Care Bears reference. That was just talking about how StreamYard functions.
Yeah.
Yeah, it's not actually on. It doesn't appear to be on my end because everything that I can see is perfectly fluid, perfectly fine.
We have real-time communication amongst each other. It's just you, the observer. So something Schrodinger, something, time dilation, blah, blah, blah.
Yeah, something dark side. All right. Next one. Okay, I think we're good now. This is what people are saying. We've finally gotten through the lag.
Oh God.
So, Aki no Kitsune says, Hogue, also talk about Chrono Trigger / other classics.
Well, rather than just take over the entire stream with a long didactic answer about the legal implications of every Japanese role-playing game to ever be created, like Cloud versus Sephiroth, I will say that Chrono Trigger presents some interesting questions about whether or not you can be held responsible for a crime before it was committed, and whether when you change your fate, you're responsible for those that don't fare as well as you when that change is made. So please do check out Chrono Trigger and its sequel, or at least spiritual successor, Chrono Cross, for more on that.
And also, we had a request for Rick to repeat his answer from before, just because there was the lag in there.
No, it's lost the time.
Right, the legal aspects of Cloud versus Sephiroth, right? So Sephiroth, you have an agent of chaos that's under control by an alien being, but is representative of certain aspects of both godhood and the state. In Cloud, you have an amnesiac that represents, as Kurt put forth in the laggy section of this video, something like rebellion, but also something about finding yourself within the constraints of both control from state and godhood. So what I think you have in terms of legal responsibility there is a conflict that can only be answered with the philosophy within us as well as within our structures of law.
There you go.
Isn't that really just a restructuring of the freaking Satan story?
Okay, first of all, I'm sure that you didn't just put a just in your description of the summary of Final Fantasy VII, right?
No, I suppose I did not.
Yes, there's certain aspects of Fallen Angel in Final Fantasy VII. In fact,
everything's just Milton. Yeah, it's refreshed. Yeah, it's
well, hey, with their 7 stories, Final Fantasy VII did a good job with their version.
Anna D says, what's the role of the judge in the deliberation? So she is outside of the deliberation. She never walks into that jury deliberation room. They are left by themselves. There's a bailiff that stands outside the closed door in case they need anything and to ensure that nobody goes in there improperly trying to mess up the process. The judge is working on other cases at the time. And when she gets a note from the bailiff saying that the jury has a question, she gets right back up there, as we saw, reads the note, talks with opposing counsel on both sides and says, this is how I intend to answer. Is that okay with you? Is that okay with you? Okay, I will write it and this will get back to them. That's basically what she does. That's her role in the process.
And this is what drives legal realism researchers absolutely insane, is that there is no way to get good data on how juries actually make conclusions. Yep.
And that's why I also would absolutely love to find my way onto a jury, is because I just want to know what it looks like in there. I want to know what it feels like in there. I'll never know if I don't get in there by myself, and it'll never happen.
No, because everybody is going to strike a lawyer from their jury.
And especially a YouTube lawyer who comments on trials.
Yeah, there's not.
I mean, we have a wealth of knowledge and experience. Why wouldn't they want us? Because
then it becomes a jury of one.
Yeah. There's There's absolutely not a snowball's chance in hell that I'm ever getting on a jury ever in my life. It's so unfortunate.
If
but
I
it'll
ever get
never
called for
happen.
jury duty and get recognized, that'd be hilarious.
Yeah.
It's like you're just stricken.
I'll just have
You're
to,
just stricken. You know why? Go away.
Yeah.
I've volunteered every time, and I always get struck.
Yeah. Yeah. And yes, to answer the chat, Greta Guiden, yes, I want to be in the room where it happens. The room where it happens. The room where it happens. I mean, the best that I can do is probably, see where Mr. Bites gets into a jury panel or something. And then after he's allowed to talk about it, just pick his entire brain about it.
You and Mr. Bites on jury together, fighting at odds.
Oh,
one
that would
for
never
guilty,
happen.
one for not guilty.
Don't do that during the trial.
Oh, Nurse Liz says that she's been a juror before that we can chat about sometime. I would love that. Nurse Liz, that would be awesome. Also, happy to see you in the chat. Sai says, was it a mistake to go for the son before Amber Heard?
No.
You don't think so?
No. I mean, the standard in the UK is a lot easier, so if you had to pick one, right?
Yeah,
That's
and particularly with what our gentleman barrister was saying, if he had lost against Amber Heard in the States and they could use that as evidence in the UK, they're toast.
Yeah. 2012 Jameson says, I hope you got my email and took it in the spirit it was meant. I hope everyone is doing well. Also, medical law gets into all of that stuff. Oh, joy. I have received many emails. 2012 Jameson, I did receive yours. I apologize. I have not had time to respond to it yet. But I have gotten many emails and DMs, and I would say that the vast majority of them have been very supportive, very kind words from people. So I really appreciate all of that. I should actually say something about that. It's been very, very nice to get a lot of very kind words from a lot of supporters. Throughout this trial and in the past week, a lot of people have had some very kind things to say, and I really appreciate that. This one. Good day from Australia, says James Scarrett. As I close in on 30, I'm in a position where I can study law part-time, but with 8 years for completion. Is 38 years too old for most employers, or should I accept I've missed the boat? I don't know about employers in Australia. However, I will say that at the end of the day, most employers are going to care more than anything about your knowledge of the law and your expertise in the law and your skills in the law. Of course, coming right out of law school, it is difficult to cover. It's difficult to show that you have experience if you are brand new. However, what you can do is make up for that by being the best at your field or studying the best, getting the best knowledge that you can in the meantime. And I will say that the ones that did the best in my class seemed to be the ones that were coming from a second or even a third career from their fields and decided that they wanted to be lawyers. They tended to be much more serious about their studies. They tended to be ones that had families to take care of. So it was like, it wasn't just a whim that they went to law school. So they tended to do better than the ones that were straight out of undergraduate studies in the United States. So
Alita speaks the truth.
I'll just say 2 seconds. Alita, you're absolutely right. And Fordham had a huge nighttime program. And those were some of the brightest, most thoughtful, most studious individuals that I had the pleasure of working alongside of. So absolutely go for it if you think that this is a calling for you.
Yep, exactly. And that's really the most important part, is that if it is a calling for you, you will do whatever you need to do to be the best in your the best that you can be in your profession. Helen John says, what time do the jurors go to lunch? Can they deliver it past 5 p.m. Eastern Standard Time? So the jurors will go to lunch around noon. I think the same about time that we've seen them go to lunch throughout this trial. And then going past 5 p.m., they can. They absolutely can. So yeah, but it kind of depends on the judge isn't going to make them sit there past 5 p.m. if it doesn't look like they are anywhere close to finishing. So, because at a certain point, after you've been arguing for 8 hours, you get tired and it's probably time to go home and then come back the next day fresh. Deliberate, I meant is what Helen John said. Yes.
Long Crime has some info on the motion filed today. Let me see if I can find out what that is. I'll be back.
Okay, sure. Miklas says, question, how does the U.S. cost system impact rule of law ideals? Is SLAP the answer to financial power imbalance between litigants? Well, how does the U.S. cost system impact rule of law ideals? I'm not sure exactly.
I think that it is a broad question, and I think the issue is that you pay for your own attorney, win or lose.
Sure. Yes.
And I think that the question is SLAP an effective fee shifting statute? I would say generally yes. In any litigation, obviously, you're taking a risk, and particularly in civil, with your own money. So SLAP is a good example. I think that maybe there should be more fee shifting statutes if that's what you're referring to.
Yeah, well, and I think that the reason why SLAP and anti-SLAP, has that kind of fee shifting burden, is or burden fee shifting provision, I should say. The reason for that is because it is a particularly serious topic in American courts. Is this First Amendment thing, right? Like we love our First Amendment. I said this earlier today. Americans love freedom of speech. We love the First Amendment. We love the ability to petition the government, whether that means through protesting or through filing litigation in the courts. We'd like to have our grievances aired. And so that's one of the reasons why there's such a strong policy for something like anti-SLAP in many, many states. And so the reason why it shifts that burden over is because it's basically saying, if you are filing litigation against somebody to prevent them from using their First Amendment rights, to prevent them from speaking, to prevent them from doing whatever that is within the First Amendment, then we are going to have this pretty strict penalty on you, that basically that not only are you going to be shut down from what it is that you're doing, but you're also going to be kind of punished in a way for doing it because we value our First Amendment rights that much, essentially.
Yeah, I agree.
Yeah, but it's a pretty unique area within the law, within American law, where you have that is such a strong shifting provision.
Well, and it's interesting because there are a lot of jurisdictions outside of the United States where if you lose, you pay the other person's attorney's fees just as a matter of course. So there is a balance there where for these particular things, we're going to have a fee shifting, but generally we want access to the court so people aren't afraid to sue somebody more powerful than them and avail themselves of the court's jurisdiction.
Yeah, I would agree. Jennifer Pettis says, can you do a mock jury deliberation going over the verdict form? Yes, actually, that was something that I was very interested in doing. I know I was talking with Nate about that. I don't have that set up right now, however, but I think I can definitely get that set up for tomorrow.
I'd join.
Okay. Yeah. And then we can
Nate had the chat do it last night, but I think it'd be interesting to have a handful of us.
I think so, to be discussing, and then we can have some polls in the chat as well if we can do that. I would definitely love to do that. Yeah, I know Nate did that yesterday. And yeah, I'm gonna look into that to see if we can have that going tomorrow, because unless we get a verdict in the next 40 minutes,
seems improbable.
Yeah, seems unlikely at the moment.
I couldn't find anything, but I decided to super chat to grift myself over on Long Crimes Network, so I feel something got accomplished.
Is that where you went?
Yeah. Someone said it was on Long Crime. I couldn't find it, but I went to their YouTube channel and like a super chat, just told people check out my channel. With 500,000 people watching, it's like, yeah, well, grift all day long. See if it works.
Good for you, Kurt.
That's awesome. The Jackal21 says, has the panel lost faith in our justice system by any amount? I've yet to see justice in the political sphere. Trump, January 6th, Mueller, etc. Rob, how can one get into woodworking? Where do we start? I'm so sorry that Rob is not here to answer that part of the question. I mean, those other ones are political questions, political topics that I don't really want to get into, because I know that we've got people of all political sides right now. And although I do believe that I like having, disagreement and discussion and stuff like that, right now, those topics can definitely go sideways very quickly, I think, on a on a day like this. But generally speaking, I have not lost faith in our justice system. I really have not. I think that there are always going to be times where we agree or we disagree with various decisions that are made. But the ones that get highlighted as like this is like a huge error that has happened in our judicial system, you will find that there is one that is talked about, and there are 5,000 others that happened where the correct decision was made, and nobody talks about them because it's not salacious. So, yes, every once in a while we have an incorrect decision, and maybe it's more often than just every once in a while. I don't have the data on that to suggest one way or another, but for me personally, I have seen many decisions go down in the proper way that, for me, continue my faith in our judicial system. It is made up just like any other organization that exists on this planet, that has ever existed on this planet, and that will ever exist on this planet. It is made up of people. People are fallible. We make mistakes. And the whole idea is to try to set up the mechanisms in place so that when there is an error, that we can try to make up for it or try to prevent those errors as much as we possibly can. It will never be perfect. We will never have a perfect system. But the whole idea is to try to minimize those to an acceptable degree. I don't know how you guys feel about that.
I'm going to go with here. I don't think I have anything to add to that. Once you hit human institutions, I was all in.
Yeah, and I'm going to go with a real quick riff. Check out J. Robine Law on Twitter. I made the point. I was on Nate's stream at the tail end of last night, and I thought it was really interesting that the chat, in my personal opinion, got it right entirely. And I genuinely do believe, and I said it publicly, that more likely than not, jurors are trying to get the right decision. And maybe they don't always get there, but more likely than not, they tend to. And that's been my experience. And that's why I think it's a better system than having 3 learned judges who are already prejudging the case.
Yeah, I would agree. Next one is let's see here. Is it this one? Did I already do this one? Nope. I already got that one. Okay. Che Dustin says, how does a jury determine amount of damages versus the filed amount requested?
They take a bunch of dollar bills and they throw them around the room, and whatever lands on the table is the number they use for the million.
No.
But it's 23 pages for curative instructions. I don't know if you want to cover it or if you just want me to read it and summarize it or how you want to do that. But
is that the damage instruction?
I don't know. You want me to read it and just tell you what it says?
Sure.
All right. Give me a second. I'll skim 23 pages and I'll give you a summary.
Okay. Sounds good. But in terms of determining the amount of damages, I think that they go with what the evidence has been brought before them, as that they can kind of hold in their hands, essentially, and what looks right, what feels right, and that's what they're going to go with. If they are particularly upset at the party that they are going against, they are going to probably make them pay more money than they would otherwise, just because they want to see some form of justice. You saw that very clearly in the Cardi B case. I know I talk about that case a lot, but it just is such a clear example of where the jury came back and said, Tasha K, what are you doing? Like, you're a terrible person for doing what you have done to Cardi B. You admitted on the stand that you were reckless as to whether or not you were lying about Cardi B. And on top of that, you said you had no shame about it. You had absolutely no shame. And you said that this is what you do. This is what you intend to do. This is how you make your money. So
I've now read 23 pages. I can now summarize it for you. So
that was very fast.
No problem. So 2 issues that the council was trying to bring up. One issue is that they were upset at the remarks at Heard's team about focusing on larger social issues.
Yes.
So they thought that the remarks about you should think about things outside this case, focus on larger social concerns, was improper legal argument because it causes the jury to think outside the confines of the case.
Yes,
so that was number 1. And number 2 was they wanted a slight reordering of the numbering of the instructions. So they thought that there was a discrepancy between the ordering given by the judge orally and in writing. So falsity, for example, is the third element as written, and they wanted it moved down to the last element. And also specifically, they wanted to say that it would have to be false about Mr. Depp, which is currently not stated. So those were the things that were denied. No problem.
Okay. So the motion was officially denied?
Well, no, the motion was officially ignored.
Ah, okay. So she hasn't ruled on it yet.
Yes.
Okay.
She said she wouldn't.
The broader advisements kind of BS. But in fairness, it's with the jury, so it's not appropriate for her to do that at that point.
The reordering thing is such a minor thing on the issues. Is like, no, I'm not going to correct for that. And if I were going to correct for the thing, I should have objected then. It's like too late anyway. So I would deny the first one as untimely, and the second one to be like, I'm not going to correct for that, so I wouldn't give them it anyway.
I don't disagree.
Yeah. I mean, you have to object in the moment. And if there wasn't an objection on that, I mean, there were a couple objections by Ben Chu during the closing arguments, but I don't believe that either of those, one of them had to do with Adam Waldman, whether or not he planted stuff around the internet. And then the second one had to do with,
it was a whole sequence on doctor's notes. It was a whole sequence.
That's right. On Dr. Curry, like what she said about Dr. Hughes' stuff, basically. And I think he definitely won on the Adam Waldman one because she immediately came back and changed her tune.
I think he won them all as best I could tell.
I think so too. So this issue though, that does appear to be a late filed objection, unfortunately.
I agree with Kurt, but still all the social movement stuff was ridiculous in the moment. It's exactly the opposite of what a jury should be looking at.
Yeah. So the next one is Bram says, please review Netflix series Trial by Media. Is that a real Netflix series?
I don't think they just made one up, but you never know.
I mean, we've got people saying that a verdict is in. I don't know.
Oh, well, we knew that was coming. Jury's back. Verdict is in. Johnny Depp is returned. I mean, Chad will have all sorts of special ones.
Johnny Depp is back from the UK, even though he's performing tonight.
The judge is dancing on the roof. She's with the inflatable dinosaurs. Alpacas are here.
The alpacas have never placed the judge.
Alpacas are answering legal questions amongst counsel.
Nickname generator failed, says US, two sides. Dollar versus zero. Dollar sues zero if zero not agrees. Blackmail?
This is a resource, what I call the chip stack of litigation threats. No, generally speaking, if you have a cognizable legal right to seek redress, it's not blackmail, even if you have a big chip stack. But obviously, you might not have a legally cognizable right to redress, at which point, yes, you can go from a legal right to extortion pretty quick. See Michael Avenatti. Seriously, see it.
Yes, who had all the fame and is still the pinned comment on bad legal takes all these years later. Michael Avenatti might be the best lawyer ever in the United States.
You dance with the one that brung you.
Yeah.
But yeah, no, I covered the Nike extortion.
Anyone remember when he was going to be president for 15 minutes there? That was good.
I do remember that. I also remember when LinkedIn recommended that I add him as a connection because he was geographically relatively close in Southern California, and I was like, why?
Stop that, LinkedIn.
He really did turn out to be the creepy porn lord. Fox News had it right all those years, man.
Anyhow,
well, I do talk about it. It's a very good example of when a litigation threat that might otherwise be okay goes over the line to extortion.
When you're extorting your own client, it isn't helpful.
Fair point. Face in the Crowd says, curious on what your theory is on why MSM is still backing AH so hard despite all evidence. They can't be this out of touch, right? Well,
ask me this.
I think that just generally speaking, the MSM just has a hard time changing its tune, at least not quickly. Anyhow,
like the Titanic, they're not going to avoid the iceberg.
It's a really big ship that takes a long time to turn rudder steering.
Exactly. Baron von Larks says, any thoughts on adding a civil law country representative to your discussion? I know this case isn't related to it, but it would be fun for comparison. Country representative.
Oh, I think he means a civil law system as opposed to we're all common law attorneys.
Okay. Well, Baron von Larks, shoot me an email, and maybe there'll be a topic that we can that we can discuss that touches on your jurisdiction. That would be interesting. I'm always interested in getting different and new kind of topics here. Okay, kitty, come over here this way. I love you so much. He's trying to get the chicken that is left in my salad because I haven't really eaten much of any of it. Chris Meets West says, everyone's favorite legal movie or show. For me, I have to go back to what it is that I originally loved. My very first legal movie that I fell in love with was, of course, Legally Blonde.
Oh, come on.
It's not the best legal movie ever. It's not at all, not by any means. But I grew up with the poster in my childhood bedroom, and yeah. So it still has it's purely just nostalgia, not because it's like a great movie to talk about law.
Measure of Man, season 2, Star Trek: The Next Generation.
You better believe it.
How about you guys? John, Rob?
I'm a trial attorney. I have to say my cousin Vinny. I also like The Devil's Advocate. That was a good one too.
Devil's Advocate is also good. Also cousin Vinny.
I'm gonna, because I'm the nerd, I'm gonna go with Injustice for All.
Ooh, that's a nice one.
Alrighty. All right. Crown V or Crown 5 perhaps says, since her home insurance is paying her legal fees, if she is found liable, can they decide not to pay her legal fees? Thank you. Well, we're still not sure if she actually is using any kind of home insurance to pay legal fees. I don't even know if she in fact owns a home by which she would have home insurance. However, I don't know. Do you guys happen to know if the insurance would decide not to pay her legal fees on that? I mean, she would have to have some kind of a cap on how much she could
Yeah,
pay.
I'm gonna say I've done first person property where I represent the insurance companies against claims. I cannot imagine what would attach to her home insurance policy on a defamation suit. And
Yeah.
I think that would be denied immediately.
I would think so too, because insurance companies are pretty notoriously hard to deal with in any kind of a case. I've had to deal with an insurance company once when I had a personal injury case having to do with a car accident, and even that alone was like, oh boy, it was a nightmare and a half to deal with them.
I'm familiar with standard homeowner 3 policies, which is your typical residential form policy. There is nothing there that is going to give you any coverage at all over a defamation claim.
Yeah.
And I'm not saying that you couldn't make the arguments, but I would fight you on that all day.
Chris Brooke Rutherford says, I'm sure this was addressed earlier, but for those of us listening over lunch, does the current panel believe a verdict will be reached today? Well, no, I definitely don't.
At this stage of the game, no.
I know. I'm sorry that I didn't get to this one earlier, but we're working our way through it. Sarah Cartland says, Law Talk with Mike, did Kate agree to a live stream? I'm sorry he's not here. I'm going to save this just in case he comes back. And if he doesn't, I'm going to see if I can save it for perhaps for tomorrow. At least pose the question to him if he pops back on. Anubatan says, anyone here seen the trial recaps done in the Phoenix Wright attorney style? They're pretty fun.
They were pretty good, and I really appreciated the mirroring of the art style was very good.
Nice. Manny Fabani says, could you ask BBB to read Wapler's out loud? I don't think we're going to be doing that. Jessica Snyder says, a question about trusts. Can an addendum be made to an existing irrevocable trust 30 years old that needs more trustees because of age of current trustees? I could not say that without actually looking at the trust terms.
Yeah, we don't give legal advice.
Well,
that sounds suspiciously specific.
First off, yes. First off, we don't give legal advice, but second off, there's no way for me to be able to even answer that without being able to see the trust document itself.
It is true. Yeah, you'd have to do all that analysis. It's just funny to me because it's like $2 super chat. Could you please tell me about a paragraph that we could put in an identification provision for a power of attorney in Florida, preferably, Osceola County? No.
Yeah, my recommendon is
that's particularly going to go badly in Florida, just as the Florida attorney here.
Okay. But yeah, it's talk to an attorney that's in whatever state that you're in, or whatever state that trust is in, because that's most likely,
Well, it's a great jumping off point for why we can't give legal advice, right? Because law is so specially oriented, facts and circumstances. You got to sit with the client. You got to talk through a bunch of the different issues. That we're not just trying to be out here saying we can't help you with questions that are legal advice. It's because we don't know enough about the situation to answer it in super chat form.
Yep,
absolutely.
And $5.
Everything is dependent upon your jurisdiction.
It is. It's so.
Unfortunately, Lita only gets 3.
It
so
is
for
so
$3
dependent.
you want the answer to this. I don't think so.
It is so dependent on the jurisdiction.
Well, regardless of the amount of money that's being paid to me to answer the question, that's not so much the concern here. The concern is whether I can give a good answer to it. And it's true. And when it comes to trust and estates law, that absolutely is going to be state specific. It is not the same across the board. I learned that when I went from California to DC, and learned about differences between those two areas. And, so you can have all kinds of weird things, but ultimately one of the basic principles of wills and trusts is that they are very document oriented. So
yes,
pay attention to the words that are in the document, just like contract law. You've got to know what words are in the document before you can decide anything else, before you can glean anything else. So have somebody read through those and give you their insight, and go from there is my best recommendation. Nana Mash says, it was stated that the place of starting litigation in the U.S. is more accessible than other countries. Is that the basis of the American reputation as being sue happy? I don't know if it is necessarily more than other countries, but I know that generally speaking, there's a policy to be much more open to filing litigation in the United States. And I do think that is something that contributes to the United States being much more litigation happy, a little litigation trigger happy, right? Because we do make it easier for those to be filed. Now, we also have a process by which we can weed out, separate the wheat from the chaff, right? Or weed out the ones that shouldn't be there. Whether or not that system works efficiently enough is another question, but we do have that process, and we do have, it's a very specific kind of process that you can follow along. So yeah. Question for the panel from Voodoo Child 69 says, have any of you been involved with a trial where opposing counsel brought in an expert that left you thinking, damn, I wish I had found them first?
Yeah, and I've used her 3 times since.
Oh, there you go.
Rob's got the definitive answer there. We like finding competent counsel. We do.
It's I love it. There's nothing better than finding an expert that conveys the information concisely, and yeah.
We always have a Rolodex, but ours tend to, or at least in my experience, it tends to be experts that don't testify often. They just do their trade, and that's because it's in the med mal sort of sphere. And I much prefer being able to say this person's doing surgery today when somebody's doing a summation, than, this person's probably testifying at another place. I don't know. But yeah, I'm going to accept Rob's answer. I apologize.
It's a different field. I mean, it's a different field. I use forensic psychiatry. Like forensic psychiatrists perform evaluations or custody evaluations. Very different than that. So they can be different answers.
Sure, for sure. Ariella Lester says, can you go over good versus bad judges' characteristics? I think yes. Good judges are the ones that you don't notice so much. I think generally speaking, bad judges are the ones that you notice everywhere. They are all over the case, and they are very vocal, very active, very proactive, and signaling to the jury all over the place. That is what I would think of as a not very good judge, or I don't know, not very good judge, but like one I would prefer not to see behaving in that way, because those are the kind of judges that can have more of an impact, albeit, maybe subliminally, on that jury, because the jury is looking to them as a neutral arbiter. And so any kind of signals made by the judge that show annoyance to one side versus annoyance to the other side, all those things can have some kind of an impact on the jury.
Yeah.
I don't know if you guys want to add anything else.
No, you just want a fair referee. And, sometimes they're going to rule against you. They have different opinions, but as long as it's not in front of the jury, I don't care. I've had a judge say that she hated the hell out of my expert and that we were absolutely screwed when the jury was out deliberating. We didn't. We won, but, she was fair during the trial. So that's fine. As long as you're a fair referee in front of the ultimate fact finder, I don't care.
All right. Yeah. And all of those. Yeah, exactly. I completely agree with that. Mark Boots says, question, which law tubers would most likely face in court?
Not me.
You're about the least likely.
I mean, court, it's bad.
I mean, Mike and Rob are always in court. So is John, I presume. You're in court quite often?
It's been a little while, but yeah, in the past, sure.
Yep. Who else? I mean, for me, it's been a minute since I've been in a courtroom, but I do miss it. I do.
I mean, the odds of us running into each other in a specific
so.
case, yeah, that's the odds of running into each other in a specific case. It's not going to happen. John's in Florida. I'm in Virginia. I can't see one of us being in that jurisdiction and then in one specific case in that jurisdiction.
Yeah.
Yeah.
I don't know. Johnny Depp and Amber Heard weren't from Virginia either, Rob. You never know.
Well, we could be pro hac viced into a neutral jurisdiction, right?
We'll just helicopter Rob into other law tubers' trials.
Oh, no.
Oh my God. Do we turn this into like a Monday Night Raw where we just pro-oc into each other's jurisdictions?
Yeah.
It would be extremely unethical, but it would be entertaining.
Annie Boyd says, can someone smart explain why Elaine is big mad? Well, first off, you are assuming that anyone on this panel is smart. That is a big assumption. Nope. I'm just kidding. No,
Not
but why Elaine is big mad? I think that may have been a reference to her delay over the response by the judge to the jury and to their question. I don't know that she was mad about that. I think that she was just trying to figure out, is there some way that I can get away with not agreeing to this or modifying the response to this? Otherwise, I'm not sure why she would be particularly mad at this point, other than I am aware of the reports of her getting upset in the hallways on Friday after her closing arguments. So aside from that, which would be the explanation for that possibly? I don't know, but I don't have any information on that. Diana Marchetti says, other than what I've heard elsewhere, Diana Marchetti says, I thought the jury stayed the same as the beginning. Why are they excused after 6 weeks of trial? I thought the choices were made the first day. The choices are made for basically the big jury panel. And they always have extras. They always have extras because something is bound to happen to some of them, right? Because things come up. One juror was excused because he had a very painful hernia and he needed to go home and take medication, put his feet up for the afternoon. He said he would come back the next morning, but the judge said, you can't do that. You have to be here the whole time. And then another one, I don't know why that other juror was excused, but basically you have these extras just in case something happens. Someone can get into a car accident on the way to the courthouse. And
you had the one that was
happen.
removed for allegedly watching testimony, which turned into an entire fiasco.
That was a witness.
Was that a witness or was that a juror?
That was Gina Duders.
Okay.
Yeah.
We definitely got to record why the second juror.
It's been a number of weeks. I apologize if I'm not.
What a trial.
I completely understand because it has been a number of weeks. It feels like it's been basically forever at this point.
Virtually everything that can happen. We got jurors ejected. We got witnesses ejected. We got voir dires in public. It's fantastic stuff.
Objections during openings and closings.
We got a mass amount of objections in the closing statements. I've never seen that.
That was crazy to me.
That was a lot. That was a lot. And you saw, and what you guys couldn't see on the channel, what you guys couldn't see the stream is Ben Chu's hand was hovering over the microphone. He knew that he was alienating the jury a bit. And there were times when he would lean forward like he needed to do more because Elaine just kept going. And every time the objection got sustained or he had to object, Elaine kind of played it even further down that road. I'm going to make you stand up.
Oof.
Oh, God.
Oof. Mr. DNA 1987 says, how could there be a split ruling if the truth of the claims is a central matter in both? Seems illogical. Well, truth is one element, but there are multiple elements that they have to show on both sides. For both sides' claims. So you can decide that there is truth or lack of truth to certain statements. And then there are other factors that may come in to decide whether or not this is defamation.
Well, yeah, and the three statements are not identical.
Exactly. Bianca Waterberg says, if Amber did have medical records, would it be protected by HIPAA? Under normal circumstances, yes. However, because we are talking about a lawsuit here where there are medical and psychological claims and defenses involved, all of that stuff gets waived. It gets waived.
Yeah,
normally
HIPAA's a statute. It's not a magic spell. It's got exceptions all throughout it.
This is what people don't understand about HIPAA, is that it only applies to covered entities under general circumstances, and there's an entire list of exceptions. And one of those is if you're in litigation over anything involving medical issues, you call over to the plaintiff's counsel, you say, sign a HIPAA waiver. Otherwise, I'm going to exclude all of your medical evidence. And they do that.
Yeah.
And that's just the way that it works.
Yeah. Helen Jackson says, it's time. Treat money for you and also for me. I did it. It's takeaway time. I beat leukemia. I have finished chemo. I am home. Food ordered. Amazing. Helen, I am so happy for you. I'm so happy for you. That is incredible. That is a huge accomplishment. And that legitimately makes me so happy to hear about that. Thank you for your generous super chat. I feel like I should be super chatting you. This is such a wonderful thing. And I'm just so thrilled to hear about it. So folks in the chat, let's all celebrate together. Let's celebrate with Helen Jackson for her health, and may her health continue. May she never have to face cancer ever again. And I hope that you have much love and health and life moving forward.
Congratulations.
Wonderful.
Good for you.
Wonderful, wonderful. Next one is Liam Weinberg says, what is the panel's opinion on the jury system? If one person hates Johnny/men for whatever reason and it affects the trial, isn't that an injustice? If one person hates Johnny/men for whatever reason. Well,
I like the jury system. I don't really want these kinds of decisions put all the way up in the ivory tower of whatever legalese you want to put it in. If one person hates Johnny for whatever reason, that's an indicia of the culture, as it would be the opposite direction, it should be noted. So isn't that injustice? This is the best we have when we're human beings. So we don't have perfect justice here.
I'm going to agree with you. I think that law and justice is a reflection of our society, and it would be wrong for a decision maker to discriminate on that basis, and it's wrong for a juror to discriminate on this basis. The other problem is that we're never going to know, but it is a reflection ultimately of what we consider acceptable or unacceptable in society. And if we live in a society where you have one person that stands that strong, that's the world we live in.
Mm-hmm. It's also a choice. Johnny chose the jury.
Yeah,
I mean, Johnny chose to proceed with a jury. He didn't choose the jury. He proceeded with a jury. So yeah, it's something where that factors in as well.
Yeah.
And well, honestly, I would still take a jury over a judge on this sort of a case.
On this one?
Agreed. Any day of the week. Any day of the week. And I will say too that, human beings, even if they have some staunch biases when they go into it, they also no one ever wants to look unreasonable, right? So if you have, there's 7 people in that jury deliberation room. If you've got 6 other people in there that are saying, hang on, let's talk about this, let's work through this, and kind of pointing to all of the reasons why that person's reasons are for being, anti Johnny Depp or anti-man, kind of working through them one by one. At a certain point, they're going to have to admit that they are being unreasonable. Potentially, probably, most likely is what I think. I mean, you can see that with witnesses on the stand, with witnesses that have not necessarily been prepared too well. Once they are pushed and probed a little bit on cross-examination, you'll see some witnesses admitting to all kinds of things just because they want to be, to a certain extent, agreeable. No one wants to look unreasonable. No one wants to look like they're being illogical. So those kinds of those kinds of discussions will happen too, and that's another reason why the jury system is flawed but imperfect, but I think largely works.
I think that's beautifully said.
Thank you. Mr. Pickles says, what happens if a lawyer from DP has sexual relations with a juror? It wouldn't be happening before a verdict. After a verdict, folks can do whatever they want, so as long as it's not an attorney-client relationship. Further extending my question, what if AH accuses JD for having sexual relations with a juror? If he has never spoken with that juror and that juror has never spoken with him, I think these are kind of joke questions, though.
It's like defamation all over again. But yeah,
exactly.
I think it's a joke.
Exactly. Lily Philosophy Adjunct says the ancient Greeks fought frivolous lawsuits by fining the plaintiff $25,000 if less than 20% of the jury voted for the plaintiff, while Greek juries were huge, 200 to 6K. Compared with ours, would a similar policy help our legal system? Well, first off, there were no U.S.
I don't
dollars
think there were
at that
dollars
time.
in ancient Greece.
And also, inflation is a thing, and so the fines would definitely have also been much, 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 much lower. So I'm not sure that I
released.
Oh, did it really?
Today.
Okay.
The jury is gone.
Jury went home.
Long live the
right.
jury.
The jury has gone.
But I guess the question is should we use, because the only way that you could do it mechanically would be contempt for frivolous suits.
No, we have enough barriers.
I think that's so un-American.
Mm-hmm.
I mean, in family law cases, we have. Look, if people file a bunch of frivolous lawsuits in family law litigation, I have seen moratoriums, so pre-filing moratoriums imposed on litigants who file. The guy who files a custody modification every single week. Mm-hmm. There's a pre-filing moratorium where the judge says no filing whatsoever for a 12-month period. I've seen that, and that's viewed as the court exercising restraints on its own justice system.
Docket, yeah.
And you have vexatious litigants, right? I mean, you have things the court can do, but we can't have a generic rule that somehow increases the cost of seeking legal redress. You want to talk about injustice?
No, that's deeply un-American, trying to restrict access to justice.
Alrighty. Yeah, no, I agree. Lindsay Kay says, if Amber wins, will the WP print a retraction? I doubt it.
They might pull the article.
Oh God, no.
Best you can ask for.
Yeah. Remember how we said that the MSM is really bad at changing, course? That. Soft Tofu says, what are your thoughts on the huge involvement of social media during the trial and the effects moving forward for both teams, CV plus BC's celebrity status versus EB and BR receiving hate?
That's not so different from OJ. I mean, I know social media is new and broader and bigger, but it's not so different from how things happened in the 90s. Johnny Cochran, I think that built his career.
I think that the difference there is that the way in which the average person can have their personal communication potentially reach that person much more quickly and much more closely, as opposed to back in OJ's time when it was much more like you would have to go and like protest in person or like voice your concern over like the radio or like get on TV somehow. Otherwise, you couldn't necessarily get that noise out there very easily like you can today.
I agree social media changes the game, but I think it's quantity, not quality. Yes. I think this has always been a factor in celebrity trials.
I agree. I definitely agree. And now now a lot of the large commentary is coming from grassroots as opposed to curated by the MSM. Katie Sims says, are deliberations recorded? No.
No
way. Those are sacrosanct. There's no recording that. Gil Gordon says, could you read the charges sheet as submitted?
That's a good possible thing to do on one of these days.
I think we might want to do that tomorrow, in fact.
It's a good recommendation, Gil.
Yes, thank you. Okay. Bernhard says, can the jury award JD with some outlandish amount of punitive damages on top of the $50 million he is asking for?
Nope, there's a cap. I think Kurt has said it multiple times, 350,000, I believe.
I've heard 350. Well, the jury could put the number down.
Nat says, why would Amber ask to steal identity of jurors? I'm curious on possible purpose. Why would one do that?
They want to make it less likely.
I mean, one of them's going to do it. It's going to happen in every case.
Oh, yeah. It still allows them to come forward and talk to people. It just makes them unreachable by others if they don't want to come forward.
On the margins, it makes it less likely or delays the big media expose.
Sure. Oslo Hiker says, could Camille's and Johnny's flirty body language be deliberate in order to put AH out?
I think it was deliberate. I think it was to show the jury that Johnny Depp gets along with women.
I think so. Valhalla Law, I love it, says, do we get to see the filled in verdict form? I think we might.
Depends on the jurisdiction.
Yeah, I think they're going to release that. You'll see that.
Yeah. Kai and High says, since the judge ignored Ben Chu's motion but didn't deny it, will she come back to it, or is it ignored for good? She will definitely have to come to some kind of a ruling on it. It just depends on, she probably will rule on it after the jury comes back with a verdict. To basically say,
I mean, here's how it's moot.
She'll moot it out, right?
Yeah.
Yeah, exactly. Threshold Coffee says, hello, crew. I'm a pilot. Oh, wait a minute. Let me see here. Oh, here, I'll share the screen here. See, we've got the legal team leaving. They're getting back in their Suburban.
Was the whole legal team hanging at the courthouse?
They were.
I guess so.
There was at least one or two lawyers that were on site, and then a few would come and go.
Okay.
Which makes sense. All right, cool. Threshold Coffee says, hello, crew. I'm a pilot, but you guys make me want to change careers. JK, I'll keep my head in the clouds. Thanks for all you do. If you need to offer coffee, Alita, thresholdcoffee.co. Awesome.
Nice. Pilot
awesome.
Cool.
Awesome.
I would love to pilot a plane. All right. Sorry.
Taking
head in the clouds.
That is a really cool job. I think so. Christopher Brody says, if the headline is the responsibility of the paper alone, surely JD loses.
He becomes materially less likely to win. I wouldn't say
they lost that argument, though. I mean, I think just you look at the instructions and you look at how she handled herself in the rebuttal case. I cannot see how the jury doesn't.
I think the very fact that the jury started asking about how to treat the headline suggests that they already passed reproduction.
Yeah.
Could very well be. But even if Johnny loses on number 1, there's number 2 and number 3 that are all chances to win. So he's got, all he needs is 1 out of 3.
I like the description as like a game show.
It is.
You've got 3 doors with chances to win.
Exactly. It's like a carnival game.
Hey.
David says, shouldn't Depp's lawyers have seen these issues with the instructions before approving them? If yes, how can they appeal a mistake they approved?
They came in hot. The instructions came in hot. We saw them come in hot.
After 7 weeks of trial. Yeah.
Well, not ideal, I would say. And you could tell that judge was upset at them for not having instructions to her by like Monday. Because she's fighting with them at the end of the day. She's like, where are we on the jury instructions?
She was frustrated with them for handling the evidence on the jury instructions. Like there were times when, I mean, kudos to her composure because it looked like she wanted to ring them up at some occasions.
It does make you wonder exactly how bad some of that stuff would have to be to not get the judge thanking everyone for their professionalism at the end of the trial. One wonders.
Mademoiselle, aka Heather, says, can you clarify, is the jury question about the instructions or the verdict form?
Yes. The actual motion is about how the verdict form misorders things from the instructions. So the answer is yes.
Yes. Fair point. Daniel W. Chukri, thank you so much for your soup chat. Paula Ursina says, confused. If the title was in the article that she wrote, so what is the issue? Don't understand. Explain. Well, typically with these online versions of these articles, what happens is you get a title that gets applied to the article that the author doesn't necessarily have any kind of a say in. It's just the publisher decides this is what we're going to title it because this is what's going to make waves. This is what's going to catch attention. They might change it a couple times just to, I mean, essentially like titling a YouTube video, you know, all those of us that have been making videos on YouTube, we might change them every once in a while to try to triangulate to catch some part of the YouTube algorithm. And then something will catch interest and then it'll kind of take off a bit. So sometimes you change it a few times and that'll happen. So in these online articles, the same thing will be true there. Yeah. So that's basically it. She doesn't really have any sort of a say in that. However, I got distracted for a second. However, she does have a say in what goes into a tweet that she decides to create from the beginning and a link that she decides to put in there. Crown V says, Amber has lied under oath multiple times. If she is not held responsible for that, isn't that a bad thing, bad look moving forward? What is the point of testifying under oath then?
Signaling function is what we would usually call it. There's a lot of people that are well-meaning and will do their best to honor their oaths and their promises and things along those lines. And the entire system kind of depends on that as a good citizen of the United States. As for whether she lied under oath, eye of the beholder, a little bit. I mean, I think a lot of us are in agreement on that, but they both presented cases.
Yeah, I think the lying under oath is extremely hard to prove, and I don't think you have enough to actually try to hit her with perjury.
Probably. Manny Fabani says, question for Hogue. Would you rather as Amber Heard's attorney or play as Abby throughout the entire TLOU2 story, including Ellie's portion?
You might be surprised to find I don't mind Abby as much as some. So I would easily rather play TLOU2 as Abby than be Amber Heard's attorney.
There you
Except
go.
for the $6 million.
The Kissy Wissy says, Hogue, I love Destiny 2 too. Have you played Returnal? Amazing.
Oh, yeah, I've played Returnal. Absolutely. If you go on my top 10 games of the year list video from last year, Returnal is very, very high up there. It is one of my favorite Twitch shooters in a very long time. Highly recommended to everybody that hasn't played it. Coming to PC very soon, says the rumors.
Peter, thanks so much for your generous super chat. Says, Hogue, any commentary on running a fiat currency across 5 different governments and 1,000 light years while operating a techno-babble pseudo-religion? Also, watch Tex Talks Battletech. I'm not sure. I feel like you understand all of these references that I do not understand.
It's just a Battletech reference. I feel like if you were to demand of speculative fiction entirely workable economies or principles, you would limit yourself to speculative fiction that maybe isn't as interesting. I love Star Trek, for instance. Do I think that their post-money society actually functions in a terribly realistic way? No, but that makes the story jumping off point more interesting. And it's the same with Battletech and the same with other things that you can still enjoy. Accept the premises and see where those premises lead. That's the philosophical fun.
Yep.
I have thoughts on fiction, folks.
You do. You absolutely do. And I love it. I love it. Rebecca says, body of the print and online op-eds are identical other than headlines. Ergo, that and isn't problematic since it refers to the body of the op-ed, right?
No. Specifically, no. That question on the verdict form is about the headline.
There you go.
It is not about the body of the work. And if that's what they were asking the question about today, and if they are confusing it the way that you did, respectfully, then we've got a problem.
Wendy Pinkerton says, sorry, only caught a little bit of this today. Have we heard from the jury at all? We got one question from them. One question, and it had to do with the title of the op-ed. And basically the response from the judge was the statement that is the title of the op-ed is basically that statement only. It's not supposed to be representative of the entire op-ed as a whole for statement number 1. Just a Ghost says, why do I feel like Hogue gives off free birth Steiner vibes? I don't know what that means. Meanwhile, I'm over here clan ghost bears for life. Queoff. What does that mean? Rick, am I reading something improper out loud that I have no idea?
No, I don't recognize the reference either. Ghost Bears and Steiner. It rings a bell, and it's a distant bell with a very small chime. I'm sorry to say, chat person. I've kept up with most of your references, chat, throughout the day, but I'm not going to get that one. I apologize. Rob is currently looking up Steiner and Ghost Bears right as we speak.
I'm nervous. I'm glad I'm on a VPN.
Yeah,
I'm also nervous because I read it out loud, not knowing what it was.
BattleTech?
Okay, BattleTech. Yep. So it's another BattleTech reference. I played BattleTech. People ask me about Dungeons and Dragons. I played BattleTech in high school, which is an inordinate amount of years before now. Okay, so I don't remember the clan names, I'm sorry to say. And since then, I've played a lot of Mech Warrior, which has completely different clan names in a PC setting. Sorry.
Yep. And just to remind everybody in the chat, because we did say this earlier, but some folks are questioning about it. But yes, the jury has gone home for the day. We did show Johnny Depp's team filing into the car again to leave the courthouse. So they are done for the day. We are just going through super chats, and then we'll be closing this up as soon as we're finished with these super chats. And then we'll be coming back tomorrow to do the same thing all over again. We'll be
More
tomorrow.
hours.
I will tell you, we're going to go over the Jennifer Howell letter. We're going to go over the Australia tapes.
What?
We're going to go over some charges, maybe some San Francisco tapes. We're going to go crazy tomorrow. We're going to go crazy.
What a
With
day.
all
We
this
can't miss that. Where would that be broadcast? Where would we find that tomorrow?
Right
here?
Would that be here?
Right here.
Wow. Don't touch that dial, folks. We'll be right back.
Don't touch
Actually,
that
we have a ton
dial.
more super chats. Because
I
the
mean,
jury's
except for if
going
you haven't hit
home.
the red button to subscribe. Touch
Oh,
that
yeah,
one.
you can subscribe. Yeah, subscribe. Like ring bells. There's like a little bell picture. All sorts of good stuff down there for you to click on.
Tim Weinebrenner says, can you introduce yourselves again? Maybe every 20 minutes.
People would die if we did it every 20 minutes.
That would get really
I
boring.
forgot who I am like 20 minutes
Rob has
ago.
no idea who he is. It's been 7 weeks between now and when Rob knew who he was. He's a completely different person. He's changed. You know Frodo at the end of the Lord of the
He's
Rings?
definitely
That's
changed,
Rob
man.
right now. He's seen things.
Yep. Oh, that's a good idea, chat. Simon Van Dyke, it's a good idea to change that pinned chat.
Yeah. Just
So
put some
I will do
Doppio
that.
up top because they're going home. Yeah. Sorry. Very topical reference. I know.
9 a.m. Okay, here we go. And Suki says, why isn't the jury allowed to use a dictionary, or have I misunderstood? The reason why is because you can have many different types of dictionaries that give many different types of decisions. And so there are very specific terms that are to be used in this case. And so those terms have been decided by the judge and by the two parties that all of them agree as to the definition of these specific terms. So hopefully they aren't tempted to go outside of that and to look up definitions from elsewhere, because the reason why they would do that most likely is because it's somehow unclear to them. I really, really hope that that's not the case. Sometimes it does happen. It surely does happen. But basically the whole reason why is because they want the jury to use the definition that has been supplied to them by the model jury instructions and by the court and by the two parties that everybody has basically agreed upon. Sarah Emberton says, just jumping back on and saw there was a jury question. Can you discuss what the jury question means for Johnny, good or bad? Love you guys. I'm neutral. Rick seems to think it's good for Johnny. Mike seems to think it's bad for Johnny. I think overall, I guess maybe people have landed that it's maybe good for Johnny. I don't know.
I'd be on the, I think it's probably on the better side, but who knows? It's reading the tea leaves.
It suggests that at least that first statement's still on the table for Johnny Depp. That's what it suggests, that they're at least considering that one pretty seriously.
They're considering statement number one is good. There's a fight about it, which is interesting. And it would appear they're past republication. And the answer is unequivocally good for Johnny, because the alternate would only lessen the impact of the headline. So the answer is good for Johnny.
Well, what I was saying is that they wouldn't ask the question if they didn't already, in my opinion, get past the republication hurdle.
I agree.
Otherwise, it's not an issue for them.
Because you can kill all that deliberation if you decide it wasn't republished.
However, let's slaughter that entire assessment, which what ended up coming back with the Rittenhouse verdict, where they went in reverse order on the acquittals. So
They did indeed.
We have our opinions, but they're opinions.
But that also had to do with a lot of that was writing on self-defense, right? So yeah. So the way that they were going about it was weird. Melanie Ann says, "I keep hearing ACLU is suing Depp. What the beep?" Yeah, it's just so that they can get reimbursement for reasonable costs and fees associated with document production. What they are
My
alleging
answer would be no.
Yeah.
If you want to go after anyone, go after the person. Yeah. I don't.
Well, I mean, his side is they're the ones that requested the documents, so it is probably reasonable to request reasonable fees and costs associated with that.
$5 a page. Go nuts.
I was gonna say 10 cents, like I said earlier.
I go $5 a page.
Even still, you don't get to $83,000. Yeah. Anon M says, if the panel was a mock jury, how would you all try to argue with best effort not to be biased? I mean, I think that if I were on the jury and we decided to sort of go around in circles about how this jury could be arguing, it would be on the definition of what is a lie, the definition of what is abuse, the definition of what else here? Also how to approach these statements. That we got a little bit of a window into, perhaps with that one question that we got, which is like, okay, you're supposed to take each individual statement on its own, but also not really on its own because it's supposed to be in context, but also mostly ignore the rest of the op-ed. So I can see a lot of interpretation kind of arguments going on back and forth in the jury deliberation room along those questions.
Well, that's why the first statement's so important. Because if they hit the headline, which is the narrowest and hardest for Amber Heard's team to prove, I don't mean to say the rest of the paperwork is kind of inconsequential, but realistically it is. Because if they find that the first headline statement is republished and defamatory, those fights get a lot less vociferous on statements 2 and 3.
Yeah.
Doesn't necessarily.
I
just feel like there's an easy way to distinguish it. Like I could see, as I said, sort of splitting the baby on the first statement, but not the other two.
Yeah, but you don't care if you won statement 1. That's what I'm saying. It gets a lot less vociferous. If statement 1 is defamatory, you're talking about the number. That's all statements 2 and 3 do.
Yeah. Okay. Yeah. Teja Mandava says, judge versus jury instructions. Don't state an opinion that pride will get in the way of versus do you believe defamation happened? Then go through the individual elements of defamation. Shouldn't it be the other way around?
She's looking at the verdict form.
Okay.
Yeah.
The verdict form is hard to understand. How it's the order of the questions, the order of the statements. It is kind of hard to understand.
There was a bunch of stuff that day that was weird because it's like the judge implied that you had to find all 3 statements in order to get to the damages page once. And like there's a bunch of things there where it's like, I know that that's not the case. I know what's happening here. I even know what you said might be technically right, but all of this is a little confusing for somebody that isn't trained in this stuff.
And we talked a little bit about that, and it just muddies the water, which is not what you want when you're giving a jury charge.
Yeah. Next one. Mr. DNA 1987 says, if a verdict comes in towards 5 p.m., do they extend the day or does it wait till tomorrow? They would extend the day so that they could let them go and not make them come back.
Mm-hmm.
Chris P says, question, if the headline is the only thing she didn't write, does it become moot if her tweeting it is shown as republication and therefore agreeing to it? Exactly.
Yes.
That's exactly the argument.
Yes.
Chitters 2004 says, could the question imply that the jury are taking the other 2 statements in the context of the whole article? I thought they are not supposed to.
No, they are.
But that's where it gets complicated because the question and the judge answered the question in a way that is separate from how the actual jury instructions were read. I don't know if it's necessarily a contradiction, but it, as I said, it muddies the water.
Yeah. Christopher Black says, how long do you think it would take for a jury of random lawyers to come to a verdict? I don't know.
I think we would have been done on Friday.
Yeah. Yeah, we probably would have, probably. Although, lawyers also are not also immune to thinking illogically and thinking, much more emotionally and with bias and all of that kind of stuff too. So keep that in mind also.
Well, and I think we'd make a bad mock jury. And I thought this in other contexts because we've been working on each other for 7 weeks. I mean, we've been talking about these things. Redirect happens for Johnny and Alita's going off in the corner yelling, "I told you so" at me. I saw that. I mean, like, I know where people are coming from. We've talked to each other about where we might come out on these things. I've given percentages almost every day. That's supposed to be entirely different for the jury that just met each other basically on Friday afternoon. Now, we know that's not the truth, but this is supposed to be that the deliberations start on Friday. And we've got what? We've got 10 hours or 9 hours of deliberation in the
9 hours.
Yeah. Okay. So, I mean, like, that's not an insubstantial amount of time to talk about this stuff.
Yeah. Yeah. Fair point.
That's fair.
So, yeah. Kai and Hi says, question, any thoughts on ACLU filing for JD to compensate them for $85K for their fees in producing documents for discovery? The court doc is on Twitter. I'm for sure going to be looking at this. If there's anything new to talk about tomorrow, I will for sure be bringing this up. But it seems about the same as what I had seen before.
I was gonna say, maybe you can figure out why it popped back up.
Yeah,
that would be a useful piece of information because
I agree.
We knew about this weeks ago.
Yeah, Kane Reed.
I'm just curious why they don't tell them to go blank themselves at this point.
They will.
Like, you could have invoiced us when we sent the subpoena. You didn't, I guess, or they didn't pay them. That would be the bad side.
Yeah. Kane Reed says, is a verdict likely to come today? Well, no. No, not at this point. Lindsay C says, any idea when we're going to show Hogue the JH statement or maybe the Australian audio tomorrow? Both of them.
There's always
assuming he's here for it.
I'm going to try to be here. I'm practicing law. You see me pop out from time to time, but I will try to be here.
Yeah, for sure. Mochi Katsu says, what are your thoughts on the Wagatha Christie trial? Wagatha Christie? Do you mean Agatha Christie?
No, she means Wagatha. It's something that's referenced in a bunch of the headlines I'm reading now, especially out of Britain. But I have no idea what it is.
Okay. Well, I'm writing it down. Just as something to possibly look up. Fozzie Blob says, I love some of these names, I swear. Says, off-topic question. Do any of you know of Tyler Pitchford? Works at Goldfine Claims Management. It's interesting that he created a BitTorrent client years ago, but works in the legal system from the UK. I don't. Don't know of this. I'm sorry. Araceli says, Alita, how many pets do you have? Non-related question. I appreciate that. It's nice to get those every once in a while. I have 3 pets. I have Indy the dog, Holmes the cat, and Astra the cat. Or the kitten, as we often refer to her. Astra usually doesn't show up in most of these videos because Indy is almost always by my side, and Astra still does not like Indy. Holmes and Astra get along famously. Holmes and Indy get along famously. But for whatever reason, Indy gets too excited still whenever she sees Astra. Astra does not appreciate Indy getting excited. So that's how the cycle continues. Antonis Pelicano says, what happens if the jury finds some, but not all of the statements defamatory? Sorry if already answered. Then they find defamation. If it's on Johnny's side, if they find that some of the statements by Amber Heard are defamatory, but not all of them are, he wins. All he needs is one. Same thing with Amber Heard on her statements. All she needs is for them to find that one was defamatory, and she wins on her claims. Gwen Gerard says, if someone has a cognitive disorder of some type, can they still be on a jury? If so, if they cause a hung jury, is that a reason for appeal? It depends on the level of the cognitive disorder, right? I mean, what would folks that have, guys that have dealt with a jury more recently, what would you say?
That's a tough question.
It is a tough question. Most likely,
could you argue that that's a removal for cause because I don't know if you would go directly at the cognitive difficulty. You'd ask them a question, more along the lines of,
yeah,
do you feel like you're capable of understanding something like that? I don't know how you'd phrase it, but I think that would be a for-cause strike.
There'd have to be a reason why that would. I mean,
there was a way to elicit that.
The judge most likely would start asking very, very particular questions of that potential juror, and basically just to get at, is this person competent enough to sit as a juror? I mean, similar to, the question of whether somebody is competent enough to enter into a contract, competent enough to enter into a will or to create a trust. There are certain questions that can be asked in order to determine that. And basically what that comes down to is, do they understand the process? Do they understand what's going on? And can they grasp the concepts at hand so that they can really make a proper decision here? So just because somebody has some kind of a cognitive disorder on its own is probably not going to be enough to remove someone from a jury. It would really depend on the circumstances of that cognitive disorder and how much of an impact it has on that person.
Yeah.
Well said.
Okay, cool. All righty. Yanni Tara Skjoldborg, thank you very much for your generous super chat. Vanessa Bobesser says, thought the ACLU spent around $80K fighting the subpoena. Maybe they're including it in the reimbursement request. Thanks to all on the panel for coverage. Well, if that's the case, then that's a personal problem.
That's not getting their way.
Yeah, that's a personal problem. That's not a Johnny Depp problem. Cha Gonzalez says, uncivil, you're wrong on number 2. It's not to decide if paper title and web title are defamation. It's the statement under. Sorry if you addressed this.
That's not how I read it. Just, defending Kurt a little bit.
Yeah, I mean, I didn't look at it as closely as Kurt, so I'm gonna have to take a look at this after the stream. Yeah, I think
I'm gonna pull it up while you're going.
Looking at it and analyzing it while at the same time focusing on all the live streamy stuff is not gonna work for me. So I've got to do that after we close things down for sure. Kelly Boyd, thank you very much for your generous super chat. John Fowler says, what do you do in court during deliberations? As one of the lawyers that is involved in the case, you are working on other cases that you have ignored and that have all kinds of fires that probably need to be put out at this point.
So many emails. So many.
Natalie Wisco gave my favorite answer to this one.
Yeah, she had a great answer. There's also that. Some judges will have the jurors that did not make it into the deliberation room. They'll have them hang out just in case something happens on one of the deliberation days, just to have them join in instead and replace one of the jurors. So sometimes they'll do things to keep them occupied. For example, Judge Schrader in the Rittenhouse trial was playing Jeopardy with them. And I remember we asked Natalie afterwards if he allowed the lawyers to answer, and she said no, they're not allowed. They're excluded from the game. So she was like, I really wanted to play, but I wasn't allowed to. It was funny. Raven Scarata says, speaking of games, have you considered trying the Ace Attorney series? Well, I know Rick is very well familiar with that one. I have never played it, but I
do the voices for my family. Are you kidding me?
Oh, yeah.
I got voices for everybody. I got voices for Edgeworth. I got voices for Wright and Maya and Mia and Payne. I got voices for parrots. I got voices for clowns. I'm a regular actor in Hogue House for Ace Attorney Night.
I love it. Elizabeth B says, what are the Depp and Heard legal teams doing while the jury is deliberating? Do they actually get to sleep now? Hopefully, or just, just running straight on to the next case. Who knows? I mean, it depends on what their workload is. My hope is that they get at least a small breather so that they can get caught up on rest and sort of clear out the cobwebs from their brains that must have formed over time just from living this case for so long.
Oh my goodness. After being on trial that long, you can only imagine how much backlog they have.
Yeah.
And exactly. I did look back at the verdict form. There is some truth in between what the chat said and what Kurt was talking about. So I don't want to go into it in detail, but It's not as clear as Kurt made it as being a compound question.
Okay. Sabine R says, can JD just pledge the money for the documents to the ACLU? Oh, that would be choice. That'd be quite choice. The Sia 33 says, if you guys weren't lawyers, what's another profession you'd be interested in? Probably to be a psychologist.
I want to be a cardiologist.
Oh, nice.
If you don't know the answer to this question for me, you're silly.
Woodworker.
Carpenter.
No, not woodworking. Rob doesn't even like woodworking.
I told you, Rob, I was a carpenter for all of my summers in college.
Oh,
a carpenter's apprentice.
That's so
cool. Awesome. I love that.
Rick, what would you do?
And I don't know what I would do if I wasn't doing this. I mean, something directly in business, I suppose. Entrepreneurship. I'd be a serial entrepreneur.
That'd be cool. That'd be pretty cool. Yeah, no, for me, it's all about getting to that the answer to that question. Why do we do what we do? So I probably would have gone into some form of psychology if I did things differently.
Come on, you're not going to pull the trigger right and go psychiatry?
Well, I don't know.
You could be Dr. Doofenshmirtz.
I'd rather go the Dr. Curry route than the Dr. Hughes route.
Fair enough.
Nakuar says, question, have you ever had a difficult client the way Amber Heard's legal team maybe got? Example, e.g. presumably demanding to take the stand against their advice or demanding a strategy that isn't advisable. How do you deal with that? Well, so there are specific rules for how to deal with that. You have to give them a very clear opinion on what you think should happen in the case. And if they vehemently disagree with that, you have to either you have to explain all of the reasons why that idea is a terrible idea. Do it in writing because you want to make sure that is in writing for a good CYA, or at least follow it up in writing with an email or something. And then if they decide that they want to continue, if it really, really, really bothers you and you cannot do it, withdraw. That's the answer, usually. So, but for me personally, I have never dealt with a client that is that bad. I have had clients where we have had to have some heart-to-hearts, have some explanations, but that's about it. It has never gotten that bad for me.
I've had some clients, well, in the insurance defense world, where you talk to the client and you have to inform their insurance carrier that we really do not want to go to trial on this because your insured is probably not a great witness in their own defense. And that's a really tough situation, but that's the best you can do in terms of advice. And then you handle it precisely like Alita said.
The Kissy Wizzy says, question, why didn't this come up during Amber Heard's cross? Why didn't AH sign the pledge document, making it an actual pledge, legally binding, rather than a wishy-washy promise? Well, because the reason why doesn't matter. What matters is that she didn't sign it, right? So she didn't actually make a pledge, even though she says that I pledged, which means I donated. So even that argument, it proves to be a false, or at the very least, not exactly accurate, right? So the reason why doesn't matter. So that asking that question probably would have been the question too many. So you may have gotten some kind of a response from her that would basically allow her to clean up the whole reason for why she didn't do it, why she didn't sign it. Maybe she didn't have an opportunity. Maybe she had verbal communications with them and everybody kind of understood where they were on the same page. She could have given all kinds of different reasons that would have made that point less salient. Notsology says, question, is it true that you have to hire a lawyer in the UK to get something notarized in comparison to the US of just finding a notary? I'm so sorry. This is one of those, I knew there was going to be some questions that we missed with Daniel earlier, but so I can't speak to the UK, but in the United States, yeah, I mean, if you're just getting a question, if you're just getting a signature verified, essentially, like you have a particular document where you need to ensure that this signature is authentic. Best way to do that is to go to a notary. You could do that basically anywhere. You can find them at a bank, you can find them at the post office, you can find them mobile, all kinds of different places. But I don't know about the rule in the UK, and I really apologize that we did not get to that before he left. Lon Dub says, can JD not being given images of Amber Heard's phones, etc., and lack of relevant jury instructions be grounds for mistrial if JD loses? I don't think that it would be grounds for a mistrial. It could be grounds for an appeal, possibly, maybe, because that issue has been preserved through the motion for sanctions, and there is a ruling on it. So that's a possibility. Whether it would win, I don't really know. Liz Smith says, I must see Hogue react to the audio and other leaked evidence not shown in court. I've been avoiding it all so I can react with him in real time. I know you said today. Any idea when? I promise you that tomorrow we will be getting to a lot of this stuff. We will, for sure. We're going to start off the day with Jennifer Howell's letter, and then we're going to go right to the Australia tapes, and then we're going to get to whatever other tapes that we can get to. Good.
Yes,
and
good.
I cannot guarantee that Rick will be here for it because I can't speak to his timeline or his calendar.
Neither
so
can
I
my
have no idea.
client.
What's that?
I said neither can my clients. There's fires to put out every day. We just try to figure out when to put them out.
Exactly.
But no, I'm happy to be here for it. I'm heartened that so many people have asked about me watching this stuff. So I'm happy to do it. I just I will be here tomorrow. I just probably not the whole every minute, and we'll figure out a good time to do it.
Exactly. Grace Nadine says Amber Heard during rebuttal said people had been mocking her testimony. Wasn't she not supposed to look at news and gossip during the duration of the trial? Thank you. Well, as a party to the litigation, she is allowed to. She's under one of those exceptions to the rule. Same thing with Johnny Depp and experts as well, because they are able to comment on it. Now, her testifying to that in front of the jury was arguably improper because you're not supposed to bring in information from the outside world. However, is that at the end of the day such a huge issue? Not really. I don't think the jury's going to be swayed one way or another by it. Lainey Briggs says, didn't the WP write the title to AH op-ed? How does this affect the jury instruction? Well, yes, arguably the Washington Post wrote the title to the op-ed, the online version of it. However, at the same time, the point that Johnny Depp's team is pushing to the jury is the fact that she republished it in her tweet when she tweeted out the link, and she said, I wrote this whole thing. I'm proud of this. I don't know if she said I'm proud of this whole thing, but basically more or less a bunch of words talking about how I'm taking ownership of this whole article. Paula Lorraine Russell. Hi from South Africa. You guys rock. Studying to be a lawyer at 30. Y'all make it that much better. Awesome. Well, good luck for sure. And I'm sure you'll do great. Theolodes Lask says, will someone of you cover Gruden versus NFL? I have talked about it a little bit on this channel. I think Rick has talked about it a bit on his, and I know that he's got like a one sentence conclusion on how that is likely to result.
Oh, I mean, I think it's going to settle because you're not going to want to get discovery into the NFL's emails even more than it already is. But yeah, I got a big long video going over the entire complaint document. Sorry, just trying to sneak in dinner.
Oh, of course. Of course, totally understandable. Colby Lewis says, in ACLU guide testimony, didn't lawyers ask questions about the info gathered being data kept as part of normal course of business? Answer was yes. Can JD's side use his answer to respond to the roughly $90,000 lawsuit? Well, $90,000 claim for fees and whatnot. Yes. And even that answer doesn't even matter because it should be just as a standard. They can only get reasonable fees and costs for something like that. They can't just like throw a number in the air, throw a bunch of employees on gathering those documents and disorganizing and then organizing everything to turn it over to them and then say, oh, you owe us all of this money. You can't do that. You have to be reasonable. You have to be as efficient as possible.
And for folks, those are two separate questions because kept as a normal course of business is a hearsay exception for the business record exception.
Yes.
It had nothing to do with whether, turning them over didn't have any cost.
Yeah. Yeah. Don Hinton says, I'd love to hear Kurt et al. Study for the bar exam in Texas. Any chance that could be a weekly thing? Well, he has done some bar questions on live streams and whatnot from time to time. I don't know exactly what he's doing to study for it, but I would imagine he would enjoy studying with folks or revealing some of his studying process with people, just because it's kind of fun and he's doing it anyway. Gabriela Hindi says, did anyone notice Amber saying she did makeup and special effects professionally in her opening statement and testimony? Could this explain her ability to create fake bruising, etc.? It could. Honestly, and also just her time on set could also explain that she may have gotten curious working with makeup artists and just asked about it and learned about it while on set. That's always a possibility on its own. Alexander Foster says, thank you all. Love this channel. Will you guys ever do reviews of an old case? I'm kind of obsessed with the staircase Michael Peterson debacle.
No, I'm going to do the Lindbergh kidnapping.
Ooh.
I'm working on that right now.
Really?
Really?
That is really cool.
They brought in a lumber/wood expert to testify to how they matched up the ladder to the wood that was in the person's barn.
That's amazing.
Rob, how are you doing your historical research for which major cases had lumber components? I'm really curious.
I'm not actually. What was funny about it, the second I mentioned the possibility of me doing these old cases, a bunch of people went through the woodwork and pulled these. I did not mean to say that.
Oh, yes, you did. Don't deny the no pun intended.
No, that was just really tired. And sent me emails of suggested cases to do. And I've been kind of trying to parse through whichever cases have the most information. These old cases, finding information on it is hard. But there's a lot of these cool ones out there.
I'm looking forward to it, Rob.
Likewise.
Yeah, me too. And I'm writing down that other case, that the staircase and Michael Peterson debacle. I will look into it. I'm happy to look into old cases if folks are interested in it. And I'm happy to look into current ones. I think sometimes being able to filter in some older stuff too helps me to kind of schedule content, which makes my life a bit easier and a bit more predictable. So that also is a welcome thing. If people are interested in also looking historically as well as current, for me, that makes my life much more pleasant. Valhalla says, can BBB finish explaining whether the UK accepted the body cam footage into evidence? I'm so sorry. I'm sorry that we missed him. I tried getting all of them in front of him, and I am so sorry. Nathan's Way says, have you ever thought about the West Memphis 3 case and the mess they had with evidence testing? I don't know about this case.
I only know vaguely enough that I don't want to comment.
Okay, sure. That's fine. Fair enough. Sean D says, love the channel. Daniel, I'm sorry he's not here. Would you ever cover Phil Ivey versus Crockford's Casino? I've never understood how he lost. It seems completely unfair. Thank you. I'm sorry. I can't answer that without him here. Very much apologize. Mark Curtis says, can JD pledge to pay the ACLU the $86,000 they're asking for? I hear it as good as real money. That's a good point. Jennifer Pettis says, can you do a mock deliberation with a verdict form? Yes, that is another thing that we will be adding to the to-do list on these live streams that are going to be going on for quite a while. Assuming we don't get a jury verdict tomorrow, we might not. Be prepared to sit tight. And just hang out with conversation and whatnot. Absolute says, question, I'm also active duty and highly trained on firearms. Why do civilians need to be less trained than me on lethal weapons to obtain and hold them? We won't answer this question because of the fact that the chat will go wild, and this is not a 2A channel, and I am not particularly qualified to answer. And here's another one. I saw it coming. Don Hinton, thanks so much for your very generous super chat, says, I'm a USMC vet and I don't see any reason anyone needs an AR-15 type weapon. I have no weapons and don't need any. This just goes to show you've got folks of all stripes coming from even the similar or same communities that have differing opinions. We've got all kinds of opinions on this channel. I encourage folks to agree, to disagree, so long as we keep it respectful. But respectfully, I'm so sorry, guys. We're not going to have further dialogue on guns and whatnot. Josette Hill says, back during the 20s to 30s, weren't machine guns outlawed? Why can't this be done with AR-15s? Again, I'm so sorry. I'm reading them out loud because I want to honor the fact that folks are asking these questions. They're sending in the super chats, but I really apologize. I wish that I can give answers to every single super chat. Annette Malero says, question, not sure if you've covered this yet, but what are the repercussions for perjury on the stand? Difference between UK and the United States? Thanks. We did discuss this quite a bit. Okay. Sorry, I just saw something that popped up. So as far as perjury is concerned, it sounds like in both the United States and the UK, based on our discussion earlier, most likely we are not going to see any kind of perjury charges or anything in either jurisdiction, because either one is going to be extremely difficult to put forward, to bring forward, and to successfully prosecute.
Honest mistake is a perfect defense.
Exactly. Ashley Townsend says, #1 cause of death for children is now guns. No one needs an AR-15. One of the parents will be doing an open casket so people can see the damage caused. Absolutely tragic. Absolutely tragic. And I apologize for the ruckus involved with this conversation. But yeah, not going to be having further conversation. Just a bill. Ashley Townsend, citations needed on leading cause of child deaths. Who are you to say what people need? Well, again, please try to keep this stuff respectful, guys. Green RN says, any thoughts on RN Vought trial or consequences? I don't know.
Was this the one that administered the paralytic?
It may have been, yes. Perhaps there was like an anesthesia or something that was improperly given or something like that. It was like a medical malpractice kind of case, but murder. I wasn't covering this one, but I was aware. I think Kurt was actually covering that one, and I think that his conclusion was, well, I don't want to speak to his conclusion because I may misrepresent it.
If it's the one that I'm recalling correctly, I think that we have. It's something that I've been monitoring and kind of looking at. I think that there is kind of a push to not allow mistake of facts to be a defense. And I don't want to get super, super controversial. I think a lot of that kind of started with other incidents, and now the idea that something that is medical malpractice or a professional error is criminal is a really dangerous line to go down.
I know there are a lot of nurses that were very, very nervous about that conclusion of that trial for that exact reason. And yeah, I definitely understand that anxiety. I haven't looked into it too much to really be able to say whether or not those anxieties are warranted. Sure. But no, I do understand that that's a concern that a lot of people from the profession have had based on what I've seen, people communicating out in the virtual world. HW says, John, set up a channel yet? I'm subscriber #1.
God, I really need to get around to actually just sitting down at a desk and doing it, but I'm having too much fun hanging out with you all.
Tiffany Delano says, why can't jury use a dictionary? Answer, we discussed this earlier, but the answer is because the definitions are supplied by the court and they are agreed upon by the two parties. There's all kinds of ways that another dictionary can come up with a different definition of a particular term that is unintended and unhelpful to this particular case. Tyra Benton says, hey, Latu, what happens if she doesn't pay him? Well, he can go after her for all of her stuff. He can try to garnish her wages, or if she's got nothing, then he gets nothing. But something tells me he's not really that concerned.
Blood from a stone.
Exactly. Adam T says, I think the worst thing was all the time he spent with Make-A-Wish and the children's hospitals disappeared with Amber statements, and yet they never got the money Amber, quote unquote, donated. Gwen Mendez says, question to BBB, Meghan Markle lied and said her intention was not to mislead the court and got away with it. Can Amber use the same excuse and get away with it? Well, it's a different case, different court system. Meghan Markle, that case was in the UK, I believe. Amber Heard's case is in Virginia now, and she's not going to be adding any claims to it. The jury is out right now, and they are deciding the case, and we have seen all of the arguments that the jury is considering for it. So, no. Gil Gordon says, are you folks creating the first internet chambers? Oh, that would be funny. Chris Burton says, is there any connection between the time it takes to deliberate and how promising it might seem for either Amber or Johnny? That is, we can come up with the way that we feel about stuff, but it's purely speculation.
Yeah.
There can be all kinds of reasons why people decide to do things quickly or slowly.
Yeah, I'm just going to defer to you on that one.
Mr. E says, enjoying the coverage, great job. If Johnny was disabled, say legally blind under the ADA, what effect would that have? Any good channels on ADA law? I don't know about any channels that specifically cover ADA law. If Johnny was disabled, he could still be a DV victim or abuser in any kind of a case, regardless of whether he's disabled. Like I can envision a universe in which that is possible. Not saying that I know of any cases like that, not saying that I have heard of any cases like that, but I'm just saying that there is a world in which that's possible.
I don't think that
at least theoretically.
I don't think the ADA has a shield against litigation.
Right.
So I don't know what the relevance would be between the two.
The question, I mean, the only way that something like that would really come into play is if it impacts his like physical ability to physically harm someone else. But remember that abuse is not just physical. You can also have mental and emotional and like manipulation type of abuse as well.
Yeah, but so what? If he's blind in one eye, that seems like an utterly irrelevant disability to the claims being made.
Yeah.
By either side.
Yeah. And generally speaking, the Americans with Disabilities Act has to do with discrimination against people with disabilities. So rather than
generally by companies and the government, not necessarily private individuals.
Yes, exactly. So basically not much relevance at all, really. Rooter K says, unfortunately, thank you for the very generous super chat. Says, unfortunately, watched the closing arguments later, so I missed an opportunity to thank you for your coverage throughout the trial. I've learned so much from all of you. Respect and love for all the panel members. Love. Also, love waiting here. Oh, thank you so much. And I'm so glad that you're joining us. Those are very kind words as well. Chris Burton says, today the jury asked the just about the headline of the op-ed and rather to consider if that defames Johnny. Good stuff, bad stuff, nothing. I mean, that's why I think it's probably neutral, because it's just asking about the way that they should be defining certain things rather than whether or not they should say it defames him. Maybe that's that probably is a consideration for them for determining whether or not it defames, but they're not going to ask the judge if it defames him, because that's their job to do, not the judge's. Rob Barron says, which panelist would be most likely to field questions about real estate law? More specifically, judgments, garnishments, deeds, non-responsive representatives of judgment creditors, jurisdiction. I don't know. I don't know if we have anybody that really focuses on real estate law.
I was going to say, am I most likely by default?
I was a paralegal for a foreclosure firm in New York for a year and a half.
That wins.
I'm not sure if I can necessarily help you, but I can try and explain some things.
Yeah, for sure. Jessica Thomas, thanks so much for the super chat. Lone Star Law says, Black Belt, I'm so sorry that he's not here. What's your impression of American lawyers? I found English lawyers to be very intense and hardworking and was generally impressed. I'm very sorry. I didn't get this one to him on time. Robert McLean says, uncivil, I hear you will be streaming the Daybell and Vallow hearings. Will you have a panel collaboration with Annie Cushing? I'm sorry that he's not here to answer this. I know that he intends to have a panel of people to join him. because usually that makes these long trial streams quite a bit easier when you have folks to talk with and to sort of help with conversation and whatnot while you're managing things on the back end. So I would imagine so. Fortuna says, is it possible that juror number 5 is paid off by Amber Heard? When Rob, Ian, and James come around, can you ask them about this? I don't know if Rob is listening here or if he's just got his camera off.
I also don't think anyone will ever answer.
Listening briefly. Is that
okay?
Juror 5's paid off? No, there's no possibility that any one of the jurors are paid off.
Got it. There you go.
Quick phone calls. So, but I'll be around later, guys.
Okay. Yeah. See ya.
See ya.
Annette Temple says, any guesses on what Ben's motion might have been? Well, now we went through it, right? So it had to do with the closing arguments, basically. And some improper arguments, which were not objected to in the moment. So that's unfortunate for Johnny Depp's team because there's a timeliness issue there. John Hendrickson says, Hogue, thoughts on Wheel of Time series? I don't know if Rick is there. Oh,
Wheel of Time starts strong, gets weak, repeats itself, which is actually pretty within the kind of theme of the book, but is what I consider to be discount Lord of the Rings. I'm sorry if that makes me haughty, but I just don't like it as much as some other series. But thank you for asking.
I can never quite get into it.
And also here's a response to the ADA issue from earlier. Corfy Stone, thank you so much for the generous super chat. Says, I'm an ADA attorney and it does not apply to this case. It applies to discrimination by employers and or by public accommodations of business. There you go. There you go. Okay. Thank you for that confirmation for that. Saffron says, does the UK have super lawyers? LOL. I'm sorry that I couldn't get that in front of Daniel earlier as well. I would imagine that they would probably have some kind of way for marketing for attorneys, but maybe they are a bit more official than we are here in the United States. So they don't have to rely on those kind of marketing gimmicks. Bob St. Clair says, is the jury smart enough to realize that if their decision was too fast, pro-AH mainstream media would use it as proof that they were biased? Is the jury smart enough to realize that if their decision was too fast? Well, I don't know that they would be very specific on pro-Amber Heard mainstream media because they are not supposed to know anything about what's going on in the media or on social media, right? But I think that they would have a sense that there's a lot of public interest in the case. And so they would want to, possibly, there's a chance that they would want to take their time so that they show to everyone that has an interest in this case that they are taking their role seriously. Susan Guzzi says, can you recap what has happened so far today? Well, today was a whole lot of nothing, other than we got one question from the jury about the headline of the case as to whether the statement number 1 was just specifically the headline or whether that was supposed to be the entire Washington Post article. And the clarification was it's just the headline. Moving forward, says BBB, what's with the black rod? I am so sorry. That's another one that we didn't get to him earlier. I'm so sorry about that. Ian Kinsel says, is it illegal for lawyers to hypnotize witness during cross? Yes. Abhinav Varma says, can Amber Heard team be tried for perjury for showing messages received by JD as being sent by him on last day of trial? Can Amber Heard's team be tried for perjury for showing messages received by JD? No. Because there's always a chance that they are just using the evidence that was provided to them by the various witnesses. So they would have to absolutely know that what it is that they are presenting to the court is false or is untrue or is inaccurate. So you would have to show that they absolutely knew that. There's always a possibility that they put something to the court that is a mistake, and you're not going to get perjury for something like that. Thylod's Lask says, will any one of you cover the Gruden versus NFL trial? Thanks for the last week's. It was so much fun to watch with you. Greetings from Germany.
I tell you what, if there's an actual trial, that is the one kind of trial I might consider putting on my channel. So I don't think there will be an actual trial.
Probably
it will be
not.
Years in the making anyway, but I will cover it if no one else will, if that's a big deal and a trial actually happens.
There you go. Briley Clark says, I'm not sure if y'all already answered this, but what day do you suggest, or do you guys think they will reach a verdict? Also, future law student, hey, congratulations and good luck.
I've said Thursday. I've said Thursday the whole time. I'm sticking with Thursday. No reason to switch now.
It could very well be Thursday. It definitely could. I can see this going to the end of tomorrow for sure, but Thursday I can see happening as well. I mean, especially with how things happened today. We got one question. That question was rather late for an early kind of question.
Right.
So
right. We're on hour 6. You're asking about the first charge of the first page. Okay.
Yep. I expect them to take their time, and it's good. It's good for them to take their time. They should not feel rushed in making a decision. Lahava or Iahava. I'm sorry. I've gotten so many super chats from you, and every single time I'm not sure if that's an I or an L. Cute question for Daniel, and I'm also sorry that he's not here to get this. Free speech dead in the UK. See Count Dankula. People arrested for social media posts that are offensive. Speaker's Corner dead. Well, one thing that I can say is that there is no First Amendment in the UK. Speech rights are very different in the United Kingdom.
It is the United K. Maybe that's their new hit name. That's their street name. It's their band name.
It is indeed. Yes. So, their speech rights are going to be different than they are in the United States as well, just because of that. So Gamer Flair says there's talk about the US jurors and the pay they get. Is it not common for companies to pay them wages on service? In the UK, it seems mostly standard.
A number of them do. Absolutely. A number of them have jury policies in their handbook.
Mm-hmm. Indy Ox says, what does the panel think of the media coverage of the trial? I think it has been really biased along the lines of pro-AH, anti-JD, Me Too narrative. Yep.
Can I pitch tomorrow's show now while I'm sitting here? Because this is basically what we do. This is going to be tomorrow morning at 7 a.m. Eastern. It's you got a little slide there. Yeah, we got a Vanity Fair article from Monica Lewinsky telling us that we are all guilty for our treatment of the Johnny Depp and Amber Heard trial. So get excited about looking at that tomorrow morning. And in answer to your question more broadly in terms of the media, I try to cover a lot of this stuff that maybe can appear biased and talk about rhetoric and argumentation and how these things work in an article setting. There are things that are still out there that are interesting and good, and there are places that are more neutral than others. So I always hesitate to paint with a really broad brush on this stuff. Obviously, I've got plenty of headlines that look like this one that we can take a stab at, but I also do try to cover ones that are out there trying to be a little bit more neutral and telling the facts of the case. So don't throw everything away just yet, but if you do come and visit me in headlines, I will probably depress you.
Yeah, I think I'm going to see if I can join you for that, because I no longer have, I have finished all of my recaps. So I might actually be able to join you.
You're welcome, Alita.
Of course. Next one. So that was Indy Ox, Mr. Pickles. And this one is, I think,
it's not a very pleasant super chat, but we do appreciate the money. Thank you.
Yeah. Thanks, Mr. Pickles. That's very generous of you. Yeah, this is, I'm not an immigrant. Also, is just one thing that I'll say. I'm not an immigrant. I was born in California, but I appreciate it. Mr. Pickles, I know you know no harm. So we're gonna move on from there.
I wasn't even mentioned.
How rude.
That's how he got you the worst.
KW New York Upstate says, you are all in the same house in different rooms. Don't BS us. P.S. If a tree fell on a lawyer in the woods and no one was around, did it really happen?
The townsfolk will celebrate the loss of one lawyer, and we are, in fact, in one super big house that we're planning on announcing as the Lawyers of LawTube house, and we're going to have some real crazy antics this summer, so get excited.
I was going to say, it covers, at least 2 states and continents. So
it's a big house. I said it was a big house.
Tarsirian says, Rick, Ashley, or Caden?
Ashley every day and twice on Sunday.
I don't even know what that means, but sure.
It's a Mass Effect question, Alita.
Got it.
We're going to just have you in to just talk about genre-defying video games. We'll do some playthroughs or something.
Yeah, we've got to do that. Get me up to speed on these things so I can at least understand what it is that I'm reading about.
That's right. I can get you some info. You can talk to Mr. Bytes about the game he's playing. It'll be great.
Yeah. Julia C says, one of you, Sicilian from Princess Bride. Discuss. I mean, I love The Princess Bride. It's a really great movie.
I think I'm supposed to say inconceivable on that.
Seems where that was going.
I'm pretty sure that's my role. People have told me this. So thank you for the super chat.
Could very well be.
As you wish.
D. London, perfect. D. London 1144 says, as a minister, I've been excused jury duty 3 times.
You gotta watch JD as your acronym.
As a minister, it could be because of your role as counseling other people, perhaps, and that would be
secondary set of like legal concepts. Sometimes people get worried about that.
Yeah,
or even just the idea that you lead people generally, like Alita was saying, is you don't want to become a jury of one.
You got to watch leaders, But if you think about like Supreme Court nomination confirmation, there used to be real concerns about like Catholics on the court and whether or not they would abide by American law. I mean, you can have all sorts of thoughts like this.
Those damn papists.
Well, yes. I mean, like that was a part of Supreme Court nominations.
That was.
Hey, what are we at now? Like 4 of 9,
something like that. It's a huge number.
Yeah.
It's 8 of 9 from Yale and Harvard. So
there's that. Yes, there is that. And now we've had 2 Catholic presidents too, Kennedy and now Biden.
Oh yeah.
Yeah, well, that second one, I'm not going to go into it.
No, Kennedy and Biden.
Nicholas Starrow says, if Amber Heard loses, will she be nominated for a Razzie Award? She may be nominated for a Razzie Award regardless of whether she wins or loses.
I found out today that she was nominated for one for London Fields. So that was put in an article I read this morning. I had no idea.
Oh boy. Alicia Wilson says, sorry if asked, is the question the jury asked in favor of Johnny? You guys, love you guys.
I think so. Reasonable minds can differ all over this place.
But we're all sort of like looking into this crystal ball and trying to teleport our ways into our brains into the minds of the jury right now, and it could mean so many different things. Like we're basically using, like, not to disparage astrology, because I know that there are people that love astrology, but it's not exactly a science. So for not something that would be used in court is what I would say, not trusted in court. So
it's just reading tea leaves.
Exactly. That's what we're trying to do here. Midnight Joker, thank you so much for the super chat with the emojis. I love it. I believe that means maybe chef's kiss.
Yeah, you know what? I just have boxes on the other one, so I just have a chef and blank.
Oh, okay. I have a hand together.
Okay, all right.
So either it's doing Italian gestures, or it's supposed to be like a
chef. Get out of here.
Get out of here.
Chef, yes, that's nice.
Yared Tufa says, considering that the live broadcast hurt Amber Heard in the public eye, did she have a choice not to have live streamed the proceeding? Well, they tried to fight it. Amber Heard's team tried to fight having cameras in the courtroom for sure, and they lost. And there were good reasons why she lost, because there was a lot of public interest, and the court wanted to minimize the number of people at the courthouse. And based on what we saw happening with the lines, that was a very good choice. They still should have had better organization for the lines, in my opinion, to prevent chaos.
An alpaca pen, all sorts of stuff could have been used.
Gil Gordon says, does the U.S. have support staff for jurors after a verdict?
Not to my knowledge.
No, like you go back to your private lives.
Yeah. Gus says, are the jurors allowed to talk by choice before the year is up? Yes.
They're not a bound party.
Secret Pseudonym says, could the jurors' question be related to whether the op-ed bodies mentioned about SA before college gives an alternative non-JD justification for the title?
Absolutely. But they're not allowed to consider it.
Priestess M. Hotep says, why is there a sketch artist if case is televised?
Why do you want to put sketch artists out of work?
Yeah, why do you
I don't know. Have you seen sketches for this case? I haven't seen any.
I haven't. I don't even know where the sketch artist would have been sitting.
I haven't seen it in the court feed.
Yeah, I haven't either. So they might not actually have a sketch artist in this case.
But seriously, sketch artists need work too.
Yeah, of course. Maxime says, make bad arguments in closing until jury gets angry at opposite counsel for interrupting them. Make even worse arguments as a valid closing strategy. I wouldn't say it's a winning strategy, but it is a strategy.
That's what Rob thinks happened with Elaine. So who knows?
Could be. Liam Smith. I mean, I suppose if the facts aren't on your side, you've got to try to do what you can do, right?
Well, they were pounding the table hard.
Yeah.
Yeah.
Liam Smith says, have you all commented on the news out today? The ACLU demanding Depp pay its legal fees? Yes.
Product documentation fees, but yeah.
Yes. Circa 1990 says, have y'all listened to the Australia tape yet? Nope. Tomorrow.
You haven't missed it. That's the good news.
Tomorrow, for sure. Yes, absolutely. Mystic Wolf 116 says, is the ACLU really suing JD? James put it out on his last tweet.
Suing is always an interesting thing. Yes, they're asking the court.
Can I ask, is it actually a suit or is it just a request for an order of fees?
It's a request for an order.
There is a difference.
Yes. But anytime someone files something and asks for money, I can understand why people would see that as a lawsuit or see that as filing a lawsuit, because it's similar, right? Like you file
You're
something,
asking the state to go get money from someone else. I mean, how is it not a lawsuit?
Not exactly. It's not an independent filing.
All right.
It's not an independent complaint at this stage, as far as I know.
Right. That's what I understand as well. Hadis Harosh says, I am a military prosecutor in Israel in the military occupied areas. I loved seeing the differences and similarities between the streams. Thanks, y'all. Of course. Thank you so much for watching, and thanks so much for chiming in. I'm so interested in hearing about what you do. That sounds fascinating. Tread Talk says, question, are any of you fans of Better Call Saul, the character of Kim Wexler? Sorry if this is well-worn territory. I'm new here. I have seen maybe only one episode of Better Call Saul, and I had never seen, but hear me out, I had never seen Breaking Bad before. So I felt like I needed to go and watch Breaking Bad and then watch
You're all
Better Call
caught up
Saul.
on Breaking Bad then now? Okay, all right. You know what? I didn't mean to ask. Better Call Saul is fantastic. I've said this in other streams. It hits a little close to home, especially for the entrepreneur starting and hanging a shingle for themselves and otherwise dealing in big law firms and medium-sized law firms and the rest. Kim Wexler is a fantastic character. However, Better Call Saul does have everyone as a generalist way past how anybody could survive as a generalist in one of these large law firms, Kim Wexler included. I think she handles white-collar crime. She handles bankruptcies. It's like everything in the history of mankind. But Better Call Saul is one of the best TV shows ever made. Breaking Bad is one of the few that actually bests it. So, yes, I enjoy the show.
Let me ask you real quick. I lost the plot after like season 3. Is it worth trying to binge back into it?
Yep, 100%. Only gets better.
I'll take your word for it.
All righty. Dwani Prabhu says, question, what is the one thing this panel has learned pertaining to a skill/strategy from this case? Organization is key.
There are multiple effective ways to cross-examine a witness.
That's a good one. I like that.
I'm going with Hoag's answer. I think that's the different stylistic ways depending, I think has been fantastic.
Yes.
Also, frankly, for Dennison, control your freaking witness.
I will also say this: never underestimate the power of a visual timeline. Especially in your
nobody gave one.
That's just confirming your own biases.
Well, of course, because I really think that's going to be one of the reasons why the jury takes longer in this case to deliberate.
A visual timeline would have been an
depending
absolute
on your
disaster.
Side.
Well, I'm saying
for Amber
a visual
Heard's side,
timeline would probably have been a disaster for Heard's side.
Yes.
And there's a reason they jumped around in their testimony the entire time.
Yeah. Oh, and I see Sternad Law in the chat saying Legalbytes to not file a cross complaint simply because we were sued. Amber should have just defended against JD and not filed a cross. Yes. That is one of the biggest ones.
How about it's not ideal to be more than a dozen hours behind in allotted time?
Yeah, there's that. I don't know if the cross claim was. I don't know if that was their fatal flaw. I think
it was.
Once you realized it was not going anywhere, using your time to still try and prove the elements really hurt them.
I think they by filing those counterclaims, they made so many problems far worse for them. They made their case so much harder to win. Jake West is total hypothetical, asking for my actress friend Timber Turd. If she's successfully sued by her ex-husband for $50 million, which country should she flee to? Ooh, I don't know. I would not give any advice for somebody to flee any kind of judgments from the United States. So I don't know.
I'm not touching that one.
I also don't know what kind of laws exist with different countries for extradition rules and whatnot. So, yep.
Yeah, I mean, the answer to that is if there were some such person, it would have to be a country that doesn't have a very close relationship with the United States. But those aren't necessarily places that Timber would want to live. So, hey, don't flee the arm of the law.
Yeah.
There's so many ways I can go with that, but I'm not going to.
Afa Farabo says, given how AH's legal team greasy approach, AH's duplicitous ways and her connections, is it at all possible she seemingly pro-JD jurors were removed due to an AH scheme? Relieve my paranoia, please. No, I don't think so.
No, it was done at random.
They were sealed numbers that never left the court clerk and the judge. I mean, they could be, David Copperfield, I suppose, but it would require some real skill.
Yeah, absolutely.
Have either of you ever practiced in a court where they literally have the rolling lottery system?
No, I saw it for the first time in Rittenhouse.
They still do that in New York, and it's so much fun.
It makes it feel like a little bit of a carnival, right?
A little bit.
Lufier says, what up, my peeps? It's been a long day without you, my friend, and I'll tell you all about it when I see you again. We've come a long way from where we began. I know this is a song. I'll tell you all about it when I see you again, when I see you again. Thank you. I appreciate that. Mr. DNA 1987 says, did they log the late motion just to get it on record for potential appeals if needed?
No, because denying it for being untimely is within the court's discretion, so it doesn't even necessarily help them on appeal.
Well, I mean, it doesn't hurt if they know that they're late, but it's at least worth a shot, so they might as well get it on the record anyway, even if it's late. I see. Yeah, I would have done the same thing if I were them, just to say well, crap, we didn't object, but we can at least do this. Why not? So you're saying there's a chance. Nicholas Savatsky says, can you guys tell me why the trial is being held in Virginia specifically? Yes, it's because although Amber and Johnny are both from California, the core of this case comes out of the Washington Post op-ed, which is the source of the allegedly defamatory statements. And the Washington Post is headquartered in Northern Virginia. So that's why.
And this would have immediately lost on motion for summary judgment in California.
Yes, anti-SLAPP laws, strategic reasons, and all that kind of stuff. But the legal reason is because of Washington Post. Yes, but very, very good points as well. Patrick Tumpain says, Hogue, what is your favorite board game and why is it War of the Ring? I'm a game designer and play test with friends who are lawyers all the time.
War of the Ring is fantastic and uses a skill set and rules to actually get you in a place where no matter how you play, you find yourself reenacting the War of the Ring, which is really, really awesome. My favorite game of all time kind of bounces between some things. I really love Eldritch Horror. Right now, I'm really enjoying Marvel Champions because I like how much variability it has between the cooperative play, the villains, and the scenarios that you play through. But I like a whole lot of games. My wife is absolutely sick of me just getting board games all the time. Jokingly says she'll build a room full of board games and that has furniture that is board games, etc. So
that sounds like a
I
dream.
love Mage Knight. I love Battlestar Galactica. I can just look at the stuff over here that's in the kind of ready to play column. War of the Ring is really, really good. The problem is it's got a billion pieces and you really need someone else that's willing to just go to the board game store with you for 8 hours in a given day, which sometimes you find, but it's a rarity, especially at this age.
Jay Michael says, motion is on the website now. Question, what is the impact if jury comes back without judge making a decision now? Well, the most likely scenario is the jury is going to come back with a decision before the judge comes back on. She's just going to put this motion on ice, and then the jury is going to come back and make a decision, and then she's going to say it's moot, because the jury already made a decision. So that's most likely what's going to happen. She doesn't want to have to rule on this. This is very common with these kinds of motions that come at this late stage while the jury is out. We've seen this before in other cases, and we'll see it probably many times in the future as well.
I can
Fleur de
link
What's
People are asking. I can link this. I can link the Fairfax County one to you all. I don't know if you already have it or not.
Yeah, and then we can also get that in the description too. Fleur de B says, Rob, I'm sorry, he's not here. Can you and Spidey analyze Johnny's facial reactions during Camille closing? He seemed genuinely moved by her words. I think so. I do think so. Pixie Blush says, do you all share the super chat money? We do not.
It's Alita's. It's her channel.
Yeah, it's her show. We're just happy to be here.
I'm very thankful that folks decided to show up. It would be incredibly difficult to figure out who to pay and how much and whatnot, because folks are free to come in, free to go. There's no stress involved at all for anybody to join in on the conversation. And then I get to go onto their channels and not worry about any of that stuff either. And they get to keep all the super chats as well. So when we are on Hangouts and Headlines on Rick Hoag's channel, he gets to keep everything too. So we're happy to hop around onto everybody's channels over time and basically just try to spread the love. And that's why I also try to send people to everybody else's channels as well when they show up on here, is because I want people to go over there. I want people to consume their content, and I want them all to make super chat money and ad revenues and all that kind of stuff on their content as well. Gareth Wallace was on an armed robbery week-long trial jury in New Zealand. We were allowed to talk at breaks. Seems strange jury can't talk during trial. They must have surely thoughts experts.
Thoughts on the experts? Yeah, we don't want our jury to talk on things that aren't fully briefed to them yet, right? So we don't want it to be a constantly evolving thought process like it is with us, right? You guys get mad at me sometimes when, day 13, I go, it's like 60%. And then day 14, I go, it's like 63%. Whatever I'm saying, it's because I'm just constantly putting on the pile down in this way. But you can have lock-in. You can do these various things. In a perfect world, we don't want them to talk at all until last Friday.
Yep, exactly. Joe Mendoza says, apologies if asked and answered, but what happened to motions for sanctions on Amber Heard's photos from Discovery? It does not seem to be addressed in jury instructions. Also, Rob, which is girthier, your mic or your lumbar? LOL. I'm glad he's not here for this one. Very funny.
I think I can actually see Rob's reaction to that with the full face palm and the bent over. Yeah, I got Rob on these now.
Yep. But what happens to motions for sanctions on Amber Heard's photos from Discovery? So it does look like they went with, I think it was option number 2, which means all of the photos will be admitted, but they are free to comment on them, which is why their expert was able to come in and testify on the metadata issues there. Marie Holman says, have you checked out Joe Smithy channel with compilation of law tubers reactions to significant moments in trial? So good. I saw that Good Logic had tagged a bunch of us in there, and he said that it was fantastic. I haven't had a chance to take a look at it myself, but I think that probably is worthwhile checking out.
Yeah, I enjoyed it. I made a couple minor cameos, but I enjoyed watching it.
Oh, nice. Sarah Welkazi says, could we receive a verdict after 5 p.m. Eastern time, or would the verdict be announced next morning if they continue to deliberate after 5? If they aren't finished today, they go to tomorrow. But if they're close around 5, they will go for as long as they feel like they need to, if they feel like they can get it done today. But
it's a good logistical question, though. If they turn in a verdict and say it was like 9:30 p.m., it's probably the next day when the court's officially open that you actually get the verdict, right? They're not going to call everybody in the middle of the night.
I think they
I think they do.
Okay. All right.
Yeah.
I'll
Because
stand corrected on that.
Because if the jury's still there, all of the court staff still has to be there.
Okay.
The judge still has to be there.
Yeah.
Okay. Yeah. I yield on this. Well, I just thought they got the run of the place. They just throw the keys in and say, just lock up when you leave. No.
Yeah. Turn out the lights when you go out.
Yeah. Maybe take a trash bag out with you when you're on your way out.
Good luck, guys.
Karen Week says, is the panel aware of Johnny's team filing a motion to strike some of Amber's team closing arguments, it relating to the abuse victim aspect? Yes, we are. And we discussed it. Thank you so much, Cameron. Law Patrol says, currently on with good logic, but wanted to pop in and show some support. Oh,
I love
thank
that
you
he
so
sent a
much.
super chat to a different channel while appearing on the other one.
That is so kind of you. I appreciate that. Thank you. Debunk the Junk 1 says, question, can the panel define abusive? Can the jury? Well, the jury is going to, right? They are going to determine what that means. It's not, exactly what Rick said. It's not up to us. ATL Junior Girls says, question, Florida law. My father passed away 3 years ago. Stepmom passed this year. Neither had a will, but both names are still on the property. The estate is currently intestate. Can I put in a claim for the property? Ooh, this sounds like legal advice, and I don't want to be giving any kind of legal advice.
I am a Florida attorney, but I cannot give specific legal advice based on that.
Yeah.
Sorry, folks.
I am very, very sorry.
I'm sorry.
You're gonna have to.
I recommend find a local attorney in your jurisdiction and obtain appropriate advice.
Yeah. I would say also just a word of caution generally on this kind of stuff, that you also don't want to be revealing confidences of any kind of a case too. So reaching out directly one-on-one to an attorney is always going to be your best bet for that, so that you can maintain confidentiality as well. Dr. Indushri Rajan, the conscious psychologist, says, hi, everyone. I continue to love the coverage. Question to all, about what jury verdict were you each most wrong? Personal case or public case? Okay. Thanks. I mean, the Potter trial.
It's got to be Potter for us, right? I don't follow that many cases.
Potter trial, and then that nurse. I thought she'd be acquitted. I did not see her actually getting criminal sanctions.
Yeah. Sancocho 1718 says, AH demands trial by combat. Weapon of choice: 1, couch; 2, muffins; 3, poo. Oh, man. Oh, my. Tiffany Byers, thank you so much for the generous super chat. Says, did you guys talk about the motion filed by JD's legal team today to strike Amber Heard's closing arguments and to correct the jury instructions?
We did.
We did indeed. We did. Gary Wilson says, after Michael Sussman being acquitted today, I've lost faith in DC area juries. Sorry about that. I apologize. Well, I don't apologize. I had nothing to do with it, but I'm sorry that you're feeling that way. I really don't know any details about that case to be able to comment.
You're just naturally sorry for disappointed people.
I feel I don't want anybody to be disappointed ever.
Sure.
So
person
Rebecca,
pleaser.
I just like I'm not sorry. I didn't have anything to do with it. I just like that walk.
I mean, it's like I could feel sorry, but maybe not apologize for it.
Well, that's sympathy, right? It's fine.
Exactly.
I was amused by it. That's all.
Rebecca Fitzgerald says, next time you have Dan back on, please chat about the Wagatha Christie defamation case. Are you guys familiar with it? I am not. Rick mentioned it.
A lot.
Yeah, for sure. Mariana De Solaris, thank you so much for the super chat. Vic and West says, question, I'm physically disabled and have a service dog. Want to go to law school? Is this possible? Hell yeah. Absolutely. I had a classmate of mine who is fully legally blind. And he did fantastically well. He was very successful, and now he's a successful attorney. So
is he the Daredevil?
Is he Daredevil? I can only say that I have never seen him in the same room as Daredevil before. So
I mean, that's pretty damning evidence, I think.
I think so.
Wasn't it one of Amy Coney Barrett's clerks was legally blind?
Oh, interesting. I didn't know that.
Yeah.
I thought she testified during the confirmation hearings. I could be wrong about that, but that's my best recollection.
All right. So basically, Vic and Wes, 100% totally possible. The question is if you have a passion for it, if it's something that you really want to do and you know what you want to do with it, hell yeah, go for it. Don't let that stop you. Not for a second. Disney 200 says, how do you think the jury feels about Johnny saying he didn't know his lawyer would make hoax statement? It's pretty obvious celebs approve what their team says. No, it scares me that it affects him.
Okay, so I think there's a pretty decent chance that he knew roughly what was going to happen, whether or not it was proved or not. But if you think every single prime client knows what every single representative is going to say and the way they're going to say it at all times, that isn't a practical possibility.
Yeah, agreed. Yep. No, I because if you think about it, how annoyed is he going to be after a while if he has an attorney that says, "Can I say this? Can I say this? Can I say this?"
You've got an agent in order to exercise their judgment, which is partly why I think the judge kind of rolled against the independent contractor argument, regardless of what Virginia precedent might say. My role in the Waldman statements is complicated because I think good chance that they actually probably did have that working acknowledgement, but I don't think the evidence entered the record on it. So, yeah.
Gabriela Martinez says, if JD wins, could he change the $50 million in damages and ask for AH to make a statement through her lawyers that everything she said was a lie instead of paying since she does not have any money? I don't think so.
No, you can always come up with terms of settlement after a verdict.
I suppose. Okay. Well, then. Okay.
It's not going to happen, but you could ask.
I guess so, because now that I think about it, you can sell off your interest in a judgment, right? So you can contract, you can make all kinds of agreements based on that interest. It is worth something. So he can also tell her, hey, I'm willing to waive this if you go up there and you tell everybody that you were wrong.
Yeah.
I don't see it happening, but it's legally cognizable.
Yeah. Martin Weiser, thank you so much for this super chat. Thank you. Very generous. Paul of P says, or Paul of P, P Olive P, and one of those says, did you watch the Johnny Depp video on AH and Gone Girl? It's a good watch.
I have not.
I have not.
Nor have I.
But Paul of P, did you watch the video on Johnny Depp and Gone Girl here on this channel on Legalbytes? Because it's pretty good too.
We did discuss it. It was fun. It was a fun live stream. Greg Meyer says, how did Mike's date with Elaine go? LMAO. Oh, that's funny. Yes, responding to that super chat from the Elaine account. Mariana Disolaris, thank you so much for the super chat. Zach Frisch says, ever look at the Dalia DiPolito case? She contracted an undercover cop to kill her husband. Her mentality and obvious lies remind me of AH. I have not looked at that. I'm gonna write it down and take a look into it.
Yeah, I see the first error in her plan was the hiring of the cop.
If you're ever going to commit a crime, do it alone. That's not legal advice.
Not legal advice, of course not. But I would also,
not legal advice.
I would also venture like maybe planning to kill her husband in any fashion is probably the first mistake. But yeah.
Well, we'd have a lot of guilty people in the country, unfortunately, I think. So I think taking those thoughts and putting them into action is the first mistake. But we can argue the philosophy of that at some point in the future.
Absolutely.
I'm with you on this, Hope.
Okay, fair point. Thoughts are not the same thing as acts. Yes, of course. And then we can even like wrap that into a discussion about like Minority Report, all kinds of fun stuff.
Get ready for day 3 of Verdict Watch, folks.
Okay, Janine Bryce says so many great
more
questions. Yeah, so many great questions. I got skipped. LOL. Wait a minute. I don't know how that's possible. I'm sorry. Just wanted to give a law movie recommend. Have you seen Witness for the Prosecution from 1957? Great film. I have not. I'm adding it to the list.
I have not. I've seen Witness. I don't know if that's a remake of that.
I recognize
my watch list.
I recognize the name. Unless, actually, come to think of it, I may have actually seen it and may have actually forgotten. It may have been a long time ago that I saw it.
Movies out there.
It may have been one of those that my mom sat me down and was like, you should watch this. And I was like, okay. But I don't exactly.
I just like the interaction there. Okay. Sure.
Yeah, I'm sure at some point she'll tell me, she'll be like, yes, you absolutely 100% have seen it. And in the Stephen Evans show, have you seen the trials and It's Always Sunny? That's another one that we probably should add.
Come on, you don't know about bird law?
I know about bird law, but I haven't actually seen the episodes. I've seen like maybe the first season of It's Always Sunny, and I loved it. I really, really loved it. I just, for whatever reason, it turned to other stuff and never came back to it. But it's one of those that I've been meaning to get back to. That one, and shows like Silicon Valley, Better Call Saul is another show that I've been meaning to watch. Of course, there's a lot of these.
Have you been doing something the last 2 months? I mean, what have you been doing? Why aren't you watching TV?
Yeah.
I don't understand. Papa Hogue has made an appearance for the first time in a while. Witness for the Prosecution is a classic. So endorsed by Papa Hogue.
There you go. There you go. Thank you so much,
All right,
Ginny
that's on my watch list.
Got it. Ditto. Esme says, do titles suggest it's about her husband? Not really. Well,
who else could it possibly be about?
And
I think they basically seeded that.
Yeah. Well, and also she said in her rebuttal testimony, she said, this is why I wrote the op-ed about Johnny Depp, was because, institutions protect him or whatever. So
after the claims she made with her stories, right? However you might think of them in terms of truthful or not, since she claims so much SV, it's kind of hard to walk back the I didn't mean Johnny Depp in the title.
Isn't it lovely when somebody concedes their own argument?
I mean, that's effectively, you can't argue, well, who says I was even talking about him when you spent days testifying to that?
Yep.
It rings a little hollow.
Mariana de Solares says, Amber's bruises look like Botox injection bruises. How come Johnny's lawyers didn't question that? Probably because they decided that they didn't have the medical documents to back it up. And they also didn't want to start asking questions that looked like they were being overly speculative, because that can start to look like basically they're just throwing spaghetti at the wall and they don't really have any theory or any idea. So if you have the documents to back it up, then you've got a really strong argument. If you don't, maybe you can make a suggestion here and there where the jury kind of starts to spin their wheels on that, but that can have a risk too, right? Because you can look like you actually have nothing.
Right. When she says no, what is your counter? And if you don't have a counter, that is not a wise strategy.
Right. Apple Pie says, Hogue. Oh, look, a game reference in Super Chat. Alita, am I having a stroke? Is probably my favorite law team dynamic to watch.
Yeah, she reads out random things like Ashley or Caden.
It's true. Beathan99 Beathan99 says, what do you think about Ben Chu's body language after the judge left today? He bowed his head and got a hug from Camille, maybe something for Spidey.
I didn't see the video at all.
I didn't see that either. Unless it was maybe when we were watching for the question and then afterwards I don't know. I mean, Ben Chu just strike me as a very formal person in the courtroom, even though Judge Oscarati said, I think you're a snarky guy. So I think that he probably has a spicy side, but for the most part, he keeps things very classy in court and very formal, which
reminds me so much of my mentor, who was the most intimidating dude, but also could have been the guy that had the alpaca in his pocket. Ben Chu reminds me so much of him, professional, but also tries to have the team. He's got that team camaraderie that comes right off their table.
Yeah. It absolutely does. And Camille being a California litigator, I could see myself in some of my work environments. I could see myself being on a trial team and those days ending with hugs, having been a California litigator myself, because it's just, that can be the vibe sometimes, depending on the firm, of course, as well.
It's just funny because my experience with Californians is that they just look down on us Michiganders.
No.
New Yorkers don't hug. We shake hands and we walk away pretending we never met each other.
That's right. I think I've described the East Coast attorneys look down on us with just aggressiveness, raw aggressiveness, and the West Coast ones look down on us with passive aggressiveness. It's all good. Midwest forever.
Wayne S. says, heard they were two different photos, knowing they were the same photo. Also said she donated $7 million, knowing she didn't. Cut and dried perjury.
It's not. It's
not
really
exactly.
tough.
It's not exactly cut and dried, because you can, of course, yes, you line these things up together and you say, how can anybody think otherwise? But at the same time, we still can't see inside their brains to see what they were thinking when they were putting that information.
It's not a crime in this country to be wrong.
There you go.
Now that's really what it comes down to.
hopefully that remains. Yeah. Kami Crombie says, do you think Johnny will win 2 of 3 claims?
I think it's 1 or 3, so not 2.
Interesting. I think it's
agree
1 or
with
2.
that assessment.
I think it's 1 or 2. I don't see the third one making it personally.
I think it's just going to be 1, but I agree with if they get to 1, the rest of it probably falls.
Francis Greco says, doesn't the jury question in the context of instruction C number 3 suggest their determination of the falsity or truth of the title on its face, literally, versus in the context of the article as instructed on instruction FF?
First of all, you can see what the jury is dealing with just from reading that super chat. So, I mean, that kind of that's the argument right there is I know that instruction. I know that's what it says. You have to take it in the context of the article, but also not in the context of the article. I don't know what could be clearer, people.
Yeah.
Yay, appeals court coming at you.
Wesley Smith says, considering the media coverage of this trial and how negatively AH team has been perceived, do you think this will damage the AH lawyers' future careers or getting future high-profile cases? Rottenborn absolutely is going to come out of this unscathed. I think he's done a good job with a difficult case and a difficult client. Elaine Bredehoft, perhaps, I don't know. It'll be interesting to see if she goes.
Her name.
What's that?
You know her name, and that's valuable in certain respects. Period. You know who Elaine Bredehoft is, and then how did she perform? Well, that's another question.
It could make her settling her cases a little bit more difficult moving forward because she's done mostly litigation that ends in settlements. However, I've also kind of thought about this further since we last discussed it, and at the same time, she can also say, "Hey, I went through one hell of an experience and I learned a lot about trial. And now I know what to do and what not to do. And I know exactly where to go with my case. And I know exactly who to hand it off to if it ever comes to go to trial."
If she actually says that, do you not laugh in her face saying you didn't learn a damn thing from this?
No, I
honestly, if you're really playing highball settlement, like, she's up against you. And remember, she is the principal of this firm.
Yeah.
And you're across the table from her, and she makes that argument. Do you not laugh at her and be like, all right, fine, let's see if you actually did?
Well, I don't
at least throw the ball in her court.
The thing is, I don't see that actually becoming an explicit argument during mediation or during settlement negotiations anyway, because that is always kind of an irrelevant argument because you know when it becomes about the attorneys, you know that something has gone wrong on one of the sides, because if you're not arguing from the facts and the law, then you're like, okay, this is just like you, if you're arguing from your own like expertise and your own like, oh, I'm so awesome, or oh, you suck, like that's when you know that something has kind of like broken down on one side, that you're like, you're no longer arguing from facts here.
Again, I think that maybe that's a California versus New York perspective, where one is playing a little bit more hardball and the other is trying to be more collaborative. But if I know that, or my experience is, if an attorney knows that the other side can't litigate the case to save their life, they're going to push a little harder.
Sure. Yeah. And I think that could definitely be an unspoken sort of subtext going into it, that she would have to sort of fight against, I think. But
again, it depends. Do you want to be a collaborative negotiator, or do you want to be a combative negotiator? And everybody has a different style.
Absolutely true. Absolutely true. Next question. Crown V says, when JD was leaving the witness stand second time, and Judge A joked, "Don't break anything on your way out," in front of the jury, can that be viewed negatively? I like this judge a lot. Just curious on your thoughts. Thank you. No, I don't think so.
I don't remember hearing it, but if anything, it sounds like it was said jokingly. No.
Yeah, and I think that it's pretty clear that she's joking here and there as well.
I don't have an issue with that.
A.E. Caniff says, the longer this deliberation goes on, do you think it's worse for JD or AH?
Longer's
yes.
Longer's worse for Johnny Depp.
I don't think so, though.
I don't know if I agree with you. Generally speaking, the longer the deliberation goes, the better it is. In my experience, it depends. This is a really weird one, so it's hard for me to read the tea leaves. Generally speaking, I think that the longer the deliberation goes, the worse it is for the defense.
And I can see that because if you get to the damage phase, you add on time, et cetera, et cetera. I just think that muddiness has always gone to Amber Heard here. So if there's muddiness in the jury room, I'm going to hesitate to say it's in favor of Johnny Depp.
I think so far, if there are like 3 more days of jury deliberation, I still say it's not bad for Johnny Depp.
If there's 3 more days, I think you're looking at a hung jury.
No.
There's no way this judge is letting them hang the jury. I swear to God, this judge will keep them in that jury room 8 hours a day for the next month.
I think it's
not doing this
again. Hung jury.
She is not doing this again.
Yeah. Well, yeah, you're probably right about that. Rob Barron says, question for Rob from another VA Rob. I'm sorry he's not here. What's the best way to initiate a paid phone consultation with you?
I'm sure he has a website.
You know what?
He has a website.
Yes. Oh, absolutely. He does. Yeah. Get his website. I'm sure you can get it through his Twitter profile. If it's not, I will tell him to link his
if it's not, we have some words with him about how to use social media.
About his social media skills. Tidy those up. But yeah, that's exactly it. It's going to be through his office. Sophia Tumazi says, question, the longer deliberations take, does it generally mean the less percent Johnny will win? What are your thoughts? Hogan Rob equals my babes. Love from London. No, I think we just talked about that.
We just talked about it, but reasonable minds can differ.
Of course.
Absolutely.
Armel says, question off topic. Alita, have the feeling you're a Francophile. Parlez tu French? No, I don't. I have folks around me that speak very good French, but I do not. And I have gotten many questions as to whether or why I have not already learned French. And it's not enough to say that I've learned other languages and have picked up other languages since then.
Not enough.
But yes, I absolutely would love it. I would love to live in France for a period of time. Absolutely would adore that. But I love visiting Paris. It's one of my favorite places, of course. Life with Marie Hogue. You said if you hit 100K, you get a picture on your wall. I believe that was the case, wasn't it?
I said I'd put something on my wall.
And
we will figure that out. Maybe we'll figure it out together. See, anything I put of any significant size is going to reveal how close I am to that wall. So we'll have to figure that out. Right now, there's a certain illusion about where is that wall? We don't know. Who knows?
Yes.
It's really close.
Yes, of course. But Armel, thank you so much for the kind words and the generous super chat. But basically, to answer your question, yes, I'm a Francophile. I do love the history. I even took a history class on the history of Paris, where we learned about the architecture and all that kind of stuff. So yes, absolutely. Absolute says, question, why should Depp supporters ignore the UK trial? Well, Depp supporters don't need to ignore the UK trial. It's a very interesting trial to go into and to understand, for sure. I mean, that's why we spent a lot of time today talking about it. But I think that the jury should be ignoring it because it could improperly influence their decision in this trial because it's completely independent from this trial. So for them to say, for anyone to suggest that they should decide a certain way because of what happened in the UK trial would be completely improper. So that's why there should have been some ignoring of that previous trial in this particular case. Team Oscarpus, thank you so much for your generous super chat. Sancocho 1718 says, question, opinion on lawyer Mills filing thousands of ADA suits. Well, lawyer Mills in general will file thousands of lawsuits, regardless of whether they are ADA or other kind of stuff. You'll get all kinds of different cases, and I don't like them when they are vexatious. However, when they have legitimate claims, they can be very helpful to get people some amount of justice, even if the process is a little bit wonky. So I wouldn't be able to comment, overall Paper plate wall art.
Sorry, I got an addition to my stream from
There you go.
co-counsel.
There you go. 100,000 paper plate wall art. I like it.
As you can see,
get that
only
framed.
The best. Yeah, only the best. So
yeah. So, but Sancocho 1718, you know, I don't want to make any generalized statements or assumptions on folks that are making those kinds of claims, because there could very well be legitimate ones and illegitimate ones mixed into those kinds of things. But people have their strategies for doing what they do, and I understand that they can also be headaches for folks that are on the receiving ends of those. So I understand that as well. Deborah Debasige, thank you so much for the very generous super chat. Says, sorry if already asked and answered. I thought you had reached 250,000 subscribers. If this is all because of the personal situation that happened last Wednesday, I'm sorry, no need to answer. Let's all advocate Alita reaching 250,000 because you are awesome. Thank you. This is so kind of you. I really appreciate it. I really appreciate your kind words. And I mean, yeah, onward and upward, right? Maria says, what would you say is each side's most damning evidence? Amber Heard's most damning evidence.
I mean, it's her testimony, right? Like, that's the only evidence she has at a foundational level.
Or maybe Johnny's like the audio tapes of Johnny screaming at her. Those are the only ones that like made me feel any kind of visceral anything.
I do really like. I'm sorry, it's amazing I didn't hear it again. I really do like on the Amber Heard side, the like whatever it is, you don't even exist, you don't exist. Audio, because that one is right in the heart of like psychological abuse to me, or potential psychological abuse. I'm surprised we didn't hear it more. Like the wailing, we heard the drunk guy in the plane supposedly like 8 times. I don't care that much.
I don't either. It just honestly, for me, I felt worse for Johnny because I could feel like he was in so much pain. Like he was like wailing in so much pain. So I felt, number one, bad for the pain that he was in. Number two, bad for the embarrassment that he had, that was played over and over and over again. So if anything, what if anything did I feel from that? It made me more sympathetic to him.
Yeah, I didn't like that.
The problem is her testimony should have been the best evidence, but she was handled so effectively on cross that became an issue. So what is your extrinsic evidence besides the statements? And I agree with you entirely. I think the sort of belittling audio is good, but they didn't use it. They used him punching cabinets, and I don't understand that strategy.
It could have been a symptom of people that have been living in a case for so long that you start to lose the forest for the trees, and you, for whatever reason, you like home in on certain things, thinking that they look like something that they don't.
Yeah, and I've spoken about that before, but if you're in a well-established law firm going to trial, why don't you establish a red team to run it by them and get a fresh perspective? And I can't imagine they didn't do that. Maybe they didn't, but that's just tough for me.
My suspicion, and this is just a suspicion, not really based on much other than what we've been able to peer about those attorney fees that we've discussed before. The fact that it looks like Rottenborn was working at a discount, as an example. My guess is it probably had to do with how many resources are we willing to put into this case that is maybe not so likely to win, and that is not going to be bringing in much revenue for us anyway, because we are operating at a discount. I have seen those kinds of conversations from the inside of a firm where you have a case that is kind of starting to bleed the firm of its resources, and sort of the ethical back and forth that you have to have about that, to say like, look, we can't suffer as a law firm, because then we're going to have all of these other cases that will suffer as well. But at the same time, we also can't just leave this one to dry, because that is completely unethical, and we would run into all kinds of professional responsibility issues. So there's like so many issues that can come up with that. So they may have had those kind of conversations in backstage.
And I am certainly not in any sort of senior position anywhere to give a commentary on that. But how much does it cost you to bring in a handful of legal assistants and paralegals over the course of lunch, feed them, and see, hey, let me run this by you. Do you have a thought? Like, there are ways that you could still try and get rid of that bias. And you're not the first person that I've heard say that sort of like in the trenches mentality. But there's got to be a way to do that.
Yeah. Venegor 10 says, Wagatha Christie about defamation trial involving wives of soccer players, one of whom claimed other was selling stories about her.
I get it now. Oh, you Brits.
WAG equals wives and girlfriends. I see. One of whom claimed other was selling stories about her and trapped her with a fake IG message. Ooh, that sounds salacious.
Fun. Yeah, I mean, in the context of the headlines I've been reading through, there's been reference to the fact that it was a surprise how much Deputy Heard took over from Wagatha Christie because they had expected it to be a bigger deal.
Wow. Okay. Yeah, that sounds really interesting. Team Oscar says, sorry if I missed it, but can you talk about why AH was never pressed on why she never reported JD and pursued criminal charges against him? If this wasn't a point of conversation, why not?
People are going to be very sensitive of accusing someone that was domestically abused of not being domestically abused because they didn't report it to the police. That's the zeitgeist. That's the moment. And honestly, I don't want to be on the side that says if you didn't report it, it must not have happened. There's so much else going on in Amber Heard's testimony.
Yep.
I also think it would have been a very different ball game if this was not postponed. And if this, let's say this came to court in 2019, in that environment, I think it might have been seen somewhat differently.
Yeah. You are wrong, says question. If the title stands on its own, how do you get it's talking about JD? That's why the answer seems bad for JD, in my opinion. Well, because either way, they're going to have to, hey, Nate,
hey guys.
Either way, they're going to have to look at it in the context of the article anyway. It's like that's why this is kind of confusing, right? That they're supposed to take the statements on their own, but still also look at it kind of in the context of this whole article.
Yes.
All right. So I'm assuming the jury hasn't come back yet.
Has not.
The jury left.
Jury's probably left for the day.
Yep. So we are going through super chats. Miles Peckover says, question, can they award both of them $1 and give them a note saying, Johnny, don't go out with 25-year-olds. Amber, go get help. Now get lost.
They don't get the note really, but they can do the dollars.
Yeah. Becky dances.
Can they do dollars? Sure.
Well, the dollar.
I'm wondering if his claim is true, then her counterclaim has to be false.
Nope.
Not necessarily.
Especially if SB is the one that you win for him on, right? Because the other is the May hoax. So if she didn't do a hoax on the getting a phone hurled at her, that doesn't give her SV. Johnny can win on SV, and they both get $1.
I agree with you in that way, but I just think it's going to be really tough for a jury to wrap their head around that kind of a solution.
They might not have to. I mean, it's like the real politic. But for that super chat, it's like we want them to both get lost with $1. So it's
possible.
Whatever.
Okay.
Yeah.
Betty Dant says, Julian Assange, will he ever come to the United States? I have no idea. Mandy, what's up, Nate?
No, I went over I just re-looked at the jury instructions and the verdict form. Yeah. And if I wasn't a lawyer, that thing would be very confusing to me.
Mm-hmm.
Yes.
I'm talking about the way it's laid out. Like the questions seem to be ordered incorrectly. Like if the first thing it says is, have you found this defamation, but then it has the elements below it. Like it's all weird. So a lot of this time could just be like, what the hell's going on with these jury instructions? Like even the note today, wasn't the note today about with the statement or the whole thing? It showed to me it was a window into their confusion back there. Like what the hell is all this stuff they just gave us?
Yeah. Let's get the next question, but actually I need to step away for just 1 second. Are you guys okay with that? Can somebody read the next super chat for me? And then I'll be back. Okay, I'll be back as soon as possible.
Cool. Mandy Stevens, I would think the UK would be the same as Australia in regards to a notary. You can go to a police station, a court registrar, a doctor, a chemist, a school principal, etc. Can't answer the UK or Australia, but we're sorry we weren't able to ask.
No idea whether.
Yep. Okay. Next. Was AH really entitled to 32 million? Love you.
I don't think that's accurate, right? Because we're talking about only the money that he obtained during the marriage. So did he obtain over 60 million that year, something like that?
It wasn't really vetted out. It was just a raw assertion designed to say she took less. So yeah, because usually it's just so everybody understands, she doesn't get like whatever half of what he's worth. It's half of what the stuff that they've gained during the marriage. So if you earn $10 million during the marriage, you get the $10 million. And there's even limitations to that stuff too. Sure.
Yeah.
Sid Dave, if a woman falsely accused a man of sexual assault, should she not go to prison for destroying an innocent man's life? It's not really set up that way right now. And again, falsely accused is not what we're proving here exactly. It's the opposite. So it's very hard to say something like that. It's just not the policy of the United States right now. Sasson 128 question, will you review Chu's motion? It's online. We did. We talked about it extensively. Daria, does JD win if jury finds just one statement is defamatory? Yes.
Yes.
Madeline Turner, how are the team of lawyers selected? Well, the client hires a law firm in general.
They hire them.
And then the law firm partner usually is going to assemble a team. And then they're going to bring in people from all over their firm and sometimes outside of it. Matt Ricci, I'm so glad I found you guys and look forward to hearing your views on other cases. Thank you. Thank you, Matt Ricci. Said Dave, should Amber Heard not be required to prove all of her claims? Either all her claims are true or none is. Will the jury pick and choose which claims are true? Isn't that wrong? She has been shown to be a liar. Well, first I would say to
There's
you.
so much.
She's been shown to be a liar to you. And I do think there's a version of these events where she's exaggerating and there's a kernel of truth there that unfortunately is very difficult for a jury to see. So that's why her team advances if you find one time. And I think the Depp team gives the right counter to that, which says, no, she's presented an alternate history of the world. You have to pick which world you believe in. So, yeah, Nate.
This is exactly why we don't allow propensity evidence in, right?
Yes,
Once a liar, always a liar. Once a thief, always a thief.
Exactly.
And Sid, what I would like you to understand is the fact that she's lied in the past, or even the fact that she may have lied about one of these events, doesn't mean she's lying about all the events. Doesn't mean she's lying about everything. Matter of fact, it would be very hard to lie about all facts. So even though the logical thing is, I that's what we call it credibility. Her credibility about these issues is going to be lower than Johnny Depp's. But the fact that she's lied in the past doesn't mean that she's lying about this particular event. So what we got to do is we got to kind of look at each event and say, okay, what evidence do I have before me that either I have to rely, if I have to rely on her testimony, it's going to be less versus there's some objective evidence. And I think we've all been evaluating it as these are the events that she's been saying. Here's the evidence presented for those events. Here's in context, and that's why I don't believe it. When the cops went to the apartment, right? She says something happened. The cops went, and the evidence doesn't show that happened. The Australia stuff.
Well, there's like 6
happened. Yeah, it's like so.
Right? There's a photo the next day. There's a photo the next day. The cops don't corroborate. There's a video appearance the next day. There's a video appearance the next day, and it's like,
but I want to be very, very clear. Things may have happened to her in the past, but we are not concerned with that. And we're not looking at those incidents. We're looking at the incidents that we've seen in front of us and the evidence that's been presented, and saying, based on what we've seen, I believe she's not being truthful in those events. That's what I'm saying.
Sure.
Well, let me push back a little bit, Nate, just out of curiosity for 2 seconds. Basically, what they were saying is, if you don't believe this bottle statement and she's a liar, why should you believe her about the rest of the things? There is a common nexus. I don't think this is a 404 issue. I think she's putting forth a common theory of actions. I think that it's totally appropriate to rebut her and judge her on the credibility after rebuttal.
Yes, you can judge it all together. I'm
agreeing in context, but my argument is that I think the question was alluding to two separate issues. One, whether Amber Heard is, since there's one event that we can prove that she lied about. What does that mean about everything else? Now, even in the jury instructions, it says you can disregard someone's entire testimony, right? It doesn't one person, you can find that they've just been totally untruthful to you. But what I'm saying is that we're doing that based on each event that's been presented to us. So I can't talk about any event that's outside of the events that's been presented to us, right? Like she said something happened to her earlier in her career in college or something like that. And people online say she's lying about that. I'm not going that far. I'm just talking about the events in this trial that we're talking about. And I'm saying the evidence that's been presented about these facts on both sides make me make the conclusion that, yes, I believe she's lying about these events.
Yeah, I agree with you. I just wanted to be clear because, I'll leave it at that.
Makes sense. Makes a lot of sense. Shalane Frizzle says, can you each fill out the verdict forms tonight and then compare your results together tomorrow? Oh, you are muted, Rick.
No, I was just not saying anything. So, no, it was just my mouth moving without talking. Maybe it's just a matter of finding minutes in the day for me. But
Agreed.
Yeah, it sounds like a great idea. We'll see if I can do one.
Yeah. You know what?
I'll fill one out.
We should do it because we already have the charts. We did it on both Joe's stream and Nick's stream today. We should have everybody do it, and we all filled out the verdict forms. And last night we were actually surprised that the chat didn't go too well. Out of the 6 counts, only 1 survived, the one for Johnny and the sexual assault, but everything else looked good.
Wow.
The chats, and even on Nick's stream, the same thing. The second claim for Johnny failed, and on Joe's stream, the second claim for Johnny failed. All 3 streams, he lost that claim. I don't know why.
So yeah, we need to poll them tomorrow on this channel because I really want to see what this chat decides for sure. Right. Crazy Cat Queen says, Rob, sorry he's not here, says, I almost became a lawyer because the Lindbergh kidnapping. I saw a Life article as a teen and I convinced myself Hoffman was innocent. I'm so looking forward to your review.
Should be fun.
Should be great.
Interesting.
B-Rad says, question, did you follow the Oscar Pistorius case? From a distance. I thought that was very interesting because he went from being this Olympic hero to being not an Olympic hero. So that was it. Yeah, but I didn't cover that. I didn't look at that very closely myself, though. It was a very sad.
That was in South Africa, though, right? That was Oscar Pistorius. Yeah.
Very sad case. Swim Sweetie 100 says, is it more likely to end in a hung jury the longer it takes to deliberate? I mean, technically,
that's kind of how the stats work, right?
Yeah, that's the general rule.
Yeah, by definition.
Yeah.
You don't have a hung jury after day 1 unless somebody comes up there and says, I'm a Johnny Depp super fan or something like that. I don't know.
That's what I was saying is that I think this judge, after going through 6 weeks of this, is not going to let them walk away anytime soon.
It doesn't matter, though. I mean, this has hung jury potential because there's no rationalizing around, I believe, Amber Heard over Johnny Depp or vice versa.
Yeah. Riker Monson says, what was your favorite part of this trial? Mine was anytime Elaine would impersonate someone. Haha.
Boo.
Oh.
Hey, did you guys realize?
Maybe because she didn't do a good job of it.
No, if it was better, it still would have gotten a boo. I hated that.
Yeah. I didn't like her impersonation of Johnny Depp in particular because he's one of the parties in the particular case, and in a very serious case at that too. Nate, you were going to say something.
No, so I just got a DM. The jury question. Did anyone notice that it was from the first question on the jury question, not the jury with the verdict form? So literally the first sentence on the verdict form. That's the question. So that you can tell when they're at the process. Like, hey, what's this first sentence mean? Send it to the judge.
Yeah. Martin Wimpress says Paul Bettany was labeled as JD's drug buddy by Amber Heard's legal counsel in closing. If he wanted to, unlikely, can he pursue a defamation case against them? No, litigation privilege.
Yeah, litigation.
Jinx.
Privilege.
That's where you get all the lawyers on the panel going, buzz, 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 buzz. I have the answer. Anytime that you are either arguing in court or you are filing a court filing, anything that you say, even if you absolutely 100% know that it is a lie, there's something called the litigation privilege.
But you shouldn't say that you're lying, no, because that breaks some other rules.
Well, of course. Of course. Hey, Ian, happy to have you back. Oh, I think you might be muted.
Yeah, we know.
But we have other means of sanctioning you.
True.
It just is not in civil court.
All right.
That is very true. Oh, now you're better.
Ah, there we go. And there's
we
the
can,
pup
we
in the
can hear
background.
Yeah.
Oh, you know what? I'm just thinking about it. If it's a defamatory statement, I believe it's probably going to break the ethical rule because it has to be false, right? An unknowingly false statement about a public figure.
But that would go to the Bar Ethics Committee. It would not go
That's what I'm
to
saying.
civil
It wouldn't go to
trial.
civil trials. Yeah.
Mm-hmm. Mm-hmm. Yeah. Ceci Peterson says, will you cover the J6 hearings? I am not. That's just not really in my wheelhouse. I think others, Kurt has been talking about a lot of these January 6th defendants on his channel, but I haven't touched really any of those. And let me get some more here for Ian that we missed earlier that I've been saving here. Wendy's Cafe says, Ian, have you had a chance to check out the Yaniv guilty verdict from the other day? Thoughts on that nasty person?
Oh, so this is a really, if I don't know if you guys have been following this person, I'm going to have to check out this verdict. But so Jessica Yaniv is a trans woman who gets a lot of flack for that, but that isn't why she should be getting flack. What she was doing is she was going around to various, in particular, minority-owned businesses and asking for certain services that I won't detail, but which are normally provided for female people, but she has male genitalia. So the issue is that they were saying, we don't know how to do this, and therefore we're not going to provide those services. Basically, what a previous court had found is that she had been doing this essentially as sort of litigation tourism, and to extract money from people, and that she'd also been targeting sort of minority-owned businesses because there's some issues there in terms of her potential beliefs about minorities in various fashions. But she's also gotten herself into a lot of trouble with regards to threatening people, possession of weapons, that kind of thing. So I'm not sure which thing she actually, sort of came back as a guilty verdict, but she's a really toxic figure. And interestingly is, she portrays herself as sort of a hero of the trans community, and the trans community cannot disavow themselves from her fast enough. So they've been saying, nope, she's not she's not an activist on our behalf. So it's a really messy scenario and kind of raises issues of, I don't think she's been declared vexatious at this point, but it may happen in the future.
Yeah. Oh boy, that sounds like a mess. Mimix Gaming says, for Runkle, what province do you practice in? Much love from Nova Scotia.
I am here in Alberta. So
there you go. Awesome. Paula Duke says, Runkle of the Bailey, first time I saw a Canadian who didn't share about hockey in a live stream. Ha 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 ha.
Yes, somebody asked me a hockey question. I'm like, I got to admit, I don't actually watch it, which surprised some people. Hogan's just shocked.
Go Red
Cargo
Wings.
Pilot Guy says, will you help me get a letter to Viva? If I email it to one of you, will you pass it along to him? It's a thank you letter.
Best way to get a letter to Viva is probably just to reach out to him directly.
It's why you gotta go through us.
Yeah, I think so.
His email's up there. He's got, local. You can reach. Viva's got a lot of ways to contact him. Twitter, matter of fact, just tag him in a tweet. Viva's very Twitter happy.
True. Carly loves Big Bang. German Hogue fan club says Depp team filed motion to strike inappropriate argument by Heard's team during close that their decision in this case would send a message to every victim of domestic abuse everywhere. Yes, we talked about that earlier.
I'm going to cover that a bit in about an hour, but yeah.
Okay. Oh, perfect.
Oh, cool.
T in Tennessee says, question 5-second recap. I just got back in town. Current predictions. So yes, 5-second recap is nothing happened today. Jury went out. Jury went to lunch. Jury came back. Jury had a question about the title, and it was exactly what that last super chat was about. And if you want even more details, you can go to Ian's channel in about an hour. It sounds like.
Yeah, I've got a copy of the memorandum.
The motion, yeah.
And there's actually a second issue, which is a correction of the verdict form. So expect to hear Kurt. I think Kurt's going to have some notions about.
He's going to lose his freaking mind.
Yeah. They didn't actually cite him, unfortunately, but yeah,
he's not wrong in his statements.
Written. It's the verdict forms are so poorly written. I don't know how they got through. It's funny because I was going to say like this judge has almost been like a perfect judge until we got to the forms. I'm like, all right, so this is this judge's weakness. Jury instructions.
Well, or it could also be that at this point she's damn exhausted and so
That's
mistakes
true.
are happening. So
Who
that's
be?
always possible too. Oh my God, yeah, I would not fault any of them for that level of exhaustion. Jeff O says, have you seen Kathleen Turner in Serial Mom, especially the courtroom scene? Gives me some AH vibes. I have not.
It's a good movie.
I will add.
Cool.
I will add that to my list. Maria del Carmen Lurosky, thank you so much for your very generous super sticker. Sarah D, thank you so much for your generous super sticker. Maria del Carmen Lurosky, thank you so much for another very generous super chat here. It says ICU doc here. Love you guys. The stickers was from me. I told the ICU nurse today, objection compound. We all laughed. Love you guys. Thank you so much.
Awesome.
And if I ever find myself in the ICU, I hope it's with you because you sound like an absolute delight. I love it.
Story well told.
Yes. Yes. Eric Jensen says, if Tampa Turd loses, who does she sue next to pay out the damages of the lawsuit? Well, you don't file a lawsuit to make money. So I would say that unless she has a valid claim that she truly believes that she has and she thinks that she can win, I would advise her. I don't give legal advice over any of these live streams, but my advice, my general life advice would be, don't do it.
What would you describe?
Stop being so ethical.
A quick question. Do you think whoever loses, do you think they appeal?
I
Probably.
suspect yes.
Yeah.
So this isn't over. This is just part one of Seem to Be a Long Saga.
I don't know how long the appeal will take because I suspect that the appeal might be something they could deal with fairly quickly.
It would seem like a quick denial.
Yeah.
Unless Johnny loses and makes the verdict form argument, that's something that the appeals court probably would have to address. So that might take a little bit of time. Yeah. But other than that, I think any appeal would be basically futile.
Yeah. Sure. And so
that's the biggest guess on earth.
Also, so that the chat knows, I know that the chat likes to point out when the cat comes into the frame. Just so you know, he's also watching you guys at the same time. He likes to sit and watch the chat scroll up because he thinks that it's some kind of predator or prey, rather, that he likes to then watch.
Chat often.
Yes. So he it's actually been a relatively recent thing for him to be like glued to a screen anytime Mr. Bites is playing a video game or we're watching a movie. He just wants to like tag everything on the screen. So he's been recently doing this with my double screen as well, and he loves watching the chat. Anyway, next one. Gene says, thoughts on 12 Angry Men movie.
Fantastic.
I enjoyed it.
Very good movie.
Both versions, personally.
It's independent review of evidence by the jury. It is actually a cause for mistrial.
However,
it's independent collection of evidence by a juror.
That's also true, that the whole knife thing is highly improper.
Yes. But I mean, Hollywood
otherwise it's fine, but that one I can never quite get past.
Hollywood will probably never get a court thing perfect. Although Better Call Saul at times gets real close.
You know, some episodes of Law and Order are really good with the process. Just out of process here in New York. When I was a DA, I was like, okay. When I first started, I was like, okay, they get the process right, the names of the hearings. So.
And by the way, not SVU, the original Law and Order, I think was actually very good on the law.
Yeah.
At least in New York.
What's going on? You look like you're trying to hide a laugh. You okay?
Oh, me? Are you looking at me? I'm fine. No, I'm good.
Okay. Jill Monroe says Johnny Depp supported the West Memphis 3 and the work that was done to set them free. I think the Innocence Project was involved. It was a satanic panic murder case.
Ooh, those are fun.
I don't know anything about
Very interesting. Crazy Cat Queen says, could y'all someday discuss Sekulis and Dunn case, the intel officer's wife who killed the UK teen in MVA, interested in the diplomatic immunity? I'm not sure what the function of this is anymore, especially in a criminal case. My understanding is that it's not just Americans that have it overseas, American diplomats that have it overseas, but it's also foreign diplomats that have it while on American soil as well. It's one of those things that is agreed upon with all countries that accept the Geneva Convention. That's where it comes out of. But other than that, I'm not big on international law, so I'm mostly
part
staying
of,
away from that.
I think, the Vienna Convention, and basically all. What you want to do is you want to protect your diplomats from being sort of molested by the other side in whatever fashion. And I don't mean that in the way the chat's going to mean that, but. And, one of the things people worry about is, will our diplomats get caught up if they don't, if they make a mistake in terms of the law? But also just if the countries tick each other off, you'd end up with an issue of these, suddenly you can arrest them for some sort of minor, whatever. And so, diplomatic immunity is a big deal. Typically, you can't prosecute unless you've got sort of the consent of the originating state. But the other sort of end of that is that, and sometimes the originating state will give that permission. But the other remedy you've got is to send that diplomat home. Yeah, you can just say, okay, you're not allowed here anymore.
And right, exactly. That's the remedy, and that immunity covers not just the folks that are working for whatever embassy that they are working for, but also their entire families. So because imagine what could happen if an embassy employee is covered, but then their spouse is not, and then the government decides to harass their family, and all the different things that can impact for the work of the embassy there. So
not for nothing, Iran 1980 whatever. Yeah.
Sir Brass says, could you explain SLAP and anti-SLAP? So it is SLAPP. It stands for, or sorry, SL.
Yeah, SLAPP.
Yes, okay, PP. I've done it so many times, I've forgotten.
Strategic litigation against public participation.
That's correct.
Can you guess which came first, the acronym or the name?
I'm going to guess the acronym.
Yes.
Yeah, I think the acronym came up first.
Yes.
Because, that one's too convenient.
Oh, yes. Now, the basic gist is we really love our First Amendment.
Patriot.
We don't like lawsuits that otherwise prevent you from saying stuff. And so we got statutes that give you some benefits and bonuses for fighting against a lawsuit that prevents you from saying stuff.
That's actually one of the greatest explanations I've heard.
Yep. Bonkers B says, how can a client know a lawyer is good or competent prior to choosing them? Well, you can look at their... What's that?
I said the eternal question. Right?
Yeah,
clients have a lot of trouble distinguishing good lawyering from bad lawyering. And
how do you know when you buy food that it's actually what it is?
Well, food you can at least have a look at, and you could theoretically test and all of that.
I have a look at you, Ian. I'm judging you right now.
That's fair, and I mean, there's all sorts of reasons to apply scrutiny.
But yeah, no, that's why you see referrals and personal relationships so heavily featured in attorneys and business development, etc. It's actually only a few decades that American attorneys have been able to solicit directly. So it's still personal referrals most of the time.
Yeah, still depends on your jurisdiction.
Yeah. Nina says, Bonkers raises a good issue. Depp's attorney made him potentially liable for defamation, as did the attorneys advising Heard on the op-ed. Malpractice?
You really have to believe that Depp had absolutely nothing to do with it. I'm not saying that the evidence is in the record for it, but question mark, question mark, question mark.
Well, and here's the interesting reality is that if you don't have good evidence either way, then Depp, we don't know, actually knew about what Waldman was doing, could be a defense on Amber's defamation claim. And us not knowing whether Depp knew necessarily could actually be Waldman's defense if Depp wanted to go after him. And both of those two can technically be true at the same time.
The area for liability for Adam Waldman for professional responsibility issues would have come from him revealing the confidences of those communications between himself and Johnny Depp. So the fact that he was a stone wall is exactly proper.
Yes.
Yeah, and the liability on that would have been huge in the sense of not only would it have implicated
his career would be over.
Yeah, that would be the bar association be like, we have opinions on this and you're not going to like them.
Mm-hmm. Well, even if he kept his license, nobody would ever go to him again.
Yeah, I certainly wouldn't go to a lawyer who had a reputation for dishing about his clients.
Yeah.
Yeah. Reb K0405 says ministers, weddings and funerals.
They do those.
They do indeed. Nita says, someone please cover the Murdaugh murders. It's huge in the South. I'll write that one down as well. I'm getting so many ideas.
That's great.
For content. And I love it. I absolutely love it because that's one of the hardest parts about this job is finding the interesting topics to talk about. So I love the fact that people are tossing all kinds of stuff our way. D-Stank or D5 Tank? D-Stank says, question to all. Do you have a favorite dedicated deck card game like Munchkin, Exploding Kittens, Uno, etc.? Yes, Goat Lords. Also Crypto Cartel, because I kind of have to say that because it's my brother's game. But I legitimately, genuinely do love it.
Just Cards. I'm playing one called Radlands right now. Love Letters, a big standby for parties.
Oh, that's a good one. Yep.
Love Letter. And then you want to go bigger. As I said earlier, Marvel Champions is one of my favorite games ever. So,
God, you all have way more friends than I do.
If we're including sort of board gamey card games, Saboteur is my recommendation.
All right.
I remember Crazy Eights.
Sure.
Paula Lorraine Russell says, hi guys, have you ever looked into South African law? Things are a little different this side. What would be your take on it if you relocated? I have never looked into it.
I can honestly say I have never looked at South African law.
I haven't the slightest idea on earth.
If there's a case with a South African lawyer, I'd be open to possibly talking about something if there's a case that comes up that would have American interests as well, for sure.
Sure.
Yeah. And I say this having been to South Africa as well. Also, I love South Africa. It's like California in an alternate universe. It's really cool. I love it because it's like a similar sort of culture, except for where all of the buildings in Southern California are like a Spanish style. In South Africa, obviously, this is going to sound stupid, but like the style is African. Obviously, duh, it's in Africa. Genius, right? But like they have a big skateboarding culture, big surfing culture, except they have penguins. It's really cool. Awesome. Which
penguins make everything better.
That is true.
I got to jump in real quick because somebody's saying, why did nobody say Magic? Yes, of course I played Magic. I played Yu-Gi-Oh! I played Pokemon. Those are not table card games. They're trading card games. It's a different genre.
Well, I'm never going to say Magic because that would sound like I'm saying something nice about Mark, and I don't want that to get back to him.
No, of course. And also, Mark has a really fun game too. It's very similar to Cards Against Humanity. His I Feel Attacked game. I do have to mention it as well. It is
absolutely.
I'm under no obligation to push that for him. But we had a bunch of friends over, and last time we did, and we played the game, and it was a lot of fun, especially where wine was involved, and having conversations about bias.
I don't have any wine, but I'm bringing it to the table next time because Mark was nice enough to send me one. So I'm looking forward to giving it a try. And giving my honest, constructive criticism, Mark.
Patrick Rutkowski says, how are the no research restrictions enforced during jury deliberation? Are they supervised or is it just trust? Well,
just trust. At least on this one.
It's an honor system.
It basically is. I mean, they're all sitting together in that jury room while they're deliberating. But as soon as they go home, nobody's watching them. There's no surveillance.
It's trust, but also narking jury members. Sometimes other jury members.
Oh, that's true. That's true too.
Yeah, juries will narc each other.
Thank you so much. Uncivil law. What are you doing? Number one, why are you donating? Why are you giving this much in super chats?
Hold on. Uncivil law. Devil face emoji. eggplant emoji, water squirting emoji. Check this link for hot uncivil cam action. Cheaper than Tinder. Follow here. Kissy face emoji. Thanks, Kurt.
I love it. I absolutely love it. This is hilarious. Thank you so much.
Thank you for letting me do that, Alita. I have to read the emojis.
Of course. I'm glad you did. Elena Morales says, what's the time limit for the jury to deliberate? Basically what the judge says it is. If she feels like they are at an impasse and they've been at an impasse for long enough, that's when she'll declare a mistrial. But she's going to try to give them as much time as she thinks that they need, especially if they are continuing to make progress.
I think she's got a lot of patience on this one because she does not want this to go again.
Yeah.
Right. KW New York Upstate or NY Upstate says, can I deny someone legal counsel in a lawsuit by first having a consultation with every lawyer in the jurisdiction so that they must refuse due to conflict of interest or at least get rid of the good ones? This is unfortunately a strategy that people with a lot of wealth can do and sometimes do.
Oh,
this is a common divorce strategy.
In Canada, they've actually, on a few cases, come up with an interesting counter strategy. And the counter strategy is, okay, you intentionally made it impossible for the local side to get a lawyer. We're going to award solicitor client or costs. So you pay 100% of their legal costs ahead of time, like midway through the proceeding.
Whoa.
So you're paying their lawyer during the proceeding at 100% rate, which real expensive. So don't do this, people. This is what we would consider... in bird culture, this is considered a dick move, and
technical term.
Yes, and also it can be, if you do this in the wrong jurisdiction, it can be very, very expensive. Also, this is part of why lawyers will charge a consultation fee, is to prevent you from just basically knocking them out of being able to hear the matter for nothing.
And Law and Lumber says that this happens to me a lot. People go around and pay exclusionary retainers to conflict out all of the best divorce attorneys. Blah.
Yep,
Blah.
I know it in my area.
That's disgusting.
It's a divorce
Sucks.
strategy. Yeah.
I hate that. I hate that so much. Lynn says WFTP is based off an Agatha Christie book. Interesting.
I'm sure it's okay anyway.
That's witness for the prosecution, I believe.
Did you just knock Agatha Christie books, Ian?
I absolutely did.
Okay, we'll talk later, man.
Shindogs.
I will keep doing that as long as people will let me. So.
Shindog City says, have we discussed Depp's Public Enemy yet? I am a Hoosier. I recommend it. Love you, Legalbytes. Love you too. I have seen it. I think it was really good. I really enjoyed it. I don't know what you guys thought.
I don't think I've seen it.
It's a good popcorn.
I saw a movie that Rick has not seen.
I'm sure there's tons.
We can wrap it up today, guys.
I have not seen it.
We officially have found the one that I've seen that Rick hasn't. It's good. It's good. I really enjoyed it. Aaron Liu says, good law movie, The Accused with Jodie Foster, Kelly McGillis. It's a true story. Good. Really good movie.
Yep.
You know, I'm going to add it. The Accused.
And by the way, I usually don't like law movies, but there are a handful that are just very good.
Yeah.
Really all Agatha Christie, Ian?
At least I got a peeve with her, and I actually took a class on detective fiction, and I had a rant during it on
Agatha Christie.
Well, on Agatha Christie, and it's easy to write a murder mystery if you're willing to lie to the audience or to the reader.
Oh my goodness!
Are you going to tell me you murdered John Grisham too?
I haven't read any John Grisham.
Well, but I mean, Agatha Christie, I thought that was one that we could all agree on. They're pleasant enough. No?
Give me Raymond Chandler, and also give me Raymond Chandler's essays about Agatha Christie. He's got opinions on her too, and I tend to agree with them.
Okay. Cynthia says, as a point of law, can Penny dismiss / set aside the jury's verdict if she disagrees? She seems pretty team Johnny. She can't just decide that the jury is wrong.
Yeah. No.
She can limit the damages on the case. if she thinks that they awarded damages that are way outside the scope of anything that has come into evidence here in this particular case. So she can limit the damages, but she can't just say, sorry, jury, I let you guys sit for a week and argue and fight about this, but I'm going to make up my own mind and do my own thing. Nah,
that 6 weeks of
she just goes full Galadriel. Yeah, no, I mean it's
technically in theory, but it's more than there's no way in hell that's happening.
But it's more than just disagree anyway. It's essentially functionally impossible that the jury came to the conclusion it came to.
At this point, with all of the evidence presented, there's no way you can find the standard, which is that no reasonable jury could have come to the conclusion they came to.
Mm-hmm. No. Alex says, Alita, if you instead had decided to become a psychologist, just so that we're all clear, would you have been board certified? Seems important.
Wow. Would you have taken dinner and drinks at a potential client's house?
Drinks.
A Moscow mule. Not a real mule. Elaine
at his house,
at his
where
house.
He is present.
You don't mean there was a mule there? No.
What, if any, boards would you have been certified by?
How many alpacas would you have drank?
Yeah, exactly. Question. Thanks for the legal English advice. Lots of ideas, lots of lesson ideas. I hope my students will agree to look at something other than tenders and tax law. Oh, of course, of course.
Nobody should be forced to only read tax law.
Oh, although it's funny, I think tax law is the most boring, or one of the most boring things on the planet.
Very technical.
And but weirdly, all of the lawyers I know who went into tax law just love it. Like they're all like, yeah, I love my job. And I'm going,
I was going to say this, that I think tax attorneys in the United States have the highest job satisfaction and like self-reported quality of life of any field. Because again, you only have to work 3 months a year.
They're specialists. They stick their head in. Not my tax people. My tax people are doing mergers.
And if you think about it, it's like you have to worry about the client versus the IRS. It's not the client versus some other individual where there will be some sort of like fights in between them. You know what I mean? So it's like, if you understand the IRS and you understand the client, like you can just have a very peaceful existence.
And nobody's ever going to give you grief when you go to a party for representing people against the IRS. Yeah. Like as a criminal defense lawyer, anytime you go to a party, people are going to say, oh, how could you do that? But if you're like, I fight the government, and specifically the government on taxes, people will just be like, bless you, let me buy you a drink.
Ian, I do insurance defense and first party work. Everybody hates me. I am the guy that everyone hates.
Oh,
I do criminal defense, so yeah, that
flip a coin.
We'll have opinions.
Sorry, is my wife in the chat asking Rob saw-based questions? I don't. Okay, all right, honey. Yes, she's asking about a difference between a scroll saw and a skill saw.
Oh,
that's my wife, ladies and gentlemen.
She knows a heck of a lot more than I do about any of that stuff. Michelle says, small request, would love a status bar on your screen during deliberations at all times, e.g. jury is still deliberating or jury has left for the day. Would help those of us who are popping in and out. Thanks so much. Well, if you take a look at the chat right now, look at that pinned comment right there. That's exactly where you got it. Jury has gone home and will return tomorrow at 9 a.m. is what it says. Stephen Even Show, thank you so much. Just Goron says, if we get a hung jury / mistrial, what would that mean? I'm not that familiar with U.S. courts. Would the trial restart? How would they find a jury that is unbiased after such a public trial?
That's a question.
All of those are difficult questions, but it wouldn't automatically restart. It is up to the parties to determine if they want to relitigate, meaning primarily it's up to Johnny Depp to see if he wants to refile.
And they'd have to look under rocks for, people who have not made it outside. And like, they're going to need a jury of like shut-ins and weirdos. So
let me ask, if it does end up in a mistrial, what are your opinions? Do you think it's even worth him to go back? Like, he accomplished what I think his ultimate aim was already.
Depends on the news coverage. If the coverage is all basically negative for him, which so far it hasn't been, well, a lot of it has been, but the people have sort of seen, so there's a lot of people who are behind him, but it may be that he feels that he has to. I don't see him as a vindictive guy. but that also could play into
Well, that's
it.
what I'm wondering is that if he refiles, does that change the narrative to it being vindictive?
It might.
And I'm wondering what that calculus would be.
I'd certainly have a talk with my client about that, because whenever you're doing anything reputational, the Streisand effect is a big deal.
Yeah.
True. Stephen Evenshow, thank you so much. Lesmond DeGaunt says, Hogue, wall pick should be screenshot from The Measure of a Man. It's not a bad idea. J. Michael T says, could the first count of the motion be formalizing one of the objections in closing, since we don't know exactly what was objected to?
We do actually know now. That's all in the motion. So,
that actually is in fact true. What this person is suggesting.
Yep.
Yeah. MJ's road trip. Thank you so much. Stephen Evenshow says, would you fight AH in a YouTuber boxing ESC thing?
Hard pass on my end.
Yeah, I think.
I don't know.
How about Hogue or Hogue versus Depp? No. I would not.
Now, Alita, I don't know. I mean, what's the payout on this thing?
Right? My dignity. If I have any left.
Hogue versus Depp. No, the question was about me. No, you can't. I need to know more details here.
You versus Depp?
Yeah, I mean, Depp is different. I'm not going to go hit Amber Heard.
But that would be absolutely terrible. So.
No, not going to do that.
I don't think that I could see myself getting into a real boxing match with anyone, especially not in the format of these YouTuber boxing matches.
I feel like there's a good payout. I don't know.
Yeah.
All right. I'm going to take it under advisement. Call my people, Johnny.
He'd get beat up by Johnny Depp, and I bet he'd be pretty good at the smack talk while he was doing it.
That's his language. I'd be getting slams like all poetic like and with ridiculous insults. It'd be crazy.
And I mean, if he did it in character, that would be even worse.
I could play that up, man. I could play that up.
Totally. Joskim Engstrom says, you ever without verbs? Many laughs without verbs.
I just like that. The question is the joke.
Oh, did you play Star Control 2?
Yeah, of course I did. I said it's my favorite game of all time today.
Oh, okay. I missed that. Sorry, I wasn't on when that came up, but that very much felt like a comment from the, what do you call it? The ORs.
Wow, we got 2 Star Control 2 references out of nowhere, straight from the early 90s. It's Ian Runkle and Rick Hogue.
Is that the all your bases are belong to us?
It is not. And -5 geek points for getting those confused.
Oh, no. You get some cracked geek points.
Forgive me. I'm lacking about a decade on
not
you
his
folks.
fault. His warship is defective.
Moonchild84 says, why did AH team constantly bring up Manson? Because he's the boogeyman.
Spooky. Didn't they make it clear enough that he's spooky?
I think they wanted to suggest that he's somehow at fault for not manipulating, but like, I don't know, influencing, or the fact that he's friends with Johnny Depp is this like terrible, awful thing. I honestly don't know.
I don't think that got any traction though.
No, it was never tied to anything. It just became this meme at a certain point.
Listening to it when she wakes up, he's listening to Marilyn Manson music in the living room. It's like, really?
Yep.
People were asking what was the jury's reaction to that. I'm like, if you thought that the jury was going to be making like the oh my god scary face, they were not. They were just kind of like, okay, she's saying Manson again.
Sally asks, what's the minimum number of yes does it take per statement to win a claim? Does there have to be one yes per statement? Also, love you guys. Great job.
That's the thing.
Yeah, everyone has to agree on at least one statement in order for Johnny to win. One of the 3. And then same thing with Amber Heard. But it has to be unanimous on that particular statement, but they only need one statement to win. The Law Patrol says, depends on the state. A notary public in Vic, I believe Victoria maybe, is a lawyer that has had further training in order to notarize documents for use overseas. This is different from getting a state declaration, I'm assuming, done, or docs certified by the pharmacist, etc. Interesting.
That'll be a statutory declaration.
Thanks, Ian.
Statutory declaration. That makes sense. Interesting. Cool. Doo-doo says, Chu drops head plus consoled by CV after judge talks. Huh.
No, this answer that answer, if anything, was good for Depp. I don't know about the question.
Unless it was about the motion that he had.
Because yeah, they would have really liked to have won that motion if they could get it through.
Sure. Yeah, agreed. Karen Glynn says, couldn't Depp's team ask the TMZ guy if the person who sent the video is in the courtroom?
Like all Matlock style? Can you point to the individual? He doesn't know.
What is she wearing?
That guy never knew. That's the thing that was weird about that whole
know.
TMZ stuff. It was all inference. It was good inference, but he never knew specifically.
Yeah. Veronique V says, Kathleen Zellner on Twitter, in all of our 6 to 8 week multi-million-dollar verdicts, the juries were out 3 days. Hard to award damages in less than 3. All right. Andy Henthorne says, I don't know if you have seen or heard, there's a YouTube video of Dr. Spiegel offering to lie in his testimony on Elaine Bredehoff live mic. She forgot to turn off. The LOL, is this fake or true?
That is not how I heard that.
Fake.
I took that as
fake.
That is fake.
Someone certainly rely.
Yeah, what can I rely on? Not what can I lie on. Yeah.
Yes, exactly. Yeah. What can I rely on as opposed to what can I lie on or lie about? Yes. So I understand why people were alarmed by it because of that mistake. It's but yeah. It's essentially, it's a nothing burger. Folks ran with it, but don't give it any more air because
he was bad enough. You don't have to accuse him of lying. He was bad enough to represent himself anyway.
Like that entire team of something really egregious, and I don't think that we're there.
Yeah.
Yeah.
Artful Stampin' with Ruth says, will you be following the Kevin Spacey case? Thanks for all you do and all you've done these last few weeks. That's another one that's very interesting to me. I think that's out of New York, or is there a UK case? I think.
Might be two. Just got filed. He just got filed with charges in the UK, right?
That's right. Yeah, but I think
so,
there already is one in the UK or in New York as well. I thought. I'm not sure if I'm mistaken on that. But yeah, the brand new one is in the UK. Libby Henning says, did anyone catch that the text JD said he didn't type actually said incoming, not outgoing? Yes. Yeah, we talked about it, about something being rightfully his. Yes, we did. But the thing is, based on what we could see on that text, it wasn't clear to us whether that was a smoking gun one way or another. It just made that text confusing more than anything.
It depends which phone it got grabbed from, et cetera, et cetera, et cetera.
Exactly. Nick Hetty says, question, Hogue, what was the best anime of 2021 and why was it Arcane?
It was Arcane because of the wonderful art style and deep narrative themes that were also juxtaposed against great musicals and sets up for a fantastic second season. So it's Arcane.
No spoilers on that because I'm still going through it. But
all I said was it looks good. It has a great story and good music.
Yeah.
I'm trying to remember. Arcane, that was the League of Legends.
Yes.
That was absolutely gorgeous and really well done.
Arcane's fantastic.
It's funny because League of Legends I'm not a fan of, and so I really didn't expect to actually like that. And I really liked it when I'm still going through it, but I was like, wow, this is really good.
Arcane's amazing. Look out for that episode 3, folks.
They used to have extremely deep lore in that game, and they kind of got rid of it, and then they brought it back for Arcane. So I'm happy to see that. I haven't played the game since college at this point, but yeah.
Addie says, Runkle, how is your dog? I hope Puppers is okay.
He goes in for x-rays tomorrow, so he's going to be very unhappy tomorrow morning because he's not allowed, because they got to sedate him, so he's not going to be allowed breakfast. And if there's one thing puppers love more than anything is breakfast.
No.
Well, other than dinner. He likes both of those things quite a lot. So
I can understand with Indy. Wildwood's Dreaming says, no verdict yet. That's correct. Richard Freeman says, Hogue, remember Isaiah Thomas Barr, Morley's PB for the win.
That's right. Isaiah Thomas had a candy bar. I didn't remember it until you just said it.
Kim Duff, thank you so much for your super chat. Simply Simple says, question, how long do lawyers need to hold on to bankers' boxes of files? Once the case is over, are they able to store the documents to a cloud drive? Well, usually there's going to be some sort of language in the attorney-client agreement that they sign at the very beginning of everything saying, we will be storing your documents for a certain number of years. Come and get it within a certain amount of time. Don't expect us to hold on to it after that.
Generally speaking, at least in New York and I believe Florida, a lawyer is required to keep their files for at least 7 years.
I think my engagement letter says 7.
They recently extended it here. I think it's now like 10. I mean, and there's a lot of storage costs. The problem is in terms of digitization, you can, at least where I am, but the flip side of that is that if you go and digitize it, think of how many man hours it takes to go through all those files and run them through a scanner.
Unless you already have them digitized. Because
Yes.
I've worked for firms where they basically said we don't keep paper unless we
they're like
except for the
paperless
parts that we
offices.
absolutely have to.
Which
Mhm.
drives me nuts because how do you review a document if you can't sit there with a pen and just read it? That maybe I'm old fashioned
On
as
your
a young
screen?
person, but
On your
That's
screen?
why you
I
get-
hate
you get it-
reviewing documents on my screen.
I've literally haven't printed out a paper document in the entire existence of Hope Law, I don't think.
That's why you get a remarkable.
Oh, tell us more about this product. Is it good?
I actually-
Stephanie has one of those, and yeah,
I love it.
I can't.
Yeah,
I absolutely love it.
Since the last time you pitched us a Remarkable, all of my Twitter timelines include an ad for Remarkable. It's pretty impressive.
No, really?
Well, I guess
that's
gonna
scary.
be mine too now.
Yes, please report on whether or not you get Remarkable ads in your Twitter timeline because I've never seen them before ever. And then Alita and I had a conversation that was like, "My Remarkable is sweet," and I said, "You're Remarkable. What is that?"
I'm like
thing?
the last person that still has a freaking printer on his desk.
I have a printer over there, but it mostly doesn't work because I use it so rarely.
Yeah. Zeke says, "Can jury misunderstand the answer and not use Y/FF?"
Please no pitching. She doesn't have a sponsorship with Remarkable. It's a joke.
Yeah, I don't have. Yeah, exactly, guys. There's no sponsorship. There's no affiliate link. There's no. I just genuinely love its product. They're getting free advertising.
We're
from
trying
me.
to get her a sponsorship from these constant mentions.
I'm still waiting for a boat.
So FF was the jury instruction, I believe, related to using the statement as a whole.
Yes,
I
think
don't
so.
know what Y is referring to.
Yes, FF maybe.
Maybe.
Don't know.
Could be, but yeah.
Look, a jury does not actually have to follow the instructions. I hate to break it to everyone.
Technically, it's true. As terrifying as that sounds for the lawyers involved, yes. Phil Jones says, "Can JD sue R. Murdoch to retract son wife beater?" Nope,
No.
because that case has already been litigated.
Res judicata, folks.
Andara Bledden says, "I've heard you reference liar, liar opinions. I have not seen that case in a long time, but I do remember the objection. This is damaging to my client."
Yes,
it's devastating to my case.
Devastating to my case. Thank you. I can't even
Overruled.
quote it properly.
Good answer.
Francis says, "How about The Good Wife? The lawyers in that are hysterical. My parents loved watching The Good Wife. I don't know if it's still running or if not, but they watched the entirety of that. If it's
The
not,
Good
still
Wife
running.
is over, and The Good Something Else is the sequel series with like Christine Baranski. The Good, it rhymes. I'm sorry.
The Good Lawyer or something like that.
I mean, I think it rhymes with wife, but I apologize. The good right. Whatever. You go find it on Paramount Plus. It's over there.
Yeah, but that
The Good Fight. Thank
they
you,
do
chat.
fall trap to a lot of the Hollywood tropes that you
Oh, of
find
course.
about lawyers. Oh, The Good Fight. That's it.
So it didn't rhyme so much as have a similar middle sound. Sorry about
Sure.
At some point, I should bring you guys on, and we should have a discussion of which Hollywood tropes do we hate most about lawyers.
That's not a bad idea. Aaron Fleming says, I'd be interested to hear y'all's thoughts on the defense or lack thereof for Chandler Halderson. Which one is Chandler Halderson again?
I'm unfortunately not aware.
It rings a bell. It rings a bell. Is that the middle school kid who shot up his school or something?
I'm not sure. It might be Canterbury, but
sorry.
Oh, yeah. I'm not sure. Yeah, I don't have enough information. He's killed his parents. Oh, yeah, that would be
that was Canterbury. Yeah.
That one, I think I popped into that case for like a minute and then found my way out fairly quickly. I had other cases, other topics that caught my attention. But it's a gruesome one.
Yeah, it's kind of unpleasant.
Yeah. Simply Simple says, Ian, I've been viewing and sharing your older content. Can you please consider creating a playlist of videos that you wished had more view times?
Oh,
I think it's just the videos tab, but
well, the classics, the Ian classics before they were stars. You could name the playlist. I look back in time when Ian Runkle was just Ian.
There's actually a few, well, still am, but there's actually a few that I've been thinking of redoing because they're on sort of important topics. But I guess the one that I would point to is I did one about like things to think about when your kid gets arrested, because there's a whole bunch of interesting stuff around that. And a lot of parents get that wrong, at least in Canada. And, parents sort of often want to side with the police and basically go, oh, okay, well, so you see this situation where parents like talk their kids into talking to the police. And it's tragic because later the parents realize that was not the right answer. And, I've had parents crying in my office wishing that they had a way to take that back. So that one, I guess.
Yeah. Joseph Sebastian says, please discuss the chances of guilty not getting punished based on the effectiveness of U.S. judicial system in restricting efficient lawyers bending the truth. Chances of guilty not getting punished based on the effectiveness of U.S. judicial system in restricting efficient lawyers. I'm not so sure about what you mean by restricting efficient lawyers bending the truth.
Well, I think it's lack of effectiveness. So this whole question is, how do you feel about the guilty going free because the U.S. judicial system doesn't do enough to curb lawyers being skeezy?
Well, I don't like
it.
Better
about it than the other way around, which is the innocent going to jail because we also don't do that.
Yeah, Ian, I'm there with you. I'm fully on the better for guilty to go free than the innocent to get punished. So I think we lean that direction in terms of the structure of the U.S. judicial system, and that's by design.
Yeah.
Yep. Agreed. Moonchild84 says, I recently finished A Time to Kill and enjoyed it.
Book or movie? I don't know why I'm expecting an instant reaction from you.
Yeah.
But
Britt Cormier says, Hogue, how did you not mention Avalon Hill's Titan as the greatest board game? You should have the board from that game on your wall.
Because I don't like Titan.
Ooh.
Yeah.
Sorry.
Okay. Simple Time says, what do you guys think about the Stephen Avery trial, making a murderer and his new attorney? Is that Kathleen Zellner that you're talking about? Because I think I've seen her referencing that case on her Twitter profile. Other than that, I really don't know much about it. I didn't really pay much attention to, I think, the podcast Netflix series that was about it.
I couldn't actually watch it just because I deal with there's just so much. I have a limited appetite for that sort of injustice kind of stuff. And it kind of causes me pain. I'm like, I deal with enough of that in my day to day.
Yeah, for sure. Pollyanna says, Runkle, as a Canadian with no experience with guns at all, how do I get over the gut feeling of absolute anxiety and fear I feel at the thought of any of them? Without getting too far into guns, but you can respond to this one. We've had a number of questions about gun laws here today.
Yeah, go to the range with somebody you trust who can start you off sort of gently. I have a video, but if sometimes people will do this jerk thing where they hand a newbie the biggest, caliber that they have. I don't like that. I don't approve of it. So find somebody who'll sort of treat you well in starting you out. And they're not actually that scary once you get into it, especially if you're being very careful about all the safety rules. If you're at a good range, you should be feeling appreciative of just how careful everyone is being.
All right.
Theophrastus 2.0 says, order 2,000 mules, you get a presidency as a bonus. I'm not sure what that means.
I don't know what that is.
Sander Canfield says, could you guys review the Fatty Arbuckle case? From what I understand, they tried him 3 times for the same crime, and he was ultimately found innocent.
That'd be a fun historical one.
Yeah, why not? I'm gonna write that down. Alrighty. Don Logic says, what do you guys think of the movie A Few Good Men?
Who was the one that ripped it apart when I said A Few Good Men was a possibly good legal movie? Who was it? Somebody went off on it. Was it Kurt?
Probably. I could see Kurt doing that.
I think it's a pretty good movie.
I enjoyed it. I
but,
very much enjoyed it.
I'm not holding to the legal qualifications that some others might be for it, but it's a pretty good movie.
I was the one that ripped it to shreds.
You ripped it apart.
Ah, there you go.
Thanks for coming and admitting it.
It was based on independent investigation by a jury that they came to the wrong conclusion. That should have been a mistrial.
No, that's 12 Angry Men. This is A Few Good Men. Different men.
Oh,
Different
no.
men.
This is you want me on that wall.
Mm-hmm.
I didn't like how that one.
If it's Few Good Men, then I don't really have a whole lot of argument with you.
All right. See, I think it was Kurt. I think it was Kurt that came off and explained.
I think it could have been Kurt.
I do have an uncle who is a JAG officer that said that that's not in any way how that would have been handled.
I'm sure of that.
Also, that one comes down to this moment of basically we've got nothing and we're going for like the Matlock moment, which is just basically in real life that is just you lose because
there is no, just so everyone knows, there is no such thing as trial by ambush.
Yeah,
we abhor that as an industry.
Yes. Yes.
It just sounds like you can't handle the truth. I mean, like that's what I'm hearing.
And I mean, witnesses just don't do that when you confront them.
They don't break like that.
Yeah.
Yeah, they just admit that they wrote the WAPO article about their ex-husband.
They did
Honestly,
do that.
I've got to be
She's
honest.
right.
I thought Camille was a little close to actually breaking Amber in that way.
Yeah.
But it did not happen because it never happens. But that was as close as I saw someone coming to that verge.
Well, and the other thing is everyone was asking, like, how wowed was the jury by that moment? I can tell you they were zero wowed. The jury had reached that conclusion long before Amber said anything. I don't think that her admission there played any real role in things.
I believe you.
Well, it was dramatic.
Mr. J says they didn't ask JD if he just really doesn't like cabinets. This might have been a crucial detail that they missed. What are your thoughts?
That should be a comment for Rob.
Tell us about your vendetta against cabinets. What did the cabinet do to you as a child?
Exactly. He was hurt by a cabinet once. Maybe a cabinet hurt his finger, and there were reminders of that throughout his life and marriage with Amber Heard. You don't know.
Yeah. Cindy Sue says, we are a huge board and card gaming families and go to BNC gaming conventions. A good review and how to play YouTube channel is Dice Tower on the web, Board Game Geek. Try 5-Minute Dungeons, Citadel's Werewolf, and Just One. You know what? I'm not going to write down all of these. I'm just going to screenshot this because these are some new games that I have not played that I should look into.
I'm a sit down and shut up guy. Dice Tower is pretty good. The Man vs. Meeple is an excellent YouTube channel if you're interested in board game stuff. But yeah, lots of good board games. That's awesome. Board game conventions are pretty fun.
How it's played is pretty good, and I'm not affiliated at all. I just enjoy their content. But if you're talking about the werewolf game, the one problem that I have with it, I think it's a very well designed game, but I always get murdered the first night. So,
as one does.
I actually know how game theory works, and nobody wants to play with me.
But I'll probably let you guys go. It looks like I am 5 minutes to starting up my scheduled time, so I will see you guys later.
Yeah,
right,
see you, Ian. Thanks for stopping in. Tor Theo says these. Oh, sorry. God, every time. I'm so sorry. Tor Theo says these SC2 references make me praise Jeffo Wup. Jufo Wup?
Jeffawup. It's Jeffawup. Sorry, like I said, Star Control 2, you go around, you see all these different aliens. They all have really cool idiosyncratic ways of speaking and goals and bizarre things that they want to do. And in this particular case, they praise Jeffawup.
You see, when I see SC2, I think StarCraft.
Yes, StarCraft 2 is not nearly as unusual, inventive, or original. So I like StarCraft.
I don't disagree.
Jeremy Chung says, check out Murder Mysteries, Devotion of Suspect X.
Okay.
Simply Simple says, why was Elaine so fixated on the amount Dr. Curry made? Have you decided on a weekly group chat day or night following the trial? Well, I mean, I do have latest in the law that I usually do on Thursdays at noon East Coast time. That may shift over time. I don't know.
Can I identify as a lady?
Sorry. Latest in the law, not ladies in the law.
Sorry, I misheard you.
Yeah.
There was a lot I misunderstood about this conversation, so I appreciate the clarification. Yeah, you're moving on for Thursdays, maybe. All right, we'll see.
Maybe I don't know. We'll see how things shape up after this.
In terms of what Curry made, that is something you always do with every expert, and yeah, it depends on how much you know about it. But Curry was not making, in my opinion, I think, what was she saying, $650 an hour and $5,000 for the day for testifying. That is not outlandish numbers. That's close to industry standard.
I think the reason why they were hyper fixated on it is because they didn't have much else to go after with their experts.
You always have to bring it up, but that is almost kind of a desperation move. You have to do it, but the fixating on it is a little bit of a desperation move.
And having it come up first is the other thing, is that it's not your strongest thing if you've got
that's
other
the last
good
question
stuff.
You ask.
Or somewhere in the middle. Like that's what Dennison did when he was cross-examining the other experts, is he would get into, let's tear up, everything that you just said. Halfway through, by the way, you're getting paid $1,000 an hour, right? Okay, yes. And how many hours have you spent on this? Okay, so you've made about approximately this amount for your testimony, or prior to your before your testimony today, analyzing this case, right? Yes. Okay. And then he goes in and he finishes his cross-examination.
Yeah.
So like it comes up. That's natural. That's normal. But yeah, I do agree. The fact that they are hyper fixated on it, it's the first thing, predictably the first thing that would come out every single time from them. To me, it just kind of says that's all you've got.
Right. You don't actually have substantive impeachment. Yeah. You're impeaching them based upon the fact that, they're a paid person.
Yeah. Jim Kinch says, have you ever looked at Stephen Donziger trials and Chevron litigation?
Yeah.
No, I haven't. I'll write that one down too. All righty. Carly loves Big Bang German Hogue fan club says, is there even a possibility for JD to completely prove his innocence? I think he presented surprisingly so much in this trial. It would be sad if he would lose. You can never destroy doubt.
You can never prove a negative. So Johnny Depp's case is strong, and it's as close as you can probably get reasonably. So I think a lot of people support him out in the public. And I think that's one of the reasons why he might not appeal if he were to lose and he was to otherwise mostly maintain his momentum.
That was one of the things that was so weird to me, because somebody commented on Nate's stream last night that in Scotland there are 3 verdicts. One is innocence, one is indeterminate, and the other is unproven.
Yeah.
And I can't imagine how you could ever prove innocence on anything.
In a coma at the time, with a camera on him.
Even then, who knows? Maybe the camera malfunctioned.
The level you can get to. 3 people were also in the room. It's
just a weird standard of proof to try and ask somebody to prove innocence.
Mm-hmm.
Yeah. Magic Medic says, JD already won. Celebrated people. AH deserves shame and got it, but now we should stop mocking her. Nobody wins if she killed herself. Absolutely. Completely agree. Don't want to be responsible for that. Plus, also don't want to give MSM an excuse. Yes, 100%. Cannot agree with this more.
I agree entirely. I would like to believe, and I'm not, don't anybody attack people or take anything I say beyond. What I'm just saying is I think Amber is far too much a narcissist to ever actually go out that way.
Could be, possibly. After having seen Gone Girl, though, and the plans that she had in that movie, I don't know.
And that is a legal document. I mean, we do know that.
What's that?
That Gone Girl is a legal document.
I said it was a legal document.
A legal document.
We do know that.
It is.
She's gonna find some way to claw back to even if she loses, and nobody should pile on and nobody should try to push somebody in that direction. I just want to make that very clear.
100% agree. Braxton Grundy says another good anime is Berserk.
It's too violent for me, I have to be honest.
Kel's Mac and Cheese says, more likely a right-handed abuser leaves injury to the left side of the victim's face. Secret message to the jury in JD writing so much. Any thoughts? More likely, but that doesn't mean that it absolutely is the case.
The two biggest injuries are a headbutt and a cell phone throw, as described. So neither of those require handedness.
That is also a fair point. Well, a cell phone throw arguably would, but not in the same way as.
Well, I mean, you did throw it with a hand, but in terms of where it hits, it doesn't matter which hand.
Yeah, but at the same time, then that would invalidate the whole point of him wearing rings on his fingers, because she was claiming that he actually struck her open-handed.
Yeah, but Camille was focused on the first 3 years of whatever. The big two events in December 15 and May of 16 are a thrown phone and a headbutt.
Yeah.
Claire says Arcane is incredible, but not considered an anime.
All right, we could talk about this, folks, but in general, I use anime to mean more adult-facing animation and not Japanese.
Okay. Dave Snigier says, if AH is hit with a large judgment far greater than her net worth, can she use Chapter 7 to wipe the slate clean of this and her pledge to the ACLU?
Legally, there's one answer to this. If she's hit with punitives, the answer is no. You cannot escape punitive damages in bankruptcy. If it's compensatory damages, she can petition the court to relieve her of compensatory damages. That is my best understanding, and if anyone disagrees, please let me know.
Sure. Tor Theo says, tomorrow equals Narcissistic Abuse Awareness Day. Verdict, please. Yeah, that would be nice. Lita Randolph says, I can listen to Runkle all day, every day. His voice is soothing, and I love his Canadian accent. Bonus, he speaks French too. Agreed. Agreed on all fronts. Carly loves Big Bang German Hogue Fan Club says, Hogue, you need an Aquaman poster with Momoa behind you.
Oh, Mrs. Hogue Law would love that, wouldn't she? We'll see if we put Jason Momoa up here.
D5 Tank says, just call me D. Okay. For any and all panelists in criminal case, do you have a trial that is the worst case of prosecutorial misconduct, like Batson versus Kentucky?
Like literally Batson?
Are there much worse cases than that?
I think there's a reason why we use that name for Batson rules. I don't know that there is a one that's any worse.
I don't know. The original Miranda, maybe. I have no idea. I don't know the answer to this question.
Yeah,
Miranda wasn't even a bad case.
I know this. I'm struggling for an answer.
Fable says, what emotions do you feel when you successfully defend a client you really believe is innocent during a criminal trial? Well, I have never defended a client in a criminal case, but I will say that when I have achieved a successful result for my client that I really felt was wronged and I knew was going through a lot of emotional pain for a long time and a lot of anxiety and all kinds of stuff, I felt very, very good in getting that result so that she could move on. She or he or they, but there's a few in my mind that I have specifically there.
Good. That's awesome.
Likewise, I've never specifically defended a criminal client, but same thing. I've been part of teams that have defended doctors who, the insurance company told them you should settle, and they're like, no, I want to go forward and clear my name, and that feels really good when the jury comes back with a not liable verdict.
Absolutely. Otto Taz says, question, what is your opinion on the TV show Suits?
Nobody's watched this show, right?
Yeah.
Garbage.
Oh, never seen
it. It's a guilty pleasure, but it's a garbage show if you're asking about anything regarding law.
All right.
Patent case, episode 1. BS.
All right. And we've got Law and Lumber back as well.
Law and Lumber.
How you guys doing?
Look at the dramatic lighting for Rob. He's got like theatrical lights.
He's already getting into the full YouTuber spirit here.
You got a better camera than me already.
Hang on, Rob. Do I see some bruise on
Have
your
you been
on
slapped?
your right?
Have you been
your
slapped by
right
Johnny
side?
Depp?
I have not. That actually is a shingles scar from when I had shingles last year.
Sorry, I was not trying to make a joke.
No, it's
I was
funny.
not trying to
It's
make a
actually-
joke about that,
it,
but
it wasn't a joke. It actually, the chat has done it before, and it doesn't bother me at all. It's
okay.
Yep. I came in to give a shout out to Mrs. Hogue, who is quite literally the champion who has taken over the chat and has won over hearts and minds, left, right, and center.
Oh yeah.
Yeah.
I love it. I love it. I saw her in the chat and I was like, why haven't I already made her a mod? I need to make her a mod. So I handed her a wrench.
We'll talk about making sure she's not drunk with power in there. Let's
No. She needs to be drunk with power. Rick is the forward face of the operation. Mrs. Hogue is the brains of the operation and the heart of the operation.
Sure. No, I'm happy to admit that. I've said from the start that I couldn't do any of this without her.
That's how it works.
Absolutely.
By never a great man.
Simple. Simple. I'm really sorry that Ian is not here for this, but maybe we can answer. Will you please explain the ban to inherit collections in future video? Where do the collections go? Who makes the money from the historical ones? I'm at least going to super chat this or screenshot this, and then I'll try to get it to him. Maybe he can give an answer on one of his streams. I'm really sorry that he's not here. Jason Shaw Music says, you guys really make me want to get into law, but I'm British and I absolutely refuse that wig.
Sure.
It's a pretty awesome wig, though.
I think you only have to have it for court, though. So there's rules beyond that. So you got that going for you.
Yeah. M. Rika says, why is the case so captivating? Love from Holland. I don't know. A lot of these trials just get captivating overall, but this one has really captured a lot of people's attention. Arctic Arcanum says, in Scotland, the 3 verdicts are guilty, not guilty, and not proven. I was on a Scottish jury a few years ago. P.S. Love the discussion. Oh, that's so interesting.
Yeah, not guilty is you're innocent there, right? And then not proven.
Yeah, maybe it was misdescribed the other night, but not guilty is innocent then.
It's like specifically not guilty. Yeah.
Doc Savage says, when the Depp v. Heard becomes a movie dramedy, who would you cast? Then again, I can't see Amber signing off.
We don't need her permission, lol.
That's true. Yeah, I don't know. We've been randomly casting things throughout, right?
I still think that Kate McKinnon could be Elaine Bredhoft.
She's got to get her huffing down. That's her signature trait.
And the voices for sure. I could totally see that. As far as everyone else, oh man, I don't know. But there could, we could definitely come up with a whole list, I'm sure.
I'd go with Dennison. I'd take Dennison.
Matthew Maddox says, or Madhu maybe says, the Jeffrey McDonald case has always fascinated me as far wonk goes. Interesting.
Yeah, as wonkiness, maybe. I mean, I don't know the case.
I don't know.
How long is your list of written down cases over there?
A lot.
Yeah, people talk about the Murdaugh case from South Carolina. It's a really interesting case.
Yeah,
Murdaugh
recommended.
Yeah, Murdaugh is like basically a king shit lawyer, basically in Southeast South Carolina. Very, very well known litigator, and he's on trial for murder and a whole bunch of other things. So it is a pretty big deal in my former home of the Palmetto State. So, yeah.
Alrighty. Dusty406 says, question off topic, but have you heard of the Quantum TV copyright abuse situation? And if you have, what are your opinions on that?
I am not permitted to comment.
Well, what is it?
It's a DMCA fight between 2 channels, and that's about what I can say.
Fair point. All right. I know nothing about it, so I can't comment on it either. Richard Freeman says, hashtag cucumber sandwiches for the win. What's your recipe? I don't have a recipe for.
Is that what my wife's talking about in chat? Is that what's happening? Because she loves cucumber sandwiches.
She cuts the edge. She said she was cutting the crust off the cucumber sandwiches.
I love it. I want some. I really want some.
She also said that she wishes she could bring all of us snacks, and I said we'd be 20 pounds heavier because of the stress eating.
Oh yes. As it is, I have to ration my Oreos because otherwise.
Your wife wants to bring us snacks.
Yeah, I'm sure she'd invite you all for tea and cucumber sandwiches.
Excellent.
Oh my
You
God,
might
I
have to
love
talk
it.
like you're in Downton Abbey. It really depends on the day.
I'm
love
available. Can I come over to your house?
What is that face from Rob? Rob is ready to down up.
I'm good. And
I will
also have
travel to
another,
see you, Richard.
I have another shout out to Miss Legalbytes. I had a friend reach out to me who made a comment and said that the coolest thing that she saw on the stream that she had to rewind and watch again was when Mr. Bites snuck in and left some food for her on the table just to make sure she was eating. So yeah, cheers to all of the supporting actors that are the lead actors in their stories.
Thank you.
Amen.
Thank you. And yes, 100%. Huge shout out to Mr. Bites. He has been my absolute rock during this entire trial. Absolutely love and adore him. And he has, I mean, yes, 100%, 100%.
Why don't you just marry him then?
What's that?
Why don't you just marry him then?
I know. I should do something like that, right?
You gotta lock it down. That's true.
Eric Williams says, as a male victim of abuse, I think this case is important to show men can be victims also. I also think AH should never have privileged position again. I think so too. I think all of that, all of the above as well. And I am so sorry that I cannot read Greek characters, so I cannot read your name. I'm so sorry, so sorry. If only we had Peter on here, he could probably read it. Mark Gaddis as Ben Chu. J.L. Curtis as Judge PA.
I can see Gaddis. I don't know who J.L. Curtis is. I have to be honest.
Jamie Lee Curtis.
Jamie Lee Curtis.
Oh, yeah, I can see that.
I can see that.
I can see that.
Mm-hmm.
Yeah,
right.
for sure.
Yeah, okay. Yeah.
Awesome. Well, I think that about does it. There's only one more that starred, but it's because it's for Law Talk with Mike, and I was saving it in case he would ever come back. I have screenshotted it. Hopefully, I can get that to him. So, but other than that, that about does it. 11 and a half hours for a stream, even though we didn't even have trial today. So didn't anticipate it would go so long, but hey, we're here. Thank you guys so much to everyone for joining and hanging out with us so that we weren't bored during this entire jury verdict watch. This was day 1. Get ready for day 2. Thank you to everyone in the chat. The fact that there's still like almost 7,000 people watching at this hour is like insane. Thank you to all the mods.
Send him over to Runkle.
What's that?
Send him over to Runkle. Isn't he about to stream
I think he is. I think he is streaming. He didn't give me the link, however, for his stream, so I don't have it set up ahead of time. Yeah. If you can find that, then yeah, that would be helpful. So thank you to everyone in the chat. Thank you to all of the mods for ushering conversation. You guys are doing such a fantastic job. And the Greek chatter says pronounced Giannis, but thank you for the courtesy. Okay, I will try to remember that next time because I remember I've seen your name before, so I'll try to remember Giannis. Let's see here, private chat here.
I don't know if that work or not, but let's find out.
Let's find out. Okay, I will redirect.
Alita's making some redirect sausage right now, kiddos. Let's see if she can actually send you over to Ian Runkle's stream. YouTube, what say you?
I don't know, but Hogue, I need that voice like 9 times out of 10, like for the cheer up, like YouTube, please go and check out this stream. Do
Absolutely. Well, I like to do the fun voices from time to time.
Alrighty. So I have it set up. So hopefully it'll go right over to Ian Runkle's live stream talking about Ben Chu's motion. So guys, thank you so much. Look at all those blue hearts in the chat. I love it so much. Thank you guys. I feel that every single time I see those in the chat. You guys are wonderful. You guys are lovely. Be wonderful, be lovely, be happy, be healthy. And I'll see you guys hopefully tomorrow for another day of jury verdict watch, day 2. Hopefully we'll get a verdict soon. See you guys.